Hi everyone, welcome to Immigration and Jobs Talk Show. I am Rajni Bharara, your host, and today we have a topic that strikes at the very heart of the American dream: birthright citizenship, a legal principle rooted in the 14th Amendment. It has long been a cornerstone of US immigration policy, but now it's under fire. Now, before I say more about it, I would like to read out this very important disclaimer, which is here on the screen. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. Today, we are going to dive into a very important topic, like I said. And to talk about that topic, we have none other than Jonathan Wasden, a renowned immigration litigation attorney with years of experience navigating the complex intersection of law and policy. Together, we'll unpack the implications of the lawsuit challenging President Trump's policies and its potential ripple effects on immigrant communities. What's at stake? How might this case shape the future of citizenship rights in America? And most importantly, what does this mean for immigrants today and in the years to come? So, without any further ado, let me give a very warm welcome to John. So, John, welcome back to Immigration and Jobs Talk Show. It's always a pleasure having you. And today we have a very important topic to talk about. So, welcome back again.
Thank you. Thank you for having me.
Thank you so much. John, without wasting any time, I directly would like to jump into my very first question, which is that is Trump's executive order on birthright citizenship constitutional?
I don't think there's very many people who think it is. I think the general consensus is this is something he did just to beat his chest and show his anti-immigrant following that he's doing something. So the general consensus, like I say, is that this will more than likely be invalidated by a court, and it'll be the end of it. Now, in the interim, until that happens, the real impact is going to be, if you're applying for a passport for a newly born child, the State Department may not issue it right away until a court order comes down telling them that this executive order is unconstitutional.
Okay, but John, can a president really change who becomes an American president? American citizen?
No, it's governed by the Constitution and it's governed by statute. And to the extent that the Constitution doesn't contemplate every possibility, the statute takes over. What Trump and his administration are trying to do is they're taking the very, very clear language in the 14th Amendment that says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. What they're saying is that and subject to the jurisdiction thereof clause somehow allows them to prevent the people being born in the country who are born to non-permanent residents and non-US citizenship. But when you look at the history of that clause, what they're really referring to is diplomats who have diplomatic immunity who are not subject to the jurisdiction thereof. And diplomats' kids, when they're born in the US, have never been granted US citizenship. And so, they're really pushing against common sense, the plain language of the law, and also history. And there's just really no angle that they can take on this that's going to be appealing to a court.
Okay. But then why do you think they did it in the first place? Like, why did they think about doing it if it's not going to go forward?
Yeah, so I mean, Trump's base, they are very upset about illegal immigration from the southern border, and that's understandable. Especially, if you're living along a border state, that's an issue that you're going to be voting on and you want tougher enforcement on. They were also keyed in and aware of the fact that there have been clinics and hospitals set up, mostly catering to Chinese clientele, where the Chinese clientele will come on a visitor visa shortly before baby's due, have the baby here, recuperate, get citizenship for their child, and then go home. And those are the two scenarios that they're trying to prevent and they're trying to stop, is the illegal immigration and the birther tourism, for lack of a better term. But in the mix, anybody who's on a non-immigrant visa here legally and lawfully is also most likely going to be impacted by this executive order in the interim.
Okay. Okay. But then, John, also I would like to know from you that how could the government legally stop granting automatic citizenship to children born in the US?
So I think the way that they will do that, the only way they really can do that is through the issuance of passports or the non-issuance of passports. And so, if you were to apply for a passport for your child right now, proving citizenship would be an issue potentially if you're a non-immigrant or you don't have legal status, until that court order comes down saying, no, this is not legitimate.
Okay. But then has the 14th Amendment ever been challenged in a similar way before?
No, probably because it's so clear on its face, nobody's ever thought that this was a good idea to do. Just looking at the language of the 14th Amendment, it's abundantly clear. And it's, the history of it shows that it was designed to grant citizenship to anybody born in the US, regardless of the status of their parents. So, the people that it affected back in the day were not documented aliens, right? They didn't come here with a visa. Their parents didn't come here with a visa, rather, and they were born to people who didn't have visas or legal status other than slaves. And so to say that the executive order has found some gaping loophole in the 14th Amendment is kind of stretching it a lot, actually. And so I just don't see a whole lot of courts having patience and time for this. I think it's going to be something that gets kicked out very quickly probably in the first month and a half of the Trump administration. They'll take a beating on this one. But it's more of a distraction, I think, from what's going on with the grander issues within the Trump administration on immigration. And it's also indicative of where he's headed. So, there's a lot of buzz earlier about, Elon Musk saying great things about the H-1B visa, right?
Mm-hmm.
So there was some optimism that maybe Trump's second time around wouldn't be so bad for immigration or legal immigration and high-skilled immigration. But, the birthright citizenship issue and the extreme vetting issue, all of that's lining up to show that no, it's just going to be just as bad as it was the first time.
Or maybe worse?
Yeah, it could be worse. I think what they learned from their last time around is, what not to do. They jumped in and rushed into a bunch of things without going through the right process. I think this time they've figured out how to game the system a little more effectively.
Okay. Okay. Well, let's wait what actually, happens there. And the first day itself had so many things coming. So we weren't really, somewhere we were expecting, but we weren't really expecting this much to happen. But then let's see what really happened. But then, John, I would also like to know from you that, how much this challenge to birthright citizenship impact future presidential actions?
So probably not much, because the other court cases are going to be brought against his policies are on issues where the law is not so clear and potentially not quite so favorable to plaintiffs. The extreme vetting piece, that is something where courts are more likely to give the executive branch a lot more leeway and a lot more flexibility to accomplish their goal of protecting the U.S. So is obvious it is as it is what they're trying to do with that extreme vetting. I think the courts are probably going to be more inclined to let that happen. And, let him have his executive order on that issue.
Okay, okay. And could this set a precedent for presidents to reinterpret constitutional provisions through executive orders? Do you think?
Where they're clear like this, I don't think so. Where there's a little bit of ambiguity, there's always the possibility that they can find a loophole, or they can find some exception that a court's going to agree with. But with this case, the language is so abundantly clear, the history is so abundantly clear, and the reason for the amendment is so clear. I just don't see it getting any traction with the court. Even if they get lucky and they get a Trump appointee from the first administration as a district court judge, that first trial court level, any court of appeals that hears this, I think, is going to shoot it down.
Okay, okay. But John, even if, let's say, it goes through, and then what might happen to the children born in the US?
Well, that's a great question, right? Because they're born here, they've been here for a while, at least over 180 days, without any type of visa. There's no provision in the law that says that if you're born in the US, you're granted immediate or automatic residency status, right? Or non-immigrant status if your parents are non-immigrants. And so, what is their status? That the law doesn't anticipate what that would be, because the law has always assumed that they would be citizens if they're born here. So there's a lot of questions that are going to be raised if this was, allowed to go through. And you would find the odd circumstance, or the paradoxical circumstance, where an infant born here in the US who can't even speak would have a ground of inadmissibility for having overstayed and been in the country without authorization for more than 180 days. And that just seems incredibly crazy that they would do that, but that would be a natural consequence of, birthright citizenship being destroyed.
Yeah. Mm-hmm. And do you think, would this create a group of children, who don't belong actually anywhere?
Possibly, yeah. But again, I don't think this is going to stand. But hypothetically, yeah, it could cause problems like that.
Okay, okay. So moving forward, I would like to also know about, how will calling cartels and gangs terrorist groups change immigration enforcement?
So when you throw out the magical T word, the terrorism word, it does loosen up certain funding within the federal government to do emergency, actions. It also gives the federal government a little bit more flexibility in what tools and what things they bring to combat the issue. By labeling it terrorism, theoretically, they're opening up activation of military to combat terrorism. Historically, if you look at it, it wouldn't be the first time that the country has brought the military in to the southern border to fight what amounts to a terrorist organization. Back in the early 1900s, there was Pancho Villa. He was a Mexican rebel that was leading border incursions across and attacking settlements on the U.S. side of the border. And we sent the American Army down there, and they had the punitive expeditions fighting in Mexico, chasing down Pancho Villa. And so there is precedent for using the military along the border. Whether or not we're going to get into that remains to be seen. I would hope not. I think that would be a catastrophe. Having been in the military, in my lifetime, I just don't see that as an operation that we would be set to excel in, because we've learned one thing from the U.S. military over the past 20 years, and that is fighting an insurgency or fighting what's called asymmetrical warfare is something that we're just not very good at, and no country is terribly good at. So it would be a catastrophe if we sent the military south of the border.
Okay, okay. But do you think also, this designation can lead to increased a legal risk of migrants, accused of association with such groups?
hmm Yeah, it does open up new grounds of inadmissibility, or it makes people, qualified to be in grounds of inadmissibility that would prevent them from getting visas or admission into the U.S. if they've been labeled. The problem with that is the way that USCIS in particular and DHS has been dealing with these issues of inadmissibility is completely illegal. What they're supposed to do when they take an adverse action against somebody is they're supposed to give them notice, they're supposed to give them opportunity to respond to the allegation, and then they're supposed to make a decision in writing and give that explaining the law and the facts that their decision is based on. What we see DHS and USCIS doing, however, is they're entering these findings in secret, not telling anybody. And the only time you ever find out about these findings is when you go to a consulate for a visa stamp or you go to the port of entry for admission. And that's when you find out that you've been, listed as inadmissible for one of these categories. And I see that all the time in regards to alleged false statements, inadmissibility based on false statements. And I am suspecting that we're going to see that happening with the terrorism related grounds, is that they will just start using that incredibly freely without a whole lot of thought or discretion, and it's going to be a tool they use to eliminate a lot of people from the pool of those that can come to the U.S.
Okay, okay. Thank you for answering the question, John. Also, what could happen if military is used for border enforcement?
You know, so the border enforcement is an interesting question. It's an easier question to say, can we send the military south of the border to combat narco terrorism? Legally, yes, I think we can do that. I think, practically it would be a horrible idea. Border enforcement's another issue, though. It's quite a bit different and it's more nuanced. So there's this thing called the Posse Comitatus Act. And it goes all the way back to post-Civil War when the U.S. Army was occupying the South. And they were the law enforcement, for the South in the Reconstruction era after the Civil War. And part of the compromise of ending Reconstruction, getting the levers of power restored to the civilians in the South, was the Posse Comitatus Act that said that the U.S. military will not be allowed to enforce civil law, and they have no authority to do that in the United States. And so, the question is whether or not border enforcement, which is on our side of the border, would violate Posse Comitatus. And I think, the U.S. military could serve in a supporting role legally to CBP, like logistics and things like that, because they're not enforcing law. But once they start putting the military into an enforcement role, there becomes a whole lot of problems with the Posse Comitatus Act. And I think that's something that it's a little bit more nuanced, but I think it's also something that the administration will lose in court.
Okay, okay. So, also, how might stopping asylum and refugee admissions affect international human rights?
Yeah, so the asylum and refugee issue, it's a program that in theory is very valuable and it's very noble. What the Trump administration, I think, is responding to is pretty well documented cases of abuse of that noble policy. And there are pretty good documented cases of people that are just running these asylum mills where they give people these backstories, they prep them for these interviews based on facts that never actually happened to the person, and then they send them for their asylum or their refugee screening. And that's probably the minority of cases by far, but it's something that has happened in the past, and I think that's what they're responding to is the abuse in the asylum system. I think for the legitimate folks that are truly impacted by oppression in their home country, it's going to be a catastrophe. They're going to be stuck in refugee camps. They're going to be stuck in their home country with really no protection or no sense of certainty of what's going to happen in their future. But again, asylum and refugee policy is something that the law does give the president a lot of discretion over and how he administers it. So it's something that's probably not going to be very easy to challenge in court.
Okay. Okay. And John, with this, I would also like to talk about, the government and workplace changes. So I would like to know from you that what might happen legally if diversity and inclusion programs are ended in federal agencies?
If there were which program, sorry?
If diversity and inclusion programs.
City inclusion programs?
Yeah, diversity and inclusion programs.
Oh. Yeah, so the DEI stuff or yeah, I think that's any mandatory or encouragement on the federal level is going to probably end if it hasn't ended already. Individual states, individual cities, they're completely allowed to have their own policies on that. However, it remains to be seen how courts are going to handle challenges to that under the Equal Protection Clause. So as we look at the history of affirmative action and how that's fared in courts, the current Supreme Court, being very conservative, they have a view of the Equal Protection Clause that says that you can't give preference based on race to anybody, even if it is as somebody who's been historically oppressed or disadvantaged. It has to be race neutral. And I think where these DEI policies are going to run into problems is, when they're giving preference to certain categories of folks and disadvantaging others, that's going to have equal protection ramifications. And that's something that, in theory, the federal government could proactively sue the municipality or the state on.
Okay, but do you think that cutting federal jobs, can face constitutional challenges?
No, it would. Let me put it this way. If Congress authorizes money, then the president's hands are limited because Congress has said this is how we want to spend our money, and this is the only way you can spend that money. So as long as Congress keeps pumping out the money, the executive branch, is in charge of spending it and has to spend it typically. If Congress is working with the executive in cutting jobs, it's very easy. There's no constitutional issue involved. The only time there becomes a constitutional issue is a separation of powers issue between Congress and the executive. If there's a disagreement there about how the law is being enforced and whether or not the executive is faithfully executing the laws that Congress has created, then that's an issue that can come about. One way that they typically are going to do things like this is not overtly. It'll be attrition, hiring freezes, pushing people out through retirement, just subtle changes in process as opposed to outright layoffs and firings to eliminate positions. So I would expect it to be death by 1,000 paper cuts as opposed to, chopping the head off the snake.
Okay. John, thank you so much for answering all these questions. With this, I would also like to know your viewpoints on the CBP app shutting down. So I would also like to know from you that how will the sudden shutdown of the CBP One app impact nearly 1 million migrants who had scheduled legal entry appointments?
Yeah, I think it's just indicative of where the Trump administration is headed. They want to make life as difficult as possible for people trying to enter the U.S. And that's simple, full stop. They are under no obligation to make things easy. They're in charge of creating process. They're in charge of dictating how services are delivered. And if they throw up obstacles or they eliminate efficiencies, it's annoying, especially if you're an immigration lawyer or you're the person impacted. But it's something courts are not likely to get involved in and tell the executive, no, this is the process you must follow. So as long as they're not overtly doing something illegal, those process type of issues tend to get a pass in court.
So then, what legal challenges can migrants potentially can take against the abrupt cancellation of their pre-approved appointments?
So not much on that. There's if they're outside the country, especially, you have very few rights when you're outside the country, and the executive branch is given a lot of authority to determine, who can enter the U.S. And if you don't have a right to enter the U.S., then you clearly don't have a right to a scheduled appointment. So I don't expect that there's going to be a whole lot of legal challenge to that aspect.
Okay, so John, also does the executive order violate any existing immigration regulation or international asylum protocols?
Well, international asylum protocols probably, but the Trump administration has never really shown themselves to be big fans of international law, and international law is one of those things that is tough because it's all based on agreement to cooperate and to follow. And if somebody opts out of following international law, there's really not a whole lot that you can do, especially when you're the biggest kid on the block. You're the one spending money to support the UN, and you're the most powerful country in the world. There's not much people can do to punish you for violating international law and conventions like this.
Okay. And what immediate risks do migrants face after having their appointment suddenly cancelled?
Just being stuck in place where they're at. I think that's the unfortunate situation is just they're on hold and their lives are on hold while they're waiting for those appointments.
Mm-hmm. And how might this action potentially increase unauthorized border crossings?
So, interestingly, right now, illegal border crossings that are kind of at a historic low, they're greatly decreased during the Biden administration. So I don't know how much of an effect it'll have, because typically the unauthorized border crossings are more a reflection of disruption and problems in people's home countries more than anything. And the lack of border crossings that we've seen, I think, is indicative of countries starting to get more stability and addressing their internal problems, which takes away the incentive for people to leave. So I'm not sure how that'll play out.
Okay. And then how might courts also view the sudden revocation of scheduled legal entry appointments?
I don't think the courts will get involved in that one. I don't think there's really a legal hook to have a successful lawsuit on. Like I was saying earlier, the courts have historically given the executive branch a lot of latitude and a lot of authority to determine who is admitted into the United States. And if the courts have given that authority to determine who gets in, clearly the executive has the authority to determine who meets the first step in that process of admission, which would be those interviews.
Okay. And then how does this action align with existing US immigration laws?
So in terms of the appointment cancellations, I think US, especially under Biden, US immigration law had been trending toward a more user-friendly experience. And clearly under Trump, they're going to be retrenching. They're trying to make it as difficult as possible.
Okay. John, also, I would like to know from you that, all that this is happening, do you think, is this about fixing immigration or punishing immigrants? What do you think?
So I don't think the Trump administration and the Trump supporters have any desire to fix immigration. I think they just want to end immigration. And so I think it's all about making life as miserable as possible for people in the US or trying to come to the US as a way to discourage them from coming to the US or staying in the US. And I think that's you know a trend we'll see as long as Trump's in power, to be honest.
But then, US is a country who's built by the immigrants. And how will this work if this happens?
That is the grand irony. Not only are we a country built on immigrants, immigrant populations have historically, spawned great innovation, economic, recoveries, and success. And the problem we're having in the U.S. right now is that we have a very small number of people that are going into the hard sciences, getting degrees in things that matter, and being prepared for even college and degree programs that are valuable to the economy. And so we're not generating enough brain power in the country to sustain the economy that we currently have. And the only way that we're going to fill that gap is frankly to poach the best and brightest from other countries to come to the US and work and drive the economy. And excluding immigrants, in the Trump mind, if you keep out immigrants, then automatically somehow some kid in the US in the Midwest that didn't study hard in school is going to be qualified to be, an IT professional. And that's just not reality. You know, they didn't study hard enough in high school, they didn't study in college, they didn't prepare themselves, they got an English degree instead of a computer science degree. You know, there's just not, qualified US workers to take these roles over. And so, immigration has been a way that we've been covering that for a long time, basically since the early 90s. And if we cut that stream off, we're really shooting ourselves in the foot.
Okay. Well, also, John, with this, I would also like to know from you that do you think that with these rules coming in, we are actually changing the rules of who actually belongs to America?
So I think they're definitely trying to reshape the landscape. They want to decrease the number of people that are coming. And Trump's made no secret that some immigrants are good, and then some are completely undesirable. And those good immigrants, are Northern Europeans for in Trump's mind. And so, yeah, they would definitely like to change the mix of people coming to the U.S. But frankly, I mean, anybody who's been to Europe and has seen what life in Europe is like probably isn't a whole lot, doesn't have a whole lot of motivation to come to the US, where we have very expensive healthcare, we have ridiculous working hours, and you know the lifestyle is just not very good. And so I don't think we're going to be getting the immigrants from Northern Europe that Trump sees as valuable to the US.
Okay, and also very recently I saw, I think on the inauguration day itself, I saw a tweet from Elon Musk, and where he wrote from MAGA to MEGA, I think make America great again to make Europe great again. So, what do you think this means? What do you think he meant by this?
So there's an American perception of Europe. I don't think it's terribly accurate, but the American perception of Europe is they have let so many Arab and North Africans into Europe that they've destroyed European culture. And you know, basically, it's they want to make Europe white again and eliminate those folks. And that's what you're seeing there when they make Europe great again. Is they're saying return back to your genetic European roots and stop letting those North Africans and those Arabs in.
Okay, so you mean that that whatever decisions this administration is going to take will not directly impact America, but the whole of Europe?
Well, I don't think they have a whole lot of impact over Europe. And I think most European leaders think that Trump's a bit of a buffoon. So I don't see him having a whole lot of sway over their internal policies. But the perception that certain Americans, especially in the MAGA crowd, have is that Europe is, somehow destroying itself internally by allowing immigrants to come in. That's their mindset they have about the U.S. That's the mindset they have about Europe, and I think it's an unrealistic view of Europe, especially. Europeans aren't clamoring to come to the US. So they must be doing something right there.
Okay, thank you so much for answering the questions, John. I have a lot of questions from our viewers, so let me quickly take them. So I think AD Sterling is here, and AD says the ploy was to get thus into the courts so the Scotus can decide the matter. All I read is the term immigrants. If you cross into the US, that person is here illegally. Okay, I think this is a comment that he made. Do you have anything to say to him?
Is that in regards to birthright citizenship?
I think so, yeah.
Yeah, I think what the Trump administration is trying to say is that U.S. citizens and permanent residents that have children, those children have automatic citizenship. But if you're a non-immigrant or you're an undocumented immigrant, then your children do not get automatic citizenship. And that's the spin that they're putting on this.
Okay, and Tricia is also here, and Tricia says 93 countries have ended birthright due to the abuse of the original meaning.
Mm-hmm.
What do you have?
So, most countries, the way they handle citizenship, it's through, their legislatures, and then their parliaments. And that's a very easy change to make. If the sentiment in the country is we want to change, legislatures can do that very quickly. Our legislature in the US, not quite as efficient. We haven't actually got anything meaningful done in Congress in at least a good decade and a half. And it's just mostly been the administration, the executive branch that's been running the show. But our Constitution is the one that creates the birthright citizenship. And historically, changing the Constitution has been a very difficult, very prolonged process. And the vast majority of proposed amendments to the Constitution have failed and haven't gotten off the ground. So because it's in the Constitution and because it would take, going through all of those incredible hurdles to get an amendment done, I just don't see it happening.
Okay. And Viking for Life is also here, and Viking says UK got rid of birthright citizenship a long time ago. Two illegal aliens couldn't. Oh my God, this is a big statement that he said. Okay, let me quickly take Monali Thakur's comment. Maybe. How do you think the outcome of this lawsuit will impact the lives of immigrants and their children born in the US, considering the potential consequences of denying birthright citizenship, such as loss of access to federal benefits, social security numbers, and voting rights? What do you have to say, John?
Yeah, I think the lawsuit is just going to preserve the status quo. So I think at the end of the day, we're going to see, people that are born in the United States getting citizenship, unless you're a diplomat's child. And I don't think it'll have any long-term effect, is my prediction. I think in the short term, the only impact that we're going to see is the State Department potentially not issuing passports. And so, people who have newly born children that haven't gotten a passport yet, they may have to sit in place before they can travel with their kid.
Okay, so Manali, I hope you have got your answer. In case you want maybe more answers, you can continue writing or posting your follow-ups. Meanwhile, let me take Ram's question. Ram says, how does this lawsuit affect the immigrant communities who are already living in the US as permanent residents or asylum seekers? Could their children be impacted even if they are illegal, even if they are legally here?
Yeah, I again, the only thing that's going to be impacted, I think, long term is, or short term rather, is the issuance of passports. That's, the only thing that's going to be a problem. I think, at the end of the day, at the end of the lawsuit, we will go back to status quo. There won't be any changes. And, anybody born here in the US, except for diplomats' kids, will get birthright citizenship.
Okay. Thank you so much, Ram, for your question. Continue posting your follow-ups if you have more. And let me take Girish's questions in the meanwhile. Girish says there are people saying that this lawsuit is just a political move. Do you think there's any validity to that argument, or do you believe there are strong legal reasons behind challenging birthright citizenship?
Well, so just to be clear, the lawsuit is challenging the executive order, and the executive order is the one that's attacking birthright citizenship. So, do I think the executive order is a political stunt? 100%. I think any legitimate, thinking lawyer realizes that this is going to die, that the courts are going to shoot this down. So it's definitely a political stunt. And in terms of whether or not ending birthright citizenship has merits, that's a question that is going to have to be resolved through a lot of debate over time, and it's going to have to go through a constitutional change that's going to require a lot of public participation and input. And I think even if we did see changes to birthright citizenship, I think we're looking at years and years and years down the road.
Okay. Thank you so much, Girish, for your question. If you have follow-up, please continue posting them. Meanwhile, let me take Arpita's question also. Arpita says, what's the long-term impact of this lawsuit for immigrants who are still hoping to become US citizens? Would it make it more difficult for families to navigate the citizenship process in the future?
I think if you're here and you're on that path, it's not going to have any impact on you, because all the executive order is doing is trying to limit, going forward from the date of that executive order, who qualifies as a U.S. citizen, when you're born here. So the lawsuit, the long-term impact of that is just returning us back to where we were at the day before that executive order, and how citizenship is dealt with. Now, whether or not USCIS and the Department of Homeland Security are going to make the naturalization process more difficult for people and for applicants, that is a possibility. I mean, that's something the executive order can do, or that the executive branch rather can do pretty easily, just by saying this is a higher priority. We need to investigate people more thoroughly. We need to make sure they qualify. Yeah, all of those things can impact the naturalization process. But in terms of birthright citizenship, the executive order's impact is going to be very short-term, temporary, and limited. And I think we will return to birthright citizenship very soon.
Okay. Sarvesh is also here, and Sarvesh wants to know that what role do you think international human rights laws, such as the Universal Declaration of Human Rights and the Convention on the Human Rights of the Child, might play in shaping the court's decision, particularly with regards to principle of non-discrimination and the protection of vulnerable population, including immigrant children?
Yeah, so when it comes to international law, the courts don't really give it a whole lot of credence, to be honest. Yeah, if you make international law arguments in a federal court in the United States, it's like, oh, that's cute, that's nice, that's interesting. But anyway, let's focus on the real issue. Very, very, very few cases in the American judicial process have ever turned on immigration or international law. And so I wouldn't expect those conventions to sway anybody in the court.
Okay. Let me quickly take Sanjay's question also. Sanjay says, how might the judicial outcome of this birthright citizenship case influence the evolutionary trajectory of US citizenship laws, and what potential far-reaching consequences could emerge for the future landscape of American immigration policy? What do you have to say, John?
So I think in terms of naturalization policy, again, the executive order limiting birthright citizenship, I don't think is going to stand. I've been pretty clear about that. But changes to the naturalization process could take the form of statutory changes, limiting who's eligible for naturalization. That is something Congress can totally do, and they're authorized to do. And frankly, if Congress creates rules on naturalization that are more difficult, those are going to stand. The courts aren't going to overturn those. And so, that'll just be at the end of the political process, the political debate and codification of the law. So, if you look at our Congress, we haven't really accomplished any major legislation or major policy changes, especially in immigration, in decades. So I'm not expecting anything, dire or dramatic to happen anytime soon, just because, the procedure used in Congress to get things done is very unwieldy, very difficult, and, hot issues, difficult issues tend not to get resolved because they're too difficult to resolve.
Okay. Thank you so much, John, for answering all these questions. I think we have covered all the questions from the viewers as well. But with that, I would also like to know from you that what more can we expect? It's just been a day since Trump has taken the office, but what more can we expect in terms of, what might happen to immigrants and immigration policies and visas? So what more can we expect?
I think if you're outside the U.S., you can expect the consular process to be much more difficult, much more limited. I think they will scale back appointments. They'll make everything as hard as possible to get a visa. And then at the port of entry, there's going to be much more scrutiny. So if there's anything in your immigration history that's been flagged, you're not going to know about it until you get to the port of entry. And you may face, questions about something that happened a decade ago, in your immigration process. So I think those types of things are what we should expect, especially for the H-1B population. I expect that the FDNS, which is a branch of USCIS that is like their immigration Gestapo, that goes out and does these visits and harasses H-1Bs. I think those investigations are going to increase dramatically. And the important thing for that population to understand is that they have a right to a lawyer in that situation. And having a lawyer represent you in those cases is about the only way that you can protect yourself from getting bullied and pushed around and, having your statements twisted and mischaracterized in some report that is going to impact your immigration future forever. So I would say get with an attorney immediately, have what's called a Form G28 signed between you and the attorney. And if there's ever a FDNS officer that shows up on your doorstep or comes to your work, give them a copy of that G28 and say, I have a right to a lawyer. I'm using that right. Please contact my lawyer for further inquiries on this issue, and leave it at that. And don't let yourself get bullied into talking further.
That's a great advice. Thank you so much for that, John. And guys, if you want to directly get in touch with John, make sure that you give him a call on the number 844-592-7336. Yes, I would like to repeat the number 844-592-7336. You can also email him. His email ID is support@wasden.law. And you can also visit his website, which is www.wasden.law. So make sure that you give him a call, reach out to him on his email, and you can also visit his website. Thank you so much, John, for being here. It was great speaking with you. Thank you so much for your insightful answers on all these trending questions. People are really looking to get an answer for these questions. So thank you so much for answering them in so much detail and depth. And we're looking forward to doing another great episode with you on another great topic. But until we meet again, thank you so much for being here.
Thanks for having me. It's good talking to you.
Likewise, thank you so much. And to our lovely viewers, thank you so much for posting so many questions of yours, and we enjoyed taking them. Thank you so much for that. And we are going to see you very soon in another webinar. And we are going to have another webinar at 12, so make sure that you tune into that. And if you want to get in touch with me, my number is 732-707-9151. My email is rajni@staffingly.com. So if you have any queries for me, make sure that you give me a call, send me a text, or maybe email me. But for now, I'll have to take your leave. I'll be seeing you soon on another webinar. But for now, I'll have to take your leave. Make sure that you like this video, subscribe to the channel, and share this episode with anyone looking for answers to these questions. But for now, have a great day. And I'm Rajni, signing off. Bye. Take care.
Hello, everyone, and welcome back to another episode on Immigration and Jobs Talk Show. I'm your host, Napasa Pradhan, and today we will be diving into another very critical topic, a pressing issue, a very timely one as well. And before I tell you what the topic is and who our guest is going to be for our webinar today, I have this very important disclaimer. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks out there, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, X, and it's really amazing to have you. And good thing is that you can also participate by commenting wherever you're watching us. And yes, join us on YouTube, it will be great. But other than all these platforms, you can also join us on call. And for that, you will have to dial this phone number that's displayed on the screen above, 425-436-6335, and the access code is 988-888. So join us, friends. And today's topic of discussion is, how is ICE's crackdown impacting immigrant communities across the US? So yes, with all the news that's we are bombarded with right now, increased enforcement actions, deportation, workplace raids, school raids, so many in the list, right? And they're all making headlines. Many immigrants, both documented and undocumented, they're all facing new challenges, and families are also being separated. Businesses are struggling, students are struggling, and the fear is growing in so many communities out there. So to help us break down this very interesting and a very timely topic, especially on what's happening, what's going on, what rights individuals have, and what to expect moving forward here on. So we have a very special guest who's going to join us once again, and he is Attorney Justin Rivera from Wasden Immigration Litigation, a very experienced immigration attorney. So please help me welcome him. Hi, Justin, and thank you so much for joining us today.
Hey, yeah, thanks for having me. It's always nice to be on, especially on a Friday. So thank you, I appreciate it.
Thank you. I'm looking forward. I know Fridays are supposed to be fun ones, especially that weekends are coming in. But our topic is such a serious one, and
Mhm.
all the dark times, I would say. So, what can folks out there expect from today's discussion?
So yeah, I think I will preface this by saying, Wasden LLC, particularly, we work with people on business immigration visas, work visas, things of that nature. So this is a little bit outside of my scope, a little bit outside my wheelhouse, but I think that after doing some research, I think I can provide at least an outline, a basic understanding of kind of what's going on right now, what is anticipated to occur, and kind of a little bit more about what this impact is going to be on not only people that are undocumented, but even people that are here in a legal status. So that'll hopefully I can shed light on that. There's a lot of great resources too that we'll try to highlight that are available to people as well.
Absolutely. I'm looking forward already. So, yes, we hear a lot of, things that you just shared before we started this webinar. We'll get into all that details as well. But I have some questions that I need to ask. And if we could start with, how has ICE's recent surge in deportation efforts, they have affected immigrant communities, particularly those without legal status? If you can
So
highlight those, would be very nice.
So yeah, I mean, anybody that's been watching the news has been aware of an increase in deportations and rates that is directly correlated to a change in administration. Where is that coming from? Basically, immigration officials are being given or have been given expanded enforcement discretion powers. So basically, they're being given a wider leash on what it is that they think qualifies someone as deportable in this circumstance. Before, under the Biden administration, there was a prioritization, obviously, of certain individuals, probably people that weren't conforming with requirements for check-ins, things of that nature, violent individuals, stuff like that. Now, it seems that there has been a wider scope, a wider net that has been cast as to who qualifies under this deportable statute, who they believe needs to be prioritized for deportation. A big thing that I was noticing when I was looking into it was that there are a lot of individuals who they take place in what's called routine check-ins. So these are people who, their immigration status is suspect or they're undocumented, and a part of what they do to work with the government in an attempt to find a remedy is they routinely have check-ins with, ICE officials or immigration officials. Apparently, according to a couple different individuals, some people in Florida and other places, apparently some of those people are starting to get detained and deported. Now, that was not a prior practice, mainly because these are people who are conforming to the government's needs and actually providing an avenue for them to be tracked if needed, or provide additional information or documentation. These people were not prioritized, but at the end of the day, they are very easy people to deport to show increased deportation numbers. And what that has done is created a fear. There are presently about 1.4 million people who currently have pending deportation orders in the U.S. All of those people are obviously going to be targeted. And that can be, basically a circumstance where someone, if they're caught, they're done. They're being deported. I think there's going to be a growing call to have people under expedited removal at a higher rate. And what that basically means, expedited removal is removal without the need to go before an immigration judge. It's literally, you're put in, you're questioned, you sign the forms, and you're done. They put you on the plane to get you out. I think that's going to probably increase. And I really feel bad for the people who have been attempting to kind of follow the rules through this check-in process. And it's frustrating for those people because they're kind of caught in a catch-22. If they go to the check-in, then they're seemingly risking being in a circumstance where they could be, detained and deported. But if they don't go, they can also be placed into the deportation pool for non-compliance. So all of this obviously creates fear. It creates a circumstance where people don't know what to do or how they're supposed to behave or act, or what steps they're supposed to take. And I think that's kind of the point. I think that the point is to create chaos. And I think right now there's definitely been a lot of chaos created.
It is getting chaotic already, and we can see, I mean, so many people are already almost getting deported. I mean, even Selena Gomez crying. Everybody is reacting to it.
I honestly can tell you personally, I have a story that I couldn't believe that I would have been talking about with people, but I'm going to tell you guys because it really happened to me. I got on a phone call on Wednesday with someone who called me because they're the younger brother of someone I know, someone I went to school with. And they called me because they needed to understand the I-485 adjustment process for people that marry a U.S. citizen. And the reason for that is because they had just found out that their girlfriend of 3 years, I believe, or 2.5, 3 years, had just been notified that their TPS status was going to expire. So this is, again, someone who's in the U.S. legally under temporary protective status. And this person's calling me frantically trying to figure it out, literally in the car driving to buy a wedding ring to expedite getting married so that he can ensure that this person can remain in the United States. That's the kind of chaos you're looking at right now. You know, going after people that are on parole, going after people that are on temporary protected status, it would very much shock me to think that those are the kinds of people that this administration's supporters wanted removed. And yet, here we are.
So, and that is just one case. There are so many stories out there. And
Yeah.
folks, if you want to share any of your stories as well, you can by commenting or by joining us on call. And it'll be really nice to have even Justin, tell us what we should do next. And with all these, deportations happening, Justin, maybe if you could give out some tips, as in what are some of the legal protections available to immigrants who are facing this right now, the threat
Right.
of deportation by ICE in this current climate.
So I would definitely say work with a lawyer that's more qualified than me in this regard. I would definitely say that. I can't sit here and say that I am qualified to handle this kind of exact case. But what I can do is at least provide general information and what people's rights are and what they can and can't do. So I want to say right off the bat, to kind of get rid of any rumor mills with the internet are always compounded. Legal permanent residents are not at risk in these circumstances. So that's a rumor that I saw when I was looking around on the internet. No, you're an LPR, you're fine. People formerly on temporary protected status could be at risk, though. The idea promoted by the Trump administration was that people with criminal convictions, pending criminal cases, and people with final removal orders were going to be the prioritization. However, people with pending asylum or parole could honestly end up getting caught in this and getting arrested and eventually deported. Specifically, humanitarian parole. I believe it was recently ended for Cubans and a couple of other different countries. So what are kind of the rights of individuals? If it's a civil arrest, it's very complex. If it's a civil arrest, there's not necessarily a constitutional right to an attorney, but you do have a right to due process and a right to protection from self-incrimination. So what I'll explain by that is you have the right to remain silent, just like they tell you, on any law and order. You don't have to provide information. You don't have to give over anything. So in the event that you're detained, I would basically say, don't talk, or express that you have the right to remain silent. And then secondly, express a right or a need to speak to your attorney. There's minutia there, but for the most part, you should have access to that counsel. I think another important thing to talk about is an ICE warrant. So an ICE warrant is an administrative warrant. And what that means is it does not allow the executing officer to demand entry into someone's home or their private space. However, a judicial warrant does. That is a warrant where they have gone and got it signed by a court to carry out an action. Typically, ICE is not going to go through the process of getting a judicial warrant because of how timely it is. So, if someone's in a situation where they're dealing with an ICE officer that is at their door knocking, you can say under the Fourth Amendment, you are required to show me a judicial warrant before I'm obligated to grant entry into my home. And then you can have them slide a copy of that warrant either under the door or through the window. You don't have to open the door. So warrants are typically going to be needed to go into sensitive areas. And sensitive areas are usually places like homes, schools, churches, doctors' offices, maybe courthouses. Now, under the Biden administration, most of those sensitive areas were explicitly non-targeted areas. And the reason for that is you don't want people that are here undocumented to be afraid to take their child to the doctor's office if their child is sick because they're afraid of being deported. So the courthouse was another one, similar thing. Maybe a child support case, for example. You don't want them to be afraid to go to the courthouse to appear for a child support hearing because then it hurts the system. Because now, the person can't pay child support, they can't put an order, paternity, any of that kind of stuff. What is the impact of that with the present administration? We're not sure. I mean, they rescinded Biden's guidance essentially. Now, they've been talking about saying, well, we're clearly not going to do that stuff, but we just don't think it needs to be, affirmed in writing that we're not going to do that stuff. So take it with a grain of salt. But this all kind of gets back to the fear avenue, like the notion that it's going to be difficult for people who are undocumented in particular to feel any level of comfort. It's scary for them. And I think that it's going to impact probably where they go, what they do, who they see, how they interact, because all of it's going to be suspect. They're going to be worried about the implications of the activity and whether or not ICE is going to be involved or even local law enforcement in some capacity. I think really for people just knowing that, and I'll talk about it a little bit more in further detail, but knowing, you don't have to talk. You can express that right. You don't have to say anything, and you can, express a desire for counsel would be my two big points.
Thank you so much. I mean, those were great tips, and folks out there, I hope you have noted that down. These are some of your rights. So I think it's always best to do more research and contact an expert, an attorney. They will be able to guide you best. And also, ICE, they're being joined forces by FBI, DEA, so many people out there. And Justin, what else do you have to say if you want to add more?
So for the local law enforcement, I think we were going to talk about it later, but we can talk about it now if you want. I wanted to do a little bit of diving into that and what role the local law enforcement is supposed to play in federal deportation actions. So there's this section of the INA that's called 287G. So under 287G, state and local law enforcement are permitted to question, arrest, and detain people for suspected immigration violations, and in very unique circumstances, place them into removal. But there is no power beyond that point. So what it kind of creates is, does that particular police unit or, like Harris County, for example, because I live in Texas, does Harris County want to cooperate with the federal government? Because if they do, they are not given additional resources because they basically are told, you're going to operate within the grounds of what we have within our budget. But if you're a state-funded entity and your main issue is to deter criminal activity, it's kind of hard to say, well, we're going to now fill up, 30 or 40% of our jails with issues related to immigration violations, and then also any time that's spent dealing with that is taken away from the amount of time that they can spend dealing with with criminal violations. So I think it really just is going to turn on where in the country that police, those officers are situated and how willing their offices are to comply. Now, in circumstances where they're carrying out issues for criminal activity, I think you're going to see some hand holding because it makes sense. Hey, this person who has an immigration issue has also been convicted of a violent crime or, something of that nature. Then it makes sense for them to play ball. The idea of deputizing the state and local police to expressly look for immigration issues, I think might be more suspect. I think time will tell on that, but it's probably not likely. That you're going to see a lot of participation unless there's changes made in the law in areas that are, maybe not predominantly blue, but maybe areas that have already large criminal issues. That police force is going to probably focus on that more so than help out with immigration issues. But we'll wait and see.
Yes, it's just getting more complicated. And from what we hear, people, or I mean, states who are not cooperating are also being said that they are going against Trump, and they are, facing more, what to say, um, like they are not compliant with what they need to follow.
Hmm.
Well, thank you for that, and thank you for those tips, I would say. And I would also like to greet some of our, uh, you know, folks out there who have joined us with comments. Santosh, we have Kiran, AJ, and Mangu also. So, yes, I think we should take up Mangu's comments quickly because I
Sure.
think it is related. I'm deeply concerned about reports indicated that many immigrants, particularly those from India, are being detained and deported without adequate access to legal representation. How can we ensure their rights are upheld during deportation proceedings?
So I think specifically in that circumstance, my experience is those are individuals who have entered through CBP, typically through an airport, and those individuals are inspected before they are admitted to the United States. When you are undergoing inspection, you are not basically granted admittance into the U.S. and subject to the U.S.'s protections and laws. So what that means is if you are coming in, let's say through Chicago O'Hare Airport. I hate that airport, by the way. I want to tell everyone on this call. It's one of the worst airports in the entire United States. It's just garbage. 2-hour waits at security. It's ridiculous. Anyway, sorry. If you're coming in through Chicago O'Hare and you're on, let's say, an H-1B visa, when you go through CBP, if they tag you after they look at your information, you can be placed in what's called secondary inspection, right? Secondary inspection is a place where they take you into a room or a waiting room and then have you called in, and then they basically question you about whatever it was that popped up in your record when they scanned your passport, or whatever information you said that they thought that's weird. We're going to need to look into that. When that happens and you're in secondary, you do not have a right to counsel. You have not been admitted to the United States. There is no right to counsel. You can even have a G28 from an attorney saying, this is the attorney that represents me. I'm coming into the US. I'm on a legal visa. Here's my G28. The CBP officer is going to take that and say, that's fantastic. I don't care. They're going to throw it right in a trash can. So the thing about this is we have had people recently be put into secondary inspection for 4+ hours who have no immigration history of violation, no problems whatsoever. They're literally just picked out. And we've had their spouses call us and say, what do I do? How can I do anything? You can't do anything. That person is basically on their own. So what we have to start doing for people, and what our firm is doing for people, is we're coaching people beforehand. We're saying, look, what are the things that you could be asked? What are the ways that you should answer that comport with what's in the petition that you're using to apply? And how do you need to answer those questions? And in doing that, we're hopeful that coupled with the fact that these people, are highly educated and trained individuals, are able to get through the system. Now, the other thing that I will say about that, when you're going through CBP, once they put you in secondary, 9 times out of 10, they're pulling all of your electronics out. They're going through everything that you have. Because now that you're back there with them in secondary, they're going to say, even if the problem that we've identified is fine, we may as well take a look at everything else to see if there's something that we can figure out to say there's an issue to make this person removable. So I think that coaching is going to be necessary, and it's going to require employers working with employees or individuals who are coming in even on maybe F1s, talking to attorneys beforehand to make sure that they're ready to come through. Because I cannot express to you how bad an expedited removal order screws up somebody's immigration future. It's just the truth. I mean, they carry with them default, you're getting a 5-year ban. So that's a 5-year ban from the United States that you can only overcome with a waiver. And then if you actually end up having a ban that comes with a finding of fraud or misrepresentation, that's a permanent inadmissibility bar. So those are issues that are colossal. And I think that it's open season now with CBP. I think that they are very willing to pull people into secondary. And so, Mangu, to answer your question, they're not going to be entitled to representation. And I think unless they're coached properly at the outset, they could open themselves up for reasons to be deported, even if they're nonsensical.
Thank you so much, Justin, for taking that up from Mangu. And Mangu, thank you so much for joining us. But yes, I would like to say do subscribe to our channel, Immigration and Jobs Talk Show, where we come up with amazing discussions like these, webinars like these that could be very, very informative and helpful. So, yes, and I think we should quickly take up Rag's question as well at the same time. He says, "Hi, Nipa and Justin. Yes, have heard bad news about ORD, but which airports are more hospitable and how does SFO fare?"
Not sure what SFO is. I'm not an air traffic controller. Is that San Francisco?
Me too, Rag. Tell us more about your question,
um,
please. What do you really want to know?
I will tell you guys just off the top of my head from practicing history and what I've been dealing with. I don't like O'Hare. I'm not a fan. Yeah, it's San Fran. I have not heard bad things about San Francisco. I have not heard bad things about Seattle. That's another airport that's okay. I'm not a big fan of Dulles, which is in DC. I'm not a big fan of that one. I've seen a lot of people having issues with secondary there. And then those are kind of my big ones. The other one that I would caution people not to travel through ever is, I think it's the UAE, the Arab Emirates or something like that. The UAE airport, don't go through there. Like I've seen removal orders from UAE where the officers don't even know what the hell it is they're talking about or what they're basing their removal on. And yeah, eventually we can work on those cases and get those people back into the US. But you have to understand, once you're out, you're looking at best case scenario, probably half a year before you're getting back in. And that's if there's clear egregious error from what has happened to you. There's not clear egregious error, probably a year and a half, 2 years, maybe more. Some people are sitting out that entire expedited removal order. Yeah, that one, the one Rog just said. No, not a fan of CBP there. So yeah, I would say that there are bad airports. As that list expands, I can keep you guys updated. But for now, those are the ones that I don't like. The ones that I do generally are along the West Coast. Now that I'm starting to kind of think about it, I think the West Coast is usually more where I recommend people to travel through if it's optionable. I've never had anybody have issues in like Denver or anything like that, but I'm not sure how many international flights you're getting there. But yeah, that's it. As I know more, I will let you guys know. There's definitely POEs also that I'm not a fan of, but I think that's really niche. That's only for people that are going to be traveling from Canada. So yeah, thanks for that question.
Thank you so much. And I think we should also just read out AJ's comment. Please don't make the places foreign national come from seem like God-forsaken places that nobody in their right minds want to return to, because for the most part, that is not the case.
Okay. Look, man, you're entitled to your opinion, but at the end of the day, there are definitely people that try to come to the United States from places that are in significantly worse off, not only financial, but governmental circumstances than what is here.
Yes.
It is
Thank
what
you
it
so
is.
much. Yeah.
Look,
Yes.
I
Yes.
understand that may be your opinion, but it may not be based in fact for everyone. Now, yeah, if somebody has to return to China, okay, they go back to China. The country at least has a semblance of a stable government, whatever your conditions against that government are. They at least have a stable government and an economy. There are plenty of places in South America that cannot say the same thing. And in fact, there are plenty of people who were just on temporary protective status who come from countries that can't say the same thing either. And at the end of the day, if your choices are between attempting to carve out a life in a place where you're unsafe and have no economic opportunities, and trying to go to a place where you could have safety and economic opportunities, not only for yourself, but for the people you care about, a lot of people are going to pick that option. And to say that we're going to shut off that valve under the notion that, no, these people are coming from countries that are completely fine, I think is nonsense. And I'll go far enough to say, would you want to visit that place?
There you go, AJ. But thank you so much for participating. He's one of our, frequent
Yeah, no, I
viewers.
appreciate it. Hey, look. He's not completely wrong in regards of all of it. At the end of the day, there are definitely people who are going to undergo removal and they're going back to completely stable countries. And yes, the world doesn't end for those people, but it does change the scope of their life. People who are immigrating typically are coming to the United States because they're seeking economic opportunity or something else that's drawing them in. That's the whole push-pull of how immigration works. So yes, they'll go back to a country where they'll be fine, but it does change what they wanted to do, the scope of what they wanted to do with their life. And then that turns into a conversation about generally what you think about immigration itself rather than where the individual is coming from. But,
Right,
all right.
right.
Thank you, though, for the question. I appreciate it.
Thank you too, Justin, for taking that up. Such a sport you are. And, we should get back to our topic of discussion. And we are hearing so many raids happening already, affecting industries that depend on immigrant labor as well. So, what legal risks do employers face?
So I'll be honest. When I was looking into this, the biggest thing that I saw people complaining about is actually I-9 compliance issues. And I-9 compliance issues, basically it's saying, when you hire somebody, they have to fill out an I-9 to show how they're in the country and able to work under authorization. If you violate I-9 compliance, you actually get dinged a set monetary amount for any violation related to the individual application. So if you have 45 employees and you have each one has 7 violations on it, however they drum it up, you're going to be looking at a circumstance where you're turning over thousands of dollars to the government, if not hundreds of thousands of dollars to the government. So that right there is a big thing. In terms of the workplace raids, I don't know if they've been at the level people were really thinking they were going to be. I think that there was kind of this presumption that day one you were going to see like just ICE everywhere, at every poultry factory or farm or any of these places where there's a presumption that undocumented workers are utilized. I'm not sure that's been seen at that big of a volume. I'm sure it's happened, but when it does happen, there are certain rights that individuals have. If you're a workplace owner, if you're the owner of a company, there's always the issue with the warrant. If it's an ICE warrant, it does not permit entry. It has to be a warrant from a judge. So until you set eyes on that, the individuals are not allowed to enter. You and your employees have the right to remain silent. You definitely have the right to counsel as the owner of that organization. I would recommend people be represented at all times at this point and have either a copy of a G28 on their phone or a copy of a G28 available in paper that they can hand over. And then have an opportunity to contact your counsel and, if possible, have your counsel present. Your employees have a right to remain silent. They have a right to remain silent, and they also should never, ever turn over documentation that is false. Never present anything that is false. Fake driver's license, social, whatever. Never turn anything over, and don't sign anything. I would recommend not signing anything until you've had an opportunity to have counsel review what's being signed. So if you are detained, be quiet, request a phone call, and request a copy of what's called the ICE National Detainee Handbook. So this is a document that has to be furbished when it's requested. Gives you an opportunity to look through it and know a little bit more about what your rights are. When you are that employer, request the ID of the individual ICE officer carrying out the warrant. Request a copy of the warrant, legal representation. Have a site manager assigned ahead of time who's going to know what to do during a raid. Don't talk without the lawyer present. And another thing about it is when you look at the warrant, you are allowed to contest anything that is beyond the scope of the warrant. So if the warrant is tailored to search in area X and the officers begin to divert off to area Y, that can be contested. And that's something that should be noted to your representation. So I would say to limit access to areas that are expressly mentioned within the purview of the warrant itself. And also, you do have a right to send all non-essential personnel home that are not required to speak with ICE. So you can clear out the area basically as well. But again, I would definitely say rule one, get representation ahead of time, speak with representation ahead of time, make a plan on what it is you're going to do, and then work from that. Let's not be reactive with this administration. Let's be proactive so that we're able to be prepared for when these things inevitably occur.
Absolutely. Very well put. And even this administration must have done just that. They have been planning this from a very long time and now putting everything out there for us.
No, absolutely. And, I honestly have to say, if you can say Trump, he sows chaos, he's a little bit, the freeze on grants and everything being what it was, going and being rescinded, nonsense, right? Have to give credit to how quickly this administration has begun implementing changes within immigration. It has been quick and it has been sweeping, not only for the undocumented, but for legal immigration as well. And so, yeah, they came in with a plan. They learned from the last time the administration was in a position of authority, and they are implementing those things very, very quickly.
Yes, very true. And, we still have so many questions to go. I would quickly like you to also highlight, how are FDNS site visits impacting H-1B employees as well, and, their employers in terms of compliance and even visa approvals.
So FDNS has been emboldened through changes in regulations, right? The H-1B modernization rule, which went into effect on the 17th, contained with it language that expressly codified the authority of FDNS. So now that it is no longer a voluntary process. It's a mandatory process, meaning that you have to play ball with FDNS. And if you don't, and they say non-compliance, then that's, their grounds or alleged grounds for opening the door for notices of intent to revoke for the H-1B. So what have we seen so far? I have not seen, as of now, a colossal uptick on the physical site visits, but those are very likely coming. What I have seen is an increase in the emails and phone calls being made to employees and employers requesting information and documentation. Now, those documentation requests, which were previously, maybe 8 or 10 things, and we would work and turn over maybe 6 because we think that they're actually related to the petition. Those have grown exponentially in scope. And, we're getting to a point where I saw one the other day that was 34 different questions. And the officer alleged that there was a 24-hour response time to provide all of that. And a lot of these things are beyond the scope of the petition. They have nothing to do with the individual's H-1B. And they're more so a fishing expedition. They're an opportunity to look back on the entire immigration history of the individual with the hope of finding a violation of status. And now that the officers have the ability to say, well, if you don't comply, we're just going to refer this for notice intent to deny or revoke. Employers are more on edge. And I think that when you're an employer and you're going into this and you're not aware of what it is that you do need to provide and what you don't need to provide, and you're handing over everything, USCIS is going to figure out that they can just keep hitting you over and over. And they're going to do so. So I think that, for FDNS, it's going to get more aggressive. I think that even though there hasn't been an increase in site visits, I think what we're seeing is the preamble to it. I think we're seeing the increase in calls and emails is a gathering step where they're going to accumulate documentation and then execute on site visits, because I think they're going to go after people who are working at third-party sites. I think that they're going to go after people who are working from home. And I think their goal is going to be to take all of the information that's turned over to them, run it against the statements made by the people in person, if they're not represented by counsel and realize that they should shut up and hand over the G28. And then they're going to run everything against each other, and they're going to find something or try to find something that shows that there has been fraud or misrepresentation, which would allow them to send a notice of intent to revoke for the petition. And I think that's what they're going to do. And I think that's going to be a powerful tool for them too. I think it's going to be something that they're going to want to hire more people to do this, because it's a great way to scare the individuals that are working subject to non-immigrant work visas. And that's not even just the H-1s. I mean, the L-1s are people that I think could face being targeted, which are specialized knowledge and managers and executives from multinational companies. I think the F1 program is probably going to be getting targeted in some capacity. So I think these are all things that are up for they need to change basically how they're practicing now before it's too late and they end up into getting a revocation, because you get one and it really does open the door for them to just kind of hit you over and over again. And also, you have to remember what FDNS collects goes abroad to the consulates. And so not only are you dealing with issues with challenges potentially that you beat back with USCIS, could be grounds again for another issue when you go to apply for a visa abroad.
Right, right. And also, you know, Justin, we've been hearing that, I mean, there's too much, a lot in the news, actually. Everything is definitely sparking more panic and everything. But do you think everything is true? There are also false rumors about ICE raids, which are really sparking all this panic everywhere across the United States. You want to say about that too?
Well, social media is both a benefit and a burden to society at large. I think that it does a lot of things well, and I think it does a lot of things poorly. And something it does really poorly is allow for the simplistic dissemination of false information. I think that, the need to verify things has kind of fallen off. I'll be anecdotal and just let you guys know I quit X. I left. I quit that. I quit Instagram. I just got to a point where I really couldn't handle it anymore. But
Me
unfortunately,
too.
it's kind of they're what is in our society now, and that information, that whole of false information, is what is constantly churned out to everyone. There are websites that are supposed to track statistical data in regards to deportations and raids and things like that. I would look at that information. I would use that as your barometer for making a decision about whether or not the information is true. That being said, just because there hasn't been this colossal raid for work sites doesn't mean that it's not precluded. It doesn't mean that it's not going to come in the future. My personal opinion from the research I've done and the conversations I've had is right now what they're doing is cherry picking. They're taking low-hanging fruit. They're trying to go after low-hanging fruit because they want those deportation numbers to be bumped immediately so they can show that they're carrying out their promises, right? A big goal of the Trump administration's first 100 days is all the promises that they're going to keep. So they'll do that because it'll be an opportunity for them to just grab people and kick them out. And that way they can say, look, we've got something done. It may be once that is done that then the workplace raids start. It's really just a matter of time to see how it is. From legal immigration, though, I will tell you guys, things has already begun to change. The consulates have changed. They've become more aggressive, more difficult. Very quickly, I'll note the F1 program is seeing challenges that we have never seen before. For example, optional practical training, which is called OPT. OPT, you are allowed to work without pay. You do have to be paid on STEM OPT, but for OPT, you can work on what's called an unpaid internship. So we are seeing people that are applying for STEM OPT, which is their 2-year extension of OPT, get RFEs and eventually denials. And basically those denials are basically coming from this idea that under FLSA rules, the internship that they did that was unpaid should have been paid. And now this is really, it's a very odd argument for the government to make, because first off, how is a USCIS officer able to make that determination? The officer is now becoming an expert in employment law and is now able to tell what positions merit pay and what positions don't merit pay. Additionally, these unpaid internships, your OPT can only be for a year. Whose jobs are being protected if you're going after people that are working on unpaid internships? Is there a bunch of U.S. citizens who feel like they're not getting their crack at unpaid internships that want them? I don't know. And that's what I mean. It's literally just a tool to deny cases. And that's what their goal is. We just saw a notice of intent to deny come in literally before I got on this call, where they're saying that this person is not eligible for STEM OPT, which again, it's a 2-year extension of your OPT, lets you work for 2 more years. There are tons of requirements on it. You have to follow a specific training plan. It has to be approved by the school DSO, has to be paid, has to be in a degree related to your field. There is regulation and guidance over it. They're saying now that for some people, you went to a school and you went into a school that had a hybrid program, and the hybrid program allows you to take classes at home and at the school. They're saying that the school has failed to register this program with ICE as a hybrid program. And as a result of the school's failure to do this, you, the individual, have violated your status. And now your STEM OPT extension is denied. And again,
It's crazy.
It's great. What frustrates me so much about this is the goal is supposed to be to weed out fraud, right? It's to weed out people who are misusing or mistreating a system. How are these people doing it? They're not. It's just a new tool that they're going to try to use to deny people when they go to change status, when they go to apply for STEM OPT. And again, these are legal immigrants. These are people who paid money to go to schools in the U.S. and get an education here. People that we allege we want to retain because of their talent.
Exactly. And it would have made little sense if probably ICE would have sent a notice to the school instead, saying that you're not registered as a hybrid program or
Well,
something like
we've
that.
seen that they wouldn't bother to do that anyway. I mean, we've worked a bunch of cases recently where we had to get people's fraud findings removed because they worked at fraudulent employers. It was ICE. I mean, are they going after the employers? No, the employers just shut down. And then they go start another business or do something else. So yeah, it is this kind of ass backwards thought process by which you're saying we need to go after the kid that, the kid that at the end of the day hasn't intentionally done anything wrong, rather than the entity or the institution that should know better or be responsible for what they've done.
Exactly. And yeah, thank you so much though for that great example. And I think we still have a little bit more time if you please, and we should take up our Facebook questions quickly. And I would say, Rag, AJ, thank you so much for coming back with more comments. I would appeal to you to join us on call if you can. Our phone number is 425-436-6335, and the access code is 988-888. All right, so let's take up this first one from our Facebook group. It's from an anonymous participant asking, "Hi, I have applied H-1B through consultancy and I got RFE on November 2024. Yesterday, they are telling RFE document submitted, but in the site, it's still showing RFE status. Once RFE document submitted, the status will change, or is it the same as RFE status?"
So usually it's going to change to like RFE received, and your case, your case is your clock has been resumed, your processing clock. So that's usually what's going to happen first. Now that being said, USCIS's online their website, the case status website, is kind of notorious for how slow it is and how long it takes to update. So I wouldn't be surprised if you just sent an RFE response if it hasn't been updated. If you know that it's been delivered and the RFE, like you have confirmation that it was delivered from the tracking, and you get to about a week or a week and a half and you still don't see an update, I would think about reaching out and maybe trying to contact the helpline. If it's premium, they're way nicer. If you just email premium processing, they're usually going to give you a heads up on what's going on. But of course, that's because you paid, or your company paid, $2,805 more for your case. So they're going to give you a little bit more detail. But usually the way it works is when you respond to an RFE, it's going to update and say RFE received and resumed processing. And then a couple of days will go by, or if you're in premium, a couple of days. If you're regular, Lord help you. But a couple of days will go by, and then it'll say RFE, case assigned with an officer, case assigned to an officer, case with an officer under review. That's just telling you that it's now on the desk of an officer so that they can look at the case and work on it. Does it mean your case will be approved within 24 hours, 48 hours, 72 hours? No. It just means that it's under active review. So after that happens, it's going to update. Usually it's going to update to either explaining that, the case was approved and an approval was emailed or will be sent to you, or additional information is needed. Another request for evidence has been issued, which don't be surprised if that's what you start seeing with the Trump administration. I'm just going to be very straight up with you. Anybody that submitted a first RFE and you didn't get your adjudication before Trump came into office, don't be shocked if a second RFE follows. That was very common under the last Trump administration, that you would get a first RFE on one issue, and then you get a second RFE on 4 completely different, unrelated issues. So don't be surprised if that happens. Just make sure you got a good attorney. But it'll update then, and then obviously worst case denial. Now, I want to tell everybody on this as an attorney that has practiced for going on 8 years, so we're all clear about something. If your case status updates to denied, your attorney does not know the reason for the denial until they get the denial notice. They are not clairvoyant. Now, yes, if the RFE is on specialty occupation only and the case is denied, specialty occupation. But they don't know why, because they don't get the adjudicator's reasoning until the denial notice is received by their office. And that can take a couple of days. So when your attorney tells you, knock on wood, I pray for you, no one gets denials. But if your attorney tells you, look, your case was denied, we have to wait and see the denial notice, it's not buying time. We genuinely don't know how to proceed until we see the notice. Do we think that there's an avenue that we can address the issue with premium processing? Do we think that we could file an appeal or a motion to reopen? How much time is left on your current non-immigrant status? And is this an opportunity where you can reapply? What is reapplying going to do versus appealing? All of those things have to be borne out by the language in the denial. So to answer your question, yes, it will update. Wait a week or two and then see what happens with it. And then if you're not in premium at this point, maybe think about upgrading to premium.
Yes, money talks, at least in this case. Premium processing is always, answered earlier. Let's go
Oh,
on
yeah.
to our next. Yeah, thanks, Justin. To our next question. This is also from an anonymous participant. Hello, everyone. I have a question. With the modernization rule of H-1B visa effective from 17th January 2025, do we need to state the starting date on or after October 1st? Another question is, my I-94 expiration date will be on June 15th, 2025. I will file I-129 on April 1st, 2025. So after filing, can I still stay in US until I-29 is approved? Or do I have to leave the US not later than 15th of June?
Okay, I'm going to do a lot of heavy lifting with this answer because I'm going to assume October 1st means you're talking about a quota case, because quota, October 1st is the first date you can be eligible for an H-1B if your case is selected in that year's lottery. You can move the start date around now. That is now permissible. So you can move it back or forward. However, if your I-94 expires June 15, 2025, and you're filing on April 1st, I would probably say you're going to want to try to get work authorization as soon as possible. So yes, if it's a quota case, you can move back that start date. If your I-94, though, is expiring, I believe that would mean that you are in a different status, because I believe F1 has DS as the status. So I'm going to handle that answer separately. If your I-94 expires June 15th, 2025, and you timely file an extension prior to that date, you are allowed to remain in the United States during the pendency of that application under what's called POSA bag. That's a period of stay authorized by the Attorney General. That POSA bag permits an individual to remain living in the United States and working subject to the conditions of that classification up to either the adjudication, or I believe it's, please don't quote me, you may have to look it up, 280 days after the expiration of their status. So it's either 180 or 280. All that is to say, I would just file the extension. You can remain in the United States while the H-1B extension is pending, if that's what it is. And then I would probably check that statute to see how long you get. And if you start to get close to it, upgrade the case to premium.
All right, there you go. Thank you so much, Justin. Let's go on to our next one quickly, please. I have joined a new company, product company, and my I-797 was approved in September last year. I have had one stamping done for H-1B, still valid, but thinking of getting another H-1B stamping in May this year. With the new changes, is it harder to get stamping nowadays? I'm worried because I have an MBA and I work in software implementation. Are there major chances of getting refusals during stamping because of degree, or is it checked only during petition?
So usually when the consulate looks at an application, a visa application, the only thing that they're supposed to send back would be fraud or misrepresentation on the petition. So as long as the petition was approved and the documentation in the petition is valid and confirmable, there shouldn't be an issue that requires inquiry into eligibility. They should not technically be looking at if the position is a specialty occupation or if the beneficiary qualifies for the position. That's USCIS's job. So I would say the MBA isn't your concern here. I think what your concern is and should be for most people is the increased scrutiny at the consulates in general that have been placed on petitions by consular officers. That increased scrutiny, I think, is going to lead to an increase in 221Gs, and I think inevitably to an increase in visa refusals. So I would be a little cautious right now to go to the consulate, to be honest. I think in a perfect world, if you have the ability to wait a couple months and let the dust settle from this new adjudication and allow attorneys and companies to collect data so that they can start seeing what trends are, I think that's going to be your safest course of action. And that's regardless. I don't care if you have the squeakiest clean immigration record in the world. I don't care if you're a software developer and you're working for Apple and you have a degree in computer science. I would just say to anyone, just be careful. We're learning right now what to expect when people go abroad. I have an individual that I worked with at my former firm, and in one of our client accounts had literally not received a denial, a blanket L visa denial in the preceding year or 2 years, I believe. They had already gotten 2 on this Monday. And that should be a little concerning because this is a massive multinational company. This is a corporation that you've seen advertisements for on television. It's a corporation that has a lot of power and money. They're getting visa refusals. So if these companies are getting visa refusals, what do you think the rest of the organizations are going to look like? What's it going to look like for them? So we have to wait and see. And that's why I say data is key. Once we figure out data, what are the trends, what are the consulates asking for, we can adjust and then make changes that are needed to make sure that people have the highest probability of an approval when they go in for their interview.
All right. So, Justin, at this moment, we actually have a caller, and he is John Santu, if I'm not mistaken.
Okay, I could
Quickly,
try. I'm very close to end on time. I'm sorry, but we're at
all
noon.
right. All right. John, if you could just quickly ask your question, please.
Yeah. Actually, I'm a non-citizen or resident of this country. I've been here for at least 24 years now. I have filed my petition for married spouse. I had got abused by that. The spouse and I had separated. I asked her to let me file a divorce of that. She never did. I have ended up in a fiancé, a person that I take and have make a life. She is a non-resident either. And we have 2 American citizen kids. Upon filing the marriage petition, they request more evidence. The immigration requests more evidence where the spouse have abused the power and said that she's no longer doing the papers. And imagine we lived together for at least 9 years.
Oh.
What is my position here?
Wow, that's an impressive fact pattern. I'm not going to lie to you. What I would tell you, to be just completely blunt with you, is if you want to have a discussion that is very fact centric, I would ask you to send an email to my office, because I would have to really delve into that. I mean, the fact of the matter is if you and the other party are no longer married, then my assumption would be your I-485. It's kind of a null and void situation. I'm honestly surprised your former spouse, or I guess still current spouse, hasn't moved to withdraw the I-130. So that's already its own independent issue. And then getting into the other issues, I think that would require a pretty detailed discussion. So if you want to send me an email with your facts, I'd be happy to take a look at your case because it sounds, complex and intriguing. So if you want to shoot me an email, it's my first name, Justin, support@wasden.law, or you can send it to support@wasden.law, and they can filter you in. We'd be more than happy to take a look.
I know you I know you're kind of busy. I can take that information from your associate right here. I have a very fast question here, sir. I know you had to. You had to go. The point is that I'm trying to get to is that I request a FOIA from immigration, and they never send that FOIA.
Okay. So you did a Freedom of Information Act, and you received confirmation of receipt of the FOIA?
Yeah, well, I did. I have conducted immigration consult, and we did send them for a FOIA, the FOIA, which means have the whole case that we dealt with.
Right. So usually how that works is you're going to get something back saying that your FOIA request has been received. It's going to be put in a particular category based on how complex or detailed it is, with a generalized timeline as to when you can anticipate receiving a response. Have you ever received any of that correspondence?
No.
Okay. So yeah, what I would probably do is follow up on that FOIA request then, just to make sure that it was properly submitted. Because the way it usually works is you submit the FOIA request, you get some level of acknowledgement, letting you know that it has been received, intaked, and assigned. And then you get a sort of timeline as to when you can anticipate getting your records returned to you. And then what they do is at the end of it, they send you basically a full breakdown of the documents, and usually what's a partial denial explanation. And they're going to say, look, we have either blocked this or X'd out certain parts of the document because of, and they'll say, national interest security, whatever have you, criminal investigation. But they have a litany of reasons why they can refuse certain parts of your FOIA. But the very first part of the whole FOIA request is you should be getting something back when you submit the request.
Yeah, because I have some of the documents that I have received from immigration, and when we went to that interview, I try to offer her if she does want our marriage to carry through. We met in, we have slept together for at least 10 years, a whole decade. As wife, husband, and wife. But something went down the line, and she decided not to carry on with her marriage. And that's when they request more evidence of me as an individual.
All right. So, John, I think I would just suggest you best to, have a one-on-one consultation with maybe Justin. And first off, email him all the details, please. I hope that you have noted this down, support@wasden.law. And you can even call him on the number that is displayed on the screen. You can note it down, please. 844-592-7336. So I think we will have to, because your case is a little too complex and it cannot be solved right now. So it'll be best to contact him. Don't mind. We will have to cut it short right now. So thank you so much for joining us from Florida. All right. So thank you so much, Justin, for being so patient and for taking up all of our questions, and also, John Santu for joining us on call just now. We have AJ, Rag, and so many folks out there. Thank you so much. But Justin, just to
last person. If you email me or whatever, that's fine. Or set up a call. Look, they don't play around when it comes to marriage visa fraud. That's a pretty serious thing. So I'm gonna tell you right now, like that's a pretty serious case, and I think it it requires the attention that it needs. But anyway, I'm sorry for cutting you off.
No, I was just saying, yes, they will need to consult you because it's a very complex case. And maybe if you could just give us a few last words, to wrap up this session, this great discussion we had today.
Absolutely. Thank you for having me as always. I feel that this has been a fairly negative oriented conversation. Obviously, a lot of negative stuff. I will say this, our office had two recent beneficial outcomes in litigation that have assisted people with issues that they had dealt with immigration. Their cases are being resolved presently, and we're hoping we can get them back, into the U.S. in the next, coming month or two. So that all that is to say this. There is still, the courts are still being the courts. Like, the courts are still doing what they can to follow the law right now. So that is always an avenue when everything else fails. There is litigation that's coming down the pipeline right now that is going to be challenging some of the modernization rule changes for the H-1B. So that's something that'll be coming up in the near future too. I'll maybe update you guys about it as it plays out. But yeah, all that being said, everybody, stay safe and have a fantastic weekend.
Thank you so much, Justin. You too. Have a fun Friday and a happy weekend ahead. I hope it gets positive by next week.
Me too. All right, have a good one. Bye.
You too. Bye. Folks out there, thank you so much for joining. I'm so sorry if we couldn't take up all your follow-up questions, but Rag, AJ, always good to see you. You guys are our frequent viewers, visitors. So keep commenting, and thank you for sharing your opinions with us, AJ. Really great to know what you think as well and your thoughts. So keep sharing. And yes, don't forget to like, share, and subscribe to us. All of you folks out there, thank you for watching. Thank you for joining. And stay tuned on Immigration and Jobs Talk Show because we got more discussions coming up, especially today at 4 p.m. Eastern Time. We have daily immigration dose, and I'm going to be back with my co-host Sam. And also, if you have to tell us more about your case or about yourself, please feel free to even contact me. And my phone number is 408-335-6444. You can even WhatsApp me in the same number, and you can email me. My email is nipa@staffingly.com. And yes, thank you once again for joining us. Stay tuned. Bye bye for now. Hello and welcome everyone to Immigration and Jobs Talk Show. I'm Nipasa, your host for today. And before we start off with today's session of discussion, and I have this very amazing guest, I want to read out this very important disclaimer. So, yes, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, once again, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X. So, please feel free to join us by commenting. You can participate with your questions. And yes, we also have a phone number where you can join us. So, all you have to do is call in this number 425-436-6335, and the access code is 988-888. And once you're in, you can speak. We will be able to hear you. So yes, very, very excited that, our topic of discussion for today is facing deportation under Trump's immigration plans and what are your legal options. I know there has been so much happening ever since Trump joined a week back. And yes, we hear a lot of deportation news, a lot of scare that is, faced by a lot of immigrants out here. So yes, if you know someone who's in danger of deportation, this discussion is also for you. So, yes, we'll be talking about the latest legal options, possible defenses, and how you can protect your rights in this uncertain times, and I'm very, very excited because joining us today for the first time is a very distinguished guest, Isadora Valacuez, and yes, an AV rated board certified immigration attorney from ISA Law PA in Miami, Florida. And Isadora has years of experience helping clients navigate complex immigration issues, and she's going to join us, to shed some light on what steps you can take to protect yourself or your loved ones from deportation. So, without further ado, a very warm welcome to you, Isadora. Thank you so much for joining us today. And
Thank
how
you,
are you
guys.
doing?
I'm doing great. Great. I mean, despite everything, happy that I get to share some information with you and all your viewers.
I'm very excited, and this is our first time, so it'll be very nice to know from yourself about you. So, would you like to tell us more about yourself?
Well, in a nutshell, I am located in Miami, Florida, but immigration law gives me the luxury of being able to travel and represent people all over the world. My niche practice is actually in removal proceedings. So I tend to represent, although we bring investors and I help employees and employers bring anyone here into the United States, I mainly help you if for any reason you're getting kicked out. So that's my niche. And that's why this specific topic is so essential to what I do and why it's
And
such a
very,
privilege
very
to share it with
timely.
you. Yes,
Very, very
exactly.
timely, I would say. Yes. So we're very lucky to have you today. And I mean, it'll be so nice to know it from you, your experiences as we, get deeper into this topic of today. So, what can folks out there expect from today's discussion?
So you mentioned it a little bit in terms of experience. We've been through this before. This may seem new because Trump just took over as president, but he was our president back in 2017, and we got some lessons as to what we can expect. Also, we have his campaign promises to follow as a good roadmap as to how immigration may look under his administration. First, I'll start by remembering 2017. And in 2017, the most shocking aspect, at least for me, in the immigration practice was the Trump Muslim ban. Basically, for those of you who don't know, or for those of you who remember, it left many individuals with valid visas out of the United States simply because there was an executive order listing specific countries, for example, Nigeria, and stating that people who were out of the United States, their visas basically were no longer valid. This has created a new warning now for my clients in terms of whether you have a visa here in the United States and if you can travel. I have many clients with H-1Bs, for example, L visas, different types of visas, many students who now may be looking to visit their families, see what may happen. So far, President Trump has not signed an executive order similar to the Muslim ban that we lived back in 2017, but we did go through it back then. He did warn us that it could happen again. And most importantly, the Supreme Court here in the United States upheld such an executive order. So I would like to start by warning anyone who may have a valid visa that although it may seem absurd, the reality is that a president can't overrule and overturn and basically cancel, revoke your visa simply with a pen stroke through executive order. So keep that in mind when you're making travel arrangements, because it's something that we typically don't consider. We have our visas, everything's fine. And it was rather shocking experience back in 2017. And I would hate for anyone to go through that again during this next 4 years. As to the
Well,
people here,
thank you so much. Yes. Sorry, I interrupted. Please go on.
it's okay. As to the people here, I just wanted to warn. I know that if you turn on the TV, it can be scary, as you mentioned in the introduction. You keep seeing ICE raids, you keep hearing at least about executive orders that may affect people in the United States. I will gladly go into details as to who may be affected by executive order, but I'll start by giving the warning that immigration law itself has not changed in over 40 years. I've been practicing 17 years. It has not changed. What changes are executive decisions that may be temporary and have a very deep effect. Right now, the rates that you are seeing are being targeted to individuals who either have a criminal record or have a deportation order. That is the warning. However, when it comes to raids and ICE, anyone who may be without status could be subject to removal, and anyone in border states, Florida, for example, Anyone close to the border by 90 miles is also subject to expedited removal. So just be careful, but understand that the law remains the same.
Thank you so much. I mean, that was a real great insight, and I'm really looking forward for this whole session ahead of us. So much to learn from you, Isa. So thank you. Yes, and like you've mentioned, ICE, and we've seen like DEA, FBI, everybody joining hands with ICE in this mission to really deport. I mean, you everywhere you're bombarded with news of deportation. So I can only imagine how scary it is for all immigrants out there,
Yeah,
status or no status.
it is terrifying. So for individuals who may be here, the reality is in the United States, the only individuals who are guaranteed entry at least and know that their status is safe are citizens. That is a truth. However, executive orders cannot get rid, for example, of your residency if you're an lawful permanent resident. But for any individuals who might be fearful as to what are their rights, how can you protect yourself, if you already know you have a removal order, then I encourage anyone to explore how they can reopen. Any removal order can basically laws change, they may change, and you may be able to go back in time and reopen your case before a judge. Anyone who does not know their status because they're afraid of finding out, now is the time to find out. It's best to know now and protect yourself. And lastly, for people who might be pending, it's good to explore what options may be available. You may still be able to seek, at the very least, withholding of removal if your circumstances in your country may have changed. So explore your options. They're out there.
Thank you. At least that was hopeful. Thank you, Isa.
I
Yes.
try.
And I think without further ado, I'm going to move on to the questions that I have. So my first question to you, Isa, is, with regard to the legal grounds, what are the main legal grounds? You've said it's not changed. But yes, when you talk about deportation, especially under this current administration, Trump 2.0.
So we have to distinguish between what is a revocation of a visa, which may be that you're here on legal status and you may receive an email or something letting you know that your visa has been revoked. That is not a deportation proceedings. That is simply warning you that you may not be able to return on that visa status. A deportation proceeding entails, a removal proceeding entails appearing before a judge. Individuals who come in under a status known as ESTA or visa waiver don't have that privilege. They have waived their rights, as the name says, so they will not appear before a judge. Only individuals who may be subject to deportation appear before judges, and these individuals tend to be people who have been in the US for over a certain amount of time, who may have a remedy, and you may appear before the judge because you either don't have the correct status or maybe something happened that affected that status. Under the new laws, and this is a new act that was recently passed by the Senate in the first week of Trump being in office, individuals who have been accused of committing a crime could be held on immigration detainers for ICE to pick them up. So although they may not end up in deportation proceedings because of the crime itself, because they haven't been convicted, they may end up with their visas revoked or their status in jeopardy simply because of the accusation or the arrest. So this is the only expansion in terms of who could be subject to deportation. During the campaign, Trump focused heavily on people who were criminals, had criminal record, or had deportation orders in absentia, which means individuals who were supposed to go to court and simply chose not to go to court. Those were the main targets. But we have seen, like I mentioned in the introduction, that when it comes to raids, many people could be subject of the raids, even if they are not part of these two particular groups. So it's good to know your status and know your rights. Know that even if you are detained by ICE, you still have the right to appear before a judge, depending on how you enter the country. And the asylum right is a universal right anywhere in the world. So you can always let the government know that you have a reasonable fear to go back home, but you must show persecution from the government or from an agent that the government cannot control. It's a very difficult remedy, so it's best to explore all the other remedies first and use that one as a last resort.
Absolutely. And I think it's always best to consult with an attorney. And why not contact? The best for now in this case would be, of course, Isadora herself. And folks out there, she's based out of Miami, Florida. So her phone number is 305-938-0676. And you can email her about your case in case you need help. And her email address is isadora@isalawyers.com. And go visit isalawyers.com to get to know more about Isadora for sure. And with what you just said, I mean, this fear of deportation everywhere and with every individual, every immigrant. So I have my next question. What should one person do? The immediate steps that the person should take, facing deportation to protect their rights.
The first step is to find out your status in the United States. If you've been here for too long, you may not know. It's good to figure out what does immigration have on you. If you maybe submitted an application and thought nothing happened with it, or it's never processed, believe me, if you were submitted, it's there. So it's good to know. And you can find out directly from the Department of Homeland Security by submitting a Freedom of Information Act request that will give you your entire record, so you will know if you have, for example, an alien number, if you have a case pending, if it was denied or maybe approved. It's good to know your immigration status if you're in the country. For individuals who are in the US for more than 2 years, it may sound silly, but it's something new and it's something that you should do, especially if you live in a border state like I do, state of Florida. It's good to have record of how long you've been in the US. I emphasize this because during the Biden administration, we had certain benefits, people allowed into the country of certain countries like Nicaragua, for example, Venezuela, Haiti, Cuba, for 2 years. Now, Trump has announced as of Thursday last week that these individuals or anyone close to a border state could have their parole status revoked. And that is a process called expedited removal, which would apply only for people in the US for less than 2 years and who are, once again, in a border state close to the border. And the border includes the ocean. So it also includes California, Washington State. It's good for you to have your record. So that would be my other advice. If you filed taxes 3 years ago, may sound weird. You may want to carry a copy of that tax return with you to show that you've been here enough time to be able to go through any proceedings if needed, instead of to be placed in proceedings quickly when that shouldn't be the case. Lastly, explore options. And I'll repeat this. This will be a common theme throughout this presentation. There are options available. You may be here, for example, as a student, and you may be able to switch your visa. You may be here under temporary protected status. Maybe you can travel and we can find another status, a more suitable status for you. Find your ties to the US, and let's find a way to make you more permanent in the country so you can rest at ease no matter who's president.
Absolutely. Thank you so much, I mean, for that hopeful message. And yes, look out for options. I think it's always best to do your research, know your rights, know what options you can have, and of course, consult an expert. And attorney would be great. And, I would also like to appeal to folks out there to call us up. We have Rohan, Bhavin, join us. So why don't you also, I mean, we will take up your comments for sure a little later in this show. But what I want to tell out to folks out there, yes, take this as an opportunity that you can call us and talk to Isa herself, and just call us on this number, which is displayed on the screen above. And so now, moving on, Isa, I have another question, and that is, how can individuals determine, if they qualify for relief from deportation? And,
I'm going to
if there is asylum, as you mentioned earlier, then cancellation of removal or even adjustment of status. So how can they know that?
Of course. I'm going to answer your question by at the same time addressing Rohan's question in the chat so that he gets a response. The best way to determine your remedies is to determine how did you come into the country. As you keep emphasizing, Nipas, and you're absolutely right. Speak with an attorney. And I give the warning that in many of our countries, for example, in Latin America, notarios may be considered attorneys. In the US, they are not attorneys. So you need to be very careful who you seek legal advice from. Attorneys have a license on the line to lose. And also, if an attorney gives you the wrong advice, there are actual legal remedies that you can use to fix your status, get some status in the United States based on that wrong advice because you relied on it. So that's the benefit of speaking with an attorney. The best way to know what remedy you qualify for is after having that consultation, determining how you came into the country. What ties do you have to the United States? For example, if you've been here for a long time and you're placed in deportation proceedings and removal proceedings, you may qualify, as Dipasa very well mentioned, for cancellation of removal, But to qualify for that remedy, you need ties to the United States, a family member. There may be waivers that may be available, whether if you have a criminal record, that would also require a family member. If you were a resident and you may be losing your status, either by a mistake or something that may have happened, waivers are also available that may not require a family member, but will be based on how long have you been here and your character. So because each case is unique, it's always good to have that consultation and know that there are many remedies that are available only if you are placed in proceedings. In Rohan's case, for example, without more information, it's important to know how we came into the United States, because coming into the United States legally, meaning with a visa or being paroled to the United States, meaning they allowed you to come in, may open the door to other remedies. For example, adjustment of status. That's what we call when you change your status maybe to a residency through marriage. You may marry a U.S. citizen. You may even marry a Cuban resident and acquire status through their marriage, but only if you entered legally. Meanwhile, if you enter irregularly through the border and you overstayed or simply stayed too long, it may be that your only remedy is to seek asylum. If too much time has passed, 15 years or more, it may be that your only remedy is to seek withholding of removal, which means that you are basically trapped in the United States. You're allowed to stay, you're allowed to work, but you won't have the privilege of a residency and you won't be able to travel. So these are little caveats that are very unique to each person's case. And also remember, some of these remedies are only available, sadly, once you are in deportation proceedings.
Right, right. Thank you so much for taking that up, Isadora, and also Rohan's answering to Rohan at the same time. Hi, Rohan. I hope you've gotten your answer and you can keep commenting and even join us, in fact, if you want to. So, Isa, I want to have ask you to explain a little bit. Why do you think people overstay or they fall out of status and still are in the US? Why not find a solution before that? Play safe.
Lack of planning. I can tell you 95% of my consultations are people coming in and telling me, so I came in as a tourist and what do I do now? And not understanding that as a tourist, you only get merely 6 months. And without a proper plan, simply coming in as a tourist, it's not like the movies where you can just stay and things will be merry. You need to find a way to adjust your status. Or the other way is minimizing it. People simply minimize the consequences. They think, what's the worst thing that could happen if I just stay longer than I'm allowed? That later on, doors that may be available, particularly employment opportunities that are maybe available, are no longer options if you have stayed out of status. If you are in the US illegally without status for more than 6 months and you decide to leave, you basically cannot come back for 3 years. If you're out of status for more than a year, decide to leave, you can come back for 10 years. Same applies for employment opportunities or other visas that may be available. If you're out of status for up to the 6 months, you may be able to change your status, apply for an investor visa, seek that job that you want, change your status. But the 6-month mark is crucial. So the lack of planning is essential. We need to avoid that, plan ahead of time. And also remember, there are other options if you still need more time to plan. You can always extend your tourist visa depending on the visa. And you can also choose to become a student, which is a very popular option, which people decide to embark on. It has many limits. You're not allowed to work, which is very burdensome, but it does buy you, at the very least, buy you time until you figure out what do you want to do in the United States.
Well, there you go, friends. I think it's also ignorance. So I think it's always best to do your research, learn more why you're there and what options you have, especially because that's not your own country and you wouldn't want to be kicked out. I mean, imagine, getting yourself paralyzed of options. I mean, greater options. So, yes, play safe and all the best, I would say. So let's move on, Isa. I have another question for you. And, this is, what role do sanctuary cities, they play in protecting undocumented immigrants? And how effective are these measures under federal law?
So we have seen their role a little bit so far in this week. Granted, it's only Wednesday, Tuesday. We've seen it a little bit, particularly in Chicago. Chicago is considered a sanctuary city, and their behavior during the Trump announcements of the ICE raids in the city shows why they're considered a sanctuary city. They were very clear that the local police enforcement would not cooperate with ICE. However, there's only so much you can do. The reason Chicago was chosen to be the model city for these ICE raids is because of the high volume of Customs and Border Patrol officers and ICE officers that were already located in the city. So the city may be an advocate for immigrants, and they may be vocal in letting the federal government know that they will not cooperate with them. That does not mean that the federal government cannot come in and choose to enforce the ICE raids as they please. What the sanctuary cities tend to do, and we see this mainly in Chicago, we've seen it, and we see it particularly in cities in California, they promote individual rights. Immigrants in the United States have limited rights. It's not the same as what we see on TV. You have the right to remain silent. That does not apply in immigration proceedings. In fact, they're considered civil proceedings because the penalty of being deported is not considered as severe as the penalty of being incarcerated, for example. So you do not have the right to an attorney. However, when it comes to warrants, having to open your door for individuals to come into your house and arrest you, or your boss having to open the door for an ICE raid, you do have rights. And you don't have to talk to anyone that you don't want to. You can always politely ask if you're being detained. And if you're not being detained, you can always walk away. Those are simple rights that everyone should know. Last, and I'll repeat that regularly, they have emphasized the right to a reasonable fair interview, meaning the right to an asylum. So for individuals who ultimate choice may be like they've been here way too long, there's no other remedy available, the right to an asylum is a universal right. And if you're able to express your persecution by the government or an agent that the government cannot control, you have the right for an interview. So sanctuary cities tend to repeat this to the immigrant community so that they know their rights, but they're very limited in how they can control the federal government coming in if they want to.
Very, very important points. And thank you so much, Isadora, for highlighting each one of them. And it's so important, to know your rights. And especially in these trying times, I'm sure people are, so anxious as in what is going to happen. They are all seeking help. They're probably Googling, which is not the right place, maybe right now. So I really hope that folks out there are not missing out this session. And yes, if you know anybody who's in this fear of getting deported or are on the verge, so please share this link with them, ask them to join. And even better that even after this session is aired live, we will still have this. So I hope that folks out there can watch this and don't miss out on the important points that Isadora is really sharing with us today. Thank you, Isa. And let's move on now to my next question. And this is, with regard to folks out there who cannot afford, what legal resources are available for individuals who cannot afford private representation during deportation proceedings?
The way deportation proceedings begin is that you receive what is called a notice to appear. That notice to appear tends to be attached to many documents, including a list of free or low bono providers in your area. So that would include here in Florida, for example, Catholic Legal Charities, that they work closely with private attorneys. We take on pro bono cases to help people. So if you're ever in deportation proceedings, because you'll receive the notice to appear, we call it an NTA because of the letters in English, know that you will also receive this list of attorneys. When you contact them, keep in mind, from former experience, these are my colleagues and my friends, they may be overwhelmed, particularly during this time. But I will also give you the second part. This is going to be a very slow process. At least here in Florida, we're having individuals, which are the final trial dates, scheduled for 2028. So that should give you enough time to find the attorney that fits your needs to create your case. That is very different than what we may see, for example, in individuals during the COVID pandemic or individuals in the border. The border right now is in a state of emergency. Doesn't mean that the border is closed. We still have people coming in and out with visas. We still have goods coming in and out. It means that individuals who are seeking asylum might be forced to get this benefit in Mexico. They're not allowed into the US. That is something, once again, that we lived through during 2017 to 2020 in the Trump administration. Those individuals and other individuals who might be in expedited removal have quick cases before judges, and they have to rush to present their case, to hire an attorney, that will be should be a low percentage. We saw that increase during the Trump administration before. It's likely to increase now, but it should still remain a low percentage. So my point is, look at the list. If you're ever in immigration proceedings and you cannot afford an attorney, look at the list you will receive with your charging document. They may be there, they can help you. And in the alternative, explore how long it will take so that you can find an attorney who can give you a hand. Last disclaimer for anyone seeking asylum. Asylum itself needs to be requested upon a year of entry. So if you've been here for more than a year, you're not seeking asylum itself, you're seeking withholding of removal, and that's based on the fear that you may have of going back home because of the circumstances at your home. So that's something good to distinguish, because sometimes we take a little bit too long to file for asylum and we're out of it, or we get promised that we're going to file for asylum, but we've been here for 15 years, so we no longer qualify. So be aware of the remedy and talk to an attorney. These are complicated cases. It's good to speak with a lawyer.
Yes, yes, absolutely. Thank you so much, Isadora. And I think, we should quickly take up a few questions from our audience, and that way we can jump back to our questions as well. So let's take up Bhavan's question. I've been detained by ICE before, but was released under an order of supervision. If there's a shift in enforcement priorities, could that put me at risk of being detained again?
Pavan, I hope I'm wrong, but if you are under an order of supervision, typically that happens because you may have a removal order, meaning a deportation order signed by a judge, or your court case may have been closed and administratively closed for whatever reason. If you have a removal order, technically you are already part of the priorities that Trump has already mentioned. So you should be very careful. Right now, my point is, if you have an order of supervision, you don't really have status in the United States. They're giving you the courtesy of letting you stay. That's why you have to report every so often. I highly encourage you to find out what exactly happened. How did you get this order? What was the final decision that led to this order of supervision? See if you can reverse it, reopen it, try to find a more stable status. In 2017 to 2020, we didn't see the Trump administration go directly after people with orders of supervision, but we did see them work closely with countries that were not taking people back to revoke these orders of supervision and send people back. I wouldn't want that to be you. So see if you can fix this. An order of supervision is not the best status. And yes, you could be subject to one of the priorities in the future. Sorry.
Thank you so much, Isadora, for taking this up. And Bhavin, if you were happy with the answer, it's great. But otherwise, we would like to know more information about why were you, put under supervision. So tell us more. And otherwise, why don't you contact Attorney Isadora herself? Yes, and let's go on to Anusha's question. I am an Indian citizen who has been living and working in the US on an H-1B visa for the past 5 years. Recently, my employer filed for my green card, but the process has been delayed due to the COVID-19 pandemic and the Trump administration's immigration policies. Okay, I'm getting married to a US citizen soon and am worried about my immigration status. What are my options for obtaining a green card, and how can I expedite the process given by my circumstances?
So I'll go through each step. First, if you're here on an H-1B, you should be okay. As you know, the H-1B, and if you don't know, now you'll find out, you have a limit of 6 years. So eventually you need to know how long have you had this visa, and it will only count the time that you've been physically in the United States. So if you're close to the time and maybe you spent 6 months out traveling, you can renew for that amount of time that may be left on the visa. As to applying for the green card, when an employer files for the green card, they have the choice of doing it in an adjustment packet, which would mean doing the petition with the residency petition all together at once. Or the way I prefer to do it is to split up, to do the petition first, get that approved, good for you, and then apply for your residency. And the reason I prefer splitting it up is that if anything happens with that first petition that is not approved, I can fix it. So instead of having it all denied. So it's good for you to know, how did your employer apply for this green card? Did they do the entire packet? was the petition will be called an I-140 petition for employment, employer petition. So if that I-140 was already approved and they filed for your residency, you can relax. You're here pending adjustment. So congratulations on your marriage, but you're okay. You will eventually receive your green card through your employer if the I-140 was already approved. If they was filed in a packet, same thing. You can just simply wait for the decision. But you asked about expediting. If it was filed in a packet and you don't have a decision on the I-140 petition, you also could file through your marriage. You can have many petitions running at the same time. You can have a petition through marriage. You can have a petition through one employer, two employers, three employers. You can have it through many spouses, but you could have it through several employers. So you can have many petitions running at the same time and see which one gets to the finish line first. Typically, we've seen the marriage petitions tend to be quicker. We've seen that. In 2017 to 2020, petitions that were taking 2-3 months during the Obama administration, that were also taking 3 months during Biden, back then were taking 2 years. So I can't guarantee filing through your marriage will expedite it, but it's definitely something you could do and just have them running at the same time and see which one gets to the finish line first. As long as you file any petition for your residency, which is the I-485 application, as long as you file that application while you're here on your H-1B, doesn't matter that your H-1B expires, the time that you're waiting, you're here legally. And you can apply for a travel permit if you need to go home for any reason.
There you go. Anusha, thank you so much for participating with your comments, and I hope you got your answer. Thank you, Isadora, for taking that. So would you like to tell us also, how important is the I-140 and the I-485?
So first, I wanted to emphasize that as to how some people do it, because I know that many of my clients many times want the entire petition together. They want the I-140 petition for the employee filed simultaneously with your I-485. It's very important for you to know which category you're applying under. If you're an EB1, meaning you are, and we're not very creative in immigration, so the letters and terms that we use are very boring. And EB1 means employment based. So when you hear EB for any term for immigration, at least, that's residency-based, employment-based petition. EB1 are the bosses, the big boss, the one that never answers the phone. He just tells people what to do. If that's your case, then you may be eligible to file the entire packet together all at once. If you're in the second category, which is EB2, that tends to be extraordinary individuals or individuals who are going to be working for the common good, something in the national interest. It's good for you to follow exactly, it's called a visa bulletin, and it will have dates letting you know if your application is what they call current or if you're going to have to wait. Because I also wouldn't want you to waste money filing an entire adjustment package with an I-140 and I-45 application for residency only for it to be rejected because your application is not up to date. I can tell everyone here who may be in the most common category, the EB3, which is for the regular day-to-day employee who has a degree and is needed for the economy, but simply can't be found in the U.S. economy to work the position. Those individuals will have to wait. By now, they're processing the applications from 2022, if I'm not mistaken. It could be 2023. So it's not current right now. So it is best to file your I-140 petition first, no matter what, because you're going to have to wait. And as it is pending, once it is approved, you will know the date when you can file your I-485 application for residency. While you're waiting, you need to keep legal status if you're in the U.S. Otherwise, you can always do consular process and receive your green card in your country through the embassy.
Thank you. What? Welcome back once again, everyone, to Immigration and Jobs Talk Show. And it's really exciting today that we are having a great discussion with none other than Isadora Velasquez. And yes, we are here talking about a very, very important topic today, facing deportation under Trump's immigration plans and what are your legal options. Well, thank you so much, Isadora, for being here today and for patiently answering, taking up so many of our questions and making this discussion a very interesting one so far.
It's my pleasure. I see that Pratibha has a question about
Right.
overstays, which I asked before, Nipasa. What happens if you overstay? I don't know if you want to read it, and I'll gladly answer it.
Sure, I can read it. I overstayed my student visa years ago, but I've since started a business and contributed to my community. If deportation becomes stricter, can my contributions or business ownership help my case? Pratibha is
Under
asking.
the law, and like I said before, this is over 40 years that the law has not changed. Your contributions while out of status will always be beneficial. The same, it's called the ties to the country. So the contributions, your business, any family you may have, the amount of time you spent in the United States will always be, they will be considered beneficial factors for you to present your case. And depending on how long you've been in the US, you may qualify for some things that we discussed before if you're placed in deportation proceedings. Now, please understand that contributions alone are not sufficient for you to seek a legal remedy by yourself. It might not be enough. So you may need a little bit more than simple than a business. And I'm not doubting your business is very successful. I'm not doubting they're contributing a lot, but you may need more, especially if you want to seek business by yourself, if you want to seek a visa or more control by yourself. So the ties tend to prefer family ties. Business will definitely help you fight for your right to stay, but it might not be enough to actually win your right to stay. So keep working on it, keep building it, and in the end, they may help work on your favor.
Thank you so much, Isadora, for taking that up. And Pratibha, I hope you've gotten your answer and you can keep asking more questions if you have any further questions. So, Isa, we also have more questions from our Facebook group. So I think we should quickly address them and then when we get time, fall back to our questions again. So, Control, if you can display them, please. Let's take up this first one. This is from Krishna asking, hi team, H4 to F1 transition. Could you please zoom in a little bit? What are the best options to choose for changing to F1 from H4? Her F1 visa is rejected in India and she came back to USA on H4.
If the F1 visa was already rejected at the embassy, the F visas, and for those of you who don't know, the F visas are student visas. The student visa, in my humble opinion, should always be processed by the school that is issuing you the visa. As international students, you will end up paying much more than residents or citizens of the United States. And the reason why your tuition is so much more expensive is because the school has to be heavily involved in the visa process. They have to apply for the visa for you. So if for any reason India rejected your F1 visa, you can always choose to change your H4 status in the United States locally to an F visa. The big caveat here is that when you choose to travel for any reason and you go back home in India, you'll need to get your F1 visa on your passport. That's the difference between what we call a change of status, changing your status from H4 to an F1, than to acquiring status. You cannot come back after you change your status under an F1 visa if you don't have it on your passport. So you will have to go back to the embassy. They may reject it again. Very helpful to know why they rejected it so that you can fight it here and be ready to get it again after you change your status in the United States.
Thank you so much. And I hope, Krishna, you've gotten your answer. I think this was a question for somebody else, but yes, great question. Let's go on to our next one. This is from Sachin. Hi, all. I am currently on STEM OPT with my end date in February 2026. I have one more chance to apply for the H-1B lottery this year. If my H-1B gets picked and approved, will I be able to travel to India in August and return to the US by October 1st? H-1B deactivation date.
So I'll explain the H-1B lottery visa process. You will know if you were chosen by this lottery basically by April. You should know by April. And hopefully your employer will be applying for your visa by the summer, before August when you leave. Because ideally, you will be coming back to the United States after your trip in August by September. So to answer your question, yes, you can leave in August and come back in October. That's perfect. But you may want to come back a little bit earlier, maybe a month earlier, before what we call the fiscal year starts, and get settled up, find the apartment, get set up to begin working. And you should be allowed to return in September if you're picked up in the lottery for April. So good luck. Hope it happens.
Yes, all the best. Since it is lottery, I think you need all the luck. So all the best, Sachin. Let's go on to our next one. This is from an anonymous member. As an H-1B holder, I avail medic aid for children and premium discounts, tax credits from state on health insurance purchased via marketplace. To my knowledge, it doesn't fall under public charge category. And will this cause any issues in future visa extensions or green card process? Any expert opinions are appreciated.
Great question. The marketplace, also known as Obamacare, is private insurance. The only reason it's called the marketplace, Obamacare, is because of the law that forces these companies in private insurance to give us that insurance, even if we have pre-existing conditions, and for the government to subsidize that insurance if we cannot afford it. But it doesn't mean that it's a private company. So shouldn't affect your public benefits, because you're not receiving any public benefits. I would encourage you to try not to accept any government subsidies when it comes to paying. If you can pay it out of your pocket, that would be best. But feel free to use the marketplace for your insurance needs. You're entitled to it. You should be okay. It should not affect your any visa or future green card process.
Great. Thank you so much for taking that up, Isa. Let's go on to our next one, and this is also from okay. My H-1B extension was submitted on August 2nd, 2024. H-1B expired on September 30th. Until today, it's been in review status with no update.
You have the option, and you may not like it because it's pricey, but you have the option of contacting, paying $3,500 more. It's called premium processing, and that will force the government to give you a decision on the extension in 15 days. Make sure you have the option available. You have to let them know ahead of time, send them a check. It is a good option if you want peace of mind. However, technically, under the law, during the time that you apply for the extension, it's the same as when you're applying for a change of status. So you are technically, legally in the United States until a decision is issued. So be on the lookout for that decision. If you really want the peace of mind, it's worth it to pay a little bit more, but be aware that technically under the law, you should be okay until you get a decision.
Okay. Thank you so much, Isa, for taking that up. Now let's go on to our next one. This is also from an anonymous member. Planning to travel with family from US to India this year after a long time. H-1B, H-4 visas have expired on our passports, but have approved extensions, I-797 petitions. Travel costs seem exceedingly high to travel with family, but routes via Europe seem relatively on the lower side. Question is it possible to travel via Germany or UK, etc., with an expired visa? And the second question is, would a transit visa help? And next is, don't bother, take a different route.
The answer I'm going to give you, what they will call in the US a very legal answer. It depends. What are you coming to do in the United States? If you're coming to work, you can use your H-1B, H-4 expired visas because you already have the extensions. It doesn't matter if you come through the UK, Germany, it doesn't matter. You should be okay because you have extensions on your H-1B and your H-4 visas. However, if you're coming as a tourist, you will be asked why you're coming to the United States. So if you're not coming to work, then yes, the best way would be to apply. I wouldn't call it a transit visa. I would call it a tourist visa. We also call it the B1, B2 visa. B1 is for employment purposes when you come maybe for trainings or for a conference. B2s when you come to visit Disney World or to check out how California is doing. So if you're coming as a tourist, that's the way to go. If you're coming to work and your visa has been extended, you should be okay. Doesn't matter where you come from.
Okay. Thank you so much, Isa, for taking that up. And let's go on to our next one. I think this is the last one from our Facebook groups. This is also from an anonymous member. Recently got a Canada PR and have H-1B job in Seattle, 2 days a week in office. Employer doesn't care if I spend remaining remote days in Canada. So for H-1B stamping, is it okay to disclose I may work remotely from Canada regularly or occasionally? Wondering how to answer the question, will you be working remote or hybrid from your work location?
Answer yes. And the main reason I would say answer yes is because now that you have the permanent residency for Canada, you may be seeking a more permanent status in Canada. And you'll find out that once you have Canadian status, you can come in and out of the US for 6 months per year, no questions asked. It's actually very flexible. Being candid and honest now, letting them know that you have your Canadian permanent residency, that you will be working remotely from Canada, will also help them relax a little bit whenever they see you and asking you questions if you choose to come in through the Canadian border. So answer yes, you will be working remotely. That's still your H-1B visa was still approved under the same conditions, so it shouldn't be an issue as you come in and out through the border. You'll also notice that the Canadian border is very flexible. If you have to renew your visa, you can do so through ports of entry through that border. So it's good to be honest with them and letting them know that you're spending time in your new home of Canada.
That's great. That's great. Thank you so much, Isa, for taking that up and so patiently answering each one of our group Facebook group questions as well. Yeah, and brings me to another question that I have for you. I have prepared some more questions, and this is with regard to mixed immigration statuses. So families with mixed immigration statuses, can they take proactive steps to prevent separation or deportation under the current policies?
Yes. So if you have children over the age of 21 who are US citizens, I don't care if your mom and dad don't want to live in the US. If you are in the United States and you're over the age of 21, give your Mother's Day, Father's Day present by simply filing for your parents. The reality is, children, we have the control. It's our petition when we're petitioning for our parents. So we can be proactive, we can file for them. And later on, when mom says, I don't want to move to the US, I don't like that country, it's okay. At least you tried. You have it there. It's ready just in case. If you're in the United States, you can also file for your parents. And if you enter the country legally, it doesn't matter if you entered 20 years ago or actually 22 years ago and you were born the year after you entered, you will be able to give your parents legal status through this petition. So for children over the age of 21 who are US citizens, petition for your parents. For spouses, any spouse who's a US citizen can petition for the other spouse immediately. They can get them status. I say immediately because technically under the law it should be available immediately. You may have to wait a couple months until it's processed. So if the individuals are in the US and they came into the US legally, you will be able to help them adjust their status to a residency fairly quickly. If they came through the US illegally, meaning through the border or something happened, they may qualify for waivers. These waivers are scary because they force you to leave the country, leave the United States, and get your residency in your home country, but they're worth it. Because if you already qualify for the waiver and you're approved by the time you leave, should be just coming back with your green card. Scary to leave, but definitely worth it. Now, Trump knows this is happening and he warned us. Part of his campaign promises were that he was willing to separate families that were mixed, as you mentioned, individuals who may have children in the United States, but the parents don't have status. And he warned us of this because back in 2017 to 2020, we saw family separation in the border as a deterrent for people not to come in. So he knew that it was going to be very shocking especially for US citizens, for his voters, to see children separated. So I know it is extreme, but I have been warning my clients to, if you know you're going to leave your child or you may be forced to leave your child, or that could happen, that if you have an encounter with immigration, your child is a US citizen, but you are not, it's good to have a plan. So I hate to send that answer in a sad note, but it is helpful to have a plan. Who will care for your children? Power of attorney if you may need it, because he has made it clear that he's willing to go forward with this, even if it's something the U.S. Citizen is against. It was part of the campaign promises, and so far he has delivered in the past 2 weeks.
Thank you, Isa, for that insight. Really, very helpful. And now let's move on to our next one. We see that there are a lot of changes. It's just been a week with Trump hitting the office, but then how have these changes, whether you talk about visa or green card policies, how have they impacted these deportation risks for non-citizens in the U.S.?
So the main impact that we've seen, of course, is fear, because we don't know. And that's why I start by always warning everyone to at the very least know your status. And after you know your status, meaning know if you have a deportation order, know if you have been in here illegally but you enter legally, and you have a business here, you have a spouse here, you have a child here. Know your circumstances, know it well so that you can present it. Know your country. So know that if you have an encounter and they want to send you back to Nicaragua, now there's a dictatorship there. You cannot go home, and then you can articulate the reasons why you cannot go home to you, not to the country in general, to you. They will follow me or persecute me because I am a woman, because I am gay, because I am religious, whatever it may be. Make sure that you are able to explain it if needed, because that's what we've seen, that these are encounters that, although he warned they would happen, people are not ready for them when they do happen. Lastly, if you have the relationship with your employer in which you can be fully honest with them and have them understand both your rights and their rights, an employer is very limited sometimes in their rights depending on their state. For example, the state of Florida gives a lot of leeway and authority for inspectors to come into my workplace. So there are limits, but you typically require a warrant. And if typically a warrant is not available, these ICE visits, these ICE raids are done on a whim. We assume this person's here. They may be looking for somebody else who's not you. So request that document. It may seem simple, but it's important and very helpful.
Thank you, Isa, for taking that up. And now that everybody is facing a lot of fear of deportation, what would you advise employers of undocumented workers who are really concerned about potential workplace raids as well and deportations? What do you suggest they do?
For the employer on a personal level, I know the concern, for example, Florida, the main concern is whether we're going to be fined, and the fines can be steep, but the fines are available everywhere, doesn't matter where you are. And they tend to be related as to having individuals work for you who don't have the proper documentation. What I've noticed in the past, doesn't matter the president, from Obama, from George W. Bush, that's when I started practicing, to the now Trump, when you're able to show that you've consistently paid the correct wages, meaning that you were not underpaying your employee because of his status, they tend to be much more flexible with the fines. They tend to lower them because they understand that maybe you hired out of necessity, which tends to be the case, or maybe you hired out of ignorance. You didn't know that you had to request all those documents to hire somebody. Now, to protect your employees, a warrant is needed to enter your place of business. In Florida, an inspector can enter your place of business to check out if you have 25 employees and to determine if they're here legal or not. That's a local law. But under federal law, to enter your place of business, it's like entering your home, and you can reserve the right of admission. You can call your business a club, and you can simply say, I'm not letting you in unless you have the warrant that forces me to let you in. And check out that warrant. May be able to give that employee a warning, a heads up. For employers, the reality is that we know when they're coming. We know, and they tend to come to us normally not for immigration reasons. So if you have a heads up, be nice. Let them know, and they'll be out of there.
That's a nice one. Thank you so much, Isa. Yes. And I have another question, and this is with regard to legal protections. We've been hearing a lot of raids in schools, even in worship places. I mean, recently, even a Gurudwara was raided in New Jersey and New York, I think. So, what legal protections are in place for students and families affected by school raids, and how can these institutions respond to such incidents?
Well, sadly, the same way I started with the sad news that president can get rid of your visa by simply signing an executive order. In this case, sadly, for the legal community, for the immigrant community, the legal protections can also be eliminated by signing an executive order. President Trump recently signed one of memorandum executive orders saying that ICE raids can occur, as you mentioned, in schools. They can occur in hospitals. However, there are some places that tend to be considered places of business and they can be protected. Churches are the most common one. So you can seek protection there. That would be, we're talking here of extreme cases, but we've noted that tends to be where people feel the safest. And in reality, that is another place in which you would need a warrant to enter. But public spaces such as schools and hospitals can no longer afford the protection that we typically associated with these areas. So we have to be mindful. A little trick. When we have minor children, we sometimes don't apply for them to have a work permit because they're little. Why are they going to work? Who cares? But now I find myself warning my clients that it might be a good idea to have their child, if they're here on a status that may be temporary, like temporary protected status, or even under particular visas like the HV. Of course, your child's not going to work, but maybe you want to pay the $500, $600 and get that work permit so that he can carry that ID showing that he's here legally. It sounds weird and not needed because it's not needed, but these rates are terrifying even for attorneys. And the fact that they can go into schools, I would like to protect my child if that were the case.
Yes, for sure, for sure. And talking about Miami and your place out there, I'm sure it's been very busy. I mean, the past week must be crazy. How is it? Would you like to share some cases or incidences? Anything you want to share with us would be great.
So Miami has one particularly notorious ICE station. It's called in Miramar, and it's fairly busy. Typically at 9 a.m., we have people who will be showing up in orders of supervision. During the Biden administration, it became routine. They would get a new number. Miami also has the little caveat or the little additional flavor of the Cuban community being very, very famous here. We have a lot of Cuban communities, many Scarface, believe it or not, from that back in the day. It's very interesting that many countries that back then were not accepting people, deportees, I emphasize Cuba in particular. Now you're finding that when you're reporting, there is a sense of fear that Cuba Cuba has accepted deportees since the Obama administration. That's something that changed. It has since stopped during this Trump administration, Venezuela, Nicaragua. So we have this new flavor of people who are coming in with deportation orders, order supervision in the morning, who are routine up to the point. And then you have the second wave that comes during the day. And that's where we see the ICE rates. And it is a little bit like Top Gun, the Miramar station, but it's not as cool. We don't have good looking Tom Cruise looking guys. It's just a simple building with no windows, very terrifying. But we do see the wave in the morning of the people reporting who regularly report. And in the afternoon, we see the effects of the ICE raids that are very notorious in Miramar.
Well, I think, all I can say it's getting scary, and I think it'll be best to stay safe. So, maybe last but not the least, if you could wrap up by giving a few tips to folks out there who are facing fears right now, and tell us what should we do next.
I'll begin and end with the same note. Anyone who is subject to removal, who may not have any legal remedy, maybe you have a deportation order, maybe you already tried to reopen that case and you failed, maybe you appealed it and you failed too, you stayed too long, you came in through the border, there's really nothing you can do. Asylum, you may not be able to qualify for asylum itself, meaning you won't get a green card, but the asylum right, the right to seek asylum, protection from going back home, is a universal right. So you can always say, I'm sorry, I messed up. I've been here for 25 years. I have no papers. You're absolutely right. But I'm terrified of going home. And this is why. Asylum must be from the government or from an agent that the government can control. So if the police is going to be looking for you because you're a girl and they don't like girls and you know it and you can say, hey, my country, women are persecuted and I'm a woman, verbalize it. Second, and I've mentioned this before and I'll mention it forever, at least for the next 4 years. Know your status. Sometimes we ignore it because we're afraid. We think if we ask, we're going to expose ourselves. It's good for you to know. By knowing how you came in, you may be able to fix it. Deportation orders can be reversed. The law changes. People may get deported for something they did 10 years ago. The best example, marijuana. Huge deal in the 60s and 70s, not as much right now. So if you were deported in the 80s because you were smoking a joint, maybe now you can get rid of it. So it's good for you to keep that in mind. Know your status. Know your family. Who do you have in the US? Siblings, you may love them. Aunt, auntie, uncle, you love them. They're not going to give you anything. You want your mom, you want your dad, you want that. Siblings, they may give you something, but it's going to take like 20 years. So, and you want your children. So know your family and keep being like your listeners. Keep growing your businesses, keep growing your ties to the US. They may help you if you end up in deportation. Remember, asylum is a right. You can ask for a reasonable fear interview. Just remember that if you forget everything else I said.
Thank you so much, Isa. That was really very helpful. And I think if we still got some time, we should take up Ansa and not leave her without an answer. So Ansa's asking, what can I use as ID for my daughter who is a pending H4 dependent visa? And can the letter I received from USCIS be used as evidence?
Yes, Ansa, it can definitely be used as evidence. Anyone who has any letters from immigration, make a copy, keep them with you. It's good to have them, especially if that letter has any dates for over 2 years, because then you will not be subject in the worst case scenario. You would not be subject for something called expedited removal. So keep that in mind. You can use that for the time being. You can also check in your local DMV department what they can accept as documents for your child to get an ID, and maybe they can get our local state ID. That would make it easier for all of you.
Thank you so much. Thank you for taking that up for Ansa. And Ansa, I wish you could join us on call. But yes, if you're still available, 425-436-6335, and the access code is 988-888. Join us. But nonetheless, it's been a really very insightful session so far, Isa, and really great having you. It's our first episode together. And folks out there, you can call Attorney Isadora herself, and you can also email her with regard to your case, your status, and with all the details, write to her. You can call her on her number 305-938-0676, and her email address is isadora@isalawyers.com, and go visit her website www.isalawyers.com to get to know more about Isadora. Well, do you still have anything else to share? I mean, this last week, do you have any deportation case that you're dealing with that is interesting that probably you want to share with us?
Yes, yes, I do. I have many of them actually. And that's why I started by mentioning that many of these cases are being reset. What we notice is some judges, Miami's a very busy jurisdiction, as you can imagine. So we have some judges resetting the final hearing dates for 2028. These notice in the mail, if you are to be placed in deportation proceedings, you could receive a notice in the mail, what we mentioned, the notice to appear. And it will have a date in the bottom. And it may seem very simple, minimal, something that you may want to ignore because what's the big deal? Don't ignore it. It's best to show up, even if you don't have an attorney. It's best to show up and simply ask for more time. Most judges, 99.9% of judges will give you time to find an attorney to move your case along. If you talk to an attorney ahead of time, they might be able to explore options to close your case or maybe see if there's something that can be done so you don't even have to show up. But most likely you will have to show up. So it's good to just simply go. Don't ignore it. As to interesting cases, that's where it's good to know that the law itself, once again, has not changed in over 40 years. I'm getting the same cases under the Trump administration that I would get under the Obama administration. What changes are the discretion that some prosecutors may have. So it's good to have a good report with the court. And what I'm finding now is that simple cases that are maybe, it's a deja vu of 2017, simple cases that I would have gone dismissed or resolved because I gave the example of marijuana. Not a big deal right now, big deal before. It could definitely get you deported. Now I find that prosecutors, and it's not a fault of their own, don't have the privilege of negotiating with me and getting the case dismissed or getting the case closed. So it's good to speak with an attorney and show up no matter what. Even if you're alone, show up. The judge will give you more time, and you will have time knowing that cases might be set for 2028. So you have 3 more years to figure out what we can do for you.
Yes, that is it. Thank you so much. Thank you once again, Isadora. It was really, really very insightful this whole session today. And I wish we could go on speaking, but I will save some, so that you can join us very soon again, maybe discuss on another very important topic. Since changes are happening, it's just so dynamic. Every day we hear new news. Everything is, popping up every time, and everywhere we see is Trump, and whatever Trump is doing is affecting so many people out there, immigrants, America, or even the world. So there we go. So I hope that you can join us soon again. And thank you. I hope you have a great day ahead today.
I would love to join you, please, whenever you need me. Lastly, for your audience, you may hear about getting rid of the 14th Amendment, which is the birthright citizenship. That is still
Yes.
pending. The Supreme Court is likely to hear it. So the law remains. People who are born in the United States are citizens as per the Constitution. Just last thought of the day.
Thank you for that. Thank you for that too. Yes, I think we're going to hear soon about that also, probably another 10, 11 days we still got in hand. And let's just keep our fingers crossed until then. Thank you so much, Isadora. Really great having you. See you soon.
Same here. Take care.
You too. And folks out there, thank you so much for joining us. And please feel free to contact Attorney Isadora herself. And you can email her. You can even call her up. Go visit her website as well. And her website is www.isadora at, sorry, isalawyers.com, and you can email Isadora at isalawyers.com, and you can call her up also at 305-938-0676. And you can also call me. You can even WhatsApp me. I have a phone number, 408-335-6444. That's my number. And you can also email me about your case. And, that way I can forward the emails to Attorney Isadora also. My email address is nipa@staffingme.com. Thank you so much for joining us today. Y'all out there have a great day ahead. And stay tuned on Immigration and Jobs Talk Show, because at 4 p.m. Eastern Time, I'm going to be back with my co host Sam on Daily Immigration Dose. And yes, keep watching our space. Have a great day. Bye bye. Hello, everyone, and welcome to Immigration and Jobs Talk Show. I'm really happy to be here. I'm Napasa, your host for today's session. And before we head on with our webinar for today with our amazing guest, I have this very important disclaimer to read. And that is by watching our videos, you agree and understand that the by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, folks, thank you so much for joining us here on Immigration and Jobs Talk Show. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X. So, please feel free to join us. It'll be really nice to have your participation. All you have to do is comment wherever you're watching us. And also, if you are in America, you can call us on this number 425-436-6335, and the access code is 988-888. Take this as an opportunity because we are going to be joined by a very familiar face who has been with us, for I think almost a year now. But it's really great to keep having him because he has such great insights to share, and he is none other than immigration attorney from SPB law firm, attorney Chand Parvathaneni from Dallas, Texas. So please help me welcome him back once again. Hi, Chanda. Thank you so much for joining us, and I hope you're doing great today.
Thank you, Napasa. Yeah, hope everything is good on your side, and thank you for inviting me to be on the
Thank you
show.
so much. And I'm pretty sure you know that it is a very busy schedule for you, especially with the Trump 2.0 and this past week, with all executive orders being signed. So I'm really, really honored, and I truly appreciate that you have taken some time out of your busy schedule to be with us. So I'm excited for today's session. And if you could tell us what can folks out there expect, on today's discussion.
Sure. So we have seen about, a week of President Trump's administration, the second term, and in the last couple of days, we've been seeing a lot of issues. We are seeing a lot of media articles and news reports. Some of it is real, some of it is fake. We're seeing all kinds of news, and I think today, what I want to discuss is the trends in the last 1 week or so. We have done H-1B filings, we have done I-140 filings in the last 1 week. We have seen approvals in the last 1 week. So I want to discuss about what are the recent trends we are seeing in terms of employment-based cases, and also compare that with what's happening on the deportations, because the deportations have started. People are getting arrested, and what's going on? What kind of people are getting arrested? What kind of means is the administration using to send people back? How quickly are they doing it? And so we'll discuss things around it, its impact to legal immigration, its impact to illegal immigration. Because when we talk about immigration, we see two kinds of situations. One, somebody is actually entering into the country and properly inspected by CBP, properly going through the visa process. And we have those kind of immigrants who are in the country who are also concerned. Then we have other side where people have entered into the country without any kind of inspection. So we don't even the government does not even have a proper data on them, and they're not inspected. So the rules are different when somebody is coming into the country through an inspection, and the rules are a little bit different. What happens if somebody overstays their visa? They can come into the country legally. Probably they're not in the country legally right now. And then there is this other aspect where somebody just came into the country day one itself, they were illegal. So the current regulations, the current law, it has uh, various laws on all these situations. And I think we'll talk about the legal immigration part and also the illegal immigration part, and it's like impact all across the board. Because in the end, a lot of these people are actually contributing to US economy. They are actually working in United States, whether it's legal or whether somebody's working in illegal status, they're still contributing by working for the local economies. So definitely, I think there'll be impact, and what kind of impact is expected, and what are the legal rights for people in various situations. I think we'll probably use that this time to discuss those things. And the goal again is to educate people with the importance of compliance, with the importance of following the rules and doing everything right, so they're not even in a bad situation where they have to worry about deportation.
Absolutely. And thank you so much. Those were great points to keep in mind. And folks out there, today we are going to, revolve around whatever Chan has just mentioned just now, because our topic of discussion for today is how are Trump's deportation plans reshaping immigration and employment cases in the US. And as we see, whichever side we look, whichever site we visit, everywhere we see is Trump, his decisions, his orders, and we hear about a lot of deportation cases, immigration, not just being affected in the United States, but the whole world is getting affected by, all these laws and orders that Trump has passed on. So it's going to be a very, very interesting topic. Stay with us, friends. And I'll quickly say hello because we have Sunita who has joined us with your comments. Sunita, stay with us. We are going to take your comments. And if possible, anyone out there who's watching us, do join us on call. It'll be very nice to have you join us. So, with that said, let's jump into our topic for today and talk about deportation. So how do you think, Chant, that Trump's deportation plans, like using military planes, reshape the future of U.S. immigration policies?
Sure. So in general, like when we talk about immigration, illegal immigration or deportation in United States, so the way it works is immigration comes under the federal law, and what that means is the local state police. So like every city, you'll see the police departments. The police departments don't enforce the immigration law, and what that means is if the police stops somebody, and they don't typically ask about immigration, they don't typically enforce immigration rules. It's the federal government that typically enforces immigration, and that basically boils down to ICE, called Immigration and Customs Enforcement, or CBP. So they are the people that typically enforce the federal law. So a CBP officer, a federal government officer, the ICE officer, so they have the power of actually asking people about immigration and enforcing the immigration rules. So nowadays, what we are seeing is in the way of doing things. President Trump has stated that people who have criminal backgrounds, they are the ones that are going to be targeted. And in terms of what is happening is ICE seems to be specifically targeting people with criminal background. So I think they're not going after people who don't have criminal aspects. When I talk about criminal, a part of the administration is talking about anybody in the country illegally, technically has broken a law, so they are criminals. But I think in reality, I think they are actually targeting people with a real criminal background. But what is happening is there is collateral damage. And what that means is when there is a raid, a nice raid, they're going after people, they have information that they have some criminal background on their records. But unfortunately, the people around them, even if they don't have a criminal background, they will have collateral damage, which means when ICE is picking up a person who has criminal background, at that time, if they see somebody around who does not have criminal background but is illegal, they're getting picked up. And in the recent times, in the last week or so, what we have also seen is military planes are being used for deportations. So military apparatus is getting used. And normally it doesn't happen that way, because the way the deportations happen are the federal government, the federal officers, they do the deportation, but typically military planes are not used. But because President Trump's administration, I think their focus on deporting people, specifically people with criminal background, what they've said is they're going to spend money, they're going to start using military planes. And that has already started. And we are seeing military planes being used. And what that means is you can see significant ramping up and enforcement using military planes. And it's a standard shift from the standard way of doing things. So in reality, that leads to a quicker and a faster deportation process, because normally it's a very slow process. You have people in detention centers. It's a very lengthy process. Nowadays, using military planes, what that means is people are getting deported very quickly. And using military planes, is it a good way or not? There is a lot of debate, and a lot of countries, the countries where these planes are going into, uh, they've raised concerns. They're raising concerns that these people are not really criminals. They are people who just went for looking for better options for their family. So it's a bad message when people are actually put in handcuffs and sent back in military planes. So I think that's a debate that's still ongoing. But at this point of time, we do see that there is a militarization of immigration policy using military apparatus, and definitely there's going to be impact on immigrant communities. There is a lot of fear. There's a lot of anxiety in immigrant communities because what happens is we're seeing a lot of mixed families. Somebody's a U.S. citizen. They have U.S. Children, U.S. citizen children, and then say one of the people in their family is illegal. So now it's causing more fear, more anxiety, and it's leading to a chilling effect where immigrants sometimes probably are even avoiding to seek help or reporting crimes when they are really like a victim of some crime. I think the reason is they don't want like the federal officers to come and then deport somebody in
Yes.
their house. So even if some people are a victim of a crime, I think they're just hesitant to ask for help. So these are the kind of consequences we can see, and since it's just a week, I think we just have to see how things will go in the future. But definitely, we're seeing the trajectory of U.S. immigration policy shift. And right now, I've never seen enforcement so aggressive. Yes, enforcement was always there, and I think we talk about the last 4 years of Biden administration, and that administration, I think definitely, I think we're not as aggressive as the current administration, and that led to more problems because I think it led to more. Uh, People with criminal background slip into the country, which I think caused this whole issue right now with aggressive
Yes.
enforcement. And we'll have to see how things will go into
Yes,
the future.
absolutely, Chand. Very well put. And when you talk about aggression, yes, it's like never before. And not just that, I mean, ICE raids are so frequent, and it just started, I think, the second day or the first day itself when Trump joined office.
Mm.
And not just that, ICE are also being joined forces by FBA, DEA. They've just become stronger, and they have been doing these raids right, left, and center. So it's really scary a situation out there.
So, yeah, so typically they're using like various. Yeah, I think it's not just ICE. I think they're using all federal officers from various other departments. So it's like multiple departments from the federal government. I think that are working together to deport people. But I think the goal, I think, it's still to deport criminals.
Yes,
I think they're like talking about like hardcore criminals. But unfortunately, I think some other people are
affected.
getting impacted because of collateral damage. But I think at least the goal is like be very, very aggressive with people with criminal
Yes,
backgrounds. Because unfortunately, I think there are some people who are like murderers, who are child rapists out there who are illegal. And I think nobody wants people with such criminal backgrounds. But because of focus on these guys, some people who don't have any criminal background are also getting
so true,
impacted.
so true. And yes, the discussion is on full, so keep joining us. It'll be really nice to have you comment and join us on call. The phone number is 425-436-6335, and the access code is 988-888. I mean, you can even join us to tell us if you are facing any such issues with yourself, and maybe, yes, join us. It'll be very nice to know your story as well. So, yes, Chanda, thank you for that highlight and a good start to our session of discussion for today. Moving on, I have another question, and that is, these deportations are already started to happen. And how do you think these deportation policies are impacting immigrant families also who are really dependent on US jobs, and maybe they're sending money to their home countries as well, to their families?
Sure. So most of the immigrants are actually like hardworking people. They actually come here to work hard and provide for their family. So a lot of people, majority of the people are of that attitude. And unfortunately, now what's happening is I think people who are impacted. I think they will have profound impact on their families because there is going to be economic disruption. These immigrants, they depend on working in US. They support themselves and they also support their families back home. And these mass removals there and this increased fear of deportation, sometimes people are losing jobs, and it's a sharp loss of income. And not only that, I mean, again, people who are legal, who are actually working hard, the whole uncertainty and anxiety and job security, things like what will happen when I apply for my visa extension, my H-1B extension, will I get a denial? So I think that uncertainty and anxiety is like increasing even among people who are having a legal immigration status, people on F1, for example. They're worried what tomorrow when I apply for H1, will I get an approval or not? What is going to happen? So all this anxiety, will there be a backlash against immigrants? So all that uncertainty and anxiety, I think what's causing is people are not able to perform to the best of their abilities because people are depressed. People are sometimes not sure what is happening. And this, I think, will definitely have an impact on remittances, not only remittances, their own productivity. I think the productivity is going to get impacted. There's going to be psychological and emotional strain. The whole this daily news about deportation, it's creating an environment of constant stress. This is for people who are legal and also people who are not illegal. Even because people who are legal, they're just worried because I mean sometimes the media makes it sound like uh, there is so much of backlash against immigrants. It may or may not be true, but the way the media, when I talk about media, even the social media, because social media, not everything that shows up in social media is the truth. And I've seen like so many reports where people called our office about something they heard on social media, somebody getting deported, even if they had a visa. So all these kinds of stuff. So definitely, I think we are seeing increased psychological and emotional strain, and it's not only going to impact the immigrants, it's also going to impact local economies because these people work in the local areas, they contribute to the economies, they rent houses, they spend money, and they do all these things because it's people want to work hard. Majority of the people are working hard. I think eventually, I think what it's going to lead is it is definitely going to lead to labor shortages, and we're going to see some impact on local economies if things are not done right. If all they're focusing is on people with criminal backgrounds and that is their focus, I think we will not see a major impact. But if they're like focusing on everybody, and again, we don't know where it'll lead to, but there is a good chance of an impact on the local economy.
Them would be people who are falling out of status, maybe people who are, you know, I mean, I think I was sorry, my audio I was muted, but I was saying, very well put, and I think yes, very surely that the worst are going to go out of the country first, but following them could be, people who are going maybe getting out of status, people who have overstayed, people who they really need to get their visa aligned with their status, right? They have to be in status to be able to be there. And another thing which I wanted to ask is, Chand, you have mentioned about the fear of being caught, if you are illegal in the country, and even more that you are a criminal. I mean, Trump or no Trump, right? Wasn't that fear always there? Like, what if somebody catches that I am out of status? Didn't they have this fear already?
Yeah, I think. I mean, we have not seen ICE raids and these kinds of stuff on a large scale previously, and now what's happening is I think there's a lot of rhetoric in the media, and not only that, all of a sudden, like somebody's putting a post in the social media saying like there was this raid, that raid. Some of it is true, some of it is false. So I think the fear was always there, but I think illegally. Um, I think. I mean, it's a little different because people who are into the country in a legal fashion, what happens is they
Yes.
have an I-94. They know how long they're supposed to stay. They know that before that day they're supposed to apply for an extension. So there is a
Mhm.
process. And those people, because I mean, they've given their fingerprints at the port of entry, so a lot of it is trackable. And for the people who have slipped into the country without any kind of inspection, it's a little different because the country probably a lot of them they're not even recorded. Their information is not even recorded. So I think
Yes.
there's a little bit of difference between these two sets of people who came with inspection and who did not come with inspection. So people who
Yes.
came into the country with inspection, typically they have the record out there because uh, there are fingerprints with CBP, there are fingerprints with the federal government, and so on.
Mhm.
So it's a little bit of different, and I think the people who are in the country illegally, who don't have any record, because nobody even knows where they are unless somebody has done some criminal act and there is some record somewhere. If not, it's a little bit of challenging effort, which is what I think the government is trying to do. I think they're trying to kind of at least figure out initially as a priority people with criminal
Mhm.
backgrounds.
Yes, yes, yes. Absolutely. Thank you so much, Chand, for that, detailed explanation. And I have more questions. So, but before I think we move on to our questions, I wanted to take up this question we received on, I think, WhatsApp. If Control can put it up, it's from Megha, if I'm not mistaken. Yes, Megha. So it's a WhatsApp question. So Megha is asking, "Hello everyone. I need to ask a question. I am on day one, I think D1 CPT, but I need to go to India for family emergency. I'm planning to come on H4. So, do you think is there any possibility to get my visa rejected, my H4 visa, as I am on day one CPT? Really appreciate it."
Sure. I think in general, when somebody has a valid visa and they're entering into the country on that valid visa, on the terms of that visa, and they have not violated their status in the past, usually they should not have a problem. Again, the entry is never 100% guaranteed. That being said, uh, usually they are not going to have a problem. So if somebody is coming on H4 to be as a dependent, they should, and their goal is to be uh, living in the country as a spouse of some H-1B holder, they should not have a risk. And even if somebody has taken day one CPT, as long as they have uh, properly been admitted to that school, they have actually studied in that school, attended classes, and taken the CPT program in a legal way, going through the school DSO and all those things, they should not have any problem. So CPT by itself is not illegal. The only thing is CPT has a lot of requirements that they're supposed to keep and maintain F1 status. And as long as somebody is going through the process and properly maintaining a valid F1 status and properly working on CPT, their future entries should not be impacted. So if somebody wants to come back on H4, I don't see it as a problem. Usually, you should not have any issue. And people do it all the time. I mean, somebody's on F1, they get married, they go out of the country, they come back on a different visa, in this case, H4. So I don't expect issues. That being said, uh, an entry is never 100% guaranteed, so you can always expect questions at CBP. That being said, legally, it is totally allowed, and people should not have any issues coming back on H4.
All right. Thank you so much. Thank you, Megha, for participating. And my WhatsApp number, I think I will just say so that people out there, can even call me there, or better just message me also. My phone number is 408-335-6444. So please feel free to join me there as well. Otherwise, the number is 425-436-6335, and the access code is 988-888. So, yes, that was Megha's question on WhatsApp. Thank you so much. So, now, Chand, I would really like to know, what challenges do you think individuals and families are facing, after deportation under stricter and even these sudden immigration rules?
I think the immediate and the devastating challenge is getting separated from the family members, because I think sometimes when uh, they have a family here, one of them is illegal, one of them is legal, for example, and they get deported. I think the fact that they're going to be separated from their family, I think that separation, I think is going to be huge, and not only emotional and psychological trauma for that individual, but also for the entire family members. So that is like the biggest thing. And then the financial hardship, because somebody who's working is leaving and they cannot work. So if part of the family is like back in US, and that somebody has to leave the country or deported, I think definitely that financial hardship is a problem. And then I think another thing a lot of people are talking about is reintegrating into the home country. So if somebody has been in this country for a long time, and now they're deported back to their home country, so the whole thing about um, reintegrating in the home country, I think it is going to be difficult. And because there are going to be cultural barriers now, again, going back and all those things, so it is going to exacerbate, I mean, it is going to like increase their struggle. And so we don't know. I mean, again, there are more than 10 million illegal people in the country, and I definitely don't think that everybody is going to be deported back because of practical obstacles and the realistic way of looking at things. But I think the last count I heard was about 5,000 people uh, are being deported, are caught so far in the last a week or so. So I think we're not. I don't really think it'll be like millions and millions of people at this point of time. So that being said, I think whoever are impacted, I think are going to face a lot of obstacles, and uh, I think there is going to be an impact on children, especially if they have children, and a lot of emotional and mental health struggles for those folks. So, and that is why I think the one thing is I think yes, people have broken a law, but I think what normally people expect is the federal government is a little bit more shows a little bit more empathy and kind of focuses on people with real criminal backgrounds, not just go after everybody like immediately, but at least immediately, I think kind of show some empathy to most of the normal people. Maybe just target people with huge criminal backgrounds, at least initially.
Yes, yes. And also with regard to birthright citizenship, right? I mean, there was that whole news, and though it's on hold right now, I think people are very much still worried, anxious as in what's going to happen. So I'd really, say to folks out there, stay strong.
Yeah.
And if you are abiding by the rules, there's nothing to be afraid of. Right, Chan?
Yeah, birthright citizenship, I don't think it'll pass because
Yes,
we have this constitutional amendment that is out there from 1868, and we
right.
also had the Supreme Court deal with this issue in 1898, a long time back. So the case is properly decided. So I don't think the courts will do anything different. And I think the only way to do that is through a constitutional amendment, and that's the only legal way to do it. And again, a constitutional amendment is not easy. It requires
Yeah.
like a whole big process. The states have to agree, the Senate has to agree, the House of Representatives has to agree. So there is a whole big process. So for all practical purposes, I don't think it is happening anytime soon. But as far as the courts are concerned, they have a temporary restraining order. They have not given a long-term injunction, but temporary orders are passed. And even if it
Yes.
goes to the appeals court down the line, even if it goes to the Supreme Court down the line, I don't think the courts will do anything different because we have a legal precedent in the United States. It's already decided by the courts previously. So I'm a little skeptical that the courts will even interfere. I think the burden will fall back on the Congress and the states to pass a constitutional amendment. If that passes, yes, it is possible. But for that to pass, I don't think there is a easy route to that.
So that is at least one good news, I think, a little relaxing and hopeful. So, folks out there, I think, yes, that's some good news for you. So, if you want to actually have a one-on-one consultation with Attorney Chand Parvathaneni, you can even call him up or email him about yourself, your status, and it's always best to consult with an expert, an attorney who's going to be able to guide you best with your immigration status. So his phone number is 817-523-8247. And you can email Attorney Chand Parvathaneni by emailing him at law@spplawfirm.com. And go visit www.spplawfirm.com to get to know more Attorney Chand Parvathaneni and Sim Parvathaneni and Brown Law Firm in Dallas, Texas. So, yes, those were a few updates, and it's been a great session so far. We also have Nilanjana join us. So, Nilanjana, just stay with us. We will take up your questions a little later in the show. So, now, though, we should quickly take up another WhatsApp message which we had received, and this is from Kakoli. Hello, I have a B1 visa applied by my current employer, Amazon. Now I would like to visit my family in USA for a small party. Can I use the same visa to enter? If so, what documents do I need to carry with me?
So one of the things that will happen, even if one has a visa, is at the port of entry. So whenever somebody lands in United States, they have to go through CBP inspection. And one of the things that the CBP is going to do is ask questions and see what somebody's intent is. And if somebody's intent is not matching the terms of that visa, they might have a problem. So in general, if somebody has a tourist visa and they go for tourist reasons, they should not have a problem as long as the intent is disclosed and the officer is okay. So in this case, if it is a business visa and somebody is going on tourist purposes, again, in the current way of doing things, because now rules have changed a little bit and now things are looked at a different way. So so the entry is at the discretion of the CBP officer. So what they're saying is admission into United States. It's a privilege. It's not a right just because somebody has a visa. That's the way of looking at the current uh, the way of looking at things. So what that means is, at the end of the day, it is that the CBP officer, and if CBP officer feels that somebody is not doing something that is a requirement of that visa class, they could deny entry. So just having a visa is not enough. The actual the entry and the intent and the purpose should match the purpose of that visa class.
There you go, Kakoli. You have your answer, and always consult an attorney. So we have Attorney Chand's contact details scrolling on the screen. You may note it down and contact him as well for further details. And for now, Chand, we also have a lot of industries like farming, manufacturing, IT also. They are all being affected by this mass deportation policies. So, what do you have to say about the impact on these and also the target immigrant workers?
Sure. So I think every industry is different, because in the United States, when we take a look at IT sector versus a farming sector, you're going to see uh, completely a different impact based on the current rules. Because if you look at the current the policies, so President Trump last week, even after his swearing in ceremony, he stated that he likes H-1Bs. He clearly stated that the country needs H-1B, and what that means is, so when you look at the IT industry is heavily staffed by people from other countries. A lot of Indians work in IT. So IT, by nature of the industry, heavily depends on H-1B employees, probably also L-1 employees, probably also O-1 employees. So IT sector typically does not have a lot of people who are illegal working in the industry by the nature of the industry. And to me, based on the current news that is coming out of the Trump's administration, his advisors, there might be scrutiny on H-1Bs, but they have no intention of completely removing H-1B. So sectors like IT, I don't think they will see a lot of impact. The reason being, people already there is a process for the H-1Bs, and the industry is not heavily staffed by people without a legal status. On the other hand, when you look at farming depends a lot on immigrant labor, and a lot of them are undocumented workers. So things like harvesting, planting, packaging, these kind of industries, they have hired a lot of undocumented workers. And the current administration, they're focusing more on undocumented workers, people who are in the country illegally. So these are low wage positions, and these are positions that a lot of US citizens are not willing to fill. This low wage agricultural jobs. And when we're seeing mass deportations typically happen in these kind of fields. So I do think that you will see a labor shortage if mass deportation continues for a long period of time. And we might see labor shortage in, say, farming industry, or probably some areas of manufacturing industry. But on the IT sector, I don't think we will see a major impact. Uh, but what we will see in IT sector is a lot of people, they're seeing wrong news in the social media. So they are probably going to be so scared. They probably are going to see this as something that is very scary. Like, they probably will think that, is it even worth going to US and working in IT sector? So what I see is, if the rhetoric is bad and if the media projects these deportations in a wrong way, the foreign talented foreign workers more than likely will be deterred into coming into US in the first place, and that would definitely stifle growth and innovation in the tech industry. So I think, in general, I don't think we should see an impact in the IT industry for people who are already in the country, but people who want to come to US to work in IT industry, highly talented people, those people might be second guessing in immigrating to United States. So we will have to wait and watch and see how this rhetoric continues and so on. But I do see this risk that some people will be hesitant to immigrate to United States.
That is very much happening. I think people out there are probably looking out for more options because They wouldn't want to go to the US and then know the next thing that they cannot stay there anymore. It's going to be very, very expensive for them, right? So yes, moving on, since they're all facing individuals, I mean, individuals or families are facing all these sorts of deportation or are on the verge of facing one. What options do you think are available for them, under these new plans? Maybe you can keep it short and just give them some points what they can do, Chan.
Yeah. So I think people who are in the country, anybody who's especially who are in the country through a legal process, like showing a visa, what everybody should do is they should take a look at their I-94, and they have to make sure they file an extension before their I-94 expires. That is very important. So that is the first thing that anybody in the country who is in a legal status should do. The reason is if somebody accidentally forgets to file for an extension before their I-94 expires, they will become illegal in the country. So that is one thing that people can do to ensure that they don't even have to go through this deportation mess. That's the first thing. And for other people, they might look at temporary protected status. Some countries, some individuals from some specific countries, they get this thing called temporary protected status. So one of the things that people can do is see if their country is designated as a TPS country. If so, they might get some relief. And right now, DACA, deferred action for childhood arrivals. So people who qualify under DACA, they have temporary relief. So they probably will not be deported right now. So anybody that is eligible under DACA, they can use that as relief. And some people who are inadmissible, they might be eligible for some waivers. So one of the things that people who are subject to deportation should do is see if they're eligible for any waiver. Waivers are extremely difficult, but under compelling circumstances, some people might be able to get a potential path. So that is one way. And another way is if somebody has a US citizen spouse, they might they might be able to apply for adjustment of status. Again, everybody's case is different, but one of the things that people can explore. And asylum, again, asylum is a program that sometimes people tend to misuse, but again, there are some people who genuinely will qualify for asylum. So that's another thing that people can take a look and see if they qualify for asylum. And asylum is only limited to people who fear persecution in their home countries due to some specific factors. So those people are allowed to file an asylum application, but there is a very strict process. So again, something for people to explore based on their scenario. So these are a couple of things that people can always explore, and then see if they come under any of these circumstances.
Thank you, Chand. Thank you. Those were very important points, and I hope that people out there, you heard what Chand has said and have noted down, and will look out for your options. Quickly, I will take up Suresh Kumar's comment on YouTube, and then we can take up some more of the other comments as well. So Suresh is asking, according to the new provision of H-1B, I can start my entrepreneurship. What would you like to say on that?
Yeah. So I think that's a great feature that a lot of folks out there should explore. And this new rule that just got into effect since January 18th, what it says is if somebody starts their own company, they own 100% stake in the company. Those people can have that entity, the entity that uh, they started. That entity can sponsor them. So it's like I'm an entrepreneur. I started my own company. Now the rules allow that company to sponsor your own H-1B. The only thing is your initial visa validity will be only for 18 months, but that's still a good option. And you still have to pay yourself. So the company will still have to pay you. You still have to demonstrate how the company will have money to pay you, and what your idea is, what your company is, and all those things. But at least now we have a pathway. So for a lot of folks out there who are budding entrepreneurs who are starting their own companies, you should explore this option. And legally now it is possible, and you will be able to file for a H-1B. And if you're able to convince USCIS that this is a legitimate company, that it has a proper business plan, that it has the ability to pay you the salary, because the salary does have to meet the LCA obligations. If you're able to do it, you should be able to get this H-1B. And it's a very new thing. It just started on January 18th. So something out there that everybody who has a very good business idea, who have started their company, they should start exploring this option.
Wonderful. Thank you so much, Suresh, for joining us here on YouTube. And you can also join us on call. The number is on the screen. And yes, to know more, maybe you can even contact Attorney Chand Parvathaneni. His details are scrolling on the screen below. So, Chand, we also have some questions from our Facebook group, so we would quickly like to address them as well. And when we have more time later, we can come back to our questions. So, Control, if you can display, yes. The first question we have is how many months it takes for I-797 approval for H-1B visa extension?
So when we talk about H-1B visa, we have multiple service centers. We have California Service Center, Nebraska Service Center, Vermont Service Center, and Texas Service Center that are currently handling H-1Bs. And what we are seeing is it is taking anywhere between 1 month to 6 months for majority of the cases to be adjudicated. And you're going to see this little bit of variation because it depends on which service center your case is, which officer is looking at your case, and so on. But starting from a month, we are seeing approvals or adjudications. And normally, what we suggest is if it is taking more than 6 months, maybe it's time where you explore the premium processing. And the rule for extensions is that once a company applies for an extension, there is something called a 240-day rule. So for a 240 days after your H-1B expires, you are allowed to work in the country. Your I-94 automatically gets extended to a max of 240 days. So theoretically, even if your case is still pending, you can work for a maximum of 240 days when your H-1B extension is filed. So normally what I suggest is wait up to 6 months. If it takes longer than that, don't wait until the 240 days, but right after 6 months, try to upgrade your case. So you definitely have an answer before your 240-day deadline is over.
Thank you so much, Chand, for taking that up. And I'm sure that was very helpful. And going on, let's move on to our next one. This is from an anonymous member in our group asking approved I-140 for H-1B EB1C. PD is not current. Can I switch company?
So, so because the priority date is not current, you cannot file the 485. And what that means is if you switch your company, the new company will again have to do the EB, the I-140 once again. The only thing is when the new company does the I-140, you can recapture your previous priority date. But in terms of applying for a green card, if the prior company where you have the I-140, if that company withdraws the I-140, you might not be able to file the 485. So if you want to do the 485, eventually you will need another I-140 approval. The only good thing is that you can recapture your previous priority date. So remember that one thing: if you do switch, the new company will have to do an I-140. You can still get the old date back, but without the new I-140, the new company will not be able to sponsor your 485 and sign off on the supplement J.
Very important. Thank you so much, Chand, for highlighting those very important points. And thank you, anonymous member, for participating by commenting in our groups. So, folks, we are on YouTube, LinkedIn, Facebook, and on X. Our handle is Immigration and Jobs Talk Show. Please feel free to connect with us, join us by commenting, follow us, and yes, participate. Thank you so much. Let's go on to our next one. And this one is how many days is premium processing for H-1B transfer taking after January 18th executive orders? I know they don't impact directly, but I'm concerned because I am due for a travel to my home country. Any leads will be very helpful. Thank you.
So our office, we had a couple of cases filed after January 18th, and we got approvals for a few, and for a few they're still pending. So from a legal standpoint, it is 15 business days. So anytime now you should see some answer, but they can take up to 15 days. So every case is different. We've got a few approvals, few are still pending.
There you go. But do you suggest premium processing though than the regular ones?
At this point of time, I would say that premium processing is probably a good idea because there is so much of rhetoric out there and people are getting scared. So it's one thing out of the way. So you do a premium processing and the case is adjudicated. It's one less thing to think about. And in this current scenario, the more you wait, the more somebody else is going to stress you. You're going to read news and so on. So the way I see it is a premium processing is one way of getting peace of mind. It's very expensive process. You have to pay government a lot of fees. It is $2,805 to the government. It's a lot of money, but again, uh, to a lot of folks out there who think that they're restless because of all this news out there, I do not see any problem. We're not seeing any bad uh, adjudications or policies being changed. So we're still seeing approvals even in the last 8 9 days, and even the RFEs that we're seeing, they seem to be the standard kind of RFEs that USCIS typically asks, because there are certain things that even USCIS has to follow. So other than the regular issues that they are raising, we're not seeing anything majorly different so far. So if anybody has a pending case out there, I definitely suggest getting it done in premium and getting it out of the way.
Thank you so much, Chand. Thank you for taking that up. And now let's go on to our next question. And this is also on our Facebook from another anonymous member saying, "Hi, my mother and mother in law both are coming to Chicago as my wife will be giving birth. I did a one-way ticket for them as we didn't know if they can or could not stay for 6 months or how long they can stay. Is it necessary to have a return ticket? Will they have issue at port of entry? If yes, is there a way to get fully refundable tickets that I can cancel as we are not sure about the return dates?"
So one of the things is the port of entry. Definitely, the office is going to question them on their intent and what they want to do, and what their goals are. And this is what I see. If somebody's intent is not to stay temporarily and leave the country within their allocated time, which is usually 6 months, I can see the officer trying to cause an issue. And in this case, if somebody's intent is to stay longer for more than 6 months, more than likely the officer could cause an issue. And this rule, like the return ticket rule, it is never a written rule, but it's always been there, because I've always seen the officers ask about a written ticket, even prior to President Trump's January 20th swearing in. So this rule was always there, that the officers can check and see what's going on, and if they suspect that somebody's intent is not to leave the country in about 6 months, more than likely they will cause an issue. And we're hearing about people being sent back. So something I think everybody should be cautious about. The intent should be for a temporary purpose, and if you're not able to demonstrate that, a written ticket is one way to demonstrate your intent, what exactly your goal is. If not, the first thing that the officer is going to think is that yes, you don't intend to leave the country in about 6 months, which means you are a high risk candidate to be sent back.
So true, so true. And we even heard the news a few days back about an Indian couple, old couple actually. They were going to go visit their kids in the United States, but because they did not have a return ticket, they were sent back. And it was very harsh and unexpected. So,
Yeah.
I mean, to avoid all of
Yeah, and
that,
I think this rule was always there. Yeah, because this rule was always there, because I've seen this issue pop up a lot of times. It is just that it got highlighted recently. The reason is because of all this immigration rhetoric, that thing got highlighted.
yes,
Even before, the officers were like heavily scrutinizing this aspect, because what has happened is during COVID time, a lot of people came into the country and filed for extensions. During COVID time, yes, they had a valid reason. And after that, I've seen a lot of people come into the country and apply for extensions after 6 months. They're seeing more and more of those situations. So for that reason, I think the scrutiny in general is that they want to make sure somebody is leaving the country uh, in a short time. And short time for them is less than 6 months. So the scrutiny is there. Not only that, another thing that people are going to have a problem with is if they leave the country and try to re-enter the country on a tourist visa immediately. So they left the country, and in less than 6 months somebody's trying to get back into the country. Even those cases, we expect to see issues, some people being sent back. So I think, as a good practice, a written ticket is important. And also, um, don't come into the country too often. So, which means that at least keep 6 months of gap between entry to entry. Otherwise, somebody is going to argue that you're misusing your tourist visa and probably cancel the visa or send you back.
thank you so much, Chant, for taking that up. And those were great details that we really need to keep in mind. Thank you, anonymous member. And let's go on to our next question. So this one is hi, my visa will expire in February this year. Extension is in process since last 3 months with no status change. I don't expect to get the renewal by Feb looking at the current trend. My question is how people manage without driver's license. There are tons of things we need a car for here in America, and without availability to drive would greatly impact the day-to-day activities. Is there any alternatives apart from under and carpool? Is there any consideration by authorities?
Um, Again, so driver's license is like a local state thing. So every state is different. And what we are saying is some states, you take a receipt copy and show that your H-1B extension has already been filed. We are seeing some states issue temporary licenses based on that receipt copy for your extension. Some states are refusing. And I think what I suggest is uh, the premium processing. It costs about 2,805. So look at that cost versus carpooling or going in Uber and all those things. And if you feel that premium processing is going to be cheaper, I definitely suggest getting the case upgraded to premium, so you can get an answer quickly and then not have to worry. But before doing that, go to your local state's DPS office and see if they can use your receipt copy and give you an extension. Some states are doing it based on that extension receipt. They're getting a short term extension. So that is the first thing probably you can try. And if they still refuse, the other option is probably go back to your employer and insist on premium processing. And that is probably the fastest way to get your approval and then get your
Yes,
license.
and I think you would also know your status with premium processing. It only takes about 15 days or so, right, Chand? So, yeah, so yes,
Uh, so the bad thing is it used to be 15 days until
okay,
April 1st last year. Starting from April 1st, now it is 15 business days. So not calendar
business
days, but it is
days.
business days. So they changed it a little bit
Thank you
last
so
year.
much, Chand. I mean, another point to keep in mind, folks. So 15 business days. Thank you. And I think with that, we have completed our Facebook group questions. And I have a few more questions, Chan. So if you don't mind, telling us, what should employers also
Hmm?
know about compliance and risks while hiring immigrant workers during these changing times?
Sure. Uh, so one of the things we hear about is the illegal immigrants being deported. But what's also going to happen is any employer who knowingly hires somebody who's not legal, I do expect criminal penalties for them. Some at least some penalties, maybe even criminal penalties for them, depending on how they're hiring people they know that are not legal in the country. What that means is every employer should follow the process. There is something called I-9. I-9 is a mandatory thing uh, for every employer like Microsoft, Google, or even a small consulting company. It doesn't matter. Every company that hires employees, citizens or immigrants, they are supposed to do and verify the I-9. So I-9 is very important. So what we suggest is every employer should be completely complying with the I-9 provisions. Make sure they have an I-9. Make sure they check the status before hiring somebody. If they don't do it, more than likely they will be at risk. If there is an audit down the line, or DOL visit, or a USCIS visit, or an ICE visit, they will be in risk. And sometimes, if the employee does something wrong, gives them a fake document, it's a different issue. But knowingly, if they hire somebody who's illegal, it's going to be a upfront. They are liable for major issues. So the good practice for every employer is adhere to the I-9 provisions, and as long as you keep doing it, you're relatively going to be safe. At least the government is not going to come after you.
Well, there you go. Thank you so much, Chand. And my next question is about these international agreements that are happening. With Trump putting up executive orders and so many changes, tariffs going high for different countries. So, how do these international agreements, such as between U.S. and Colombia, affect immigration enforcement and even employment policies?
Yeah. So one of the things is for people who are in the country illegally, I think the administration has already stated that they're going to start sending them back to their home country. And we have few countries who cause a problem. For example, China. China, I think, normally doesn't take people back that easily. So I think what President Trump is trying to do is trying to work with all the governments and trying to make sure that they take their citizens back. And some countries are agreeing because I think some countries see that as their moral obligation. It is somebody, the citizen of their country, they see it as their moral obligation. They're ready to take them back. For example, if you see India, India clearly stated that yes, they're going to take back their citizens once verified into their country. So most of the countries in general, what I am seeing is they are willing to take their citizens back. Some countries, I think, are trying to cause a problem. And last week we saw this news about Colombia. So Colombia initially stated that they don't want to take their citizens back. I think then the administration, I think, put some pressure and they try to put some visa bans and other steps to pressurize them. And at this point of time, looks like Colombia, they agreed. And not only that, they did say that just don't do it in military planes, but as long as it is civilian planes, do it in a decent manner, we will take them back. So looks like that issue is resolved. And that is what's going to keep on happening. What's going to happen is the administration is going to try to work with all these foreign governments to make sure that there is an agreement and people are sent back and those countries accept them back, which is what I think we will keep seeing in the future. And majority of the countries seem to be willing to take their citizens back.
So true, and we are seeing, many countries, even India is one of the major ones who are, joining hands in this deportation process. So, I mean, let's wait and see. We really need to keep, illegal immigrants aside and economic policies, on the other hand, totally different. So, yes, thank you so much, Chand. And I also got a couple more questions if you still got some time to be with us, if that's fine with you. Okay.
Sure, sure. Yeah.
So, my next question is, you as an immigration attorney, and I'm sure many folks out there, I mean, your colleagues as well at SBP law firm, and there are so many community groups also. Maybe you can tell us what are you doing, or how can, attorneys like you or community groups help individuals prepare for potential deportations that are happening and the changes in their legal status.
Sure. I think we get a lot of questions, and I think my practice is a lot on the employment side. And I work with a lot of employers, and the main cases that we see are like people who are wanting to work in this country on H-1B, or somebody who's a student on F-1 trying to work on H-1B, and so on. And what I see is, unfortunately, most of the people, they're highly qualified, but what they try to do is sometimes they don't follow the rules. They don't comply with the immigration rules. So what we try to do is we try to educate people and uh, talk about compliance. And because we don't want somebody to be in that situation where they are scared to be deported. I think our goal is to educate people so they're not even in that situation where they will have that risk of getting deported. And what that means is making sure you're always maintaining valid status in the country. So every visa class will have a set of rules. Always adhere to those rules. For example, if somebody is a student, the typical issues lately that we've been seeing is people are doing some part-time jobs. These students, they're like, for example, master's students. They already have a very good education. They're getting a master's degree. They are going to be highly skilled down the line once they get their degrees. So we don't want them to do anything that will jeopardize their career. And what that means is we discourage people from doing unauthorized employment. We discourage people from working in restaurants or working in the jobs because it is short term. Very soon they'll graduate. Very soon they'll have such a good career. Now, doing these kind of things now, they are stressed on what's going to happen and all these things. So rather to be in a situation where somebody is doing unauthorized employment or doing anything that is against the regulations, I think our goal is to educate people, let people be aware of the rules. We encourage people to go through USCIS website and keep following up the regulations to ensure they are not even accidentally not complying with anything. And one of the things that a lot of people we have been seeing is lot of people on H4 or sometimes even on H1B, they forget to check their I-94 every time they enter the country. Everybody is supposed to download their I-94 and look at the I-94 end date. Sometimes people don't see it. They assume that they can stay in the country until their visa is valid. Sometimes their I-94 is shortened for various reasons. Maybe their passport is expiring. And by the time they come to us, what happens is they're already they are out of status. So our at least our work is heavily involved in educating people to make sure they are able to figure out their status, figure out their identity for end dates, and do these extensions, do these things that they're supposed to follow before they go out of status. So our focus is entirely on how do you maintain your status, how do you do things that are compliant with the law, and at the same time we also want to make sure that people, sometimes what happens is on the social media they get scared with things that are not true. Yes, there is a problem, but not on such a large scale where people have to be worried, because we've been getting calls this week, and one of the questions was, is everybody getting deported back who's on F1 and traveling out of the country on OPT? Things are not that bad. It's just that there is scrutiny, and their goal is, if somebody is following the rules, they will not have a problem. So things are not bad, or things are not anything where people have to really worry. It is just that there is going to be scrutiny, and what that means is, watch out what you're doing, watch out what you're doing on the social media. Um, uh, Always follow the law. Don't drink and drive. Don't steal in the departmental stores, because we had some cases where somebody got drunk, drove, got caught. Now they have a big mess because now they have a big RFE and all those things. So it's more about things that you can easily avoid, because uh, half of the problem is people accidentally getting into some issues that they don't really have any intent. So at least a lot of things can be avoided by getting properly
Yes.
educated about the rules, and that's the goal. Doing so, I think you will keep yourself safe, because if you don't break the rules, nobody can even touch you. Because this country follows due process. Due process works as long as you follow the process. You break the law, that is when you can't really use due process, because uh, the rules
Right, right.
say
Very
something.
well put, Chand, and thank you so much for that. And I'm sure that folks out there are able to take notes down, because these are very important points. And you are educated, you know what you're doing, and just don't act stupid. Don't do things that will make you fall in trouble. And with that said, Chand, we have a caller actually. She's online, and she's Satya. And Satya, please go ahead. Tell us where have you joined us from, and ask your question.
Yeah, sure. Thank you. Hi, Chand. This is Satya here. I'm calling from Michigan. I have a quick question currently. I'm on my OPT. Initial OPT is going to be closed. But the question was a bit different. So I came to US in the year 2022 August. And initially when I entered, while filling my days 160, from 2015 to 17, I did my master's in India, but I did not mention that while filling my DS 160. In the place of 15, 17, I kept it that I have already working in some company since 2015. Now, like my current company informed that they wanted to make me as a full-time employee for them. So now the question is, because in future, if my H1 got picked up and if I wanted to, go for stamping while filling the DS 116, so do I need to mention everywhere that I did my MBA in past, or I should completely remove that? So I don't know. So I just have a question on this.
Sure. Sure. Uh, and I think from immigration perspective, if that omission was material to your visa, it could cause a problem. But I don't think it is material, because I don't really think you gain any advantage by omitting that information. That being said, I think what you should do is, at the next given chance, you should correct it. And what that means is, eventually when you go back to India, and you're going to apply for your H-1B, definitely put that information on your DS 160, because that is your chance to correct. If you correct something before they catch you, you should probably not have any issue, because this is such a simple thing and it is not really material to your case. So that accidental mistake that you did, next time correct it. Make sure the next time you do the DS 160, correct it. Okay, and put it. And if somebody has a question, you can answer it. And if they don't even question you, you pretty much disclosed it to them. Okay, so at next given chance, definitely disclose it, and I think you'll be fine, because I don't really think it is a material issue to
But I
your
cannot change the past one,
class.
right? I can't change the past one. But I have to accept that it
Um,
was done by all of a mistake, but it's a typo mistake, right?
right, because one time you make a mistake, that's okay. But again, the next subsequent chance that you have, where you will be able to correct it, you should correct it, because you don't want somebody to say that you misrepresented it even after knowing about it. Now that you know about it, I think put on your DS 160. I don't think it is material. I mean, you did not gain any advantage with your admission by omitting that information. Say, for example, you put fake experience, and because of fake experience, they thought you're qualified and gave you the visa. Then I see a problem. Yeah, so I don't think it is material, whatever that omission was. But again, definitely, I think next time, definitely include that on your DS 160. So nobody's talking about any kind of a misrepresentation in the future.
Yeah, got it. Yeah, but yeah, I got you. Yeah.
Okay, so Satya, is that all? Or if you have any other question, you can go ahead. Otherwise, thank you so much for joining us from
Yeah,
Michigan.
that's yeah, thank you.
Thank you. Thank you. Please don't forget to like, share, and subscribe to us. And folks out there, you can also join us on call. And our phone number is 425-436-6335, and the access code is 988-888. I think with that said, we should wrap up our show for today, Chand, and maybe leave our folks out there with what strategies that immigrant workers or immigrants they can adopt to stay safe and compliant with all these. The existing law, and the changes as well.
I think the main thing is, again, ensuring that you don't overstay your visa. And again, if somebody has overstayed their visa or did something, there are potential waivers that some people could be qualified. So at least, even if somebody is in not in status, try to kind of at least make sure you do something to proactively uh, get some relief under the current regulations, but don't just not do anything. So if you accidentally did some mistake, try to kind of figure out a way and see if you can get some relief using the existing regulations, and follow the law. And for everybody else who is in a legal status, make sure you accidentally don't do anything to jeopardize your legal status, and keep following the rules, keep applying for extensions on a timely manner, because if you miss filing for extensions on a timely manner, you will jeopardize your legal status and future entry into the country. So just try to be compliant and don't do anything very stupid, because things are like, some things are like very uh, it is like just common sense things, like should you work illegally, like off campus, things like can you work for some employer for cash illegally. So these kind of things, some things are common sense. So just I think try not to kind of do anything that is going to jeopardize your legal status in this country. And I think people who are actually following the rules, I don't think the administration is probably doing anything drastic. I think they're only talking about people who came into the country in an illegal way, and again focusing on those who typically have criminal records. I think if people don't have criminal records in general, I don't think they should have a lot of issues. So people who are currently in the country, make sure you even accidentally don't do anything that could have criminal implications. And to me, that means speeding, DUI, theft, hitting your spouse, hitting your girlfriend, because even those things are big issues. Anything that is illegal, stay away from it. And I think that should kind of safeguard everybody's status.
Absolutely. And these are all very easily avoidable things. So, folks out there, play safe, stay safe. And thank you so much, Chand, for joining us on this amazing, insightful session. So much you have shared with us. The knowledge imparted, I'm sure, has helped everybody who joined us today. And really great to have you. I'm looking forward for February for another great session with you. So soon we are saying bye to January. So really great that you joined us today, Chand, and I'm hoping to see you soon.
Yeah. Thank you, Dipasa. Thank you all.
Thank you, friends, and thank you so much for joining us. Don't forget to like, share, and subscribe to us. We are Immigration and Jobs Talk Show, and folks out there, who got your answer. And Satya, thank you so much for joining us on call from Michigan. All the best for your future endeavors, and yes. To all you folks out there, stay tuned to Immigration and Jobs Talk Show, because we got a lot more content coming up, and we also got daily immigration dose that's coming up at 4 p.m. Eastern Time. And yes, it's Nipasa saying bye for now, and Chand also saying bye and thank you, everyone.
Hello and welcome everyone to Immigration and Jobs Talk Show. I'm your host Sam, and today we are back again with another very exciting topic. That's too very controversial and that's too very hot. So before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So use of information is at your own risk. All right, once again, friends, welcome back everyone to Immigration and Jobs Talk Show. And today, the topic that we are going to delve that is H-1Bs and legal immigration reform, Musk versus Mega. So this is a very hot topic, and this is actually creating a lot of buzz on social media and is on top of everyone's notification right now. So today we are going to explore lots of different opinions, a very eye-opening facts, a very different information that most of our viewers are not aware of. And as the topic is very interesting, and even to make this session more interesting, I have a very special guest for you, friends, and who has joined us for the second time in today's channel. So let me welcome attorney Emin Yakub, an expert in immigration law with an impressive track record with a strong background in litigation. And before his current role at Bogan Months and Months, Mr. Yakub also ran his own solo practice, helping clients navigate complex immigration and litigation challenges. So welcome, Amin. I'm really happy that you are here, and we are so grateful that for the second time we are meeting again, and after
Thank
again
you
a
for
very,
having
very
me.
insightful topic.
Yeah, thank you for having me for the second time.
Absolutely. So I think before delving into the topic, I would like to know it from you that what's the status right now? I mean, what's the current rule that's happening around Musk versus Mega? I mean, what's in the plate right now?
Yeah, so I believe before we delve into this, it's worth noting that there is the final rule for H-1B, which was passed and went into effect on January 12th, I believe, or 17th. Basically, it reformed somehow the H-1B to a great extent. So it made several changes to the old H-1B rule, and now, for example, the H-1B is eligible for entrepreneurs. So entrepreneurs can apply for H-1B for the first time ever, and of course that they have to meet certain requirements and they have to meet certain specifications. But for the first time ever, entrepreneurs can actually petition for themselves under certain conditions and apply for H-1Bs. So the Biden administration, before leaving, actually passed the final H-1B rule, and it went into effect on January 17th. So that is, I would say, a good way of starting this discussion because the new rule was not reversed yet. So right now we still have the valid, effective new H-1B rule, and it was put into effect before Biden administration left. And it would be interesting to see what happens next regarding the H-1B. But for now, what we have into effect is the Biden administration's H-1B.
I think due to some reason we have lost Amin, but Amin, can you hear us? I think, friends, due to some connectivity issue, I think Amin is here. Amin, can you hear us?
Yes, I can. So what was the last thing I've stopped at?
Yeah, you're saying about the rule that now we are going to look forward towards this year and
Yeah. So to summarize, there was the H-1B new rule, and it was passed under Biden's administration, went into effect on January 17th of 2025. And it, for the first time, it opened the way for entrepreneurs to self-sponsor themselves. So that is a unique way of basically sponsoring yourself under the new H-1B rule. It will be interesting to see what happens in the future regarding the current debate on H-1B under Trump's new administration. But until then, what we have into effect is the Biden's administration new and what we call final.
I think due to some reason we are not able to connect with him. But I think, friends, we should wait for some time so that I think Amin can connect with his internet again. And I think he's back again. All right. Amin, can you hear us right now? We can't hear you. I think your mic is off.
Yeah, I was saying if there's a problem in the connection, probably I'll need the help of the IT, and I can be back in 5-10 minutes. Okay.
That's okay. That's okay. That's completely okay. I think our viewers can wait for some times, and till then, viewers, it would be great. We will connect back after some time. So prepare your questions. Prepare all the information that you have been going through related to this topic, and make sure to comment all those questions. Because this 1 hour is going to be very informative, very insightful. So make sure to post all your questions and put the comments so that we can have a very lively discussion, a very healthy discussion. So stay tuned. We are coming back just after some time. So keep watching the show and we'll be right back.
Hello? Can you hear me again?
Yes, sir. Thank you, sir.
Perfect.
Sam will.
Yeah, hopefully this time it's not going to go offline. So the IT fixed something here. And,
No problem, sir. Thank you.
yeah, apologies regarding this. Thank you.
Hello and welcome back, everyone. After a short break, I'm so sorry that due to some reason we just need to take a leave. But that's okay, we are back again, and I think now I would like to welcome our attorney, Amin Aku. Please, Amin, come to the floor and let us know as you were explaining about the H-1B rule. So please go ahead, our audience are really waiting for your insights.
Yeah, apologies regarding going offline. We fixed the problem officially. So going back to the final H-1B rule, so it went into effect on January 17th of 2025. And for the first time, it opened the floor for entrepreneurs to sponsor themselves. And it also included some changes to specialty occupation and the cap for the H-1B between basically going from F1 status into the H-1B status. It extended the cap for that and the gap between statuses. So it made several changes that are kind of positive for everyone. Now, it would be interesting to see what the Trump administration will bring to the table, uh, probably by an executive order, because he likes issuing a lot of executive orders. So we will be interested to see what's going to happen in the future. I just wanted to introduce this because this is a new development into the H-1B arena, and it would be a good kind of introduction to the debate about the legal reform and the H-1B that is going on between Musk and Trump, or let's say it's not Trump, it's MAGA. Trump sided actually this time in this administration with Musk's side. So let's see what happens in the future. But you can go ahead and ask me regarding the debate that is going on.
Absolutely. And my next question is to you, first of all. Thank you so much, Armin, for letting us know about the H-1B final rule. And that's also a very important news. And I'm sure most of our viewers know about it and, gets into the deep analysis of it. But coming back to our topic, Musk versus Mega, it's a very, I would say, a very controversial topic, and it's for the very first time, that our viewers are seeing that there's a division, there's a split between in the Trump's administration itself. So this is a very new thing, and this is a very, I would say, a different thing, and people are so confused. So to make them even more clear, and I would like to know it from you. Like, can you explain what is actually Musk agendas and what is actually Mega agenda? What they both are looking in terms of H-1B visas and the immigration reform?
Yeah. So to start answering this question, I would have to give a little bit of history about Musk. So he came here to the U.S. on an H-1B, and then he applied for the EB1A, and then he got it, and then he adjusted his status accordingly. So he was a beneficiary of the H-1B program in the past, and he understands as an employer in the tech industry the importance of the H-1B program. So starting from this point, Musk's position is we need engineers, we need high-level engineers, we need high-level mathematicians and people in STEM fields. And his argument is mostly people come from India who are highly developed in these fields, and they are advanced way more than most other nations. So the argument is why not open the H-1B to the merit-based Indians who come here and benefit the U.S. Through our companies. And the reply from MAGA was, if we've done that, then they're going to be replacing Americans, and we should put America first. And the counter reply from Musk's side was, basically, what you're saying is wrong, because if we have expanded the businesses, if we have expanded the frontiers of human knowledge and tech, that means basically we're hiring more employees and we're getting more Americans hired, even in top positions. So no one replaces anyone in the system because the US is a capitalist country. It's not like we have limited pie for everyone to eat. It's like the more you work, the more you develop, you have a bigger pie, and that means more people are going to eat from that pie, to put it simply. So after some while, Trump engaged in conversation, right? And he was like, "Well, I've used many H-1Bs in the industry. I like them. I like the system, and we're gonna keep it." So he sided with Musk's side as opposed to MAGA's side. Now, MAGA did not basically stop attacking the other side because America's first, Americans first, and it's what everyone was voting for Trump for. So what happens if Trump sided with Musk and basically they expanded the H-1B rule instead of basically allowing Americans to assume the highest positions, they allowed foreigners to assume the highest positions. I would say 70% of H-1B holders are Indians. So it's specific for the population of the H-1B somehow. It's not their problem that they're smart in math and tech. But the thing is, now the question is, should we remove the cap from the H-1B for Indians or in general? Because we have 65,000 for bachelor's degree holders and 20,000 for master's degree holders.
Absolutely, that's a very good point. And also, I would also like to know, Aman, from you that how could their views impact the future policies? I mean, what differences or what changes can we see in the future?
Yeah, that would be very interesting to see. But what I think is, or what I would predict is, the H-1B would hold its place, and it's basically for the functionality of most enterprises, high-level enterprises in the U.S. So there is, unfortunately, the way MAGA thinks about it is not accurate in terms of economic development of the U.S. and making the U.S. a leader in tech. So to maintain its position as a leader in tech and all basically the frontiers of knowledge, the U.S. needs the H-1B. I cannot get rid of the H-1B. We have also Professor Matthew Cook, who is a physicist. He spoke about the H-1B a long time before. He was at a conference and he said, well, that's the American weapon to get very highly talented people to the U.S. and to keep the U.S. At the frontiers of human knowledge and entrepreneurship and businesses and tech. So I would actually expect if something happened to the H-1B program, the U.S. would very much feel it as soon as they do that, and that for that reason, I don't believe that Trump will actually pass something that would contradict what I'm saying here. He's not going to go for like basically stopping the H-1B program, but I believe there is going to be some kind of reform to the H-1B program.
All right. Okay, but also, Aman, I would like to know it from you that if we look into the first term of Trump, then he was quite against the H-1B, right? He was mostly, we have heard in his speeches that he has said that they're not going to have H-1B more. H-1Bs are not very much good for the Americans, for the nation, right? And in the second term, we are seeing a little shift on his ideologies. So he is right now, I won't say that completely in favor of the H-1B workers, but in the mega, they are the people who are a bit conservative. They are the people who are very much on their phones, and that's about America First agenda. So my question to you is that what do you think that during the first term till the second term, what made Trump shift his ideologies? I mean, why is he favoring right now the H-1B workers, and why was he so against in his first term? I mean, what can be the reason behind it?
Yeah. Um, Personally, I think the reason behind it is Elon Musk again, just the way he sees him. He invited him to see the SpaceX rocket going back and forth and landing back after it went to space. And Trump was mesmerized by what he saw, and he actually went back and in his rallies was talking about it all the time. It's like this guy is doing something above and beyond all nations combined, even the U.S. So for Trump, who is always in a position of power, and power seems a big aspect of Trump's administration and Trump himself as a person, he wouldn't like to lose power. He wouldn't like to lose Egypt. He would like to be at the frontier of power, no matter what the price. So if Musk is powerful and if Trump likes power, then he wouldn't basically let Musk down in this debate. That's why I believe he sided with Musk this time as opposed to Mega. I mean, Mega or whatever, they're good people. They're trying their best and so forth, but they're not creating rockets that can actually basically put the U.S. on Mars or the most advanced technology on planet Earth. So it's for Trump. He sees that this term in his administration. Last administration, it was not that obvious. He was thinking of H-1Bs, unfortunately, in a lesser way. He was thinking of them as he actually spoke about it. Like they're the winemakers. They are people who come here with very specialty occupation, and they do a great job in creating wineries and stuff like that. But he saw the firsthand what Musk could achieve in different companies, and he was like, well, we can actually have a better America if we allowed more people like Musk in. And that's the way he changed his views, in my opinion.
Absolutely. And I think that's very well understandable because in his first term, we haven't seen Musk being more close to Trump. And in the second term, we have seen that they have a very good bond. They have a very close relationship. And it's very obvious that they both are businessmen. So they have a little common genre, common niche. So that may also be the reason. And also, my next question to you would be that, okay, fine, you are saying that Trump is going to support the H-1B workers. And in the upcoming year under Trump's era, we are going to see a little, towards the H-1B workers, there will be little reform, but it won't be any restrictive kind of thing, right? But what can you say about ending the birthright citizenship? Because it's a very I would say a very difficult and a very challenging executive order that Trump has put up during his first day only. So it's affecting mostly the H-1B workers because they are the one who is contributing a lot to the US economy and they are the one who is going to suffer. So what's your
Yeah,
call on that? Do you think he's doing something but he's not saying something, or what Trump
yeah.
is actually?
It's a very interesting question actually, because he cannot support H-1Bs on the one side and disagrees with birthright of citizenship on the other side, especially for Indians, again, because we're assuming that 70% of H-1Bs are Indians. And we Indians have a very late priority date for EB2 and EB1As. So when we're talking about H-1Bs, we're actually talking about mostly Indians, uh,
Yeah.
and that's based on facts. So that means he cannot basically support that and at the same time say, well, your newborn is not going to be a U.S. citizen. And once he passed this, for now, that's my view. Trump's view is there are two distinct matters. For him, he is trying to fight people who come to the U.S. and try to get their wives to give birth to a son or a daughter and make them American and then return back to their home countries. And they would be holding the U.S. passports for life. And honestly, and actually, it does not mean anything. I mean, someone who was born on the U.S. Soil, and he or she will go back to their home countries with their kids. So why you did it in the first place, and what is the meaning of the U.S. citizenship for that baby, for the future? He or she would be a different nationality. He would be belonging to a different country all his life. He would be actually fighting for a different army if they lived in their country all their lives. So he's actually trying to stop that from happening. That's why he mentioned tourism, temporary workers, and so forth. But I believe it was a rushed executive order because even the terms of the visas in the executive order was put as examples, but not limited to, and they were put and it's like tourists, students, and temporary workers, and then it was temporary people who are staying in the U.S. But it did not detail any kind of visa statuses. It did not detail what kind of temporary status versus permanent. I mean, like, is it a green card the only way to actually get the people who are born in the U.S. to get the citizenship? So it was very summarized and very rushed executive order. 2 days after Trump passed it, the federal judge actually issued a restraining order. So the restraining order legally keeps it blocked for 14 days. The next step is a preliminary injunction, which usually takes place before the end of the 14th day. And if the lawyers can prove that there is irreparable harm, and at the same time the petitioner will be able to win on the merits, the judge will be likely to actually block the order until further notice, usually after the Supreme Court is done with the review of the order. So I expect the order to be blocked until maybe a year or two afterwards, until the Supreme Court sees the matter and decides it. Now, if we talked about the Supreme Court and how it would decide the matter, honestly, I don't have a doubt. I mean, as the federal judge said, anyone who sees that kind of order as constitutional did not go to any law school. It's just super obvious. It cannot contradict with the 14th Amendment in the U.S. Constitution. And if he needs to actually reverse the 14th Amendment, he cannot do it via executive order. He has to do it through 2/3 of both the Senate House and the House of Representatives, and also the 3/4 of all the U.S. states parliaments. So otherwise, it's not doable. So that is the beginning of all problems. But again, going back to your question, if we have people who are on H-1Bs and they are having a kid, a newborn right now, the newborn will be a U.S. citizen. And in 14 days, he or she will be a U.S. citizen. And I believe in the near future, they will actually be U.S. citizens until the U.S. Supreme Court decides whether that actually holds up or not.
Mhm. Right. And also, I think Trump was about to end the birthright citizenship during his first term as well, but he didn't get the majority of support during his first term. And that's why he is right now. But also, we can see that most of the temporary workers, they are finding it quite unfair to have this ending the birthright citizenship. But I think we don't know what's going to happen. But I think the judge, he also said that it's unconstitutional, and it's not going to happen. But we can't. We can't decide anything. What's going to happen? What's not? But okay, that's all right. But also, I would like to know it from you. My next question: that how might this internal conflict in Mega is going to influence the future immigration reform? Yeah, about the future, I would like to know.
Yeah. So if we actually took a look at, so the new debate actually made us all think about the legal immigration system in the U.S. And that's a very, very important topic. So the first point of Trump was, I'm going to be fighting the illegal immigration into the U.S.
Yeah.
But this kind of debate about the H-1B was now it's talking about the legal immigrants in the U.S. And if we took a closer look at the legal immigration system in the U.S., it's kind of repelling. It's not actually designed to attract and keep and retain people in the U.S. Basically, you're a student here in the U.S., unlike Canada, for example, you have to go back to your country. You are a temporary worker, you have to go back to your country. So, unlike Australia, Canada, and other countries, you're not here to get a green card afterwards. you have to be some kind of special to obtain the green card. So the system initially was designed not to keep as many foreigners as we might think, actually. The exceptions are EB2 national interest waiver, it's a waiver, EB1 extraordinary ability, EB5 investment visa, which is $800,000 up to $1,050,000. And if we thought about all the immigrant visas, unless you're married to an American spouse, it's kind of very, very difficult to actually get the green card, as opposed to different immigration systems all over the world. So it's not that new of a discussion here. It's actually referring to an old discussion regarding what immigration should be like in the U.S. But since many immigrants are super successful right now in
Yeah.
many positions, now people are reconsidering their positions into all of this. Should we keep the H-1B? Should we try to expand it or not? Now, a very important point is the H-1B is abused. Everyone knows that somehow. So the question here becomes, what can we do not to allow people or employers to abuse the H-1B system? So what kind of measures can we take to stop the abuse of the H-1B system? And if we can actually put forward those measures to fix the system, there's no way we Americans are not going to benefit from the H-1Bs. Again, it's H-1Bs create more jobs, at least statistically, to everyone else. So it's not that far away from seeing Americans benefiting from the H-1B as well.
That's right. That's right. Also, Amin, I would like to know it from you as this ending the birthright citizenship is a very, I mean, problematic right now, especially for the H-1B workers. So, is it like the time there's 14 days of extension, right, for that decision, that final decision? And for example, if that gets implemented, for example, if that becomes in the constitution, so the people, those who are already the US citizen, those immigrants, especially the H-1B workers who already got the green card with the H-1B visas, do they also have to get worried after the implementation of this ending the birthright citizenship, or they won't have to worry at all?
Yeah, they don't have to worry because there is a rule of law basically that says you cannot apply the new law retroactively. So no matter what happens in the future, it will stay to the future, including this executive order, by the way. So it was not applied. It's not supposed to apply until March. So the judge stopped it anyway, and the opposing argument was very convincing. Honestly, was saying, well, even though it's unconstitutional, why are you issuing a restraining order for 14 days if it's not going to be applied in 14 days? So the law cannot apply retroactively because, again, that's unconstitutional. And there is no constitution in the world that I'm aware of that actually allows law to apply retroactively. So anyone who has citizenship or anyone who has kids who have the U.S. citizenship, they all should be okay. Now, my advice is, if you do have a kid right now, you have a newborn, don't be late in registering, going for the U.S. passport procedures or whatever, or getting the birth certificate and going further with the procedures. There's nothing that can stop you from doing so, and probably the executive, again, the restraining order will extend into a preliminary injunction, and it all will stop sometime until the Supreme Court decides the case. But why risk all of this? Just go ahead and go for the U.S. passport for your newborns.
Right, right. That's very well explained. Also, Amin, I would like to know it from you because most of the, especially the mega movement, I mean, there are people who are not in favor of the H-1B workers, and there is the other side, Musk, who is pro H-1B workers. He has, I think in Tesla, there are more than 70% of Indians who are working over there, and they all are in the H-1B visas. So it shows that the one of the biggest companies in the whole world, that is Tesla, and there are lots of H-1B workers. So, from my side, I don't think without the H-1B workers or without the immigrants, America can be that great. But I would like to know it from your end. Like, for example, if the H-1B visas are not very much favorable, then what challenges do US companies face if the H-1B visas are restricted?
Many challenges in my view, and in Musk's view, and in many leaders' view, and that's based on personal experience. So it's not like Musk is saying that out of like theory or something. It was in practice, in his experience, trying to hire engineers for Tesla, or trying to hire aerospace engineers for SpaceX. But again, SpaceX has a special occasion because it's funded by the U.S. federal government.
Yeah.
Has contracts with the government, so he's not allowed to hire many foreigners. He's not allowed. I believe he's not allowed to hire, for example, pending leads in different categories of immigrants. It's like NASA, for example. So no one who doesn't have the U.S. citizenship can be hired in NASA. It's like a matter of national security. But otherwise, in terms of Tesla, he hired many engineers. If you actually heard the engineer beside him when he's testing the autopilot for the first time, he's an Indian engineer. The second one is basically most of the engineers, leader engineers at Tesla, they're mostly Indians, according to Musk. So he said basically, if we're retaining the best talent in the world, we're going to keep the US at the front of knowledge and tech. So we should keep doing that, and that's the main argument for Musk. And he also said that negatively, basically, if I could find people, find Americans who can actually do that, who can actually be at the forefront of the tech level and the engineering level, then I would hire them. But for now, I cannot find any, and that actually made many people furious, especially MAGA supporters. And later he said, well, maybe the H-1Bs can actually train the Americans in engineering and other fields so that they make progress in that respect. And then Ramaswamy, he wrote a tweet regarding the situation saying, well, in India, math and tech is encouraged among kids. People would actually be proud, saying, "Well, I'm the first in my class in math or science or whatever." In STEM field, in America, the situation is not the same, and that actually got him out of Doge to some extent, and according to some people at least. So it's a very hot debate, and it's a very political debate. We cannot, unfortunately, in immigration, detach the politics of whatever is going on from the legal side, because usually the politics feed in the legal side and says, well, we're going to change the law in that respect. We have to go to the Congress. We have to listen to all points of view, and then they start drafting something new. But again, that happened multiple times in the past, not to the same strong extent. And the Congress has not changed the ENA Act since 1990. Immigration is not that easy to change. It's very, very controversial and very strong topic to actually say, well, we're going to go right or we're going to go left. And no one will actually agree on right or left. So it's going to be a very hard debate in the Congress if Trump actually proposed something. What I expect to see is Musk trying to play a role using Doge in trying to actually do something regarding legal immigration and H-1Bs by basically introducing tech and other criteria to institutions like USAS, and probably trying to influence some changes in the final rule of the H-1B to make it suitable for the next generations of H-1Bs. But otherwise, through the Congress, I don't believe that it's a strong chance, but who knows? No one can actually predict the future for 100%, especially when it comes to topics like immigration.
Absolutely. All right. I think that's a pretty lot of information that we are getting right from you. And thank you so much, Armin, for, making us aware about these political views, about these how the immigration reforms will take place, and also the future perspective. Following these questions, I have another question in my mind, and that's about right now. It's not. It's just few days, that Trump has sworn in as the 47th president, and in these few days only, we have seen lots of changes, and not only the changes regarding the policies, but also in Trump's administration, we have seen a little chaos, mega versus Musk. And before that, we haven't seen, the mega movements. They are having conflict, internal conflict. So, is it something that in the future, because now Musk is there, who is a complete supporter of H-1B, and mega movement, I mean, mega people who are not the supporter of H-1B. So, is this the beginning of the clash that we are seeing right now, or in the future also we could have more clashes between these two different ideologies in the Trump administration? I mean, how the administration would look like in the future.
Yeah. So again, no one can actually guess the future when it comes to immigration stuff like this because it's a very hot debate. But I would say um, the debate is gonna right now it has cooled down to some extent, but it's gonna fire up again if anyone said anything about H-1Bs again, especially Trump. If
Right.
he, for example, talked to the people in the upcoming month, for example, and said, well, I'm going to work on the H-1Bs, I'm going to expand the H-1B program for the talented and skillful immigrants. I believe MAGA is going to reply back, and we're going to see a hot debate again on this issue. Until then, I don't believe anyone's going to bring it up, especially after what happened to um, Ramaswamy, in my opinion. But again, it's just the way things are in immigration. It's very controversial and it's very hot always. And I believe Trump doesn't care much, to be honest with you. And if he wants to do something, he's going to do it anyway, since he's the president here. So he is not going to be taking care of what MAGA will think. And it's his second administration, so that gives him a lot of leeway of doing whatever he wants. So many people is questioning why is Trump different now than the first administration? Basically because it's the second. He can do whatever, and he doesn't care about a new administration in the future. So this is the final 4 years, and he wants to leave the best stamp possible on all issues in the U.S. And I believe he wants to leave a good legacy after he leaves as well. When it comes to maintaining the U.S. and retaining it as one of the leading countries in tech and all fields.
Right. I think that's very well said. That Trump is like he can do anything whatsoever he wants, and that's very true because most of the time we have seen that he has been selling burgers in McDonald's. Then he is being putting a lot of things. His different comments, his most I would say hilarious comments also regarding Justin Trudeau by considering him the 51st state governor. So I think these are a very witty comments that we get from his side, and it's too very interesting to watch. But I think that's so interesting contents, right? And I think I would like to know it from you. Like, which is your favorite statement from Trump?
Well, too many favorable statements. I think it's just like the getting Canada to be one of the U.S. states and getting
Yeah.
it's just. But anyway, can he do it or not? Who knows? I mean, this guy is super serious this time, and it's like he's going to be having talks about this with the Canadian Prime Minister for sure. So he's not saying stuff this time. He's actually implementing or trying to implement whatever he says. And again, I'm saying this because in the first administration, during his first administration, he was not actually acting on many of his promises. But this time, since he took office, he is trying to act on most of his promises. And we shouldn't take that as a surprise because he was actually talking about all these issues during his rallies all over the U.S. So no one would be should be surprised right now, saying, "Well, what is going on regarding the deportation of illegal immigrants or undocumented immigrants, for example?" So undocumented immigrants, because I get too many questions regarding that. are people who have no papers in the U.S. They have never passed through a port of entry, a legal port of entry, like an airport, or through the siege, or even the land border through CBP officers. So they have no papers whatsoever. And people mistake them with pending asylees, for example. So pending asylees have legal papers. They have a COA status. They have pending asylum case that allows them to remain in the U.S. and so forth. So Trump's focus is on undocumented immigrants, and he's trying to deport as many as possible, as we've seen yesterday and 2 days ago, and possibly every day until he has deported most of the illegal immigrants in the U.S.
Absolutely. And I think that's a very brave move that any president should look upon because, according to the stats, also, according to the Pew Research, also, we got to know that there are 4 million illegal immigrants in the US right now. And
Yeah.
these are like currently caught. We are not even sure that there can be more. They are hidden somewhere. They haven't been caught. But it's so unfortunate to feel that there are 14 million, and that's a big amount, big number, and that too illegal. So I think it's just that most of the people they have misused the immigration system, and that's why Trump is taking such a big and such a bold step. So instead of just cribbing, we should also understand that there's also misuse of the immigration system, and that's how it's going to get a better way until and unless there's a very strict rules applied on the immigration system. I mean, what do you
Yeah.
think on this? I mean, what's your call?
Yeah. I would say if Musk or anyone, even Trump, fixed the legal immigration system, that would actually prevent illegal immigrants from coming into the U.S. on the long run. So they're kind of correlated somehow, because if you stop immigration at all for everyone, even the talented and the skilled, basically people try to come in using different ways. And sometimes you would find that you never know. Sometimes a criminal, sometimes a PhD holder coming through the border because they were rejected like a tourist visa like 200 times or whatever. So you cannot fix the illegal immigration issue by just deportation. You have to do something regarding the legal immigration issue. And basically, what I think is it has to be done when the person is at or in her home country. So if you want to get this system better, and basically, or you're trying to retain the best talent in the world, try to give them the green cards when they're back in the home countries based on certain criteria. I would say the expansion of EB2 or EB1A or stuff like that, instead of getting people to be stuck in the US on H-1Bs and then trying to wait for the priority date for EB2 and then wait for the priority date and try to apply and the combo card and then wait again until they get the green card processed. And now the new idea of the citizenship and stuff like that, the executive order, people would actually have newborns if it applied without this restraining order, who might be stateless actually if the country of origin does not grant citizenship based on the right of blood, as we call it. So we have two systems, the lex soli and lex sanguinis. Sanguinis is the right of blood, and soli is the soil. So the U.S. and Canada and other nations are having the right of soil. If you're born on the soil, you get this citizenship. But what happens if someone is from a country that does not allow someone basically to pass by blood the citizenship to a newborn, and they're born in the U.S. and this executive order applied? Then we're going to be seeing some very, very difficult scenarios worldwide. It's not going to only influence the U.S., but also different countries in the world. Again, the deportation matter influences different countries' policies as well. So we've seen this yesterday with Colombia and the communication between the Colombian president and President Trump. And basically, the question becomes, is it about Trump deporting people, or is it about non-communication between Trump's administration and other countries' administrations? Because that becomes a matter of sovereignty. Each country has its own sovereignty. So basically, you cannot just leave people to go to a different country by force. It's like, it's not, you cannot force a different country to accept even its own nationals. So you would have to at least talk to the president of the other country and do that through political and diplomatic ways. Otherwise, it's going to be a kind of an affront to the sovereignty of the other nation. And that's what happened yesterday, until, of course, Trump used his power in negotiations and so forth, and it was resolved. So it's going to be interesting to see what's next. But my point of view here is, if the U.S. changed the legal system of immigration and influenced the legal immigration to attract the best talents in the world, and made the system very efficient, the U.S. will not have a big problem regarding illegal immigrants, especially if it had strong borders. So if it has strong borders plus fixing the legal immigration system, that's done.
Absolutely. And I think I also completely agree with these information that you have been sharing. It's more about like, if the if the immigration system is going to be set up properly, then automatically the illegal ones have to leave the country. And I think that's very well explained, and that's very well, understandable what you are saying. Also, I would like to know it from you. Like, if we go ahead and if we also went through those news, like Trump is about to give green cards to the international students. So this is also a recent news that we have been through. And what's your views on that? Because Trump is on the other side. He is not favoring the H-1B workers. And on the other side, the international students, he said that he is going to give them the green card. And I don't know what to say, but what's your call on that? I mean, what it is? He's
Yeah.
okay to give green card to the international students, but not the H-1B workers. So yeah, please go
Yes.
ahead.
So it sounds kind of like he likes the legal immigrants. He sounds like he likes them. But at the same time, in his administration this time, he also likes H-1Bs to some extent, as opposed to the first administration, based on as I shared my point of view, based on Musk and so forth. But the thing is, would it be possible to grant green cards based on education in the U.S.? To a great extent, the answer is no, because again, there is a lot of pushback, and the system will maintain its way of keeping only the best talent or people who are spouses to the U.S. citizens or legal permanent residents. It's not going to be an open immigration system like Canada or other countries, in my opinion. It would be interesting to see something that is happening against my opinion, but it's in my opinion, it's kind of impossible to have a U.S. That is inviting everyone to be U.S. citizens by giving the green cards to every student who actually has a degree from a U.S. university, because millions of students come to the U.S. and study here. So unlike Canada, who can actually apply for the permanent residency afterwards and so forth based on different criteria, here it's if you're not talented enough, if you could not secure a position with a U.S. employer, like to get sponsored for an H-1B, you have no way of staying in the U.S. People actually try to do like a file for asylum and stay here, even the pending asylum application. The ENAC says, well, this is a legal authorization, not really a legal status. And there is a lot of problems that actually goes into this, because when you try to adjust status, you try to think about it. Have you maintained legal status since the moment you actually entered the U.S. until now? Now there's a matter of Orban decision and so forth, but 20% of USCIS officers have, they don't apply it, for example. So it's the way the system is designed is to keep only the best, and not necessarily the best, because if we took a closer look, actually, you're going to find the diversity visa that takes people randomly from all over the world and grant them a green cards when they're living in their own countries. So, like internally, the system seems like it only attracts the best and retains the best. But externally, it seems like the system attracts random people with very low profiles. I mean, who knows? Like some of them are very high profile or very high profiles, but some other people are with very low profiles. So why are you stopping them from coming through the borders and allowing the diversity visa to take place if you just want the best to come to the U.S. and to be permanent residents here? So there are a lot of questions regarding the legal immigration system that I believe we cannot cover in here. But it would be interesting to see what's next for Trump.
I think we all are waiting so much that what's going to happen next, because with these few days only, also, I mean, there are so many things that's covering a huge news, everywhere. So people are concerned, some people are happy. So there's a lot to discuss. But also, Amin, thank you so much for letting us know. And one thing I loved about is that you have been, uncovering all the positive sides as well, because most of the people, they are very afraid, they are very concerned. I mean, obviously they have to be concerned, but it's not that it's something negative they are going to happen, or it's not something that they are losing the hope. They should not lose the hope of permanent residency, because it's more about highly skilled workers that Trump is looking in his term. And that's one of the best way, because that's also going to improve people, as their skills are also going to develop, their degrees are also going to get better. So it's basically the competition needs to be tightened enough, and that's how, if you're best, then go ahead and come to the US. So I think that's very well explained, Alman. And I would also like to take up our viewers' question. So firstly, here's Bal Krishnan question. And he's saying that as someone running a startup, I'm trying to hire talent from abroad. With Musk advocating for easier access to skilled immigrants and Mega wanting to tighten the rules, do you think we will see more scrutiny or changes in the H-1B process?
Yeah, so for now, we are sticking to the law in effect, which is the final H-1B rule that went into effect on January 17th of 2025. Based on that law, you yourself will be able to sponsor many employees if you're having a valid job offers, valid contracts, and basically tax returns showing that you can pay them and so forth. Regarding yourself, you can actually sponsor yourself based on that rule as well. Now, whenever Trump passes something in the future, we will have to look at it, and it's going to be applying to the future, not retroactively. And that would be the time to actually answer your question, because until then, we're applying and we're abide by the new H-1B rule that was passed during Biden's administration before they left.
All right, so thank you so much, Balakrishnan, for your question. In case if you have any follow up or want to know more about the scrutiny or the changes or the process regarding H-1B, then please go ahead and post it on the comment section. Let's move ahead with Anjali's question, and she's asking, I know Musk has been critical of current immigration caps. If there's push to lift or reform these caps under his influence, how soon could such a change realistically happen? And there's a follow-up question, and how would it impact industries beyond tech?
Yeah. Honestly, I don't think there's going to be much change to the caps of H-1B. Even if they changed it and expanded it somehow to Indians and talented people, regardless of where they come from, it's not going to be a huge of a change. And the reason there is a cap in the first place was to maintain diversity in the U.S. nation. It's basically if we allow only merit-based people to come into the U.S. and let's say 70% of merit people are Indians, that means 200 years from now, mostly the most population of the U.S. might end up as Indian race, So it was in a way designed to put caps on countries that have billions of people, like India and China. That's why we have a backlog as well. But the thing is, and I believe that would be the argument for the other side, basically saying, well, if you're trying to get merit-based people, we have to make sure that there is also a ceiling to that, so that basically not a quarter of India would be a quarter of India would actually flood the U.S. Would actually replace all not Americans, everyone else. So it's
Yeah.
like they would have to keep it capped. But honestly, I believe they're going to expand it a little bit because right now it's super low. Again, 65,000 plus 20,000, that's nothing. And the exempt from the cap would be nonprofit organizations and community and stuff like that. So it's not efficient in terms of getting H-1Bs in the tech industry right now.
Absolutely. And there are so many H-1B visa applicants who have been waiting for 10 years, 12 years, so that they can just get the approval. So it's a very, I would say, a very lengthy process, especially in the country regarding India and China. There are so many people who have been applying for this, and it's very hard, it's very tough for them to get those, H-1B visas. So I
Of
hope,
course.
Anjali,
Yeah, I
if
just want to comment very fast on what you said right now because
yeah.
it's very important. So the people, especially MAGA, they assume that if you applied for the H-1B, you're going to get it, but they forget that it's a lottery process. Only 20% of people actually end up with an
Right.
H-1B. So it's not that guaranteed to actually get the H-1B. It's super difficult to get an H-1B. So there's no way we people like Musk and others who have used the H-1Bs in the past would actually agree to limiting the H-1B because they know that it's extremely difficult right now. If they want to do something about it, they're going to expand the cap a little bit, as I suggested, but I don't believe they're going to remove caps. That's what I'm saying here, and try to make the process efficient. So instead of having a 20% chance, probably the chance should actually transform into merit-based considerations. So instead of having 150,000, for example, instead of 65,000, they should actually do check the merits of the 150,000 instead of do some kind of lottery and choosing those 150 instead of the others. So that's the kind of change we would like to see, and probably that's the kind of change Musk has in mind, or other people who are leading in the tech industry.
Absolutely. And I think that's what, how it's going to make better the immigration system because time to time we have to keep on changing. And that's very well said, Amin, that instead of focusing on the 65,000, it's better to look for the merit based. And also there's lottery system that's in the middle and that completely depends upon your luck. So there's a lot of, I would say, a lengthy process and even, very risky chance that there's no surety regarding the H-1B workers. So basically, H-1B workers have to, face a lot of challenges and look for lots of, they have been a concern on lots of different things. So I hope, Anjali, that, you got your answer. And in case you are looking towards applying the H-1B visa, then please let us know and we can try our best to guide you as attorney Amin Yaqub is here, so he will guide you the best. Also, let's move ahead with Hardeep question, and he is saying that I have my H-1B and H-4 stamped. Due to medical conditions, I am planning to travel in H-4. Can I change my status later to the H-1B after recovery? And how long does it take to change status? And I would really appreciate it if you tell me about the process. Yeah.
Yeah, unfortunately, that would actually amount to a legal advice. So I would have to read the case and I would have to read the documents before I can actually say something regarding this factual scenario. Otherwise, I can be easily mistaken. So if she would like to, or if he would like to reach out, I can take a look and let him or her know as soon as I can.
Absolutely. I would like to suggest Hardeep that you can please go ahead and contact attorney Aminiku. And given us the contact detail, you can call him 407-578-1334. You can also email him on ayakub@boganmonths.com. And you can visit his website that is www.boganmonths.com. So please go ahead and share the documents and share the details so that he can guide you the best. All right. Thank you so much, Hardeep, also for your question. And next is ZQ. So ZQ is saying that mass deportation is nothing new in America. It has been done before. Apart from Trump, has any other president of USA taken such strong deportation measures? Okay, let's answer this. What's your call on that, Amin?
Yeah, it has happened in the past. Usually, Republican presidents are known to strong deportation measures as opposed to Democratic presidents, for
Mm-hmm.
example. But we have to understand that Trump is the strongest Republican president who actually applied this measure to the extreme. So, to my knowledge, no one ever in the past uh, deported as many illegal and documented immigrants as Trump. Uh, so it's kind of interesting to see because he's an extremist. So it's kind of interesting to see again what's next in terms of the immigration policies that he's trying to reform. But I believe it's not going to touch the legal people living in the U.S. no matter what the status is.
Hope so. Hope so that happens, and the legal people, they are completely safe. All right. Here we have another viewer, and he is Ayan. So Ayan is saying that any thoughts on whether the new administration's policies will impact marriage-based immigration? I'm writing as a LPR who has been awaiting the approval of my spouse for past 16 months.
I don't think so. So the only kind of immigration that is not spotted as a problem or not contested in this scenario is actually marriage-based immigration, and basically that is because it involves a legal permanent resident or a U.S. citizen. So as long as someone has a legal status as a legal permanent resident with a green card or a U.S. citizen, it's very difficult for them, for the administration to actually disallow them from having a spouse who's from a foreign country, for example. So I don't foresee any changes to the marriage-based immigration system in the near future.
Okay, I think that's a good news. So thank you so much, Ayan, for your question. And in case if you still have any follow-up doubt, then please go ahead and share with our viewers. And also, I would like to take a permission from Amin. You know, Amin, we have been across 1 hour, but I still have some questions from my viewers. So it would be great if you could let us extend the session for 5 more minutes. Will that be okay?
Yeah, sure.
All right. That's so great. Okay, so here I have a question from Sagar, and Sagar actually put this question on WhatsApp. So he's asking that, hello, I'm Sagar. My I-140 was filed with employer A, and my wife's H4 EAD was filed with them with expiry date in March 2026. In January 2024, I switched to a new company B with H-1B valid through February 2027. So this company did not agree to transfer I-140. Also, we didn't make any changes to my wife EAD that was issued while I was at company A. I have an offer from a new company C, and they are currently in process of filing the H-1B and has agreed to support I-140 transfer in this year. So shall I request company C to file my wife's EAD to extend along with my H-1B in premium, or do they need to transfer my I-140 first?
Yeah, again, that's illegal advice, unfortunately. So I'm not allowed to say it on
Mhm.
a podcast or a broadcast. So he or she can reach out to me, and I will be able to answer them in hopefully in 24 hours.
Absolutely, absolutely. And I think, Sagar, you know, for to answer this very specifically, I think Amin needs to have a look on your documents and need to consult you personally. So please go ahead and contact him on the contact details, and you can also email him, and that would be more preferable. Or you can also call him on the given number as for your convenience, and you can share your doubts and you can share your documents. All right. Thank you, Sagar, for your question. And coming back to Akshay, Akshay is saying that, hi, I'm Akshay. I have a question. My wife's visa is valid until September 2026. She's on H4 visa. However, her passport expires in April 2026. So when we recently entered US, the USA Border Control Officer allowed her entry only till April 2026. She gave us the option to renew the passport and re entry US before April 26 or go to LA. Can we submit our updated passport in USCIS office in LA?
Yeah, same thing. I'm not allowed to give any legal advice over
Mhm.
broadcast, but they should feel free to email me these facts and any documents, and I will take a look and answer them. And basically, the first answer via email and phone call even is for free, so they shouldn't be discouraged from communicating such information. I will try my best to actually answer them in 24 hours if that's.
Absolutely. And I think that's how it should be, because it's not that possible that just with a few details, the attorney can answer. It needs to be a proper detailed answers and need to look a lot of in the case. So it's a request, Sagar and Akshay, to please go ahead and contact Eamon's details so that you can have your answer. And it's definitely going to be very helpful. So make sure that you contact him on the contact details. And with that, we have come across more than an hour, and it was really insightful. It was so fruitful. But my last question from you, I would like to know that what advice would you like to give to those, especially the H-1B workers who are currently in the US, who are so afraid, who are so tensed, and what advice would you like to give them, because just to make them little relaxed, just to make them what solution would you like to provide them?
Um, so I would like to say that you're lucky that you're having an H-1B. That's the first thing. You should actually be grateful for having an H-1B. Many people fight for it and can never get it. So that's the first thing. Second thing is, if you're having a newborn right now, uh, go ahead and get the U.S. passport for them. Even though I believe that is gonna the block is gonna remain in place until further notice. Uh, Third advice, I would say, the final rule of H-1B is expansive in nature. So, and Biden's administration made sure that it passed as law as opposed to an executive order. That means there is more protection to the final H-1B rule than being in an executive order, and it cannot be reversed by an executive order. So you basically future H-1Bs might actually be lucky that this H-1B final H-1B rule was passed and went into effect before Biden's administration left. And Trump was asked about it, and he didn't demonstrate any intent to actually reverse the final H-1B rule until now. Until he changes his mind in the future, you should feel safe about the H-1B and safe about the new H-1B rule, which actually allows entrepreneurs to apply and self-sponsor themselves. Just remain relaxed and see what happens, and hopefully nothing bad will happen to legal immigrants, because that's what Trump said, at least in different rallies.
Absolutely. And that's what we can trust on his statements also, because he also knows the value of the H-1B workers, right? And that's why he is in favor of Elon Musk as well. So thank you
Right.
so much, Attorney and Yakub. It has been really a great session, and I knew that it's really going to be a wonderful one, because our first session also was very amazing. So thank you so much for this, and it was really great to have you here. So I would say thank you to all our viewers who has joined us, and it was so good to have you also. Friends, don't forget to like, share, and subscribe to our channel, as we'll be coming up with more episodes and more insightful episodes. So stay connected, stay updated, and thank you so much, everyone, for joining us. Thank you,
Thank you.
Evan. Thank you so much. All right. Thank you so much, everyone, for being here. It was really lovely. It was so insightful. Good luck. Stay connected, stay informed, and don't forget to like, share, and subscribe to our channel. Me, Sam, signing off for now. Hello and welcome everyone to Immigration and Jobs Talk Show. I'm your host Sam, and today we are back again with another very exciting webinar that is lined up just for you today. So make sure to watch this video till the end because today we are going to have a very insightful and very impactful session. And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, after this very important disclaimer, friends, I would like to welcome you all once again. And thank you so much for joining us. We are live on YouTube, LinkedIn, Facebook, and on X as well. So go ahead and join us from whichever platform you can and post your comments, post your questions because we are here for an hour. So make sure to question each and every section of your doubts so that you can get the best solution of your doubts. Okay, and today the topic that we are going to have a very insightful discussion that's about how to prepare for Trump's new immigration policies in the barbed wire era. So it is again a very timely topic and a very essential topic because most of our viewers are very much concerned regarding Trump's administration. And as Trump administration is fully active and aggressively throwing away the illegal immigrants, so we need to make sure, we need to be aware, we need to be very much concerned about the latest updates and how you can protect yourself. So, without any further ado, let me welcome our today's very special guest who will be joining us in this webinar and even make this webinar more impactful and more insightful, who is none other than Attorney Uma Mantrawadi, a leading immigration attorney and an expert in US immigration policies. So, welcome, Uma, and thank you so much for joining us. We are really, really happy that you are here and we are super excited for this session.
Afternoon.
All right. So I hope, Uma, you are doing great, or anything that you would like to tell our viewers about how you are doing.
Well, I have a bad sore throat. I just want to tell the viewers, I'm going through a severe bronchitis, but, the show must go on. We have made a commitment, and so the show will go on. So if I'm coughing in between, pardon me for that. And we will discuss all the questions that people have because this is a time of fear, chaos, frustration that people are going through in the United States, particularly. Any immigrant community, I'm not talking one community. Anybody is from Jamaica or somebody is from Colombia, somebody is from Brazil, Venezuela, Singapore, Malaysia, Dubai, India, Bangladesh, Nepal, doesn't matter. I think everybody is in a chaotic situation. And we'll go through bit by bit.
Absolutely. And I hope, Uma, that your sore throat gets better, and we all are hoping that it's not much painful and it won't hurt you when you speak, because
Thank you.
we are really hoping. We were waiting for this session for a pretty long time, and that's okay. I think our viewers can understand it. We can take a break in between for your comfort, and after that we can get back to our
Sure.
session.
Thank you.
Okay, so I won't, delay this session anymore, and I would directly jump into my very first question, Uma. So, can you provide an overview of the recent executive orders and policy shifts in immigration laws?
Sure. The very first thing on January 20th, when President Trump was sworn in, the first executive order that he had signed was to decline birthright citizenship for those children who are born to parents who are not here in the United States legally, uh, and anybody who's also born to parents who are non-immigrants. The only exception he gave the birthright citizenship is for those people who are children of legal permanent residents and US citizens. However, Sam, this has been met with a lot of um, litigation. 22 states have filed lawsuits, and the federal judge in Seattle has blocked this case. There is an injunction pending against the executive order issued by President Trump, and we will come to know the future of it. My gut feeling is this is probably going to go all the way to the Supreme Court, and it is the Supreme Court who will make the decision. And I hope intelligence prevails with the Supreme Court justices to make the right decision on this case. So that is the first executive order, and there were several other executive orders, but the DHS passed a rule called the expedited removal, which is what is creating a chaos in the country. Previously, we had an expedited removal policy or a regulation which said that if anybody who is crossing the border from into the United States from any border, could be from Mexico, from any other country, from the northern borders, if they are caught within the 100 miles, then they would be placed into what's known as expedited removal. But that has been changed to a new policy which says anybody can be caught anywhere in the 50 states. They can be in school, they can be in a hospital, they can be in a church, they can be in a mosque, they can be.
Uma, can you hear us? I think due to some technical issues. Uma, can you hear us? Are you there?
I'm here.
Okay, all right. Yeah, please go ahead, Uma. We lost you in between.
Okay. So they can go to a school, they can go to a hospital, they can go to a church, they can go to a workplace, they can go to a mosque, a temple, gurdwara. There is no sanctuary cities anymore. There's no sanctuary places anymore. With this expedited removal, what they are saying is if we find anybody who's here illegally and has not established that they've been here for at least 2 years or more, we can actually pick you up and place you into expedited removal, which means that individual does not even get a chance to go before an immigration judge. These are the regulations and the orders passed. However, what's happening is different. So we'll get to that.
Definitely, we will. And I think thank you so much, Uma, for making us aware about the executive orders. And I think our viewers should also get to know that we already had a discussion on birthright citizenship. So, friends, on 23rd Jan at 2 p.m. EST, we already had a show on this topic. So if you are confused about this topic, or if you are really going through it, then please go ahead and watch that session. That will really be helpful for you. And with that, Uma, you mentioned about some of the executive orders, and that too very important. I would like to come to my next question and want to know that what are the immediate implications of these policies for undocumented individuals and also mixed status families?
It is not looking good, Sam. There's been a lot of raids by ICE at workplaces, at schools. Children are fearing going to school. A lot of parents are not dropping the children at school because of this. And we've seen that the school authorities are sending out letters to parents saying that you need to bring your child as per the school requirements. But the parents are scared because they're worried that if they go to drop off their children, who are possibly US citizens, the parents can be picked up and they can be deported, and this child will be left at school, no one to, take care of this child.
Oh my God.
So they're worried about that. A lot of people are not going to work.
Mm-hmm.
So employers are calling us, complaining that they're not able to get their workers back to work because, they are fearing that people will come pick. Some of them have, even US citizens have been picked up and placed into removal proceedings because the ICE is not doing their due diligence in following the regulation. They're just indiscriminately picking up people. What has happened is The Trump administration has told ICE authorities they have a quota. They have to pick up at least 75 people, each officer in each city, state, county, have to pick up a minimum of 75 people. So, what started out as picking up criminals and deporting them has now become indiscriminately picking up people, even US citizens, even people who've been approved of asylums. A court has given them an approval, but nobody is going to be carrying a court order with them. And even some of them who've shown their documents have been told by ICE that those are fake documents.
Oh, oh God.
I had a child who came yesterday to my office, Sam, 10-year-old child, telling me, "Ma'am, can I go to school? Is it safe for me to go to school?" I came here when I was 6 months with my parents. I didn't know until a few days ago that my parents are illegal and I'm illegal. I had no clue. I was brought here. Now I'm going to school. I'm following what I'm supposed to do, which is go to school. And will I be deported? These are the kind of questions we are facing. And it's very, mind-boggling to people like me as attorneys to see this kind of reaction
Right.
from the public, from children, from parents. There are people who are sick, who are not going to the hospital. I had a parent who called me and said they've been diagnosed with a bladder infection, liver enzymes have gone up, and they need to actually remove their bladder because they found stones also. And this man is refusing to go to the hospital. He's just sitting at home suffering in pain because he's scared to go there. He thinks he'll be picked up. So there is a huge impact on the communities. There was an ICE raid about 1,000 feet from my office.
Oh, okay.
The people in my building are getting scared if they should be coming to work or not. There were a few attorneys in Rhode Island who were picked up. All their computers were taken away because they're representing illegal or undocumented workers.
All right.
Yesterday, an attorney commented in one of our groups that she's in Georgia. She saw the FBI truck parked right in front of her building. They have 5 attorneys in their building, and all of them are worried why this truck was parked there. And possibly they think it's because a lot of clients come to them who are undocumented. So they're trying to possibly come to an attorney's office and pick them up. So this is how chaotic it is right now in the United States. I cannot say it's one city, one state, but it's happening everywhere.
Yeah.
Some of the offices are locking their doors, saying we're not going to allow anyone to come in. They're losing business. They're doing what they have to.
Right.
There are a lot of cooks who are not going to work.
That's so sad.
There are a lot of restaurants that are suffering.
Yeah.
Because they can't find people to come and work and replace them. A lot of farmers who are complaining. So what's going to happen is with the tariffs and with the lack of labor, we're going to see a spike in the pricing.
Right.
So it is not a comfortable situation right now.
Absolutely. It's very chaotic right now, and it's so sad, when a 10-year-old boy come to your place and he's just confirming that he should go to school or not, only for these things. So I think people sitting outside the US, they have no idea like how everything is going, because we are just getting to know that ICE is arresting these many people, these many illegal immigrants are being deported, but we actually don't know the situation right now, like how they are deporting, how they are connecting with those people. So we'll be coming to that question, and we'll be understanding in every way, how do they detect them. And I think thank you so much, Uma, for letting us know and giving us really a very personal touch on that. Like there are people who are being diagnosed, but still they are not preferring hospitals even to go just because they may be deported. So, Uma, I mean, for the illegal immigrants, we understood, okay, it's been a very tough situation right now. But what about the legal ones? I mean, why are they being targeted under ICE?
Well, that's why I said, ICE is not following the policy that the government has implemented. And since they have been given a quota to pick up, they're not following the regulation. They're just following that we have a quota and we just need to pick up people. And let's say about 75 people were picked up in New York or New Jersey area.
Mm-hmm.
Out of those, only 2 or 3 they were found to be criminals.
Yeah.
Rest were not criminals. Rest were just people living their lives. They do have some immigration pending with the USCIS, with the courts, and the ICE is not willing to even listen to them, not look at their documents. They're just picking them up and placing them into expedited removal proceedings. They're not being allowed to talk to their attorneys.
Go. So, is there any way that they can try to protect themselves? I mean, is there any advice that they can try to make their situation a bit safer?
Well, we are giving out, as an attorney, I have sent out letters to my clients
Mm-hmm.
saying, know your rights. What is it you can do? If you're pulled over by a local police, and if you're not carrying any drugs or any illegal um, paraphernalia, you can always take the Fifth Amendment, which is you have a right to remain silent. You don't have to say anything.
Mm-hmm.
You can show your insurance papers or driver's license, or if you don't have one, if they give you a ticket, do not fight that. If the officer is asking for your immigrant status, you don't have to respond.
Oh, okay.
And we've told people if they come to your house
Mm-hmm.
and knock on your door, you don't have to let them in because they don't have a judicial warrant.
So now the ICE officers, those who are deporting, I mean, those who are arresting those illegal immigrants, are they going with proper judiciary warrant or not?
We have not seen them carrying any warrants.
Oh, okay.
We have not seen any federal judge issue warrants to them.
That's a big
So
thing.
they're just going as ICE officer. Most of the time, people are scared.
Mm-hmm.
So they'll just talk. Sometimes they sweet talk to people saying, oh, we're just here saying hello to you. How are you doing? How's your day?
Mm-hmm.
How are your kids? How many kids do you have? So they sweet talk.
Mm-hmm.
In that way, in that fashion, also they're collecting information
Right, right. That's the
and
motive behind.
determining. And sometimes people fall for that, and
Mm-hmm.
then start talking. Once you start talking, you give information, then they've taken everything from you. We're also advising people not to carry their original passports, foreign passports. If you have a work permit, I would carry the work permit or at least a copy of it
Mm-hmm.
to
Right.
ensure, to show them that you are legally working. If you have a court hearing, we tell them to carry a copy of the court hearing,
Mm-hmm.
immigration court hearing.
Right. Absolutely.
Do
So,
not carry any originals because once they take that, you're never going to get it back.
oh God.
And if they take your passport, it makes it much easier for them to place people in deportation proceedings.
Okay, okay. I think this is a whole process, and passport is one of the easiest way to deport them. And
Correct.
it's so tough. But all right, Uma, I would also like to know it from you, and that ICE main agenda is to deport all those illegal immigrants. But I just want to know it from your end. Like, what's your call? Because ICE is aggressively, just detecting those illegal immigrants and picking them up and throwing them away. It's like that. It's a very aggressive rule that they are applying right now. So, do you think that those illegal immigrants they are right in their side? Because somehow legally we also see then they are not legal in that citizens, right? So it's not very much fair enough to support them also and to support ICE as well, because they are also taking a very major step. They are also taking a very bold step. So what's your call on that? I mean, who was right, who was wrong, or how the situation, why the situation is being so chaotic? Do you think the illegal immigrants, if they would have been following the rules, then the situation might be little better or different now? Or, I mean, what's your call on that? I would just like to know your views on it.
Well, I'm not saying, I'm not encouraging people to come illegally. I always encourage people to come legally. But
Absolutely.
once they've already come, let's say somebody's come 10 years ago, 12 years ago, 20 years ago, 30. So, whatever the laws were at that time, they filed their applications based on that and they're living here. Whether it's an asylum, whether it's a withholding, there's something called as cancellation of removal, or they filed for adjustment of status. Their cases are still pending because there are backlogs with the USCIS and ICE. Immigration courts are flooded with cases and they're moving slowly. So each time an administration changes,
Yeah.
the policies change, it affects them. There are a lot of these people who are actually paying taxes to the government.
The
They don't
illegal.
have social, yes, in the US.
Oh,
They
okay.
don't have social security numbers, but the IRS has issued something called as, you know, temporary identification numbers. Based on that, the government is also collecting taxes from them.
Okay.
They
We
also
didn't
pay
know that.
sales taxes. When anybody goes to purchase a jeans or they're buying a Coke or they're
Hmm.
buying medicines or they're buying anything, they are paying the local city state taxes.
Yeah.
They're filling up gas, they're
Hmm.
paying a tax.
Right.
So the government is collecting all this money from the illegal immigrants over so many years. So it is also unfair if you collect money and now tell them, get out of here in just a flash like that. I would say if somebody is a criminal, yes, you gave them an opportunity to live in this country and they didn't do very well on that. They've committed crimes. They don't deserve to be here.
Hmm.
Fair enough.
That's
But
true.
don't apply that indiscriminately to everyone.
Hmm.
I think it's a very un-American policy to do that. You may say, why am I saying that?
Yeah.
I've been here for almost 4 decades, seen different presidents come and go. President Reagan is the one who passed an amnesty, giving people amnesty back in 87, 88. If he thought it was not the right thing, he wouldn't have done it.
Hmm.
Because he wanted to make sure all those who were illegal at least get an opportunity, get a work permit to begin with, pay all the taxes, carry your insurance, health insurance, car insurance, so that the local citizens and the residents are not affected by this. America has always been a melting pot, Sam. It's all about immigrants coming to this country.
Absolutely. That's true.
The actual Americans are the Native Americans who are living somewhere
Yeah.
which we don't even see much.
That's true.
The rest is all a melting pot, including so many of the congressmen, senators. Their parents are immigrants who came to this country.
Trump's wife. herself is an immigrant.
Yes, Elon Musk,
Is an immigrant.
a
That's true.
great businessman, he
Mhm.
came. So he brought in businesses. He's doing so well. So similarly, we have so many people, and again, Indians are one of the top tax-paying people.
Mhm.
Indians contribute a lot to this community,
Right.
whether in the form of taxes or whether in the form of services, whether it's in the form of labor.
Mhm.
I know a lot of Indians who are here illegally, but they're all paying taxes. They take the ITIN number from IRS and they want to follow and pay the taxes, and government is collecting that. So it would be unfair, in my opinion, as an immigration attorney, for the Trump administration to just indiscriminately deport everyone.
That's right. I think that's very informative and that's very eye-opening, Uma, that you are letting us know because most of the time we have this a very negative impact towards the illegal immigrants. Mostly we think that they are criminals or they can't do anything, and that's what we have the perception. But as you mentioned, that they also have been paying taxes, so this is something that I don't think that most of our viewers knew about it. But thank you so much for letting us know. And Uma, as you are saying that you have been familiar with so many illegal immigrants, right? So I would also like to like deep dive into this segment. That why is it like these illegal immigrants are not legalized till now? Because they had a lot of time, right, to work on their documents, to visit courts. So why is it that till now they are still on that status, and that's the illegal one? What can be the reason
It
behind it?
takes a lot of time for each case to be adjudicated, Sam, and each case is different. For example, somebody is coming from Ukraine, somebody is coming from Russia, somebody is coming from Pakistan. We have a lot of people coming from Afghanistan, and those are real asylum cases from Afghanistan. And yet they don't get their asylums approved like that. They don't believe them. I have a client who told the officer, she's from Afghanistan, that her father and brother their necks were chopped off right in front of her by the Taliban. The officer was asking for a death certificate. Now, where is she going to produce a death certificate? Is the Taliban going to give her a death certificate? There is no government right now in Afghanistan who can give any documents.
Right.
So these people are all suffering with all these situations. When it's chaotic countries, you can't get documents. You can't get documents. The government is saying we can't give you asylum.
That's true.
So it's a catch-22.
Mm-hmm.
So even when the government knows fully well that Afghanistan is facing this, Pakistan is also facing a lot of chaotic situation with ISIS, with whatever's going on. The local people are faced with a lot of problems.
Right.
Bangladesh is facing a problem. You look at Sri Lanka, there's still a lot of fighting going on.
Mm-hmm.
So cases take a long time. Somebody's come in illegally and they want to marry a US citizen, they can, but they cannot get a green card right here. It takes at least 4 to 5 years before they can go back to their native country, get a green card, and come back because they have to file a waiver. And these waivers can take year, 2 years, depending on each case. As attorneys, we try to file them as quickly as possible,
That's right.
but we cannot move the system. So what would be the advice from attorneys like me? I'm not talking just myself. I know all my attorneys, friends, colleagues would be in agreement with this, is for the government to hire more people. in USCIS, in ICE, in courts, so that they can expeditiously move the cases.
Absolutely. I think
So
that's so
people
much.
would not be waiting for 20 years and 30 years.
That's true.
Or the alternative would be for the government to implement some kind of a temporary amnesty
Hmm.
where they're not giving green cards to people, but they only give a work permit for 1 year and renew it based on the fact if you don't have any criminal background, you don't owe any taxes to the government, you're paying for your children's birth in the United States. Forget about birthright. I'm just saying having a child there.
Hmm.
So the government is going to get money based on all this. The Treasury, the US Treasury,
Right.
will have more money.
Absolutely. I think that is so much to process, and that was a great advice, Uma. That you said there should be a work permit, and according to their criminal records, according to their background, it should be provided to a green card. I'm sure our viewers or somebody who is related to this, I mean, legal advisor or any legal expert may understand these things and definitely going to implement these advices in the administration if it goes. And I really don't want to take a break, Uma, because I'm so much into this conversation. I'm sure our viewers are also. But
Sure.
I think let's take some breaks so that you can have a little hot water and can give some relief to your neck. So I think, Uma, let's take a short break. And friends, don't go anywhere. We'll be coming back with more informative and with more eye opening topics. So please go ahead and watch this session till the end. We are just coming after some time, so don't go anywhere. We'll be right back. Thank you so much. Hello and welcome back, everyone, to Immigration and Jobs Talk Show. I'm your host, Sam, and today I'm joined by none other than attorney Uma Mantravadi. Until now, we have explored a lot of different information, a very eye opening facts, and something that we all are not very much aware of. So stay tuned, friends, and we are back again. So thank you so much, Uma, for being here once again, and we are loving your insightful, advices that we are learning from you today. So thank you so much for that. And meanwhile, I would also like to welcome our viewers. I can see Roshni, I can see Subhash, and Sneha as well. So thank you so much, viewers, for being here. I think Uma, let's take one question from our viewers so that we can proceed with our own one. So Sneha is here and she's asking that I came to the US legally on an H-1B visa, but with Trump possibly reinstating stricter immigration policies, should I be worried about my renewal next year? How can I prepare to avoid last minute problems?
No, if you're on an H-1B and you're renewing your H-1 in a proper time, I don't think you should be worried about it. But of course, as Sam and I went through some of the H-1B regulations in one of our podcasts, we talked about it.
Yeah.
The extensions may be getting a little bit easier because there is a policy they brought about where they said they will be deferring to the previous H-1B approvals, which will only make it easier for the extensions. However, I'm not saying they're not going to look at all the documents. If you're going to be placed at a third party location, they'll want to see end client letters, MSAs, work orders, all of those. So you need to be prepared for all that. I'm sure your employer is preparing for that. So, make sure you comply with the regulations.
Absolutely. Thank you so much, Sneha, for being here and putting up this question. I'm sure you got your answer in case if you still have any follow up question or still having any doubt regarding the H-1B visa, then please go ahead and put it up in the comment section. We will definitely try to give you the best answer for it. Also, Uma, here's another question that our viewers are very much into this and they're very much worried about buy American, hire American policies, right? So they just want to know that how Indian Americans, especially the Indian Americans, can increase their chance of being selected for an H-1B visa under this policy, hire American and buy American.
Well, the H-1B is a lottery, as everyone knows.
Mm-hmm.
So it's got nothing to do with the buy American or hire American. There is a lottery. You have to go through, the employer has to go through a registration. And if you're lucky, you get picked in the lottery and your employer is ready to move forward with it, then yes, you will be filing your H-1. When they're talking about buy American, hire American, they're talking generally, maybe, let's say there are a lot of federal projects that are going to come out. Maybe the projects will insist that they cannot place an H-1B in that project. Maybe they can insist that the project has only, the worker has to be a US citizen or a permanent resident. So we may see those restrictions coming in place.
Mm-hmm.
And there are thousands and thousands of federal projects.
Yeah.
So we may see those kind of restrictions because that is in the hand of the government. Now, but if it is a job with Elon Musk, with Tesla, or with Microsoft or Google or Yahoo, I don't think they're going to place those restrictions because they have seen the worth of H-1Bs.
Absolutely.
The foreign workers, they have seen the worth of it, how good they are.
Yeah.
And those are individual companies. So the government has no say in who they hire and what they do.
All right.
At the moment. At the moment. I'm using that word at the moment.
Absolutely. We can't predict for the future, but at the
I
moment,
don't
I
know
think
what's
it's
going to come tomorrow. I don't know what's going to come day after.
that's right. That's absolutely correct. I think we have
And
to
I don't know if a
Mhm.
lot of people have seen on, this was on Tuesday, today is Thursday. Yeah.
Mhm.
The government brought in a freeze on all federal
Yeah.
projects, like including, grants, including a lot of, proposals that people Everything was frozen, including Medicare portal was shut down.
Right, right, right.
Then a court came back and told the Trump administration they cannot do that, at least not with the necessary federal allotments that were previously made. They cannot hold it back. But we've seen that too.
Absolutely. We can't assure, our viewers that this will be remaining for this year because we already have been seeing lots of changes, that too it's just been a week that Trump is here in the office, and there's a lot of changes, there's a lot of implications, that we have been seeing in the Trump's administration. So I think for now, especially for now, Indian Americans can have this relief, and I don't think that there's much to worry about, like Buy Americans and Hire Americans policies, because they are being very much concerned, Uma. So that's why, I just wanted to be.
Everyone is concerned. Everyone is worried. Everyone. Let me also say something. Yesterday, the Trump administration announced that they are looking at deporting some of those students who were protesting the Palestinian and Israeli war.
Oh, okay.
So I don't know if you remember last year, a lot of universities had to shut down
Yeah,
because a lot of students were protesting
testing, huh?
when a lot of Palestinians were being killed,
Yeah.
a lot of bombs being attacked, by the Israelis. So
Mm-hmm.
yesterday, Trump announced that he's looking at deporting all those students, foreign students, who were in those protests.
Oh, God.
So when will this implementation happen? We don't know that. This was
Mm-hmm.
barely announced yesterday. So every day we wake up, we see something else coming.
Right.
By the end of the day, we see something else.
That's true. I think that's how, that's why people are so worried. And that's why, especially the immigrants, because they don't know what time they can get deported or what time they can have a different news about the immigration system. So it's a very high time. It's a very, people are so scared and people are so worried. I hope that this session will be helpful for them, and I hope Attorney Uma Mantravadi is, going to provide such insightful answers that will definitely be helpful for your cases, for your problems, and for the situation that you might be suffering from. Also, I would like to tell our viewers that, friends, you can also call Attorney Uma Mantravadi on the given number, so that all the problems that you are facing right now, you will at least have a better outcome for that. So please go ahead and call her on the number that is 713 787 5297. You can also email her on uma@mantralaw.com and visit her website that is www.mantralaw.com. So make sure, friends, to call her on this number or to mail her on this email ID, and that will be easier for you all only because it's really going to be very helpful. Okay, so with that,
And continuing with that,
mhm,
Sam, I'd like to say something
sure.
that this is not a time for people to experiment with the law and do something on their own. I'll definitely say that this is not the time. This is not the time to experiment things. To say, you know what, I'll go and Google, somebody said this in a vlog, in a blog, and I'll just apply that to myself. I'm going to save some money. I would highly advise, please don't do that. I just had a student who called me and I'm meeting her this afternoon.
Mm-hmm.
She was on an OPT, then she had a STEM OPT and applied for an H1. Her STEM OPT expired. She didn't realize when it expired and she thought she applied for an H1, so she's in legal status.
Oh,
They did it on their own. Neither the employer nor the employee knew. And all of a sudden, today they realized she
mm-hmm.
doesn't have a STEM, she doesn't have a status. So these are the kind of mistakes we see that people make over and over again.
That's right.
So this is my sincere advice to people. Please consult an attorney, even if you don't hire an attorney. Talk to them. Find out what are your options, even in this chaotic condition.
Mm-hmm.
And we're also advising people who don't want to come in person, Sam, to do a call over Zoom.
Oh,
As I told you, people are scared to be on the streets.
yeah.
People are scared to come, drive and come. So we're telling them, don't come. Sit in the comfort of your home and do a Zoom call. Find out what your options are, whether you're here legally or you came, you overstayed, you fell out of status, you're a student, you didn't take the required 12 credits.
Mm-hmm.
Anything can happen. I
Absolutely.
have a student who failed in one class and she had an F1 visa stamp valid until 2027. So
Mm-hmm.
she thought it's very easy. I'll just go to Mexico and come back and they'll reinstate my F1. She was coming back. They placed her into removal proceeding. She's right now sitting in a jail.
Oh God.
That this is why, because we hear these kind of real-time stories. These are not reels. These are real-time stories
Right.
from people that are facing. And based on that, I advise people, please don't take a chance if
Absolutely.
you want to be here.
That's true. And I think now it's very important to stay vigilant, to stay careful, and absolutely, if you are not hiring any attorney, then make sure to contact her at least so that you can get some better advice, and that would be more than helpful. Okay, all right. And let's move ahead, Uma, for my next question. And that we got from Roshni. So, Roshni is here. Thank you so much, Roshni, for your question. And she's asking, I have been waiting for my green card through EB2 for years. And now I'm hearing about potential restrictions on employment based immigration. Should I speed up my process or consider a different route like EB1 or NIW? What's the safest move?
Well, NIW is the same as EB2. A lot of people get confused with that.
Mm-hmm.
EB2, NIW comes in EB2. So if you're in the same line, you're not gaining anything. Now, if a person qualifies for EB1, I would surely say please go that route. Or if you want to go work outside for 1 year with a multinational company and come back on an L1, you can come on an EB1. I mean, you can come on an L1A and then convert that to an EB1C. That's an option. Right now, Sam, I'm working with a lot of employment based Indians who are on EB2s and EB3s who don't have a scope of getting an L1A, or even if they do have an L1A, the employer is not willing to do a green card for them. So they are jumping into EB5. And I work with at least 2 regional centers in Houston who provide, green cards for EB5 investors. And they've been doing this for over 11 years. So my advice is if you have the money, jump into EB5.
All right. So thank you so much, Uma, for making that advice, and thank you so much, Roshni, for putting up that question. Next up, let's take Subhash comment, and he's saying that I have been living in the US on a visa waiver, but I overstayed by a few months due to family issues. If Trump reinstates strict deportation policies, could I still fix my status, or I am at risk at immediate removal? Oh God, this
I
is what
have
we
no
want to
idea
hear.
what visa waiver removal that
Mhm.
he's talking about unless I get more details. I
Mhm.
cannot answer this question. So I would advise Subhash to contact me so that I get more details before I can respond to his question.
Absolutely. And Subhash, please go ahead and you can get this number that is on the screen, or you can also email her if that's pretty comfortable to you. Okay. All right. So I hope that our viewers, we already collected these questions, and now, we have some questions from our Facebook group as well. So
Sure.
there are people who really pose so many questions over there regarding H-1B, regarding F1. So I think let's take some Facebook questions from our viewers as well. So, control, please share the screen. And this is the first question that we got from Facebook group. How many days is premium processing for H-1B transfer taking after January 18th executive orders? I know they don't impact directly, but I'm concerned because I am due for a travel to my home country. Any leads will be very helpful. Thank you.
Premium processing is 15 business days, not 15 calendar days. It used to be 15 calendar days. It is now 15 business days. So after January 18th, there's no executive orders on H-1Bs as such. Jan 17, there was an H-1B modernization rule that was passed during Biden administration, nothing particularly that the Trump administration has come up with. So what will happen in the future, I don't know. But if you've already filed it, you should be getting an answer in 15 business days. I would advise please contact your attorney who filed your H1 so they can give you better answers.
All right. So let's move ahead to our next comment that we got from our viewer. And this is from Dia, and she's saying, "Hello everyone. I got my H-1B approved on 30th December. The status of visa changed to issued on 31st December. I still didn't receive an update, neither could see a change in status on my visa. As it's been a month, I'm worried. Can someone please advise or let me know any information regarding to this?" Yes.
I don't know, it's kind of confusing. She's saying it was approved on 30th
Mm-hmm.
and the status changed. So her attorney should have received an approval. If they have not, they should be receiving it soon with the change of status or whatever they have requested. So I would advise you to contact your attorney and find out if they have received the original I-797 with the approval notice.
All right. I hope you got your answer. It's best to, get in touch with your attorney, and she will definitely help you out. All right. After Dia, I think we should move ahead to our next question, and that we got from Ram. So Ram is saying, my wife has H4 independent visa, but she does not have her EAD approved yet. Her H4 visa expired a couple of months back. An application on behalf of her was supposed to be applied before the expiration, but the immigration lawyer screwed up. After the screw lawyer has informed us that she cannot cross 180 days of overstay in the US under any circumstances. There is no information regarding this grace period for a person who is on H4 visa, but no work authorization in USCIS or anywhere else. The question I have now is, what is the grace period for someone with a H4 visa without an EAD?
The EAD has nothing to do with the H4 visa. The EAD is only incidental if you have an I-140 approved, the spouse has an I-140 approved, then the H4 dependent spouse can apply for an EAD. But the EAD has nothing to do with the H4 visa status. Now, they can file something if they messed up. We usually file something called as a non-pro-tunc filing, which is a legal term to say, a mistake happened, please put us back in this, as though we filed it in a timely manner. And we show the USCIS the extenuating circumstances leading to why it was not filed in a timely manner, where the mistake occurred, and things like that. Now, I don't know if she qualifies for a non-pro-tunc or not. I would advise Ram, please reach out to me. This is a very concerning matter. You are not just writing emails writing these on any Facebook or Instagram or LinkedIn is not going to help you. You need to reach out to an attorney to find out how you can resolve this.
Absolutely.
A
So I
lot of
think,
times I see people complaining, but they're not taking action.
yeah.
You got to take action. If I say I feel like I'm sick, The action I have to take is go to a doctor. I can't say my doctor is not curing me because I haven't even gone to the doctor.
That's right. I think that's
My
beautifully
advice is,
explained.
my email, my number is there. Reach out to me. Send me all the documents. Let's see if we can do a non-pro tongue filing to bring your wife back onto the H4. Don't worry about the EAD, that is incidental. You don't have to have an EAD. There are a lot of H4 dependents who don't apply.
Okay. All right. So I think thank you so much, Ram, for your question. And here we have another comment from, I think let's take the Nidhi's question after some time. I would like to take up our viewer's question first. And this is, we received from RB Bites. I'm sorry if I'm mispronouncing the name. And he's asking that what was Biden's policy regulation on H-1B extension? Can you please elaborate it? Also, what is the future on H-4 EAD? Will it be challenged, though it's a regulation? Thanks.
Anything can be challenged by the Trump administration. When they came in, they rescinded all the executive orders passed by Biden. Just one scratch, on all the executive orders. But H4 EAD is not an executive order, it's a regulation. So will they pass a regulation? We don't know that yet. Is there a possibility? Yes. Now, what about Biden's H-1B modernization rule? It's a whole big topic to talk about. And I think we'll have to do a session on that, Sam. We did one. We'll do one more as a continuation for a lot of the viewers. If we have a lot of viewers asking for this, we can do a repeat session.
Absolutely. I think that will be very important, and most of our viewers are likely, for the H-1B visa mode. So we are definitely going to have another session. So RB Bates, please stay tuned, stay connected, because with Uma, we come on every Thursday at 2 p.m. EST. So make sure to join this session and put up the questions. We are definitely going to answer it, and that will be very helpful for you. So thank you so much for your question, and let's go ahead. And Uma, I would like to know it from you. The other question that right now we have been seeing that Trump's immigration policies is actually leading to deport many illegal immigrants to Mexico and India. So, do you think that this deportation process, especially regarding Indians and Mexicans, is going to cause some tensions between these countries?
Well, I don't know if a lot of people have seen. Originally, the president of Mexico, she refused to allow the plane full of people coming to Mexico who were being deported. She said, I'm not going to allow this plane to land. And President Trump then told her, if you don't allow, I'm going to put a lot of tariffs on you.
Oh.
And those will impact the Mexican government. So based on that, she allowed the plane to land. And Indian government also agreed to take back, I believe initially they said 18,000 Indians.
Yeah.
And India has been told, if you don't take back your people, you're going to face the same thing. We are going to place tariffs on you. So this is being threatened to a lot of countries, including Colombia, a lot of countries,
But
where they said,
yeah, please go ahead.
Even Canada has been threatened with tariffs.
Yeah.
So we're going to see a lot of these bully tactics.
But Uma, if we look into the current news, also, I have been through that. Indian Prime Minister Narendra Modi has said that they are going to do what's right regarding the illegal immigrants. So they have been saying that they will accept those illegal Indian immigrants back to the country. Even the Foreign Minister S. Jaishankar, he also said. So, isn't something that we can expect? I mean, how the relation with India and US will be after this deporting? I mean, do they have any hostile, or will it be a normal one?
I don't think it'll be a very pleasant one. And I don't think Trump wants to have a hostile relationship with India. India is one of the biggest democratic country in the Asian continent, and both the countries have a lot of business trade dealings going on. India has one of the largest population where a Verizon or a T-Mobile can come and set up businesses, have set up businesses. Google has their offices there. Yahoo does. Microsoft does. I'm sure many other giants will be. Deloitte has offices. Uh, Ernest and Young. So they're not going to completely mess up their relationship. Maybe there will be some strained relationships between the two countries, but I don't think it'll be to an extent where it's going to be strained. But yes, if H-1B is completely eradicated, or EB2, EB3 for India, nothing has been done, I think there will be a little bit more strain when it comes to that, because H-1B is predominantly used by Indians. And the same with F1. If F1 is affected,
Mhm.
Indian students will all suffer. And I don't think the government will do that. I hope not.
We absolutely hope not. And I don't think that if there will be something against from Trump's administration towards India, then it's automatically will not benefit USA as well, right? Because India and US, they have something like trade is a good relation. Then immigration is also a very, I mean, important factor in USA. So it's not that easy that their relation will become hostile. It may be a little strained, as you mentioned, and let's see what happens. And we can hope for the best as it goes on. Also, Uma, it's already 1 hour, but there's a last question that I would just like to know it from you because our viewers are very much concerned about it. Like, what tips or how can you say that how to prepare for Trump's new immigration policies in this barbed wire era? Any tips, any pointers that you would like our viewers to know about it?
Like I mentioned earlier, Sam, all my clients, we are giving out this know your rights information to them, especially undocumented people in the United States. Doesn't matter they're from India or any other country. And we're asking them to connect with us, have a consultation, talk to me, find out what are your options, how best you can protect yourself and your family. We have a lot of people who are undocumented but have children born in the United States, and they are worried what will happen if all of a sudden the parents are picked up and deported. So we're asking them to have a family member become a legal guardian through a guardianship process in the state courts, so that the children are just not left abandoned due to the deportation of the parents. So if they have a legal guardian who's willing to take up guardianship of these parents, of these children, we're telling them to do that. Or if somebody wants to adopt these children, we're telling them to do that. There are many, many options that we are telling people to take. And it's not a blanket thing that I can tell people.
Mm-hmm.
It's a case by case.
That's true. Absolutely.
Talking to an experienced immigration attorney is going to help people. And as I said, don't come to the office, don't drive. Sit at home and do a Zoom call.
Wow, that's so good. I think that will be so
Are
helpful
scared
for
of
them.
driving. People are scared to be in a parking lot. People are scared to go shopping. If you
Mm-hmm.
believe it or not, we have spoken to some of the gas station owners, most of them being Indian Pakistani, and they
Mm-hmm.
said their business has dropped by 50% since the executive order of expedite, not executive order, the regulation of the expedited removal has been passed. Their businesses have come down by 50% because people are scared to
Mm-hmm.
stop by, fill up gas, go
Yeah.
buy a beer, or, get a
Mm-hmm.
pack of chips and Coke, which they would do. They're not doing that anymore. Restaurants are seeing a
Mm-hmm.
slowdown. So this is affecting a lot of businesses too.
That's right. And somehow it's not also being very much beneficial for US as well, because as you said that they have been collecting taxes, so they also might see a little shift towards their US economy as well, right? And there are lots of things like Trump has said that there won't be any income tax, there will be tariffs. So I think with that, Uma, we really need another session, and we have so much to discuss. I still have so many pending questions for you, and I'm sure our viewers are also having so many questions, those intriguing questions that they have right now. So, friends, don't worry. We'll be coming back again next Thursday at 2 p.m. EST. So, make sure to like, share, and subscribe to Immigration and Jobs Talk Show, because it's very important to stay vigilant this time, knowledgeable, stay updated with every news, every statement that Trump is putting on in the media. And with that, we are definitely here to help you out. Attorney Uma Mantrawadi is here with lots of different, legal experts, legal advices. So you can contact her on the given number. I would like to tell it. That is 713-787-5297. And you can also email her on uma@mantralaw.com and visit her website www.mantralaw.com. So thank you so much, Uma, for being here. It was really, really insightful, as I was expected the same from you. So it was a wonderful session, and we really loved this, and we are hoping to see you soon.
Yes, and before I sign off, Sam, I know a lot of people who are going to question me today, tomorrow, and in the future. All those people who paid taxes to the government as illegal or undocumented workers, will they get back the money?
Oh, right, right.
We have to do a session on that, because I'm
Wow.
going to reach out to some of the senators or congressmen. I'm going to actually send them an email and see what is their response to that. Will the government give back their money? Okay, fine, you're deporting all of them,
Mm-hmm.
but you took their money.
Right, right.
So will they get back the money?
Wow. I'm
So
feeling
this
so
is something we're
excited.
going to.
Absolutely.
And I'm
Mm-hmm.
telling everyone, please go to my website. I'm putting up the information about Know Your Rights. Please get that. Use it as it applies to you. It's not a blanket thing again.
Mm-hmm.
Consult an attorney, please. In this time, this is the time of chaos, confusion, frustration. Every day we are seeing different things that are coming around. So be very watchful, be very careful. Talk to an attorney, not blogs. That's not going to help you. Or come on the show every week. We will bring you the most current information, and we will discuss your questions. This is not a national television. We're not looking for TRPs here. We're looking to provide facts to y'all. We
Mm-hmm.
give you the facts. We don't sugarcoat it. But you get the facts and then apply it to your case as it's applicable. With that, I'm just going to tell everyone, be safe and be happy. Provide positive information to people. Try and help each other in the community, in the US. This is a time of camaraderie, friendship, brotherhood, sisterhood. This is the time to reach out. Don't be vindictive. I had a fight with my friend. I don't like her. I'll make sure she gets deported.
Oh my
This
God.
is not the time for that.
Absolutely.
Let's have a humane approach. Let's help each other. I'm not telling you to commit any crimes by bringing people illegally. That's not what I'm saying. If you can help your neighbor, give them a meal, give them a ride, whatever you can do.
Wow.
Just be humane.
That is so thoughtful, and that's so good. Thank you so much, Uma, for bringing this so much, to process. I think it's so much to learn from you. We got so much wonderful insights about today's session, and I'm sure our viewers are feeling little confident right now after watching this session. So, friends, go ahead and still, if you have any questions regarding the today's topic, how you're going to prepare yourself under Trump's new immigration policies, then go ahead and put up these questions or doubts on the comment section. After this live session, also, we can take up those questions and provide the answers to your comments. So, thank you so much, everyone. And Uma, we are really looking forward to another session, another very
Absolutely.
insightful sessions with you, right? So,
Absolutely. Thank you, Sam. Sorry for my throat today. I apologize. Hopefully, I'll be better by next week.
no, that's that. We really didn't get to know that your sore was that your throat was sore because we were so much involved into the conversation. But still, that is so nice of you, Uma, that you came here, you took us some time and provided these insights. Thank you so much, Uma, for being here, and we
My
are hoping to
pleasure.
see you soon. All right,
We'll see you next week.
absolutely. All right, and with that, friends, thank you so much, everyone, for joining us, being a part of this session. And make sure to like, share, and subscribe to Immigration and Jobs Talk Show. Today, we discussed a very important topic and very essential topic. And don't try to miss this session. Don't try to miss any pointer because each session, each seconds of today's episode is very valuable. So make sure to go ahead and watch this session till the end. Thank you so much, everyone. Don't forget to like, share, and subscribe to our channel. I'm Sam, signing off for now. Goodbye and take care, everyone.
Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm really happy to have you, and thank you so much for joining us. And before we have our guest for today's discussion, and I introduce you the topic of discussion for today's webinar, I have to this very important disclaimer, which I have to read it out. So, yes, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X. So please feel free to, join us by commenting and participate. You can also join us on call, by the way, and this is a new thing that we're doing. And if you want to join us on call, all you have to do is dial this number 425-436-6335, and the access code is 988-888. And yes, once again, friends, I'm very, very excited. And we actually have a very fantastic guest joining us in today's session. So she's going to bring us a wealth of expertise and insight, especially into the US immigration policies. So, yes, we will be, exploring this topic, a very, very timely one, I would say. Merit based immigration, is it the future of US immigration under Trump 2.0? And yes, with so much uncertainty around immigration reforms, the conversation is more crucial and interesting than ever before. So, yes, I'm very, very thrilled and very happy to introduce you to our special guest, none other than Sophie Alcorn, the founder of Alcorn Immigration Law and a leader in the field of immigration law. Yes, Sophie has been recognized as a 2024 Woman of Influence by SV Biz Journal, a TechCrunch Disrupt Audience Choice Award winner, and she is also the best selling author of Ask Sophie. She also hosts the popular Sophie Alcorn podcast and serves as an advisor in the immigration space. So, yes, without further ado, please help me welcome her back. Hi, Sophie. Thank you so much for joining us today. Really excited to have you and very good to see you.
Hi, Nipasa. It's wonderful to be here on the Immigration Jobs and Talk Show. Thank you so much for having me back, and Happy New Year.
Happy New Year. Yes, our first session with you. So I'm very excited to have you and I'm really looking forward to, for a great 2025 ahead.
Thank you
So
so much.
yeah, Sophie, how are you doing? How busy is it at your end? And what can folks out there expect from today's session?
Thank you so much. We're very busy. I'm doing well, thank you. There's a lot of people who have questions, and it's really a changing landscape, and that's okay. It is what it is. It means that I have some answers, but not all answers, because nobody has all the answers right now, because nobody knows, because the whole immigration system is in flux right now. So particularly for folks coming into the United States through our high skilled and STEM immigration and startup founder pathways, I mean, there's a lot of tumultuous announcements for every immigrant or aspiring paying attention to what's going on in U.S. immigration right now. But for this audience, I do have some hopefully words of assurance to share about the system overall, and that these pathways will continue, and we can get more into those details. There's a bunch of things happening. Obviously, President Trump's executive orders, H-1B season coming up, the H-1B modernization rule that just got published. So there's a lot of topics, and I'm happy to answer whatever questions everybody would be here.
Thank you so much. Thank you, Sophie. And yes, I'm very excited to have all our folks join us. And we already have some of them commenting. So I would just like to tell all you folks out there to please stay with us, because we're going to take up your questions. Hopefully, each one of them will be answered. But yes, a big hello to Rag as well. He says, "Hello, Nipasa, Sophie, excited for this episode." Thank you once
Hi.
again, Rag, our very, very frequent viewer. So thank you once again. So Sophie, yes, I think we will waste no time and get into our topic of discussion. And I have a few questions prepared and lined up for you. So I'll hit on, with the first one. And that is, what changes can we expect, with the shift to a merit-based immigration system? And how do you think this might affect the workers who are selected?
Yeah, great question. So we are not seeing any wholesale shift to a new merit-based immigration system as of yet. We are seeing shifts to the overall immigration system. We've seen the declaration of an emergency at the southern border. We've seen a lot of changes to various law enforcement agencies when it comes to immigration. As of yet, when it comes specifically to employment-based immigration, I have not seen any specific executive orders or changes that directly affect any of the existing visa types. There are many calls to improve the system. So I'm actually a little bit excited and hopeful that maybe after everything shakes out, we'll see some ease of processing for employment-based visas and green cards, maybe new priorities for who we want to welcome into the United States. Some of President Trump's key statements on this issue included last summer when he spoke on the All In podcast, and he said that we should have an opportunity for anybody pursuing higher education in the United States to have a more immediate path to a green card. So that inspired a lot of hope in many individuals. And there was a lot of questions about, is that just campaign rhetoric? Is that one of the things where President Trump is referring to, promises made, promises kept? How will that play out? Because there's several different voices in his administration who all care about this issue deeply in different ways. But a couple of his comments that you can watch on YouTube in the last few days, one of them was on the first day of his presidency when he was signing executive orders, and he spoke about the intersection of potential tariffs and immigration. And in that, I believe he said that he likes competent people. He's familiar with the H-1B program, and it's basically a good program. So that is positive news for this audience. And then there was another comment, I believe on Wednesday, where he was at a press conference with technology executives, and the H-1B came up again, and the president said something to the effect of, it's great to bring in highly competent people, and maybe we could pair it with training up the American workforce. So that's a very interesting policy development that could be mutually beneficial. There was also some talk about how with potential tariffs, this I believe was in the context of Canada and Mexico, that might encourage more immigration to the United States, and we're trying to build up more manufacturing here. So it could be that the president and his advisors are even contemplating an expansion to high-skilled immigration, and that would be consistent with a very conservative think tank, the Heritage Foundation, and what they wrote about in their brief called Project 2025, which has been a conservative Republican roadmap for policy priorities in this administration. And one of the topics in that document was actually that their position was we need to fix immigration enforcement and fix our immigration process. And therefore, it would help employers recruit the world's best and brightest talent to work here legally on these shores and get here quickly and efficiently. So there's no immediate changes to high-skilled worker immigration that I am aware of right now this instant, although I'm like watching with bated breath and checking the news all the time to see if anything has happened. But I do see a lot of shifts that could potentially come into play. Some of it could require new legislation. I don't know if that's a priority, but we're definitely, or a priority yet, but we're definitely, going to continue having high-skilled immigration, and it might theoretically get easier within the bounds of our current framework.
Thank you so much, Sophie. I mean, those were some very unavoidable updates, and yes, very recent ones, which, Trump has been making statements across. We have been watching him on news every day, and it's only, I think, day 3, Trump in the office. And yes, so much has been happening. He's signed a lot of things. He has said that he wants to start so many things, and absolutely what you have mentioned. So hopefully, yes, for especially high-skilled immigration, or folks out there who are studying in the US and who are excellent at what they are doing, I'm sure it's going to be a little easier for them. And whatever Trump has stated, I think it's also bringing in like an air of competitiveness, where people are really going to pull up their socks to be better at what they're already good at. So
I think so.
yes.
And one of the things that was interesting too was I saw there's 2 other factors that I'm watching. One of them is Elon Musk, who's tweeted repeatedly about improving startup founder immigration and removing immigration barriers through his work at Doge. And then additionally, I saw an interview from very conservative Republican Senator Ted Cruz of Texas, who actually shared that his father was an immigrant from Cuba who came on an F1 student visa and, found his way through working at a restaurant to pave their family's way in the United States. And so as more of those stories are coming out, it seems like a more broad consensus is emerging in support of high-skilled immigration, which is exciting.
Yes, it is. It is. Thank you so much. A great start to our session. And thank you for shedding light again and bringing up those very important updates. So yes, to Sophie. And this gives me lead to another question that I have, for you. And this is with regard with what's getting stricter, when we talk about checks on companies, whether it's, hiring H-1B holders or even site visits for that matter. How do you think that this, stricter checks are going to affect or impact the employers, and what should they really do to be ready for all of these more strict policies that are coming up?
Yeah. Great question. So Another factor amidst all of this legal shakeup is that President Biden and his administration took several initiatives in the last month, which have also changed the immigration landscape. So one of them is called the H-1B rule, and it's the H-1B a long time. It became 1 week ago, January 17th, and the administration went through great lengths to secure this regulation by very intensely following all the proper legal procedures to ensure that this regulation would have to stand and be upheld, whatever this new administration brings. So theoretically, there are still ways, like if Congress passed a law, that they could get rid of it, or they could create a new regulation after going through another year of paperwork. But for right now, this new H-1B modernization stands. And one of the other things that it includes, in addition to making the H-1B more accessible and more clear, is that it also includes many mechanisms for stricter checks on employers to ensure that the jobs are being offered in good faith, that there is a bona fide job offer. And indeed, some of the language even shifted from the H-1B about the employer-employee relationship to the structure of the bona fide job offer. So that's a new standard that got put into place. But in order to ensure compliance and that the companies do have that bona fide job offer, employers should prepare for potential increased USCIS scrutiny. So that could include things like mandatory site visits. It could include things like enhanced documentation requirements, and it could also involve potential challenges with offsite placements. However, there is specific language in the H-1B modernization rule that does take into account that work from home and hybrid work are viable options. But theoretically, the beneficiary who's working from home could have a site visit to their home. So a really important thing to remember if you're on H-1B and if your H-1B is set up so that you can work from home all or part of the time is if you move, you don't just need to update human resources so that your paycheck gets mailed to your new address and your tax information, but you have to make sure that human resources is working with your company's immigration counsel to potentially update the address on your H-1B in case of any site visits. So there's more compliance. Employers should ensure that they have the public access folder for each H-1B ready to go in case of a visit. For early stage companies, if you're just like renting a WeWork somewhere, it's really important to make contact with that office, actually visit there, pick up the mail, go in person, get the keys, get to know people, because if there's an inquiry, you want them to be able to attest to how your company is doing business and how it's a good faith job for the candidate. So those have always been requirements, but paying more attention to them again coming out of COVID will become even more important.
Right. Thank you so much, Sophie. And talking about COVID, we also hear that with Trump coming in, he's trying to, implement the Title 42 once again. And he's, trying to make the vetting system more hard. So what do you want to say on that?
Yeah, so this primarily asylum seekers, and it came out of coronavirus and quickly expel people coming in through the southern border. And
right.
So we're going to see a completely different situation at the border moving forward. There have been at least, this immigration policy website that I use to track what's going on, it has 60 immigration policy actions that have happened in less than 48 hours. So it's an overwhelming amount of changes. It includes interim guidance for civil immigration enforcement. It includes new migrant protection protocols. It includes new sanctuary cities enforcements. It's changing what enforcement they can do near protected areas. It has border patrol updates. So they're really trying to close off the southern border for asylum and refugee entry into the United States. And so I think we're going to start seeing those changes take effect immediately.
Right, right. Also, the app, there's a shutdown of the app.
Yes, yes. Yeah, and that app was only for people from a few specific Latin American countries.
CBP1 app, yes, right. CBP1.
Yeah. So it allowed people with a financial sponsor to like proactively come here with permission ahead of time. So yeah, that has ended. But most high-skilled immigrants have not been using those pathways because for people who get involved in that system, I mean, there's a ticking clock. Like maybe you get into the United States, but you're probably going to have a court date and you are here on a finite timeline, even if you can get a work permit. So for people in the high-skilled immigration arena who have a great job at a company, who've worked hard for their education, the H-1B and O-1 routes and employment-based green card pathways have definitely remained the choice option, because that allows you to actually put down roots and have a life here instead of living in constant uncertainty. So there's, a lot of changes that might be happening, that are happening.
I know there are just too many updates to catch up on, and just under one question. I don't think 1 hour is even enough to keep discussing about the changes that are coming up. So, but yes, thank you so much, Sophie, for those highlights as well. And yes, that brings me to also, I have another question, and that is, since we're talking about H-1B as well. So the modernization rule, which happened last week, the 17th of January. So, it's really making headlines. And can you break down what it means for employers and even applicants in simple terms, in short?
Okay, sure. Employers, there's good news for employers. There's streamlined approval processes for H-1Bs. There's more flexibility to retain top talent because extensions will get easier. There is improved program oversight, which I mentioned, which is, you should really review your internal hiring policies, make sure you have comprehensive documentation prepared about any H-1Bs or other visas. Definitely now's the time to get an immigration lawyer if you don't have one. And you want to make sure you have strategic frameworks to comply with immigration, as well as clear hiring policies around immigration. And for candidates, some of the interesting news is there's updated definitions of specialty occupation. There's potential to get cases completed and adjudicated more quickly. And there's also benefits for F1 students in the STEM fields and other fields as well for cap gap extensions. So if your employer isn't paying for premium processing, or if there's a subsequent lottery round for the H-1B that happens after October 1st and somebody is on cap gap, historically they would have to stay in the US but stop working with a pending change of status on October 1st until the H-1B gets approved. But now that date is going to extend until, I believe, April 1st. So folks on cap gap won't have to stop working if they're still waiting for their change of status to H-1B. So that's a really exciting benefit for candidates and companies.
Right. And also, how is this going to affect the entrepreneurs? That's my next question. Is it encouraging immigrant entrepreneurship?
Yes, the rule, and this is a large part of my practice, in addition to helping established companies and individuals with self-petitioning employment-based immigration green card pathways, we help a lot of startup founders. And so the H-1B modernization rule specifically authorizes many of the things that we've been developing as our tactics to help founders get approved, but it calls them out. It makes them even more explicit. One of the key benefits is that founders who now own their companies are explicitly allowed to get H-1Bs to work at those companies. And so we don't have to go through a bunch of setup anymore to try to make those companies in compliance. It's just very clear that that type of setup is allowed. And that is not just for startup founders. That also applies to people who want to own consulting firms. And some of the questions I've been fielding show that there's a lot of ways to use this. So one really great option is for somebody already in the United States on an H-1B working at a tech company. If you want to start a side job as your own consultancy to be able to take on extra work. Now you can start your own company, maybe an LLC, maybe a corporation, doesn't really matter, but get that set up. And we could get you a 5 to 10 hour a week concurrent H-1B in addition to your day job. And that's also wonderful because it serves as a type of layoff insurance, because if you have that H-1B going and you get laid off on your main H-1B, you're not in a 60-day grace period. You're still in H-1B status. So that's been really valuable as we've done that for people over the years. Now that's explicitly allowed. And there is one drawback for startup founders and people in this situation, but it makes sense given the increased oversight and compliance mechanisms. If you own more than 50% of your company and you're getting an H-1B to work there, your first 2 H-1Bs are going to be valid for 18 months each instead of a total of 36 months. So that is one thing to keep in mind. If you do this part-time H-1B concurrent setup for your own company, it's initially going to be valid in 2 18-month increments and then on to 36 months as normal. So that is very exciting for people to have other options.
Yes, yes, Sophie. And one more thing I want you to speak about is, how entrepreneurs can sponsor themselves under H-1B.
Yeah.
Another very interesting thing.
Yes. So we've done it a lot. Like a few days ago, we just got another H-1B approved for somebody who owns 100% of their company. And it's a wonderful new mechanism that we've had in place now for about 2 years, actually, but it's sort of been under the radar, and we were testing it with clients for a while to make sure it could work. But essentially, if you're a founder and you want to sponsor your own H-1B, first of all, you got to make sure you're not working without authorization. So no work at this new company until the H-1B is approved. But assuming you're planning the company and doing research and figuring things out, that would be the appropriate time to have a consultation with me to discuss because it's different for everybody based on your immigration status, what state you're in, what type of business you want to create. There are different economic, financial, and legal considerations that might affect, the type of company you're creating and on what timeline and with what co-founders and with what funding source and capital or loans. So there's a lot of nuances, but once we get that setup planned, within 6 weeks, we can file an H-1B for like part-time employment or just to completely transfer all in to your new startup. So we do that a lot for founders, and it's really exciting and rewarding every time we get those approved. People are really grateful.
Yes, thank you so much, Sophie. And, that brings me to one of the very important questions I can see in our audience. So I think this is ZQ. So I would like to take this before we head on with our other questions, Sophie. And that is, he's asking more and more questions are coming up that people are being deported because they have been in the US for more than a decade or dozen years, and still they do not have legal documents. So why don't people collect these documents? Is it so expensive?
That's a really great question, Nipasa and ZQ. There's a lot of people who are economically motivated to work in the United States who don't have a high educational background. And there are many people who are fleeing persecution, and so they're coming here for safety. And although we have an immigration framework that theoretically allows some types of people to get jobs here and work legally, whether they're high skilled or low skilled or able to work because of their, asylum seeking status, the system's extremely backlogged. So for example, I've had several owners of Mexican restaurants say, I have this amazing Mexican restaurant. We serve Zagat rated gourmet food in the San Francisco Bay Area. We've identified the perfect chef from this little town in Mexico who has a gourmet restaurant there. I've flown there many times. They're an expert chef, but they've never won awards and nobody knows about them. But I want to do all of their immigration right and hire them to bring them here. Well, you know what? It's going to take 4 years to get that person into the United States, and employers can't wait for that. So the system's so backlogged, there's a huge disincentive for people doing it right. And then we've seen such an influx through the southern border of people who are able in the last few years to get work permits that has been in this country. And for the people who are in that situation, very, very difficult to fix your status and to get into some sort of normal, correct status. And so there's just a lot of structural barriers in the system that prevent it from working functionally for people.
Okay, and how do they come in otherwise? Like, there's another question. So why allow them first place and not stop them in the first place itself?
Well, President has decided to do. He's trying to stop me in. And because our political parties have different views about this and, you know, whether they're choosing to value the humanitarian situation or the economic situation, our border has been in flux and the policies on this have been in flux for several years.
Right. Thank you so much for patiently taking up ZQ's questions. And thank you so much, ZQ, for joining us with your comments. I wish you could join us, you know, on call. To all the folks out there, AJ, Rag, we have ZQ, Vihan, Yash, and Akshay. Thank you so much for all your questions. If possible, join us in call, okay? We are online and the phone number is up there, 425-436-6335, and the access code is 988-888. And also to folks out there who are in a dilemma on what to do with their status or visa, and you want to have a consultation, why not contact, Alcorn.law, and you can actually contact Sophie herself, and her phone number is 855 644-2581, and you can even email her. I think emailing will be better, so go mail her hello@alcorn.law, and go visit www.alcorn.law to get to know more about Sophie Alcorn and Alcorn Law. All right, so Sophie, getting back to our questions, I have more. So, you know, with this new definition of specialty occupation, which we hear is changing soon, so how do you think, this will affect who qualifies for an H-1B visa?
Yeah, it's a completely new definition of how the specialty occupation is defined, which is one of the most critical components of the H-1B. And there was a lot of regulatory pushback and back and forth on this in the notice and comment period. And the qualification criteria have changed and potentially in some senses narrowed. And so now there's a more stringent interpretation of what type of degree is normally required for each type of job, because the government is asking to see a logical connection between the educational background and the job duties. And so as we're seeing this push to have the degrees directly related to the specific occupational position, we're all, this has been in effect for like a week. So I'm not aware of any cases that have been adjudicated on the new framework yet, but it's definitely we're going to see a lot of new RFEs in the coming months, and also especially with H-1B lottery season, where practitioners are going to be experimenting with how do we argue that the degree qualifies under this new regulation? How do we get the H-1B approved? I mean, the Biden administration's intention in all of this was to make the H-1B more efficient and more accessible and more clear. So hopefully, all in all, it will be, overall clarity for people in the field to get H-1Bs approved. But we're still seeing how it will shake out.
Yes, we will. And, they say January is just buffer time. The real year starts with February. So I think you can just count in 2 months, because the lottery, the system starts on 1st of April, right? And you have to register before the October, I think, the month of October. So yes, a lot is happening.
Sorry, I was just going to add,
Sorry.
that if people have a company that wants to put them in the H-1B lottery, this is absolutely something that we help with at Alcorn Immigration Law, and we would recommend that you reach out sooner rather than later, because we get really busy close to the H-1B lottery, and so it would be better if you reached out now. But in addition to the new benefits for entrepreneurs and people with consulting firms, people who don't have an H-1B yet, who are not being entered in the lottery by an employer, those individuals could start their own companies, even if they're in India or some other country, to create a bona fide job offer, and that new company could put them into under the new guidance.
Yes, that's very interesting. And folks, I think you should not wait too long. And it's the perfect time, to plan your H-1B out. So why not contact Alcorn Law? And yes, thank you, Sophie, for that update. And that brings me to my next question, which is very much related to what you just said. And that is, if someone really wants to start a new business out there in the US as an immigrant, what challenges do you think they might face, under these new rules? And you think there are still opportunities for them?
Oh, absolutely. Yes, there are new and stricter visa requirements in certain ways, but in some, it's much easier and much more clear than ever before. And so, we can't just do this for a company that got set up yesterday, right? You need to have a business plan. You need to have potential customers lined up, or you need to have investment or loan. The company still has to meet the fundamental H-1B requirement of having the ability to pay any workers the prevailing wage who are on H-1B. So it's really, designed for people who are serious, who have customers lined up, who have investors lined up, who are investing their own capital into the company because they're really, dedicated to setting up operations. And the fact of the 18-month renewal period, demonstrates that there is going to be stricter oversight to make sure that the company is operational and can continue hiring you for the second 18-month period. So I would say the clarity helps, and people who than ever before to get their own H-1B company.
Okay. Thank you so much. Thank you so much for taking that up, Sophie. And yes, very interesting how it's all getting and shaping. So there's so much more going to happen. We just have to wait, watch, and stay ready, I think. So thank you, Sophie, for that as well. Now, coming back to folks out there who are students, international students, they're moving from their F1 status to an H-1B. What do you think the challenges that they're going to face, especially with these new updates? And how can they set themselves up for success with all these changes that are happening?
That's a great question. I think some of the basics that international students should know to continually, be set up for success, as you mentioned. One of them is probably basic, but I've met a few international students over the years who didn't know this. But if you major in a qualifying STEM degree, you will get 3 years of work authorization instead of 1 year after you graduate. So choosing your major are very, very important. If you are able to secure a job, graduate, please ask your employer into the H-1B lottery 4 times. One, while you're still enrolled in school, second, on your first year of regular OPT, and the third and fourth on your next 2 consecutive years of STEM OPT. Additionally, there are more and more opportunities for CAP exempt H-1Bs as a backup option if you're not selected in the H-1B lottery. So as you're working with your employer or as an entrepreneur in OPT and STEM OPT, and you're gaining that relevant work experience and you're developing your skills aligned with these, merit-based criteria, there's a lot of actions you can take to secure your future beyond STEM OPT, which can include building up your portfolio of accomplishments for an O1A visa for extraordinary ability, or an EB1A green card that you can self-petition, an EB2 national interest waiver green card that If you're from India, you'll have a long wait time, but at least you'll get a priority date, which is a spot in line. And then the other new development regarding H-1Bs is the cap-exempt H-1Bs are becoming more accessible. And this is something I'm testing out with some select clients right now. But they've changed the definition. Somebody who is working at a qualifying educational institution or research nonprofit could qualify for an H-1B without. So that's a really exciting field to be watching in the coming months and years. And if and when I have more details on success stories, you can follow me on LinkedIn and Twitter and other social media avenues. I have a YouTube channel, and we have our Alcorn Immigration Law newsletter. And so that's where we would be public.
Absolutely, yes.
Potentially.
So, so sorry, I was getting a call. Actually, it's Akshay. I think, Akshay, you'll just have to wait a bit if you don't mind. I'm going to call you back in just a short while. I'm going to take up a few more questions because it's calling my system. No worries at all. Please don't be sorry. I thank you so much for joining. Just be patient a little bit. All right. So moving on, to my next question. So, how do you think, also, about the F1 students? There was an extension. Have you mentioned that too, like from October to the next of April, right?
Oh, yes. So that is the cap gap. And basically what international students need to know about that is that if they're at the very last year of their STEM OPT, or if they don't qualify for STEM OPT, then the very last time of their regular OPT, the H-1B lottery happens in March. You find out if you were selected before April. And so basically this cap gap thing comes into effect if your end of OPT or STEM OPT will expire between April 1st and October 1st, and you get selected. Basically, as long as the employer files the full H-1B petition before your STEM, let's just say your final day of OPT expires, regular or STEM OPT, then you're allowed to stay in the US. And if the employer is doing a change of status, not consular processing, then you're allowed to stay in the US, stay employed at the company, keep earning money. You probably shouldn't travel during that time, but you're allowed to be here. And so historically, if October 1st came around and your H-1B hadn't been decided yet for whatever reason, you would have to stay in the US but stop working and stop getting paid, which was a really unfortunate situation for a lot of people. Move that date forward to the future where you don't automatically have to stop working on October 1st. They've extended that range for many months. And so that's just going to help give employers and kids more peace of mind as they go through the H-1B lottery process. But definitely do look for options if you're not selected, because there are alternative ways to stay in the United States beyond that as well. I mentioned some of them.
Absolutely. And, best be guided by an attorney. So why not contact Sophie Alcorn herself also, and Alcorn Law, because they're going to be able to guide you as well. What suits you best, because who knows, you could be extraordinary and you could fit in very, very well in an O1 as well. So yes, look out for your options. And thank you so much for joining.
And occasionally,
yeah.
Oh, thank you. I was just going to say, occasionally I get to have those conversations when an employer and employee contact me about an H-1B, and I get to surprise them and say, did you know that? And they're like, what? That's amazing. So there could be surprises. It's fun.
Yes. And surprises are good, I think. Yes. So yes, thank you so much, Sophie, for, highlighting that as well. So why not, look out for your options always. Sophie, I think we will take up some of our questions from the audience. And to start off, I think we should take up Rag's question. And, Akshay, you can call in just right after Sophie answers this. So Rag's question is, what is your latest guidance for L1A? Recollect your previous advice of smaller firms facing more scrutiny.
Well, thank you for this episode as well. I appreciate it and your memory. Okay, so my guidance is that under Trump 1.0, there was more scrutiny for L1s, especially for companies with less than 10 employees abroad. and less than 5 companies in the United States. There was no official rule about that got published. That's just my sense based on my experience at the time. On the last time I chatted about that on this show, I suggested that, we don't know if we're going to have a return to that in this Trump 2.0 administration. Still too early to tell, but my initial response is it's less likely that we're going to have a return to that, given tariffs, the importance of U.S. manufacturing, and President Trump's statements that we want come to the United States and that immigration will be essential for that. So I'm hopeful that the L1 will remain more accessible in this administration than the prior. That's a great question. Thank you.
Thank you, Rag, for joining us. He's one of our very frequent viewers, and we're always excited to have you. Rag, thank you once again. And we have Akshay on call, actually. So thank you, Akshay. Hi, Akshay. You can speak now. Sophie's here too.
Yeah, hi Nipasa, hi Sophie, thank you for doing this. And I just had a couple of questions. Like you had said, even if you're outside of the US, you can have your own company and then try for the H1. Can you just explain a little bit about that?
Thank you. Yes, absolutely. Thank you so much, Rod. Great question. So the companies that are allowed to sponsor people for H-1Bs have to be US companies. But anybody in the world in the United States. So let's say somebody is in India and a new US company, they might already have a company in India, in which case it might make sense to have a US subsidiary that they might create with a tax advisor or a corporate attorney. It could be their first company, and it could be a startup, in which situation they might simply choose to use an online service like Stripe Atlas or Clerky to set up a US Delaware corporation. Or it could be your very first consulting company, and you work with an attorney or tax advisor to set up an LLC, perhaps in California, even if you're in India. To having that company, once the company is set up, it will need a federal employer tax identification number. It will need a bank account. You will need to transfer money in to show how you're going to create initial operations. You're going to need some sort of business plan or client base or letters of intent or investors showing that there's some, work to be done. And then we've been very successful at getting the very first employee an H-1B at a company that just started operations. Now, most of our clients are funded technology startups that have raised hundreds of thousands of dollars of venture capital investment, but also from time to time, I've represented people with smaller companies, with consulting firms where they're getting it off the ground themselves. And so a lot of this setup can be done remotely from overseas. And once we have the once we have the company properly established and meeting all of the compliance requirements, then we can initiate the H-1B process, either through the lottery, if it's somebody's very first time. If you had an H-1B before and there's remaining time, we could transfer it to this new company. If you're already on an H-1B, we could set this up for part-time concurrent employment. And if the lottery doesn't, it's great timing right now for the lottery, but if the lottery doesn't work out, then we can explore some of these new cap exempt options, which could involve, one example could be like a university affiliation with a US college or university. And then I'm exploring new pathways there to see if we can help entrepreneurs get their H-1Bs approved any time of year with no lottery based on those types of routes. So it's an exciting time. And if you're interested in entrepreneurship, I would definitely, urge you to consider it further. And you're welcome to reach out to the number Nipasa provided or email and at alcorn.law. And we're super happy to help you explore that.
Yeah, thanks for that explanation. And the other question which I had was I'll be applying for an F1 visa for this coming fall. So if I travel to another country, for example, like Singapore, and set up my appointment there, would that be any issue other than Mumbai? Because the wait times for Mumbai are very high.
Yeah, and I don't know how those are going to change over the next year. So you'll just have to pay attention to each consulate, because Singapore might offer that right now, but each consulate can change their guidance at any time about which third country nationals they're willing to accept for visa interviews. So theoretically, that option should remain available, but it would just be something that you would want to definitely check. And maybe there would be a different consulate that would be better for some reason, but the wait times are continuous. We saw a bunch of State Department senior officials reserve stay of President Trump's administration. That could expand, and the Biden administration hired back a bunch of contractors who had resigned 2.0, and that was how they were getting through the post-COVID visa backlogs, which, there's still visa, but those extend their career. How I think to be prudent, everybody who needs a visa should just be aware that there might be persistent backlogs until the border crisis is determined to be clear, and then potentially there could be a renewed emphasis on high skilled and clearing up the consulates. But for now, it's safe to plan all your travel with the assumption that there are probably going to be delays, and you might have to look for alternative consulates, which could change at different times.
Great. Yeah, that's awesome. And also, I can explore the option for entrepreneurship, while I'm on an F1, right?
Yeah, but you can't work without authorization on an F1, and nobody in their first year of F1 is allowed to get a work permit unless there's some sort of extreme financial hardship situation. But on an F1, things that legally students can do to explore entrepreneurship would be taking classes in entrepreneurship through their university, getting curricular practical training for paid or unpaid internships, using part-time or full-time pre-completion OPT to legally work on their own startup before they graduate. But you have to get permission from your school to do those things. But there are many, many ways to do it, which is exciting.
Yeah, thanks for the help. Yeah, thanks, Nabasa.
Thank you so much. Thank you so much, Akshay, and I hope you've got all your answers. And thank you so much, Sophie, for patiently taking up Akshay's questions.
You're welcome, Natasha.
Thank you, Akshay, for joining us on call. That was actually very nice. We hardly get callers on, so it's very nice when we have one, really. So this is real time, and it's really nice wherever you joined us from. Thank you once again. And now I think we should take up more comments. Yes, I think we'll take up one of Rag's last question. Does premium processing invite RFEs off late? He's asking.
Depends on the case type. I've not seen that for H-1Bs. The scrutiny on EB2, NIWs, and EB increased, but most of my clients still use premium processing because we're very, judicious about who we accept as our clients. But we have seen delays in premium processing as well, such that the agency takes longer than the 15 or 45 business days, and if so, the title refund of a $2,805 premium processing fee.
Okay. Thank you so much, Rag, for your question. And, we have more questions, some of them on our YouTube channel, and one more actually from my WhatsApp. Thank you so much for, coming in and asking your question. So, Control, if you can display it, please. This is Osman Boy from Gambia, and I'm a PhD student in pharmaceutical science at the University of Mississippi. This is my second semester. I have tried to apply F2 visa for my spouse who has no bachelor's degree, but she has advanced diploma in science working as a junior school teacher. She was denied F2 visa under Section 221G in December 2023 due to missing marriage photos. In January 25, she was denied under Section 214B. I want to buy a property in her and my name so that we can have one shared property. Secondly, all her parents and family are in our home country, and my family is also in our home country, although. although I lost both my parents. I'm sorry for your loss. I want to reapply, but I am still wondering what to do to convince the consulate officer. So, Sophie, what do you have to say?
Okay, so thank you. And I'm sorry to hear about the challenges you and your wife have been having with this. They can be quite strict with these. So 221G is basically when somebody doesn't appear to meet the eligibility requirements. 221B has to do with failure to establish non-immigrant intent. So these are very common denial reasons. I think, you're also asking how to get her here to buy the property. But one thing is, people in the US people outside of the US are allowed to be property owners inside the US. But if you buy a property in the US under her name, which you could legally do in the US, that would be further evidence of immigrant intent, which would be challenging. In this situation, it might be best to apply for a completely new type of visa that's dual intent, such as an H-1B. And so, this would take a longer discussion about your wife's educational background and her skills and where she could get a job and what company could sponsor her. But theoretically, an H-1B, which is dual intent and doesn't require if she can find an employer or company and go through the process and come here to pursue work, that could be an alternative way for her to come to the United States. And if she did that route, then if she already owned property in the US, it would be okay prior to her coming, because that wouldn't be a bar to the H-1B.
Okay. Thank you so much, Osman, for joining us with your question. I hope you've got your answer. Thank you, Sophie, once again. Let's move on to our next one. This is on YouTube, Sophie. I'm sorry if I'm rushing, but I do hope
this might have to be our last question because we're almost
okay.
at time here.
All right.
I can
Sure.
do more. I love everybody's questions. It's great.
Okay, then let's just take one more from, or let's just wrap it up, because since we are talking about our topic today, and maybe if you could just tell us, for someone planning to apply for an H-1B visa soon, what should they start doing now to make the process smoother with all these new policy updates, and it'll be really nice to help folks out there.
Okay. Figure if you want to be in the H-1B lottery this year, now is the time for the company representative to have a consultation with the law firm to ensure that all the documents are in order and we can get the case filed on time in the next lottery cycle. That's the critical one thing at this juncture. If you're applying for an H-1B without the lottery, then the main thing is make sure that the future company has the right setup, has the ability to pay. But in any event, talking to an immigration lawyer sooner rather than later is important. And of course, we would be happy to help you. So thank you so much, Napasa.
Absolutely. Thank you so much, Sophie, for taking time out and spending it with us, making this session so insightful and enlightening to so many folks out there who have joined us. And also for patiently answering not just my questions, but also some of our viewers' questions. So I would just say thank you. And if you have any end notes, to wrap up this session, it'll be great to say if you have anything, especially, with regard to what we have been hearing. There have been so many protests also about, too many immigrants coming in, and what about Americans and their jobs? So if you can just say, wrap it up along those lines.
Right.
Yes.
Well, I think that probably a lot of people at companies listen to this, and a lot of people who are immigrants or aspiring immigrants are listening to this. And so I would just encourage you to remain steadfast. The U.S. is a nation of immigrants. We are a country that's about making money and leadership in the world. And so if you have the skills to help us contribute to that mission, the United States will welcome you. So please, if you have that dream, don't give up because of the rhetoric that you're hearing. You're very much welcomed here. And there's many routes to finding your way that legally exist and are very stable that you can rely on. So please don't give up on your dreams. We're happy to help.
Thank you. With that, I would say thank you once again, Sophie, and thank you to Alcorn Law, for participating with us and helping us have this very smooth webinar. And I hope to see you soon again when you have some time to join us. So, Sophie, thank you once again.
Thank you so much, Napasa. Thank you to the show. Really appreciate being here on Immigration Jobs and Talk Show.
Thank you. Have a great day, Sophie. All right, folks out there, thank you so much for joining us. I really hope that you resonated with this session, and I hope this was very helpful for you. Do not forget to like, share, and subscribe to us. And if you have people or friends out there who would really love this content, do not forget to also share with them, and yes, comment. So also sorry, folks, if we couldn't take up your questions this time. Some of you, I'm so sorry, but we will hopefully address it in some of our other webinars. And thank you once again for joining us, each one of you. Rag, AJ, Akshay, also thank you so much for joining us on call. It was really nice having you, and lovely having you all. So stay with us, because we have so much more updates here on Immigration and Jobs Talk Show, and also another very important session lined up at 4 p.m. Eastern Time with my co-host Sam, that is Daily Immigration Dose. So until then, keep watching our space and have a great time ahead. Bye-bye for now.
Hello and welcome to Immigration and Jobs Talk Show. I'm Rivera, your host. And today, before I talk about anything else, I would like to read out the very important disclaimer, which we display on our screens before the show. So by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. I'm Rajni, your host, and today we are tackling a very hot topic that could reshape the future for thousands of foreign professionals. H-1B visa updates 2025. What do they mean for you, and how can you adapt? Well, joining us is none other than Ruby Powers, a powerhouse in immigration law and founder of Powers Law Group. With years of experience helping individuals and business navigate the complexities of US immigration, Ruby is here to break down the changes, share insider insights, and answer the big question: how can you stay ahead in this ever-changing landscape? So whether you're an H-1B holder, a hopeful applicant, or an employer trying to make sense with all of it, this episode is packed with tips and strategies you can't afford to miss. So without any further ado, let's give a very warm welcome to Ruby. And yes, welcome her to Immigration and Jobs Talk Show for the second time. Hi, Ruby. Welcome to Immigration and Jobs Talk Show for the second time. Happy to have you back.
Thank you for having me. I'm glad to be here and help answer questions and be a resource for everyone.
Thank you so much. Thank you so much for your time. And now, Ruby, without any further ado, we have so many updates coming and going, especially regarding H-1B. So people are really excited and nervous at the same time. Sometimes, the big names, the politicians and the business people, they are backing H-1B, and sometimes they are not backing H-1B visa. So, a lot has been going on when it comes to H-1B visa. So I would like to know from you that what are the key changes in the H-1B visa renewal process starting January 17th, 2025?
Well, there's been a lot going on because, as everyone probably knows, we have a new president who was previously a president, Donald Trump, and we had the inauguration just days ago, and so now the immigration in the news space has been flooded with a lot of changes. There haven't been a lot in the H-1B space other than the H-1B rule that was announced that would go into effect on January 17th, which was to further streamline and the modernization final rule to improve program integrity and efficiency that was going to go into effect by January 17th of this year. That was put under place under Biden. What is in the news a lot, which just looking at it right now, is this going back and forth between Elon Musk and it's Vivek Ramaswamy and the whole Department of Government Efficiency about something about regarding H-1Bs and things like that. So there is a lot of talk because it has been confusing leading up to this moment as we're in cap season, H-1B season right now, about to start. And this is a time when you think about it, you talk about it, and you get screened. What will this administration do differently, if anything at all, on H-1Bs? I do have some information just generally that I can share about the H-1B process, and just to make sure we have some good background, if that's okay, and then we can go into taking in some questions. But let me go ahead and share some information. So in terms of updates and what people need to know, a little bit about myself. I'm board certified in immigration here in Texas, and it is federal, so we can help individuals all around the world on U.S. immigration matters. And the firm is Powers Law Group. It's 15 years old, and I've been practicing 16 plus years. So the H-1B is well known, I think, by our audience here as a non-immigrant visa that allows U.S. employers to temporarily hire foreign workers in a specialty occupation. And usually what we're seeing is in IT, engineering, healthcare, academia, and it's a really great place for skilled workers. Unfortunately, we just don't have enough visas allocated for the demand. And what the process was before, and this is one thing that Trump put into place in his first administration. Remember how it used to be that everybody who was applying had to prepare the entire packet, FedEx it, and for that April 1 arrival, flooding the USCIS locations, and then they would then take those and do their lottery system. But one thing under the Trump administration was to create the registration process where before you did all of that, yes, you need to double check that you're eligible, but what they would do is you would go on the USCIS website, registration, and then they would randomize. There was an opening of about a 3-week period in March, and then you would have that randomization and be able to see who's got chosen. Then you would prepare and submit. So this saved a lot of legal fees for companies, individuals, and things like that. And so I really do think that was a great suggestion to streamline the process. But then over time, they called people gaming the system and applying for multiple people and trying to get more chances. And then they were cracking down on that later in 2024 by some of the innovation and efficiencies that they put in place. But in general, you either have a bachelor's degree or higher in a specific field. You can use equivalent experience. But for the most part, we're working with the bachelor's or master's or beyond. And the job offer isn't a specialty occupation requiring the applicant's skills. They have to demonstrate that they need this, the foreign talent. And so just some of the things to know, there's 65,000 H-1B visas annually. And what we're talking about are the cap. The cap is where there's a limitation. There are exemptions to the cap where there's not the same limitation when we're talking about universities and affiliated nonprofits and government and research organizations that qualify for being cap exempt. And back to the annual cap numbers, additional 20,000 for individuals with advanced U.S. degrees. And so that does put a priority on those with, like, mostly we're talking masters from the U.S. That helps with the U.S. schools, but generally people might be here with their F1, they get their OPT. If they don't get picked up for their H-1B, and they're in the STEM, they have some more years. And so there's been like an opportunity there to help them. Often what I find is even though you can do consular processing, that most times it's the employer knows the potential employee and has worked with them in some capacity in OPT or some other visa status and is willing to, because of that, willing to petition for them. So we in 2024, according to this, they received 758,994 applications. I think that's registration actually, but there's a lot of demand. And so that's the other thing that there's been talk about is why can't we increase those numbers? And basically it's a political issue too, because there's just that concern that you're not taking jobs away from U.S. workers. But a lot of statistics and research show that there's not enough U.S. workers to do these jobs. And by bringing in foreign skilled talent, we're infusing a lot of ingenuity and just creativity and just, I don't know, I'm thinking of synonyms for like the amazingness, let's just say, and that later on can turn into other opportunities because they're making great strides here in the U.S. And what's great about the H-1B is that it is a nice pathway can be a nice pathway with it being a dual intent for perm sponsorship. And so anyway, there's the process. And just one other change that did happen was because of that final rule that went into effect on January 17th. There's a new I-129 that came out like the same day, so that's a new thing. H-1Bs, you can get them usually around up to 3 years at a time, but the 6 years, and then you can get the 1 year extensions while your perm is pending. And the prevailing wage requirement is critical, and that changes over time with Department of Labor and where the person will be working and based off of experience. And this is how they make sure that they're protecting the domestic job market, and also the potential employee and beneficiary to make sure that they're paid that prevailing wage. One other thing about the H-1B, which I think a lot of people know, is that H-4 is for the spouses and married children under 21. There is a small carve out for giving work authorization for H-4 spouses if there's a perm pending. That had been going in and out of availability over the years. I hope that remains, because for some individuals with a long time visa wait, then this makes life a lot better while the spouses are waiting for the green card to be available, especially for Indian nationals when the visa wait time can be quite long. And because otherwise the spouse would need to get on another visa. And the other thing we always have to remember is while that visa wait time is pending, watching out for the children and what visa can we move them over to. So like we said, there's a lot of political changes going on right now. And a part of the base in which the Trump administration or Trump, his candidacy, was really trying to protect U.S. workers. I think that there's a section that are using the H-1B that are not part of his base that would be at risk. But I think just the concept can be very politicized. I'll just say it like that. I don't know. I don't want to go into the nitty gritty, but I think that's why we're seeing a lot of headlines right now where there's a little bit of some confusion as to is he pro H-1B or not? And it sounds as if he has been, but then it's been really confusing, honestly. And so anyway, a lot of big name companies have been stepping up for H-1Bs, just like they had for DACA, for example, and saying, hey, we need this. We need more of this. We need to stay relevant and stay competitive for us to be able to keep these jobs here in the United States. And so that's a lot of part of this conversation. There were so many other changes, executive orders that happened in the last few days that even though we are gearing up for H-1B season, so this is timely, I feel like this is just one of many things that are going on right now to sort of see if he's going to have any substantial changes other than what has been happening under the last year or so under Biden and the improvements. So he has said that he wanted the need for the skilled individuals and supports the personal. He knows about the program. I think he's had employees within the program. We need the best people in the field. Apparently, he said that. But in terms of expanding it, I think I'm not sure what he's going to do. There's a lot of supporters like Elon Musk, who's a part of his Doge. Is that the Department of Government Efficiency or something like that? I'm still memorizing all these new things from this week. But and then there's others who are not as are critics of the program. But anyway, a lot of big name companies have used a lot of H-1B, have a lot of employees through the H-1B process, and are definitely strong supporters of it. I think it says a lot that with Elon Musk in his Trump's ear, that who's a big strong proponent of H-1Bs, and we'll continue to see what will happen. But right now, there's the 85,000 visas available, and 20,000 are going to the advanced degree holders, which really is not enough. Like when the economy is strong, when there's labor shortage, I mean, these numbers go by so fast. When we before the registration process, and you all flew all your cases there by that April 1 date, usually they would stop accepting them within like 2 days or something like that, maybe 3 days, because they knew that they already hit the numbers and that within that they were going to do their lottery. So I think when you look over time, when historically economy is strong, labor market is tight, these go by really fast. And anyway, well, we know the importance of it. They contribute to the economy, that innovation, and it does provide a lot of options because individuals can have a pathway to, usually it's like the foot in the door. Maybe they were already here on their F1, then they get the OPT, the company likes them, they do the H-1B, it gives them an opportunity to get that experience, build their resume, and then the traditional path is to be sponsored by the company. But, if there is a timeline to get that done because the H-1B visa is available only for 6 years. So you want to get that perm going usually within a couple of years. That usually works if you move quickly. Other than that, depending on your nationality, you might want to try to move to another visa, or you build up your resume and try to be a national interest waiver candidate of some sort. Or depending on your spouse's nationality and eligibility, you might be able to get on some other type of visa. But lots of global collaboration, lots of options, and there's been different talk. We don't know. Removing caps for U.S. educated international students, simplifying that transition from H-1B to permanent OPT would be great. Streamlining processes to encourage top talent to stay without being so bureaucratic and confusing. But honestly, there's been so much change this last couple of days. I don't know when we're going to get to this conversation, but it's probably going to be hot because we're going into H-1B season. So what will some of the changes be? We're not sure, but I think that other issue that was clarified recently was making it easier for the OPT, so F1 OPT, H-1B, and that whole gap, clarifying that, streamlining that. And then, that was awesome when there was given more time for OPT for STEM degrees. That gave people more of a chance, bite at the apple of the H-1B registration. And so it's hot. It's prevalent right now. This is timely. And other than it being in the news and the January 17th rule and some of the other changes from 2024 with the fact of how that needing to show your passport when you do the registration to minimize the amount of multiple registrations per person beneficiary. Those are like sort of the hot changes that have been happening in the last year. So this is a little bit about my information, and we'll go ahead and open up to questions.
Thank you so much, Ruby, for explaining everything in so much detail, for pointing out all the changes that has been happening with the H-1B visa. So that was very detailed and very insightful. Thank you so much for making the efforts, on creating the presentation. It means a lot. Thank you so much for that. But now I would like to move to my next question after this. So Ruby, with this, I know that you have explained each and everything in so much detail, but still I would like to ask you a question before I move into the viewers' question, because I know the viewers are also waiting to get an answer from you. And guys, if you directly want to give a call, so you can also give us a call on the number 425-436-6335. I would like to repeat it, 425-436-6335. You can put the access code 988888. Yes. We'll put you through and you can directly ask your question to Ruby, through call. So, but right now, Ruby, I would like to come to you and ask you that now, can all H-1B visa holders now renew their visas domestically, or are there specific eligibility requirements?
Oh, okay. Well, there's if you could, if the individual is here in the United States, you can do that. And there's a lot of different considerations about if you're planning, to travel and with your stamp and things like that when you're coming back in. But you can you can do an extension while you're here in the country. One of the other things that happens with this is that one thing that happened a lot under the Trump administration, and just thinking about consulate right now, is that there were a lot of resignations and there was a lot of change. And then they had a hard time filling some of those roles. And so then things just got slower and a little more difficult. And one of the other things that I remember during that first administration was, and I'm just sort of talking in general, so I'm just sort of putting that thing in perspective. So when you're deciding whether you want to do an extension here or, abroad, but I would definitely, if you're here, and I would do it here. And you can also take advantage of premium processing if you need it or things like that. But the other thing that happened is that there was this sort of, even if you had been approved before at the consulate, they were reviewing under Trump first administration, reviewing things de novo, like looking at it with fresh eyes as if it had never been approved before. And one of the first changes that Biden put in place to basically honor the fact that it had already been reviewed and approved was to give a lot more credence to a prior approved petition and not look at it with fresh new eyes, assuming that it was a brand new case. and sort of giving it the deference of it being approved before. And so I'm bringing that up because there's going to be a few things that are going to happen. Like with the change in administration, it just happened on Monday. And we are going to see, I remember when with Biden, it took about 6 months or so to really feel like he had made his administration change footprint and on the and on immigration. And so I think we're going to concede that. But right now, a lot of new cabinet members are getting into office or being confirmed and everything. And then they're changing their leadership. They're changing the marching orders of what they're going to do. And so that's why a lot of this there's going to be a lot of moving parts, more than a typical year. And so I think even though there's lots of questions and I love being able to help give some general ideas, I think that nothing takes the place of just having a good old consultation and with an immigration attorney. And maybe if you have a company that is sponsoring and doing all of the the process, but you want to have an attorney that just is helping you know what your options are, then that's also like what we do as well, or that's an option that you can have. You don't have to just ask the attorney that your company has. You can ask another one just for like a second opinion to know what your options are. So anyway, I went a little bit over there, but I wanted to explain that a little bit for you because there's a lot of different moving parts. And one little policy, even though there's probably only going to be one law that's going to be passed anytime soon that's regarding immigration, and that's the Laken Riley bill act about the some criminal matters that even if you're arrested could have you detained. But what I'm getting at is that for the most part, we haven't had immigration laws in many years, but what we have had is policy interpretations or rule changes. And so when there's a lot of these changes that are announced, like about 80 executive orders were returned or rejected or reversed. I think it was reversed of Biden and Trump on the first day on Monday. But when you think about all the changes that are being proposed, you have to think about where is the source of power or where is the source of law that the things that we assume or that we know come from. And sometimes it could be, like I said, a rule, a policy. It could be an interpretation from like USCIS, for example. And after a while, they're like, we may have a new interpretation of it. And they create a memo and they say, this is our new interpretation of it. And so maybe that's a little too nerdy about it. But like right now, that's sort of how immigration works. And so when you ask questions and when there's a constant change, us immigration attorneys have to evaluate these things when we're answering those questions. And with a lot of moving parts, I am starting to liken this to playing 5D chess. I don't know if that's a thing, but it's sort of like what we know, what could potentially happen, and what could change. Anyway, but this isn't going to be that complicated as 5D chess, as like some other areas of immigration right now.
Right. But a lot of things has been happening when it comes to immigration. Since the time President Trump has taken the office, he has signed executive orders and, ended birthright citizenship. The courts have also challenged it. And then the mass deportation has already begun and so many things, and the ban on CBP apps. So, I mean, there's a lot to actually talk about. And then these changes in H-1B visas. And then sometimes they are backing it, they're in favor of it, then sometimes they're going against it. So a lot has been happening. So what do you think? Do you think it's more than what they're trying to do is they are actually it is more of a political move than what they're trying to do?
Well, I think that one of the things to note is that okay, that's probably where I saw the 5D chess was on Star Trek. Thanks for putting but I've been using it this week in media because I that's why I feel like my brain is like hurting already. Okay, this is the way I approach this right now. There's the political motives, and unfortunately immigration has been politicized, but ultimately life must go on, immigration impacts so many different aspects of the U.S., from the economy to the movement of people to the food that we eat, to our culture and innovation. We're in this whole AI revolution and everything in the tech space as well. And so I think on the political side, the way that our president is part of his base, that part of his campaigning is to stoke fear amongst immigrants, and unfortunately, and so I think a lot of that is through the expedited removal expansion, the mass deportation talk, the getting rid of the CBP-1, making asylum harder, the Lincoln-Riley Act, which is, in theory, it sounds good, but when you realize it, a person who's just arrested could be mandatory detained, even though they haven't had their chance to defend themselves and clear their name. And so that's contrary to what we normally do. And even ICE has said that we're not going to be able to implement this because we do not have the resources. But anyway, so one of the things I've said is that we have to evaluate what really can happen and where are the priorities. I think the priorities really are a lot about border and deportation and with crimes. I think that he may have swayed back and forth about H-1B, but I think ultimately he knows it's important for business and companies. And I think for the most part, he'll stay a little bit out of it, but it is getting a lot of headlines right now, especially with Elon Musk and such, who's a strong supporter of it, and a lot of other big companies. So I think for the most part, it's not going to be changed that much. And plus, there's not a lot of time to make a lot of change. Like, it's January 24th. Registration should start in early March. It should only open for a few weeks. We already had, rules take time to be put in place. There's a comment period, there's the posting, and then you have to give people advance notice about it. So I think for the most part, whatever was done under Biden in the last year is probably what's going to stay forward. For this next season, it could be like the present following H-1B season that we see a little more change. But for the most part, I think it's relatively safe. But like I was saying, like, you have to look to see where's the source of power, and how long and how quickly could one person, or could he make a change to it? Or would it require Congress to act, which is going to be a little bit easier because there's a lot more consistency on the Republican side and numbers there. But that's probably only going to be for maybe 2 years. And then the pendulum will swing again, and so forth. So, yeah, those are some behind the scenes type of thoughts about it. But I think, some of the things that we remember under the Trump administration were, he made that registration process. He made it a little bit harder for F1 students, and there was a lot less students. And you know what? F1s, they're the pipeline for H-1B. And so I don't know. I don't think there's been a lot of talk about like reducing that, but it could be that target certain nationalities that they target reducing F1 for, but that really hurts the schools because of the international.
If you can give some example of nationality, like what all countries?
Well, it could be like Chinese or something like that, or certain countries that like he might be like retaliating against for political reasons or something like that, or security reasons. But I don't. Honestly, I really try to stay in my immigration lane, but it looks like I need to go up like 30,000 foot high level and see like a whole lot of big picture. But even with immigration, we're a full service law firm. So, I mean, I'm thinking about asylum and complex citizenship and family based on a regular basis. But yeah, I think, yeah, so I don't know if he's actually said anything about F1s, but I was just giving, a student But what I have said is that what I was mentioning that was something he did before. He made it a little bit more stringent because, okay, where do F1s come from? Usually the consulate. If you make it difficult at the consulate, which, like, if there's more scrutiny, less discretion, less staff, whatever the policy is, less reviewability. There was a Supreme Court case last June that gave a lot more power to consular review. And so if that's that pipeline, so at the consulate is where all the F1s pretty much were coming in. And then for the most part, you could do a change of status. And then the F1s usually turn into OPT, and then they turn into H-1B for the most part, right? One other good thing that happened, and I think that was pretty much only under Biden, was that you could do a change of status to an F1 and pay the premium processing. I remember how you used to have to wait a whole year and a half for them to adjudicate the change of status before you could start school. That was so stupid. And that's another thing that Trump did under Trump 1.0 is that he got rid of premium processing for so many things, which was really unfortunate for USCIS because USCIS, that's extra money. Like, you do something faster, you get more money, and that helps the USCIS be more efficient. But also it makes it more difficult for companies and individuals if you don't have premium processing. And so that was one thing, if you paid attention to that under Biden, having more premium processing for even national interest waivers, student change of status, and things like that. Anyway, I guess I'm going on a little bit of a rant there, but giving a little bit of a history lesson of things and keeping in mind what might potentially happen. So.
No, I think that's necessary and that's very important. You know what you're saying. You have to inform the immigrants, especially because they are expecting a lot of things. But Ruby, before I take from the viewers, but before I take that, I also would like to know from you that before we already have seen administration, and now that he was coming to power for the second time, I know we were expecting a lot. But then, as an immigration attorney, were you expecting, all of this to come on the first day itself?
Well, we had heard rumors that there was going to be a whole bunch of actions on day one. So, I mean, I sort of lost count on the number. I heard 150 or 200, I don't know, whatever. But, the one thing to note, it's like there's more to the U.S. than just immigration. I'm thinking his presidency, there's other areas of law and life, but I feel like he just really wants to focus on this one. But anyway, I think we had heard rumors. We knew, I think, as the day was getting closer from him winning the election to January 20th, we were getting more things were getting leaked out and more was coming out. A lot of that first focus in November was really in early December was to try to get a whole bunch of things filed and take care of things that we knew would probably not be run smoothly under the Trump administration. So that's where our focus was. And then as we were leading up, we were thinking a little bit more. But honestly, it does feel like it's like drinking from a fire hose right now. We had a little snow day here in Houston for 2 days. And so there was the inauguration, there was a snow day on Tuesday and Wednesday. We all had to stay home to be safe. And then Thursday, yesterday, I was just like, it's hitting me now. It's really hitting me because it was there's this game like whack-a-mole, you're trying to hit the thing or something. I feel like it's a little bit like that because, there's this CBP1, no vaccine needed for the COVID vaccine for 45. There's, just all the different things, the mess, the talk about the law enforcement being at schools, places of worship and hospitals. People are getting concerned about that. Just so many different things. Oh, getting rid of that. The Nicaraguan, Cuban, Haitian, Venezuelan parole program. So honestly, what I was telling my staff is a lot of these things are sort of like you maybe get 2 a week or 1 a week of these things, but to get a deluge of all of them on a 2 or 3 day period it's like that going back to the 5D chess, or it's a huge paradigm shift. And so right now we're trying to evaluate all what does that mean for our existing clients and how we can best give them advice for the future.
Okay. Thank you so much again for taking that up and answering the question, Ruby. Now, I would like to quickly shift my focus to the viewers' question because they've been waiting in line for a long time. So let me quickly read out the questions. So MBB is here, and MBB says, I'm sure the USA will lose hugely the talented students from all over the world, especially from India with Trump's executive order, and huge gain for India as brain drain will be arrested. USA's loss is India's gain. And I think it's like a statement that this person is making. And also says, goes on to say that on the other hand, the USA will become, I don't think so that's going to happen. But what do you have to say about this? What do you have to say about this statement of his?
Well, I think that the sentiment of it is whoever can make it attractive to bring in the skilled talent and educated and innovative talent is going to win, right? And what we saw under some of that Trump 1.0, just going to call it that, make it simple, is that we were turning away great talent. And so where were they going? They were going maybe to Canada or Europe, or I don't know where they were going, but some of them were not wanting to they weren't feeling so comfortable to come to the US. And so what does that mean? Well, then those countries were going to get, and those companies were taking advantage of that opportunity. And then that can lead to, more innovation, more profits, more strength. And so, right. I mean, that is the problem with brain drains when there's political issues or there's just not a lot of options for those to move up. And so the countries that take advantage and look around and say, hey, let's make it easy for companies and individuals to come here and bring their awesomeness, for lack of a better word, to our country, they're the ones who are going to win. So I hope that we're not going to see that these next 4 years. What I will say is if we do unfortunately see that, then I will believe that we do have the pendulum swinging back and forth. And so it could just hopefully be a temporary loss. And then we rebuild with new leadership and new insights. But ultimately, I think that there's so many different aspects of immigration to this conversation, from a person who has no status to a person who's has some type of a quasi status, to someone who's coming from another country with education, to a legal permanent resident, to a naturalized citizen. And each one of those individuals is taking something away from a lot of this last week's news. And as to how really these things are going to impact them, I think it depends on where they are in the totem pole of their status. But for the most part, Trump was a business or is a business person, and he's surrounding himself by certain ones like Elon Musk and such. I think that there'll still be some reason in knowing that we need to not harm this process. There could be maybe some more potential restrictions, but I think for the most part, it's not going to be too greatly impacted, unlike some of the other areas, like if you you don't have a status or you're trying to come in from the border.
Okay. Thank you so much for answering the question. Ruby, let me quickly move on to next viewer question. Gauravi is here, and Gauravi says, I have been working in the US on an H-1B for 3 years now. With these 2025 updates, what specific changes should I be worried about? Could these updates affect my ability to renew or transfer my visa? What do you have to say?
I think for the most part, if you already have your H-1B and you're secure with your job and things like that, I think you're going to be fine. I think what I normally would tell someone in that situation is, have you already talked about legal permanent residency, perm? Do you have a plan? Because remember, you're at the 6 years, unless you've traveled and you can recapture some of that time. But you're going to be wanting to be having those conversations if you haven't already, because 3 years has gone by fast. What's your plan afterwards? And are you married? Can they get a visa? Can you what can you do? That's what I'd be more concerned about. The typical plain vanilla thing of what's your plan. I wouldn't be worried about these changes right now. There's not a lot of changes, honestly. There's not. It's really what Biden put in place, and we already knew about that coming in before this administration started.
Okay, so Gauravi, I hope you have got your answer. In case you're looking for more, continue posting your follow-ups in the comment section. And meanwhile, let me move to Rekha's question. So Rekha is also here. She says, I'm currently on OPT and planning to apply for an H-1B through a consulting firm. With the 2025 updates, are there additional restrictions or red flags that USCIS might focus on for consulting or third-party placements? What do you have to say, Ruby?
It was for, okay. For the dual intent doctrine, I don't see any changes on that aspect. Right. This is the different question here. I haven't seen about the dual intent one question. I don't see any changes with dual intent. I think that's still there, and it's still a benefit. And like we said, it's sort of a gateway to legal permanent residency through the perm, but it doesn't have to be the only way. And there's other options that you could try to pursue. But let's see. So for the I think that there's just a lot more protection for the beneficiary. I haven't seen exactly something completely on point to answer this question about through a consulting firm, but I think that it's just they're just wanting to make sure that there's a lot more integrity and efficiency and protection of the beneficiary, and also making sure that employers are not gaming the system and things like that. They are going to be conducting inspections and imposing penalties for failure to comply, and that proving that it's a bona fide position of specialty occupation. But for the most part, I don't see anything that is to be of concern for this specific question.
Okay. So Rekha, I hope you have got your answer, but in case you're looking for more, please continue posting your question, and we'll be taking that and asking it from Ruby. Let me move to Lokesh's question in the meanwhile. Lokesh says, in the context of H-1B visa programs, dual intent doctrine, how do the 2025 updates affect the ability of foreign professionals to pursue permanent residency or citizenship while maintaining the H-1B status? And what are the strategic considerations for balancing short-term and long-term immigration goals?
All right. Well, that's
yeah.
Well, okay. So I don't see there was a change or a mention about the dual intent. And so, the general path, the general traditional path that we usually see is the H-1B, probably after 1 or 2 years, you start the perm process, which can take a couple of years depending on different factors and if there's an audit and things like that. And then you, if you have the I-140, approval, and then you can continue the H-1B extensions beyond those 6 years. And so that's generally what we see for individuals. But if for some reason that doesn't work, then there are ways to try to either recapture some more time, stay out of the country for 1 year to restart your H-1B clock. I don't see a lot of people do that, but it is something that exists. Maybe you have a spouse that can get on a different type of visa, and like an E2 or an L, and it can include you, and then you are able to work on as an E2 or an L2. Or maybe you're eligible for a national interest waiver, or an O or something along those lines. So I think that those things are still there. A lot of the implementation changes that were announced just a month or so ago are just like little tweaks, but it doesn't have a huge impact on the big picture of those short-term and long-term goals that you want to have. And usually when I have a consultation, we're talking like, okay, short-term, mid-term, and long-term, plan A, B, and C, and the different permutations. And sometimes we're like the individual, the beneficiary's attorney, and we're like there to give ideas and suggestions, but the company is the one who's sponsoring has the attorney in house or what have you for the H-1Bs. So those are other potential options to just keep in mind so that you're thinking about the big picture. But I think you're going to be okay. So just as long as you're having a consult and you've already thought about these plans, because if you have your plan in place and then there's a little change in the policy or interpretation, then it should just be a little bit of like, okay, how do I refresh this and look at it in the new perspective? And it won't be it should be a substantial shift.
Okay. So Lokesh, I hope you have got your answer. Thank you so much for your question. Let me move to Ciara. Ciara has actually posted this question on Facebook, and she says, hello, I am Senegalese. I am H-1B seeker. I have a master's degree in finance accountant with a non-profit area. Is it possible to get sponsor job in accountant or financial?
So it can, but one of the things that's important is that the job description and the position requires that you have that degree. But there are a lot of private situations where H-1B sponsors accountants, and that's very common. But if the nonprofit, I think one of the things to note is proving that the nonprofit can pay that prevailing wage, has a role that can include a master's accounting professional on staff. Those are some of my little things of thinking a little bit, but that might be a little extra, but it is possible what you're asking for to be. And then if they qualified to be a CAP exempt, then you wouldn't even have to go through all this registration stuff we're talking about. But you have to look closely to that and have it evaluated to see if they are or not. Because if they are subject to the cap, then you have to go through it just like everybody else that we're talking about here.
Okay, so Ciara, I hope you have got your answer. Thank you so much for posting your question. If you have more, please continue posting your follow-ups. Meanwhile, Ruby, I also have a lot of questions from Facebook. I would like to share my screen and ask those questions because, those are some people, who post questions in the Facebook groups. So, yeah, I think it's already shared. So, okay. I would like to take them one by one. Before that, Ciara is actually back and she says, okay, thanks. And I have visa B1, B2.
Oh, okay. I was looking at that question. Okay. So for the B1, B2, you're usually only given 6 months of I-94 at a time. You can usually do one maybe extension inside the country. But you have to realize that, okay, if you are subject to the cap, you wouldn't be eligible to start being in the H-1B until October 1. And that's more than 6 months from now. And if you were to do a B2 extension, you might not know how much time, if it's approved or not. It could get a little risky if you're trying to do a change on top of a change. So I would just do a consultation. And if the nonprofit you're talking to doesn't have an attorney that they've ever worked with, then, we help in those situations. And that's a pretty common thing for us, or if, just in general, is if the company or the nonprofit that you're trying to work with has never sponsored anyone before, then what often happens is they comes to us, they get an opinion, and then they hook us up with their employer and say, hey, maybe this could be a good attorney for the employer. And this usually happens with more of small operations that haven't ever gone through the H-1B process before. So that's something that could happen, I'm suggesting, but also just it is possible to do what you're saying, but I'm a little worried about the timeline of it, especially if you are subject to the cap. you might need to just leave the country and, make those connections, leave the country and do the consular processing to finish it all up instead of a change of status. Because we still a lot of unknowns. If you're subject to the cap, then you have to be chosen the registration and it has to get approved, right? So there's a lot of unknowns there.
Right. So, Ciara, you can also directly get in touch with Ruby. I would like to share her details. I would like to show the details over here, Ruby Powers. You can, for a detailed consultation, get in touch with her so she can help you because she also by now she also knows your case. So you can directly get in touch with her for a detailed consultation. Give her a call on the number 713-589-2085. I would like to repeat the number 713-589-2085. You can also email her. Her email ID is contact@rubypowerslaw.com. And you can also visit our website, which is www.rubypowerslaw.com. So please get in touch with her so that she can help you in a better way. And because of the time constraint, she is not able to. We won't be able to take all of your questions. But then you always have an option of getting in touch with the attorney directly. So here are her details. Get in touch with her. She says, "Okay, thanks. Thank you so much, Ciara." And now I would like to, again, Ruby, I would like to share the screen and show those Facebook questions to you, and would like to get an answer from you. Okay, so this question was actually posted 53 minutes back by an anonymous person who says, my lawyer by mistakenly sent I-485 to family-based AOS logbox instead of employment AOS logbox in Dallas. Now, starting February, they will only accept application on final action dates. I'm filing based on filing dates. It's been 3 weeks already. What will happen? Is there anything I can do? My checks haven't been cashed yet. What do you have to say, Ruby?
Well, that's a very technical question, but like in theory, if something is sent to the wrong place or it's not the right, something's wrong, they usually reject it. And rejections can take, I've seen take 3 to maybe even 6 weeks sometimes. I've actually done a tour multiple times of the Dallas lockbox, and they open everything up, they look at the numbers, and they blah, blah, blah. But I would also check, okay, you don't have a receipt number. They didn't cash the checks, and it's been 3 weeks. And you probably already checked the FedEx or the mailing, and it wasn't, okay. I think I would probably give it another 1 to 2 weeks, and it'll probably be rejected and come back. I don't know off the top of my head if it'll get routed to the correct place. It probably won't. But in those cases, if something is sent to the wrong place, then, or something is deficient with it, then they reject it. And then it can take a little while, and then they'll just give you that rejection page, and then they'll just send that to you and the whole packet. Now, I get what your point is that you lost that opportunity because of the visa availability. There can sometimes be, with some great advocacy, being able to, if it's super worth it, there could maybe some advocacy to show when it was sent and trying to retain the priority date of when it was sent, but for the error. But given the situation, I think you have to look at the whole picture and see if it might just be worth just waiting another month for the visa to be current at the right time. I don't have that, what you're saying, memorized where it is and how, if it's backlogged, retrogressed and everything off the top of my head. But these are some things to consider. But rejections usually can take about 4 to 6 weeks usually. And if they haven't cashed it in like at least 4 weeks, then it's probably going to get rejected and it's probably going to be sent back. So but then watching the visa bulletin and strategizing what you're going to do once you get it in your hands is another thing to have in mind.
Okay. All right. Thank you so much for answering the question, Ruby. Let me quickly move to another question. I also have a question here from Jeremy. But Jeremy, we are going to take that in a while. Let me please complete these Facebook questions before. So this next viewer says, "Hi everyone, I'm currently on an H-1B visa and have received a jury duty summons. Am I eligible to serve as a juror, or is there an exemption for visa holders? What steps do I need to take to confirm my eligibility or respond appropriately? Any guidance would be appreciated."
Well, that is quite a fascinating question because I think you have to be a U.S. citizen to be a juror. So what I've seen be an issue is that they tie jury summons with driver's license. Did at any point you say you were a U.S. citizen when somewhere accidentally? Because as far as I know, you need to be a U.S. citizen to be on a jury. But I think that I don't know if that's a blanket across the country. I think it is, though. Actually, I've never been asked this question before. But let's see. I think that, yeah, I think you have to be a U.S. citizen to be on the jury. So now I'm wondering, how did you get that? But it might have been you might have checked a box somewhere on the driver's license. So look to see what might have triggered you getting that, because I've seen this happen a couple of times where people accidentally registered to vote when they got their driver's license. So look to that, and then I'd say have a consultation just to see if we need to clean something up there.
Okay. Thank you so much again for answering the question. Let me quickly move to the next one. So the next one says, if we can zoom
And I
it in a
think
bit.
we might have to make this one of the last ones. Sorry for timing purposes, if that's okay. I've got
Okay. So this person says, Indian citizen living in USA on H-1B. I recently renewed my Indian passport from USA. So while traveling to India, do I need to carry both the passports, new and old? Also, while coming back, will I-94 be marked to the new passport? But it doesn't have visa, as USA visa is an old passport. Will there be any issue? Also, I'm planning to go to India for a visit for a few weeks. Any suggestions on necessary documents needed to come back, even if I have stamped visa on old passport that I would be carrying?
Usually this is just that annoying thing that happens because your visa's in the old passport. So it's best to have both of them. Often, I believe they put the visa stamp in based off of where the visa is located, but ultimately it would be good to eventually transition to having it in your new passport. But this is just sort of what happens. We're going into some new territory, so I don't know if you have an attorney already, with your company, or you need to have a consultation just to make sure what the requirements are at the time. But for the most part, verifying your employment and having those up-to-date information it's always safe to have. And we could be getting some updates as to what the answer of returning or getting, that was one thing I forgot to mention that Biden did, is that they waived interviews, right? They waived interviews for people who previously had like a B2 or an H-1B, like in some select situations that they were exempt from that when they were at consular processing to come back. And I'm not sure if that's going to be continued or not, or if they're going to, make them all go do appointments and things like that. So I'd say have a consult in your particular situation. But yes, in general, when your visa's in one and it's expired, you're going to be showing both, and then eventually you'll be trying to phase out the old one. But you always want to keep a copy of your old one and keep scanned of it, because if your long game is to get your green card, you're having those are so awesome, because It shows entries, exits, validity of periods, and so much. So no, always make a copy of that and have it somewhere safe so you can use that in the future.
Okay, thank you so much for answering that. But Ruby, if you can please give us like 2 or 3 more minutes, I'll be quickly be taking 2 more questions. Yes, because they've been waiting for quite some time. So Jeremy is here and he says, "Hey there, we've been living in New York City from 2019 August, and we are using Fregomen and they have told my wife and I from September 2024, we are just waiting for our green card. My wife is on L1 and I on L2. So any clarity on these types of visas and green card?"
Okay. Well, was it the L1A or the L1B? And is it based off of perm, or is it, you didn't say what your nationality was either for visa availability. So I wish I could help give, I don't know. There's so many different factors, right? So what was the basis of the green card? What are your nationalities? What's the visa wait time? And how much time do you have on the L's? And is it L1A or L1B? Because the L1A has 7 years and L1B has 5. But so those are things I need to know to help get, and what's the exact question? Because I think I don't know what the question is, but, or there's a follow-up and clarity of these types of visas, British and Indian. Okay, well, who's British and who's in, okay, well, so let's just say in general, but I mean, you can have a consult just for you, even though there's Fragaman is the attorney for the company, but just to understand some of these things. Okay. The L1, there's the L1A and the L1B. The L1A, like I said, has 7 years, L1B for 5 years. You have some of the same rules as H-1B. You can recapture time and there's dual intent. So it's really nice. If you're the L1B, you're usually going to do the perm. And if the L1A, there's another way and it's a little bit, okay, so you're British. My wife is L2 and she's Indian. Okay. So, but you didn't say whether or not you're L1A or L1B. Maybe you're L1A. I don't know. But anyway, if you're L1A, then the green card process, especially if you're British, is probably is a lot faster if the company is sponsoring you. And so I don't know what the original question mentioned, something about September. They have told my wife that we were just waiting for our green cards. So I think if you're saying that they filed the green cards, the 485, then you would have those receipts and you're just waiting for the processing. And you can also go to USCIS website under processing times to see what those processing times are. But if you're saying like they haven't even filed the I-140, okay, the wife is British and she's an L1A. Okay, well then this is a faster process because of that. But I don't know exactly if you're asking me like we filed the 485s in September and you're waiting for the green cards to come in the mail. Check to see what receipts are there. You can check the receipt on the processing times and for the case status, and then that can give you a better guidance. But if the wife is British and she's okay, did they premium process the I-140? So the wife is L1A, she's British, she's the primary. The I-40 was completed. Well, it's likely the company sponsored. And so I think that you can check for those processing times. And I don't know if the I-140 and the 45 were filed concurrently or not. But anyway, these are some of the things I need to know to help give you a little bit more guidance. But it looks like
Jeremy, maybe you can directly get in touch with Ruby. How about you directly get in touch with Ruby? Yes,
that would probably
the details.
Be best.
Yeah. The details are displayed here on screen. Give her a call on the number, send her an email, visit our website, get in touch with her. And yes, I'm going to read out those details in the end. But before I do that, I would also like to quickly take one more question before I let you go, Ruby. It's from Erin. And Erin says, due to technical issue, my employer submitted 2 applications for the same employee due to this USCIS and sent RFE for H-1B. Then how can we handle this? What do you have to say?
You're welcome, Jeremy. So due to my employer submitted 2 applications for the same employee due to USCIS sent RFP for H-1B, and then how can we handle this? They sent 2 separate H-1Bs completely. What was the RFE asking for? I need to know a little more as to are you talking about registrations or are you talking about H-1B complete packets? Like they just sent the same one twice. And then was one of them supposed to be like for you potentially? And there are sometimes you can try to solve problems with liaisons, like with the American Immigration Lawyers Association, we have liaisons. But I really, unfortunately, need a little more about this question to sort of figure out how to troubleshoot it, and how big of an issue it is, and knowing what the RFE is for would be helpful. So, there's been, I mean, I don't want to say second guess your attorney, but there is a benefit to having a second opinion occasionally, just like you would with a doctor, right? And if you want to, if they're not, completely answering your questions, or you just want to have another opinion, there's no harm in that. You just pay for a consultation fee, you get another opinion, and maybe you don't even make any changes, but it gives you a little bit more peace of mind and to maybe think outside the box of what could be a way. These are sort of the situations I call, like, when the train gets off the track and you're like, oh, this is, how do we get it back on track? And sometimes it could be a human error, the firm, or it could be a human error or some type of error at USCIS, and it can cause unnecessary stress. But when people, crowdsource other attorneys, and even those attorneys are talking to other attorneys, they can, and have practiced for a while, they can find out ways to troubleshoot things. I know that I've had some funky things in the past, whether it was because of ours or USCIS, and the more I practice, the more I go to CLEs and talk to other attorneys, the more I'm able to figure these types of things out. So I know that doesn't exactly answer you, but I do need a little more to help answer that question. But I think that is that our last one for today? We went a little over.
It is. Yeah, so Erin, maybe you can also get in touch with, with your detailed question, maybe write your question in detail with each and every aspect regarding to your case, and send it to Ruby or give her a call on the number. You can directly get in touch with her by calling her on the number 713-589-2085. You can also email her. Her email ID is contact@rubypowerslaw.com. You can also visit her website, which is www.rubypowerslaw.com. And we also had one more question by Vivek, and he wanted to know about EB3 visa from Nepal. But Vivek, we are going to do one more episode on EB3 visa. So you stay tuned on this space. Make sure you subscribe to Immigration and Jobs Talk Show. We are going to give out more, we are going to come up with more webinars and more updates regarding EB3 visa. But for now, that's it. So thank you so much, Ruby, for being here. Thank you so much for, giving us this time, and your answers were insightful, detailed. So thank you so much for everything.
Oh, well, my pleasure. Thank you, everyone. I hope I could give you a little bit closer in the right direction. And nothing takes the place of just having a good old private, consultation. But, it is good to see what's out there and learn. And it's great that you have this forum. So thank you again for inviting me, and I hope we can find some other ways to collaborate in the future.
Of course, we'll be more than happy to do it. And yes, I'll get in touch with you again for maybe another episode. And whenever you have time, please let me know, and we would love to do another webinar with you.
Thank you.
Thank you so much. Guys, thank you so much for being here, for posting all your interesting questions. And yes, if you were able to get your answers, great. And if you want, make sure that you get in touch with Ruby so that you can get your answers in detail. But for now, I'll have to take your leave. Thank you so much again for posting your questions and watching the webinar. Make sure that you subscribe to the channel, like the video, share with your friends and family who are looking out for answers to these questions. And like I said, for now, I'll have to take your leave. I'll be seeing you all very, very soon in another webinar. But for now, take care. I'm Rajni Parara signing off. See you.
Hello, everyone, and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host, Sam, and I'm back again with a very exciting episode that is lined up for you today. So, before diving into topic and announcing the name of our guest, here's a very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, friends, once again, welcome back to Immigration and Jobs Talk Show. I'm your host, Sam. And today we are diving into a very important and timely discussion. And the topic is, how can E2, L1, and EB5 visas open your path to US immigration through investment? So if you have ever considered starting a business or expanding your enterprise or making significant investments in the US, I think this is going to be a perfect opportunity to explore how the E2, L1, and EB5 visas can open doors to your American dream. And to help you in this, we are honored, to have one of the best attorneys. That is attorney Alessandro Giordano. Alessandro Giordano is a highly experienced immigration attorney licensed to practice in Florida, New Jersey, and New York. He has also dedicated his career solely to the practice of immigration law, helping individuals and businesses navigate the complexities of US immigration. So, Alessandro, first of all, a very warm welcome to Immigration and Jobs Talk Show for the very first time. And it's an honor to have a show with you, and we are really grateful that you are here with us. Thank you so much for joining us.
Of course, Sam. Thank you. Hello, everybody. The pleasure is all mine. I look forward to sharing this important information with you all.
Wow, that's lovely. So, Alessandro, why don't you go ahead and share something about you, like how did you started your immigration journey with our viewers who don't know much about you?
Sure. So my name is Alessandro Giordano, and I am an immigration attorney. For the past 10 years, I have exclusively practiced immigration law. I am an immigrant myself, and having gone through the immigration system, so to say, I really found my vocation in helping others navigate as you said, the complexities of the immigration laws and the immigration journey. And this is why I almost exclusively practice immigration law.
Yeah, I think you were immigrant yourself, and that's why you decided to help, as you mentioned. So I think that was lovely, and that's why our viewers can connect with you more because you yourself is an immigrant. So I think that was a wonderful introduction, and now our viewers also got to know about you. So, Alessandro, my question, before diving into today's session, I would like to know from your end that how are you seeing the US in the upcoming year under Trump's administration? Do you think there will be a new era for the US people, or it's going to be a nightmare?
There will definitely be significant changes. I practiced during the first administration of President Trump between 2016 and 2020. And I can tell you that things were different compared to the previous administration, the Obama administration, and the current administration, the Biden administration. So I definitely foresee changes. What I can tell you is it's something that all practitioners say, and I would say it's common knowledge that things will be hard for people who are in removal proceedings, people who are undocumented. But what I can tell you is that when it comes to employment-based and investment-based immigration, I have not seen many or as many changes, I would say, during the past, the previous Trump administration. So while there will definitely be things will definitely be different for people in removal proceedings, family petitions, and many other things. Hopefully, we will not see as many changes for people who are who intend to invest in the United States or intend to immigrate through a lawful path, such as investment-based visa or employment-based visas.
All right. Okay. Thank you so much, Alessandro, for letting us know about it, how the future we might think and we might predict regarding these visas. So with that, here's my first question to you is regarding today's topic that how can E2, L1 and EB5 visas open your path to US immigration through investment? I mean, what do you think? What our viewers can expect from today's episode?
So these are three different options: E2, L1, and EB5 visas. E2 and L1, the first distinction that I would make is that E2 and L1 visas are non-immigrant visas, which means that they allow you to live and work in the United States temporarily, right? The EB5 is, on the other hand, an immigrant visa, so it will lead to once the requirements are met, to a grant of permanent residency. So these are three very good options for those who are seeking to live and work in the United States, either temporarily or for those who are seeking a settlement in the U.S. for a longer term, permanently.
All right. So, Alessandro, here's my another question with you. Like, this is a question that majorly most of the people, the investors, they ask for. Like, which visa from E2, L1, or EB5 would you consider most suitable for an entrepreneur, and what are the key reasons for your recommendation?
That's a great question to begin with. So, as I mentioned, the first distinction to make is that the E2 and the L1 are non-immigrant visas. So they will allow you to live and work in the U.S. temporarily, but do not directly lead to permanent residence. So both E2 and L1 visas can be renewed. The E2 can actually be renewed indefinitely, so long as the business still qualifies for E2, for the E2, and the investor qualifies for E2 status. And the L1 can be renewed for a maximum of 5 or 7 years, depending on the type of visa. On the other hand, the EB5 is an immigrant visa, so which leads to a grant of permanent residence, leads to a green card if the requirements are met. Now, that said, the most suitable option, the most suitable visa, depends on one's specific goals. So the E2 is a great option for entrepreneurs from treaty countries, and we will discuss also what that means, what treaty countries mean within the context of an E2 visa. No, it is a great option for those who want to establish or manage a business, grow a business by investing a substantial amount of money. And we will also discuss what a substantial amount of money is considered for E2 purposes. The L1 is the ideal option for those companies seeking to expand into the United States. And the EB5 is the option for those with the resources to make a significantly higher investment and who wish to obtain permanent resident to live and work permanently in the United States.
All right. So thank you so much for letting us know about it and giving us a detailed explanation on this. Also, Alessandro, I want to let my viewers know about it that friends, we are live on YouTube, LinkedIn, Facebook, and Twitter as well. And it would be great if you could join us. It would be great if you could post your questions from any of these platforms that you are watching this session in. And we are here for an hour, so it would be great to take your questions up and we will definitely answer them. So, yeah, I think with that, as we already understood about the basic understanding of the E2, L1, and EB5 also. Here's another question that how does the E2 visa allow investors to manage their businesses in the US and eventually bring family members?
So that's what the E2 visa is designed for. So the E2 visa is designed to allow investors to come to the United States and direct and develop, so actively manage and grow their business in the US. Besides that, the investor, the E2 investor, can bring his or her spouse, and the spouse can apply for work authorization and pursue employment anywhere in the US. Doesn't have to work necessarily in the E2 company like the investor has to do. And then the investor can also bring children. Children are those, under 21, children are under 21 that can attend school or college in the US. So I never stress this enough. The E2 visa is temporarily and must be renewed. But if the the business keeps meeting the eligibility requirements, it can be renewed indefinitely. So if the business remains operational and meets the requirements, it can be renewed, for indefinite period of time.
All right. So, also, Alessandro, here's a question that's coming in my mind, and that's a very basic one. Like, till now, we have been discussing regarding visas. But if we specifically discuss about the business, then is there any business or is there any other options related to business that you would like to suggest to our viewers? Like, this business will be a good one, good idea in US to put an investment to it. Is there any business types or is there any recommendations to it that you would like to tell to our viewers about it?
I would say that, again, we have to look at this question within the context of each specific visa, right? Referring to E2s, there is a requirement that the business in which the E2 investor will invest has to be an active business. It cannot be you cannot obtain an E2 visa by making a passive investment. For example, I cannot invest money in the stock market and apply for an E visa based on that investment, or purchase real estate and rent it out as is. That's a passive investment. That's not going to work for an E2 visa. So definitely for an E2 visa, what we're looking for is an active investment. There has to be some sort of a entrepreneurial activity or commercial activity that supports the business.
All right. And would you like to say about the L1 and the EB5 as well?
The EB5, there are two ways to invest, quote unquote. There is one can apply for an EB5 by making a direct investment. So applies it, investing in a new enterprise, or investing through a government-approved regional center. So somebody who wants to take a more, I would say, quote-unquote, passive role within the investment and just invest the money without having to manage the business can apply through a regional center. These are the two ways that we're, the one can invest for within the EB5 context. As far as L1, really there is no type of business that's more suitable. The L1 boils down to there is a company abroad that's seeking to expand in the United States. They're looking to transfer either somebody who has held for 1 year within the past 3 years, managerial, executive, or specialized knowledge, capacity, or role. They're seeking to transfer this employee to work for a sister company, an affiliate company, a parent company, or subsidiary company in the United States in one of these three roles.
All right. So I think that was a very insightful answer that we got from you, and thank you so much, for putting that up. And let's move ahead with another question that is of L1 visa. So, Alessandro, we all are aware that L1 visa is known for intra-company transfers. So, can you please explain like how a foreign company can use the L1 visa to expand into the US?
Sure. That's exactly the purpose of this type of visa, of this visa classification. The L1 visa enables a foreign company to transfer employees to the US to establish or grow a US branch, an affiliate, or as a subsidiary. So the very first requirement, when we're looking at L1 visas is the qualifying corporate relationship. For example, shared ownership. As I mentioned before, the foreign company and the US company, they have to be their affiliates. They have to be, one has to be parent and the other has to be a subsidiary. That means that one has to own and control the other, or they have to be owned and controlled by the same person, the same company, or the same group of owners. So that's the first requirement. Second requirement is that the transferred employee has served for 1 year within the past 3 years as an executive, as a manager, or as a specialized knowledge employee or worker. And this person needs to be transferred to the US to hold one of these three roles. And the role doesn't have to be the same. So if I was a manager for a year within the past 3 years in the company abroad, I worked in managerial capacity, the company in the US does not have to transfer me necessarily to work as a manager. I could be an executive or I could be a specialized knowledge employee. These are pretty much the nuts and bolts of L1 visas and how they can help companies, foreign companies, expand into the US market.
But Alessandro, I am thinking about it. Like as you mentioned that the company can. It's not important to have the managerial post only. If a person is manager in this company, then through L1, it's not compulsory to have that managerial post. Then don't you think it's going to reduce the skills? Because if the designation is not exactly the same, how they are getting in that different nation, with the same company, then don't you think it would be a little affecting the employer in a negative way because the designation won't be the same? So, what's your point on this?
Not necessarily. Not necessarily. So there is no legal requirement that the person holds the same role abroad and in the United States. And if, given the fact that there is this flexibility, if the petitioning company in the US decides that that employee is better suited or is needed in the US in that new vest, quote unquote, or in that new role, maybe there is a reason. So I would say that pertains more to business decision rather than a legal decision. From a legal standpoint, we can have somebody who was a specialized knowledge employee in their home country for the company abroad, the foreign company. Maybe they're needed managing personnel or managing, department or a unit or of the company in the US, and that's perfectly fine. How that affects the operations of the US company, that's more of a matter for the US company from a business standpoint, I think.
All right. I think that's very well explained, and I got my answer. I hope our viewers too got the answers. And meanwhile, Alessandro, the great thing is that there are some viewers who has joined us, and I can see Sanjay, I can see Sudhir, I can see Ravi. So, friends, it's lovely to have you all. And do let us know from which platform you friends are watching us right now, and keep on posting a question. It's not mandatory, to just post one question. You can ask follow up. You can ask any question related to today's topic, and we will definitely take them up. But till then, wait for some times. After asking some random questions from my end, I'll be coming back to your questions. Okay, now, yeah, Alessandro, now I have another question regarding the EB5.
So we know that EB5 is more for the green card and it provides the permanent residency. But we want to know more about it. Like, what does the EB5 visa offer other than just a green card?
So I would say that there are three main benefits. Number one, the EB5 investor can live and work in the United States permanently because they're going to get their green card if they meet all the eligibility requirements, and they can work anywhere in the country, and they can you know, do any kind of work, lawful work. Obviously, they don't have to work in the business where they invested funds in, like the E2 investor has to do. The E2 investor has to work in the E2 business, in the E2 company. The L1 transferee has to work for the L1 petitioning company. The EB5 investor, once they get their green card, they could live and work anywhere in the United States. So there is that kind of flexibility. Then family, they can bring along the family, so spouse and children under 21. And once they get their green card, they can also work and live anywhere in the United States, right, indefinitely. And they have access to, especially for the children of EB5 investors, they can gain access to U.S. schools and colleges at the same tuition rates as American citizens. Usually, that obviously, depends from school to school, college to college, but that's what I have seen and what the trend I think is. And then number three, after 5 years of being a permanent resident in the U.S., if you meet all the other eligibility requirements, you can apply for U.S. citizenship. These are the three, I think, most important things that EB5 option offers more than E2L1, just beyond getting, I get my green card. This is what happens when you get your green card. You can live and work anywhere. Your kids can go to school at the same rates as, American citizens. And then you can apply for citizenship after 5 years.
Wonderful. I think that's wonderfully explained, with the pointers. So thank you so much, for letting us know about it. And I think it was a great answer. And most of the viewers, mostly think about, there's a confusion regarding EB5 most of the time, because EB5 mostly they consider for the permanent residency. But now I think after watching this session, they might be knowing more about it. But, I have another question that it's just a random thing that what can you say about the visa process out of like E2, L1, and EB5? Which visa process takes more time or maybe less time? Can you just talk about
Definitely the EB5, this is notorious. EB5 processing times are way longer. E2, you can apply for an E2 visa in two ways. If you're in the United States in lawful non-immigrant status, you could apply for a change of status. That doesn't give you a visa. That puts you in E2 status, right? If you are abroad, you apply for the E2 visa at a consulate. So the processing times depend on the times of the consulate. There are consulates who have higher backlog or lower, more of a backlog or less of a backlog. So it depends. The L1 visa has two steps instead. Well, you could also apply for a change of status, but let's say you're abroad and you're applying, you want to have the actual visa in your passport to be able to travel and enter as an L1 transferee. So you first petition, the U.S. company first petitions files a petition with USCIS, so in the United States. And then once approved, the petition gets transferred to the consulate abroad. So we also got to wait for, consular for the consular interview or consular appointment, and that depends on how long the consulate will take. EB5, different ball game, very long times, could take up to 2-3 years. But if you're looking to get your green card and establish yourself permanently in the United States, it's definitely worth waiting.
Absolutely. I think waiting for 2 to 3 years instead of and getting in return for a lifetime permanent residence, and I think it would be much worth it, But I think that's great. And
we are getting to know about the visa process also with these three visa categories. So thank you so much again.
Yes.
We have, I think let's take a few questions from our viewers because we are getting so many questions, so I don't want to upset them. And let's take Ravi's question. So Ravi is asking that my passport is currently under renewal and I have a valid H-1B visa stamped until September 2025. However, my I-94 is set to expire on January 12th, 25 due to the passport's expiration date. Once I receive my renewed passport, what steps should I take to extend or update my I-94 to reflect the visa's validity? Can I do this within the US or do I need to leave the country and re enter?
Can you go back to the slide before?
I think, okay, let me read out this another question. And what can I do if my passport is received after my I-94 expiry?
I'm assuming this person is in the US, right? Ravi, I'm assuming you're in the US.
I think, Ravi, it would be great if you could let us know where you are actually asking this question in US or some on the other country.
I think you are in the US. So the I-94, so this is a general, generally speaking, the I-94 is what dictates your period of authorized stay in the US. You have to be very careful what's the expiration date of the I-94. And also if there are very fact-specific questions, I would rather address them individually. So I encourage you to give me a call or to contact, an immigration attorney. There's my contact information right there, because there might be other questions that I want to ask you, and that might play a role into the answer.
And here Ravi answered yes, he is in Denver right now. So I think you predicted right.
Right. Yeah, I would assume so. So seems that there is a 994 that is expiring soon. That seems something time sensitive, very delicate. I encourage you to schedule a consultation.
All right. So
generally speaking, you can extend your status. You can extend your status being in the U.S., but you have to file paperwork. You have to wait. So it really depends on what the facts are, what the circumstances are, to determine what's best, because you could leave and re-enter if your visa is valid.
Absolutely. So thank you so much, Ravi, for asking this question. And in case if you still have any follow-up question or would like to know more about any other question, any other topic that you would like to know, then please post them on the comment section and we will take them up. And meanwhile, you can also consult with our today's attorney, Alessandro Giordano. And the contact details are visible on the screen. You can see the telephone number is 973-494-5649. And you can also email him I would like to spell it out. That is AGIORDANO at THECOMPASSFIRM.com. And you can also visit his website, that is www.thecompassfirm.com. So I think it would be one of the great thing, if you could directly ask this question or any other question if you are facing related to immigration process, so I think this would be a great one. And with that, I think let's take the another question that we received from a YouTube viewer, and that is from K. Vishwanathan. So his question is that L1 visa petition to be filed this month, but mostly after 17th Jan or 20th Jan. What will be the challenges and new rules with Trump administration? What would you like to say?
So it's hard to predict exactly if there will be any new rules. I think that after January 17 or January 20, after when? How long after those dates? I think that's still early in the administration. Maybe it might still be early in the administration to have any meaningful changes. So I would just, unfortunately, that's the only thing that you can do for now. Wait and see. But I don't know if there will be, again, catastrophic changes for these kind of business visas. I've seen, yes, during the past administration, the previous Trump administration, um, adjudicators were a little tougher. I could, I noticed that trend, you know, um, tougher decision making on immigration officers' part. But really, the big changes that I expect are for people in removal proceedings, individuals in removal proceedings, or individuals who overstay their visas, individuals who are here undocumented. Um, I'm not saying not to worry, but yeah, wait to worry.
Absolutely. And, with Trump's administration, we have also come across that in his first term, he was trying to limit the H-1B visas, but now most of his statements, he is actually favoring H-1B visa. So,
Right.
H-1B visas, people are more into it. But what's your opinion on this?
Yeah, as I said, employment-based and investment-based visas, I have not seen the administration being so tough as in other aspects of immigration. I practice a great deal of not only E2s and L1s, but also EB1s and EB2s. And to be honest with you, I haven't experienced that much difference. One thing that was different was when the travel ban was implemented. So that could affect the ability to travel, but that's not specific to L1 petitions or E2 petitions. That is across the board. Um, the only thing that I can say is that we're all, anxiously waiting for these changes. We just need to wait for now.
Absolutely. We can just hope that everything goes smoothly. But
Right.
as most of the people are very much concerned about like what's going to be under Trump's administration, but mostly, we have seen that he has been very stiff towards the immigration. But
Right.
if we look now for the H-1B visa, I think that's the mostly highly skilled workers that people need, right? And he's actually in favor of that. So I don't think any other visas like E2, L1, or the EB5 will also going to face some kind of hurdles or problems, regarding this
Yeah,
administration.
that's consistent with what I've seen before. Yeah, they were a little tougher. Administration was a little tougher, but nowhere near other areas of immigration law. So yeah, I don't expect a catastrophe like for other immigrants.
Well, we hope so. And what do you think about the Biden's administration? Was Biden administration more in favor of immigration as compared to Trump's administration? What's your call on that?
I have seen. So I have two takes on this. Definitely more in favor under certain, um, you know, from a certain standpoint, not as tough, not as hard. When it came to individuals in removal proceedings, um, seeking benefits before the immigration court, and even adjudication of benefits like L1, C2s. Yes, not as tough, but also I have not seen this current administration favor immigrants and the immigration system as much as I thought it would. But now it's passed. We have, 2 weeks and we have to move forward and look what's ahead.
Absolutely. And I think it would be a great year, and that's what we can hope. So good luck to Americans, and obviously not just to Americans, it depends upon the whole globe. So
Right.
yeah, and, I think with this, Ravi has commented. I will definitely contact you, Mr. Thank you so much, Ravi, and it would be so good, that if you could directly consult with our attorney. And Vishwanathan is also here and saying thank you. Thank you so much,
Of
Vishwanathan,
course, you
for
guys are very welcome. My pleasure.
Absolutely. And with this, Alessandro, I'll be coming back to our viewers' question after some time. But I would like to continue with another question that's mine. For someone who is considering the E2 visa, what are the common mistakes that applicants make when proving their investment?
That's a very nuanced question. I like it. I will give you first the three most, I would say, common misconceptions of the E2 visa.
Yeah.
First, so that we clarify what the E2 visa is for and for whom it is. The E2 visa, people think that E2 visa is for everyone. Unfortunately, it is not. It is for only nationals of certain countries. It's a treaty investor visa. That means that the U.S. has to have a treaty with your country of nationality or your country of citizenship. Okay, so only citizens of E2 treaty countries can apply for the E2 visa, and this is it's simple to find out what are the E2 treaty countries. You just Google E2 treaty countries, and one of the first results is the for the website of the Department of State, and they will tell you what the treaty countries are for the E2 visa. So another misconception is that any kind of investment will work for the E2 visa. That's not correct. What I said, what I said before, the investment for an E2 visa is to be active, cannot be a passive investment. So many people ask me if they can buy real estate and rent it out as is for profit, and then if this kind of investment is suitable for an E2, and it is not. So an E2 investment must involve some sort of commercial or entrepreneurial activity. So passive investments such as in the stock market or buying real estate and renting it out typically do not qualify. Another misconception is that the E2 visa might lead to a green card. No, there is no direct path from an E2 visa to a green card. So if you, after you're here in E2 status, you want to apply for a green card, you have to, seek an independent basis. And you cannot pass from an E2 to an EB5 automatically or directly. That there is no such thing. However, the E2 can be renewed indefinitely if the business keeps operating and qualifying. So you could be here for as long as you want, so long as you keep meeting the eligibility requirements. Now, as far as mistakes when it comes to E2, one of the main mistakes is failing to demonstrate that an investment is substantial. We have to demonstrate that we have invested a substantial amount of money into the E2 business. And then another mistake that I see frequently is insufficient documentation of the source of funds. Remember, when you invest in the United States, this is valid for both E2 and the EB5, but you have to demonstrate that your funds, the funds that you're investing, originated lawfully. It's called the source of funds. So we have to thoroughly document the lawful source of your investment. I would say that these are the main misconceptions and most common mistakes when it comes to E2 visas.
Absolutely. And I think that was a great one because it's not just important to understand the mistakes, but also, what people predict and what people think with that, what mistakes they do. So thank you so much, Alessandro, and also for letting us know that these mistakes are not common only for the E2, but also for the EB5 visa. So
Right.
I think, it would be great if you could also, the EB5 investors can also look for these mistakes. And with that, here's another follow up question that we received from Ravi, and it is: will having a child born in France provide any advantage in expediting the green card process for an H-1B visa holder? What would you like to say on this?
Not directly, not that I can think of.
Okay.
Not that I can think of.
Mhm. Okay, that's not an issue. I think.
I don't. Not that I can think of in the sense. I don't think so. I don't think it will provide any advantage in expediting the green card. No.
Okay, I hope Ravi, you got your answer. And let's move ahead with another question also that I have in my mind. That is, Alessandro, we can say that entrepreneur. I want to talk about the entrepreneurs and the business people. So, is it like can an entrepreneur start a new business in the US under the E2 visa, or do they need to buy an existing business?
Great question. I get asked this question 100% of the time that I have an E2 consultation. People ask
Right.
me all the time, do I have to buy, do I have to start from scratch, or can I buy an existing business and maybe keep it as is or make some changes? The answer is both. Either option is viable. Entrepreneurs or investors who are looking to come to the United States on an E2 visa, with an E2 visa, they can either start a new business from scratch or purchase an existing business.
Mhm.
So starting a new business allows obviously more control over the business, but it requires, there are some hurdles to starting from scratch, right?
Absolutely.
Purchasing an existing business offers the advantage of maybe an established business, some maybe operational history, customer base. So from a legal standpoint, both options are viable. You can come to the United States with an E2 visa by both starting a new business or purchasing an existing business. Which one is better for you depends on what you want to do.
Absolutely. And I think that was a wonderful answer. So I hope our viewers got to know that it's not exactly necessary, that to have to start a new business or to buy a new one. It completely depends upon your situation. And if and still you want to need a further clarification, or still you want to personally connect with our attorney, then you can directly contact him on the contact details that's visible on the screen, and that is 973-494-5649. And with the email ID that is definitely I would like to read it out, and that is Agiordano at thecompassfirm.com. And with the website, you can also visit there. That is www.thecompassfirm.com. So with that, we have another viewers also, and Sanjay is here. So I would like to take up his question. And Sanjay is asking that I am running a successful IT business in my home country, and I'm thinking about expanding it to the US. Would the L1 visa be a better choice than an E2 visa for me? What factors should I consider when choosing between the two?
The very first factors that you want to consider, Sanjay, are number one, are you a national of one of these treaty countries? Meaning, you have a passport from a country that qualifies for an E2, right?
Right.
Not all countries, not all countries qualify for an E2 visa, right? So if you're not a national or a citizen from an E2 treaty country, your only option would be the L1. So that's the first thing that you want to look at. Number two, the investment. This is something that we haven't discussed, but I would like to touch on it, Sam, if that's okay with you. The
I
difference
think
between
yeah.
right, the difference between the investment part, between E2s, L1s, and EB5s. They're three completely different, type of investments required. For E2, the investment has to be substantial. The law doesn't tell us what is substantial, right? What substantial means doesn't say under 50 is not, over 50 it is. Under 100 is not, over 100 it is. No. Usually what I like to see is at least $100,000. So Sanjay, you want to look at, the funds that you can invest. Number one, if you're a citizen of a treaty country. Number two, if you can invest $100,000 at least. Those are the two requirements that I look at. Now, circling back to the differences, between the investment requirements, E2 has to be a substantial amount of money. L1 doesn't mandate specific investment. We just need to show that the company's operations in the US are adequately supported in terms of resources, personnel, but there is no set amount. And for the EB5 calls for a more significant investment, $1 million or $800,000 depends on on where the funds will be invested.
All right. Okay, so here's another question, Alessandro. And with that, thank you so much, Sanjay, for participating. And in case, if you have any follow-up question, then please post them on the comment section. And with that, here's another question, that what are some of the challenges and advantages of using the L1 visa to move employees or executives to the US?
Interesting question. So the first challenge that I see when it comes to an L1 transferee, this is more for larger companies with a lot of owners, right? We have to prove that there is a qualifying corporate relationship between the company, the foreign company, the company abroad, and the company in the United States. When you have a large multinational company abroad with a lot of owners, it's complicated to prove that there is that relationship. Maybe the owners are not the same in the US. Maybe ownership is not the same in the US, right? And that's the first thing that usually, could be challenging when we deal with large multinational companies. And then number two, it's something that USCIS tends to question a lot, and it's the capacity in which the individual worked in the foreign company, right? So this is always challenging, demonstrating the employee's executive, managerial, or specialized role. So we have to be very, very detailed in the description of the duties. We have to be very, very specific, because that's usually a challenging part.
Absolutely. And also, what would you like to say about the advantages?
So the advantages for the L1, I would say off the top of my head, number one, there is no minimum investment required. It's not like the EB5 or the E2. E2, again, as I said, I would like to see at least $100,000. For L1, there is no such thing. There is no minimum investment amount required. Number two, if you qualify for an L1A, chances are you also qualify for an EB1C, which is a type of green card, an immigrant visa petition that leads to a green card that has the same or very similar requirements to an L1A. So if you have L1A status, you qualify for L1A status, you're here in L1, as an L1A transferee, chances are you can pursue, after some time, you can pursue EB1C classification and apply for your green card. So that's the second advantage that I would say. Then number three, you're allowed to bring your spouse and your children under 21. You can come with the entire family. That's the third advantage, I would say.
I think there are lots of benefits to it, and I think it would be one of the great, a very safe kind of visa category to invest on. So thank you so much, Alessandro, for letting us know about it, and for explaining, not, I won't say in a very detailed format, but in a very crisp and clear way. And I think with this, you were correct. The short answers are more correct and more accurate to understand. So with that, I would like to continue with my next question. That is, how do E2 visa holders navigate the challenges of renewing their visas, especially if their business is still growing? And what steps can they take to ensure smooth renewals and improve their chances for the approval?
So when you renew your E2 visa, I feel like renewing is a kind of an improper term, because you're reapplying for the visa, right? And you have to show exactly the same requirements, that you made the same requirements of eligibility that you showed the first time. Just, you don't have to invest again, because you can use the initial investment, right? But the renewal success for an E2 depends on a few things. First of all, the business has to show continued operations, right? The business has to still be operating and running. So we want to provide financial records, to show that the business is operating and financially healthy, quote unquote. Then we want to show. I like to show that we are employing people in the United States, so job creation. These are usually the main point. There are obviously other requirements, but these are I think that the things where an E2 visa holder that wants to renew his or her E2 visa should be more proactive about.
All right. Okay, and with that, here's another question: that how does the E2 visa allow investors to manage their businesses in the US and eventually bring family members?
So this is what the E2 visa is for. If you are an E2 investor, you're investing in a business in the US, has to be an active and operating business. And as an E2 investor, you're coming to the US to direct and develop the business. That's what you have to do, and that's all you can do. Differently, the spouse can come to the United States as an E2 dependent, apply for a work permit, and work anywhere else. They don't need to work in the E2 business. And then children under 21 as well, they can hold E2 status up until they're 21. They can go to school. They're allowed to study here. So this is something that's definitely worth considering. I would say it's a great advantage for an E2 family that wants to move to the United States.
Absolutely. And I think it's one of the most good benefit. It's going to be a very beneficial for them as well. So we can see, lots of benefits regarding L1, E2, and the EB5 as well. Though the visa process are different, but it depends which category they are choosing for. But these three categories have their own benefits. And if we also look for the 2025, then we can just hope that it's going to be beneficial year for these categories too. And I think with that, Alessandro, we have covered almost all the questions. And with that, we have been left for 10 more minutes. So I think with that, want to take my, okay, let's take the viewer's question. And and here's another question that I have got from Sudhir. That is, if I apply for an EB5 visa and invest in a regional center, how do I ensure my investment qualifies under USCIS rules? Also, what happens if the project fails? Will I lose my visa?
That's a loaded question. So if you're going through a regional center, these centers are pre-approved. So they should already qualify, under USCIS rules. But still, EB5s are very complex and nuanced. So get a lawyer to assist you, even if you're filing to a regional center. Okay. And then what happens if the project fails? There could be an issue. There is a conditional period of 2 years, and after 2 years, you have, after the investment, you have to show that the project is still standing. So EB5s are complex. If you have the intention to invest a large amount of money, 800,000 and up, I would say it's worth contacting an attorney and being counseled and assisted by somebody who has experience with EB5s, because again, it's very nuanced, very complex, and there could be some pitfalls. And you need to be explained all these things so that you can make an informed decision.
Absolutely. I think taking expert advice would be a great suggestion here. So with that, we have touched Sanjay's question, Sudhir's and Ravi's question. And Alessandro, we have more questions from our Facebook group, because there also we have our viewers who regularly post questions regarding the immigration topics, that we mostly have our webinars with. So here's another question that I would like to ask from you. That is, does buying an existing home care facility qualify for EB5?
Overbroad question. I think There are many requirements to an EB5. Many requirements to an EB5. So, you have to invest in a new for-profit enterprise. So a new, commercial for-profit enterprise is one established after a certain date, or if it was the certain date is November 29, 1990. If it was established before, you have to restructure or reorganize it, or make some changes. So it really depends. Is a very fact-specific question. And you need to invest the required amount. And that depends on where you're investing. You need to show that you are creating a certain amount of jobs. So I think that it's hard for me to answer this question based on the very, very, very little information provided.
Absolutely. I think it would be great, the one that who has posted this question. And if you're watching this session, it would be great to have more details. And, it would be better for us and it would be better for our attorney also to answer your question. So, no worries. Let's move ahead with our next question. And the question is that I'm a Canadian citizen of Indian origin. What is the processing time for obtaining a green card via the EB5 route? Are there any quota restrictions applicable to individuals born in India?
So for the EB5, again, the timings are very, very long. What does it mean, a Canadian citizen? So you have a Canadian passport, but Indian origin. Where were you born? Because the restrictions are for certain nationals.
I think he has been born in India only, and after that, sometimes he took Canadian citizenship.
Right. There is some backlog, and nationals of India are a little, we know that there are some restrictions. But again, I would need to have a little more information to answer this question. To answer this question, there are some restrictions. Most EB5 categories now are current, or they have been current as of recently. But again, I would need a little more information to answer your question. So if there are questions that are very fact specific, I encourage you to, you don't have to. I like that you're posting anonymously. So I'm a big fan of confidentiality. But if there are, they're very circumstances or fact specific, I encourage you to shoot me an email and we can take it from there.
Absolutely. I think that would be the great one. And thank you so much, Alessandro, for taking this up and at least letting our viewers know about it, like what they can expect from you. And with this, we have another question that how long does it currently take to receive an EAD and an advance parole card? Are applicants still getting a combo card? Also, are these cards being issued for 2 years or 5 years?
Again, I don't have enough information to answer this question. I can tell you that yes, combo cards are still being issued. It depends. For example, recently I had a husband and wife. One of them got the combo card, the other one got the work permit only, and that got the advanced parole in the good old paper fashion. But yes, combo cards are still being approved, are still being issued. And then it asked if they're being issued for 2 or 5 years. So at times the duration of the work authorization document, employment authorization document, depends on the category under which you're applying. So I would need to know maybe more about about the situation.
Yeah. Absolutely, we completely understand this thing. And with this, I hope this question looks a bit detailed. So let's expect something from this. Control, if you could zoom in a bit so that it will be clear for
Thank
us.
you.
Thank you. Yeah. So it's the question is that good day to all. I have a few questions regarding E2 visa and would appreciate if some experts can provide advice. Firstly, if my spouse gets E2 visa and dependents, myself and kids, gets E2S, can the spouse who got E2 visa switch to E2's subsequently and dependent become E2 status?
I think
Let's
this question is asking if this person has E2 and the spouse has E2 as a spouse, and then they
Yeah,
switch. So the
true.
main E2 becomes the E2 spouse, and the spouse makes the investment. I mean, if you qualify, that's what I'm understanding, but it's a bit confusing to me. um, the way it's posed. If I understood correctly, it would be possible so long as you meet the requirements. And then I see that there is another question. After changing the status from B1, B2 to E2, while staying in the US, how E2 applicants may leave the US and re-entering. So I'm assuming the person enters the US with a B visa, a tourist visa, or B1, B2 business or tourist visa, with a visitor visa, and then change status. So if you want to re-enter in E2 status, you need to go to a consulate abroad and get the E2 visa stamped in your passport. And then you can re-enter with a E2
Mhm.
visa and have E2 status. So you would need to get the actual visa stamp in your passport for E2.
All right. So I think with this, Alessandro, we have completed our Facebook questions too, and I think most of our viewers also got your answer. And it's almost 1 hour, but there's one more question that I would like to know it from you because this is a mandatory one and it's very important to know. So, is there a famous company or entrepreneur who used the L1 visa to enter the US? And how did they ensure that their visa approval and what can others learn from their journey?
I love this question. So I love this question because many large multinational companies used L1 visa option. Like many large multinational companies,
Yeah.
go have their employees go this route to transfer them to the US. However, this is something interesting that I actually want to emphasize. The L1 visa is not just for large corporations. Small and even new companies can also take advantage of this option, the
Yeah.
L1 option, provided that they meet the requirements. Like there is something that is called L1 visa for a new office. So if you are a new company in the US, you can apply for an L1 if you're starting brand new in the US. You're in business for less than 1 year in the US. You can use the L1 to transfer employees from the foreign company into the new company in the US, even if you have nobody working in the US yet. So it is not just for, again, many large corporations use the L1 visa, but it is not only for large corporations. Small companies can use this too to establish or expand operations into the United States.
All right. So I think with this, we have almost reached to an end. And this was the last question that I wanted to know. And thank you so much, Alessandro, for taking this up and letting us know about it. And I'm sure, our viewers loved this session. They got to know so much about it. And the most importantly, I think they got more clarity regarding these three visa categories. And I think most of the people, they were concerned about the complexities and the problems, that is going to happen, that they predict that's going to happen in the upcoming year. But thank you so much to you for clearing that up and, taking all the questions very patiently and answering them. So from my side, I think this session was amazing one. And after all, this was your first time on our show. So I want to know, how did you feel? How was your experience?
I am very happy that you guys invited me. I appreciate the opportunity to be here and to share, all this information with your public. I hope they enjoyed it as much as I did.
Absolutely.
Thank you again. It was a pleasure for me.
Same here. And I think it was truly an honor to have you with us today and, to have this session and to introduce you to our viewers. It was one of the great thing. And thank you so much to our lovely viewers also who participated in today's webinar and asked their questions. And even after this 1 hour that got ended, after this also you can keep on commenting, you can keep on posting your questions. And in the next show that we are going to have with Alessandro, we will definitely take that up. So don't be upset with the fact that we are not going to continue our live session, because soon or the later we are definitely going to come back with another very exciting episode. And that's all. I think it's almost a wrap and we have reached 1 hour. So thank you so much, Alessandro, for being with us, for sharing such an insightful answers with us. I'm sure our audience loved it, and it was truly an honor to have a show with
Thank
you.
you.
So thank you so much.
Pleasure was all mine. Thank you.
All right. So thank you so much, everyone, for this amazing session. Don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. And we will be coming back with more exciting episodes with different attorneys. And stay tuned. Keep updated yourself by also clicking on the bell icon that is going to visible on the screen. So thank you so much, everyone. And I think good luck and take care. Bye-bye for now.
Hi everyone, welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me read out this very important disclaimer by watching our videos. You agree and understand that the information provided by our attorneys and guests, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this important disclaimer, welcome back everyone to Immigration and Jobs Talk Show. I'm your host Rajni Bharara, and today we are here to unpack the ever-changing world of immigration with expert insights and a lively discussion. Whether you're navigating the complex maze of visas or just curious about immigration trends, you have come to the right place. Today's topic: EB2 NIW visas. Are USCIS making it harder to get it approved in 2024? Buckle up, because we are diving deep into this hot button issue. And trust me, we have got the dream team to break it down. Yes, but first, let's give a warm welcome to our wonderful audience, whether you're watching us live or catching the replay. Thank you for tuning in. Be sure to stick around, because this episode is packed with valuable insights and maybe a sprinkle of humor too. And don't forget to drop your questions in the comments. And yes, after we get answers from our dream team, we will be asking your questions to them. So now, without any further ado, let's meet the dream team, our incredible guest for today's show. First up, we have Rob Melvin, a 26-year veteran in the legal arena and a licensed attorney by the Texas Supreme Court. Rob's journey has taken him from litigating in Texas courts to serving as a Foreign Service Officer for the U.S. Department of State, where he held consular commissions under 3 U.S. presidents and adjudicated over 9,000 visas. From diplomatic scrutiny trainings to managing high-profile visits from the likes of Hillary Clinton and Mike Pompeo, Rob has done it all. Today, he's a powerhouse in employment, business, and investment-based immigration. So, Rob, welcome to the show.
happy to be here. Thank you for the invite, and we're humbled to be on your show and thankful for the opportunity.
Of course, it's a pleasure having you on the show. And after Rob, everyone, let's meet our second guest, Philip Rodriguez, who might just be the Clark Kent to Rob's Bruce Wayne. Philip is a partner at Dos Rodriguez PLLC and brings 13 years of stellar experience to the table. He's represented clients globally, tackling everything from family-based petitions to removal proceedings with finesse. With a Juris Doctor from St. Mary's University and a knack for delivering personalized legal solutions, Philip is a force to be reckoned with. Philip, we are so glad to have you here. Thank you so much for joining us today.
Yes, thank you very much, Rajni. It's a pleasure to be here.
Well, thank you so much to Rob and Philip. And guys, let's get into today's topic. The topic, like I said, is the EB2 NIW visas. Yes, EB2 National Interest Waiver visas. With the USCIS rolling out the new guidelines, are these coveted visas becoming harder to secure? Are we entering a new era of red tape? Or is this just a bump in the road? Let's find it out from Rob and Philip. So now, without any further ado, Rob, I would like to come to you first. You know, while I was introducing you, you have this 26 years of experience. I might have accidentally called you a 26-year-old, which you also look like, the both of you. But Rob, also I would like to know from you, recently the US presidential elections results were out and the Trump is back with his very aggressive team and his administration, because every day he's giving us a shocker with picking those controversial candidates and making it harder for immigrants to actually think that is it going to be possible for them to get into the US now, or is it going to be more difficult? How is the situation going to be? So it's so chaotic and it's all over the place right now. So were you happy with the results? Let's first come to you and then we can see how Philip felt about it.
Okay, well, I mean, to my knowledge, I don't consider this bad news at all, especially for Indian nationals. It may be bad news for people from the Western Hemisphere that have come over irregularly, because I could see removal practices being very more difficult. But there's some things that I think that maybe your audience should keep an eye. I mean, listen, there's three people close to Trump now that have his ear and will have it regularly. You have the second lady, Usha Vance. You got Vivek Ramaswamy, and then you have Kash Patel. All three of those people are going to be talking to him every day. And believe me, they've been in the U.S. for a long time. They know the plight of the Indian retrogressed visas and the problems that people have been having coming from India to here. As for the comment on the adjudications becoming more difficult, we've actually seen in our practice, 2023 was the dream years. Those were the golden years for the EB2 NIW. We were shooting 3-point shots, getting approval without a lot of pushback. 2024 actually turned into a bit of a quagmire. That I don't know what happened. I don't know if USCIS was pushing back against the administration because of all of the irregular immigration coming in, maybe as kind of a retribution, if you will. But we have seen in 2024 more pushback, more stringent, more new requirements, almost pre-Danisar analysis to the EB2 NIW than we did in 2023. So I have high hopes for 2025 for the Indian national population. They're some of the smartest applicants that we have, the most highly educated, the most qualified, and I mean, in my opinion, everybody's got an opinion. I think Trump and his team are going to be looking for people of that caliber that are going to come in and kind of lift the boat of the U.S. economy with especially STEM, financial investment, those types of visas coming in. So I'm actually super hopeful that 2024 will go away for the EB2NIWs because it's been a rough year. And that 2025, once things start rolling, we're going to see a better improvement. Again, that's if USCIS, each agency kind of has its own culture, does its own thing. I worked for state under Trump. They pretty much ignored Trump and just kept doing their own thing. I mean, of course, they had to do some policy and economic and political moves that he made them do. But I was in the consular section, and they just kind of, they're like, yeah, whatever. So I don't know. I don't know if that is too much information or answers the question. But I think that we're going to see, I hope that we're going to see an improvement, especially in the fields of STEM, and cases where we can make a really good argument that in addressing a very specific national interest for the United States.
Philip, what about you? Because, Rob said that it's going to be, with Trump coming back with his team, it's going to be good for the market and good for the economy. And, we have seen that Trump is already talking about putting those percentage of tariffs on those countries, especially Canada. And, recently Canada's Prime Minister Justin Trudeau, he met President Trump, and he actually joked with him for becoming, Canada becoming the 51st state of and merging into the US. And he said, you are more than welcome to become, you will not be the Prime Minister, but then you can become the governor of the 51st state. How about that? So, he has really scared Canada. And, there are talks about putting 100% tariffs on the BRICS countries if they think about, getting another, if they are getting those, instead of, if they will give priority to some other, anything else apart from dollar. So what do you think? Because, there are so many talks about that. So how do you see? Do you think it's going to be good?
Well, yeah, I agree with Rob in terms of the EB2NIW visa, right? Because that visa is for people who can show that their work is in the national interest of the United States. And touching on what Rob mentioned, how we have seen, so under a Trump administration, we may see a stricter interpretation of USCIS policies, but I don't necessarily think that that's because it's the Trump administration. If we go back, let's think about DANISAR, which is the guiding framework for an EB2NIW petition. DANISAR became law in 2016 under Barack Obama. And since then, and think about that, 2016, that's only 8 years ago. So that framework hasn't been in effect for very long. Prior to DANISAR, we had a much stricter framework for EB2NIW under the New York State Department of Transportation. And that went into effect, I believe it was 1998. But the point is, we may see stricter interpretations of USCIS policies under Trump. I don't necessarily think it's a function of Trump. I think we'll get into this a little bit later, but I think it's more a function of the fact that a lot of people are learning about EB2NIW now, and a lot of people are filing those types of applications. It's become highly competitive, and that is why USCIS has to do a better job of sifting through all of these applications and finding out which ones are truly in the national interest of the United States. And I think what we're probably going to see is the industries that will be favored under a Trump administration are going to be manufacturing, I think national security, and I think technology, which may not be good news for those who would like to apply under the humanities or the arts. They may have higher hurdles to jump.
Okay. Well, thank you so much to the both of you for that amazing answer, and also for sharing your point of view. But with this, Philip, I would also like to know from you that what do you think? Do you think that USCIS gets influenced by who takes the office? Let's suppose, because earlier it was the Biden administration and now it's going to be Trump administration. So do you think they make plans and they make the policy changes or whatever updates that they give in? It somewhere gets influenced by who takes the office?
I think the leadership does have an effect on policy directives and adjudication standards. However, I don't think it's necessarily going to be a complete shift, right? I mean, USCIS is a relatively large organization. It has its own culture, right? So because a new leader comes into office who may have a differing opinion on policy, sure. I think it is fair to say that might influence some adjudication standards. However, I don't think that it's necessarily going to just make it impossible for people applying for EB2 and IW. As I mentioned, what we may see is a shift in the industries that are favored by this administration, because it's no surprise. Trump and his team have come out and said that they want manufacturing in the U.S., technology, and national security. And so I think we may just see a shift in the types of industries that are favored. Would you agree?
Rob, what about you? What do you think?
Definitely. I mean, it does depend who's put in charge of DHS, and then it flows down from there. And then they'll have the director of USCIS and the deputy director, and they will push downwards. But I've been inside the belly of the beast. I work for state, and I know they do have their own corporate cultures. I think, in my opinion, they're going to be more in line with, if these predictions are right, with the emphasis of Trump and his team continuing to be on manufacturing, tech, STEM, anything like that. I think it will influence the adjudicators in favor of pleasing their bosses. These people are all bureaucrats. I was a bureaucrat, right? So what's the one big fear to a bureaucrat? It's your career. And what is that? That's your review at the end of the year, okay? These are all civil servants. In fact, they're all graded on a G scale, which means you don't just get promoted. You actually have to, if you want a higher, better job, you want more pay, you have to apply for a higher scale, a GS 14 instead of a 13, right? Mm-hmm. So the only way that they're going to do that is they're going to have to show that they have a track record of pleasing their bosses. If their bosses are telling them, look, Trump says X, we need to go in this direction, and that's the order they're getting from the top, they're going to need to move that way if they want to eventually secure a higher level government service job and keep continuing on. There's some that'll be perfectly happily being a GS-12 and couldn't care less and just want to draw their check, do their 40 hours and build their pension, right? Mm-hmm. But there's some go-getters, and the hustlers are going to want to see, they're going to want to comply. So I think it's going to be a great year for EB2 and IW. 2024 has been a challenge for us in our practice, and I know it's not specific to us because we're members of ALA, and we have our distros with thousands of immigration attorneys all over the United States, and we constantly keep an eye on it because it's one of our areas of emphasis is employment, business, and investment, immigration. So we really keep a close eye. And I think it's going to influence them. Yes, I think there's a misperception that it has as much influence as it actually does, but that's just my experience in working for state. And I have a lot of friends at USCIS and DHS, so I kind of keep my thumb on that pulse as well.
Okay. So, but then, Rob, when you say influence, do you think that influence is going to be good or is it going to be bad?
I think for the Indian national community, it's going to be fantastic. Mm-hmm. it's one of the smarter applicant pools, one of the more ambitious applicant pools or countries, and just more qualified, and they're more hustlers. I mean, they just are go-getters. And I think that's going to be what the policy that they're going to want to be pushing downstream at DHS, down to USCIS and everybody else, to the adjudicators, is look, we're kind of changing the way we look at immigration. We want to do, as you've mentioned before, kind of a merit-based system. The family system will always be there, but they want to improve our economy. And the only way to really do that is to do a brain drain away from other countries. And India's got plenty of brain drain power to provide to the US. I think it's going to be good for India.
Okay. But then what do you think about the visa? I've still not delved into our questions that actually we have prepared for you, but I'm still coming up with the follow-ups. But then I would like to know from you, Rob and Philip, that then what about the wait times that India actually sees, from whenever the visa bulletin comes, the processing times, the wait times for India specifically are very long. So why do you think that happens? Philip, I would like to start from you.
Well, the reason you see these retrogressed visas and the wait times is because of the per country caps on green cards. It's a 7% cap on green cards from any country, and you have a lot of applicants from India. 7%, I believe that works out to around 9,000 visas, 9,500, something like that per year. But because we have so many applicants, that's what leads to the retrogression. And something that I think maybe we could see, there's legislation pending right now to remove the caps on green cards. And so that's something that we could see help with these retrogressed visas. But that's a great point that you bring up. And that is the biggest India-specific challenge, is that we're seeing retrogression for decades.
11 years to visa availability and 12 to adjust.
Yes.
Wow.
Yeah, so that's a very good point. And what you do in that instance, and what we advise our clients is, well, let's look for, if that's what you're going for, let's look for other ways to keep you in the US lawfully, keep you working. Let's look for other options, because the EB1A visa is just one tool in our toolbox, just one. We have so many available options out there. So that is key when it comes to an analysis for an Indian national who is seeking the EB1A.
Okay. And Rob, okay. So now I would like to actually ask from you that, but do you think in 2024, I mean, it's just about to end and 2025 is about to start, right? So do you think in 2025, EB1A is still going to be that golden ticket, for the immigrants?
Yeah, I mean, so here's what's happened, and Phil can put in his 2 cents. I think the H-1B program, the CAP H-1B program, has become such a disaster over the last 2 cycles that everybody kind of flooded from H-1B over to EB2NIW. And I think that's what's caused the problems in 2024. So what I would like to see happen, what I hope to see happen, is they actually fix the H-1B, because people have been gaming the H-1B so badly that the percentage of the lottery winners, I think, was 10% last year and 17% the year before. So people are opting for other ways. So they're going to the EB2NIW. EB2NIW is definitely the golden ticket. I mean, same with EB1. But you got to have a good package, you got to have a good plan, and you have to be qualified. It's not the golden ticket for everybody. We usually can knock out the first part relatively easy, to the EB2 analysis. It's when you get into the national interest NIW analysis, substantial merit, they usually just give it away, because the ones we're throwing up there, we're not throwing up to open up a McDonald's restaurant, right? We're opening, we're doing naval inspections and maintenance on cargo ships, oil platforms, logistics and supply chain cases, warehousing and distribution. I mean, those types of cases, you're not going to just get an EB2 NIW for any reason. But we usually, substantial merit, usually they just kind of give that one away because it's easy to articulate how something might be in the substantial merit. So then there's 3 prongs, but there's actually 4 because the first one has 2. Then you get to the national importance. This is the one where they're currently really sticking it to applicants. Okay, so what? Your program, that your subject matter expert has substantial merit. So what? How is what you're going to do going to be in the national interest? We have to now lay out the breadcrumbs piece by piece from their business plan, from their proposal to the substantial merit piece and connect the dots very explicitly for the applicants. And then you drop down to is well-positioned. You know, before well-positioned was kind of like, well, they've got a master's or they've got a good professional history. Now they want more. They're even asking for kind of like, okay, you're going to do this. Do you have the financial wherewithal? Where are you going to get those funds? Do you have any kind of track record in doing this particular endeavor? So they're making that one a little bit harder, but that one is usually we're able to overcome relatively easily. But then they jump to the last one, which is the most nebulous of them all, whether on balance it would be in the interest of the U.S. government to waive the labor certification. Well, what the heck does that mean? I mean, I thought we answered that in the first three questions, but basically we're making the argument that this is so necessary that we need to just move away the year and a half labor cert process, which is currently just getting longer and longer and longer, and just get this person in. Let's get him in. Let's get him going. Let's get him improving the country. You know, whenever there's a national crisis that or an international crisis that we can link to and cling on to, that's related to our client still, we do that to, you know, and try to file as quick as we can to, you know, to hit that particular piece. Like, we need this person in now. So anyway, I don't know if that answered your question, whether it's the golden ticket. It's not for everybody.
Yeah.
Not for everybody. It's not the Willy Wonka chocolate bar. You have to actually, you know, come in with merit in this deal. When we make you look as good as you can possibly look, but you have to have some juice behind you as well.
Right. I mean, if this is not the golden ticket, maybe US can also come up with, you know, golden visas like Dubai or maybe, you know, other countries. They offer golden visas, right? So maybe US can also come up with something like that. Right, Portugal. So, okay, coming back to my questions, Rob, I would also like to know from you that with President Trump now returning to the office, what do you think? What are the risks of reversing the more lenient policies recently adopted by USCIS regarding EB2 NIW applications? And how do you think that this might impact applications who already have begun their petitions?
Well, first of all, the more lenient policies, maybe that applied in 2023. We are not seeing that in 2024. So I think the question may kind of presume an erroneous answer. We think they're stricter now than they have been for the last couple of years. Although on paper they might be lenient, in as applied, they're much stricter. So everybody who's already in play, they're going to get adjudicated under the standards when it's on that person's desk. So whatever the policies are at that time, there's not going to be any kind of grandfathered in, because DONASAR is the standard, right? And has been since, what'd you say, 2016. So that standard hasn't changed. The way they implement the standard, that's changed. One couple things that have been problematic or troubling to us that we've seen is, we've read a lot of articles and tracked a lot of things that it looks like they're adjudicating a lot using AI tools, which everybody uses AI tools now, right? Problem is, I used to work for the government and I know what kind of software they usually get. And let's just say it's not ChatGPT 4.6 or whatever, we're seeing RFEs that are misspelled, incomplete sentences, jumbled, garble, repeat boilerplate clauses just that maybe don't even apply to the same case or the same subject matter. That's a problem. Mm-hmm. We also saw the recent article, they've subcontracted a lot of their work to Chase. So here you have civilians adjudicating these cases. I can't say for sure that they're adjudicating EB2NIWs, but by the RFEs we've received, it wouldn't shock me because it seems like the person making the decision doesn't even know what the heck they're talking about for the case.
Yeah, it's Rob brings up. So a request for evidence, just for viewers that don't know what that is, that's what USCIS sends to us after they've reviewed our initial submission, our initial visa submission. If they would like to see more evidence about our application, they'll send us a request for evidence. And it is no exaggeration to say that we have seen, I would say of the RFEs that we see, about 50 to 75%, they literally make no sense. And just like Rob pointed out, grammatical errors throughout, requesting evidence that was included with your initial submission. So on the topic of the AI and RFEs, I totally agree with Rob. And then as far as going back to the leniencies, I also agree with Rob. In our practice, we don't see any leniency. These applications, this visa is a very tough visa to get approved. Thankfully, we've had great success with that. One item maybe that could be considered a leniency is premium processing, and that may have been a leniency early on, but now you ask almost any immigration attorney who's in this area who handles these types of cases, and they will tell you maybe it's not such a good idea to file premium processing because that's almost like you're putting a target on that application, and it may draw greater scrutiny from USCIS. I would say in our practice we see that more likely than not. Certain applications that are just stellar applications, maybe they could benefit from premium processing, but again, what we see frequently is that premium processing, which could be considered a leniency, wasn't so lenient.
Not only, why would you pay $2,800 and probably some extra attorney's fees to do premium processing when your visa category is retrogressed by 11 years? So you're going to get a yes much quicker. People were doing that because of the elections. But now, we recommend our clients don't even utilize it at all because of the negativity. We think it's like a boogeyman out there that if you use premium processing, you're more likely to get a strong RFE, and they're really going to come at you because it's a war of attrition, right? Mm-hmm. A lot of people don't respond to the RFE on time, or it's much more work or much more cost. They just go away. So that's just that many less petitions that they have to adjudicate. But if there's no, it would be very difficult for me to imagine the benefit of a premium processing especially to an Indian national, a Chinese national, a Mexican national, any of the ones, Philippines, that are very retrogressed. Why do you care when you get your approval? Because you still got a long wait before you can do anything else.
Wow. Okay, as they say, nothing comes easy, and especially, if it is something really good. So I think those EB2 applicants, will really have to buckle up, and maybe they can start binge watching some stress management videos. How about that, Robin Phillip? So, but Philip, I would like to come to you and ask you, but do you think that with this, do you think there will be rush among applicants to file their petitions before, any anticipated policy changes? Because people, especially now that Trump has won, because they are every day thinking that some or the other policy change might happen. So do you think that there will be rush among applicants? And if people are considering that, what advice would you like to give them?
Well, I can tell you that the short answer is yes. And I say that because we've seen that. We have seen a rush in applicants trying to get their applications in before the change in the administration. We have had and any number of applications, but also the EB1A. We have people calling us every week, 10 to 15 possibly calling us a week, trying to get this EB1A petition, trying to get it filed. So we do see a rush, and we're seeing a rush from all countries in all areas. People want to come to the U.S. And so what I would advise anyone who is in that position that would want to get their application in before this current administration, I'd say, talk to a lawyer as quickly as possible. Give us or someone else a call. However, be realistic about your timeline, because in all likelihood, the EB1A, because as we've outlined, it is a difficult visa to apply for and come up with all the evidence. So it's not necessarily going to be filed before the new administration begins. So just be realistic about your timeline. And also, again, I know there may be some anxiety out there about the change, but come on, we change every 4 years almost. Whether it's the same political party or not, there's change in the administration every 4 years or so. And we've seen that in our practice, in Rob's employment with the government, in my practice in immigration law, in both of our practices. Change is going to come no matter what. You just have to select a team that is prepared to handle that change.
Right. So I think we are going to see a lot of people more than the attorney's office. They are possibly going to go to the astrologer's offices now, especially for these 4 years. But Rob, I would like to come to you and ask you that what do you think? What do you think about the Muslim majority countries? How are people dealing from those countries? And are you also getting calls from those countries? Because Trump with Project 2025, Trump and his administration are thinking of putting a ban in the Muslim majority countries, travel ban. So if you can please tell us about that too.
Yeah, we haven't seen a lot of that in our practice. I've seen zero. We both take calls and we usually interview the clients together. So we really haven't seen that as an impact at all. We have many clients from Muslim countries and it's like the boogeyman effect. It's like that's something that may never happen. Maybe it will happen. If you're that afraid of it happening, then get in. Let's get your case filed and go. But I can't predict with any certainty that that's going to happen again.
Yeah, we don't. On the topic of the boogeyman approach, we cannot advise our clients based that are rooted in fear. Right? We try not to use fear. We do not use fear to influence the way we handle our practice. Again, change comes every 4 years, and sometimes faster, depending on what the judicial system is doing and what new case law is coming out. Really, as Rob mentioned, we're members of the American Immigration Lawyers Association. Mm-hmm. It's over 1,000 immigration lawyers across the United States. And we are on listservs and distribution channels and emails. And so we follow this all day, every day. And new cases come out every day. Every week you get 3 or 4 or 5 new cases that change the law. I think the judicial system, it's on its track. It's going the way it's going to go. And I don't think that there's necessarily major influences on who's in charge.
Okay. Okay. Thank you so much again for answering the question, Rob and Philip. Now, I would like to come to you again, Rob, and I would like to ask from you, given the historical context of, the heightened security scrutiny during Trump's first term. So, do you anticipate that the USCIS will revert to a more stringent interpretation of national interest? And if so, what evidences might applicants need to provide to counteract this?
Well, I sure hope they don't get any more strict than they already are, because they're at a pretty high level, and Trump's not even in office, and they've been at that level all year this year. So, like I said, the strategy is you have to have a strong business plan. So you need a professional business planner, right? And they're going to take all of your strengths and all of your history, and then articulate the national interest. But now we can't just say, okay, great, this person is in cybersecurity and has a good professional background. This is a national interest. We're getting hacked by Iran and China and North Korea. So that's a good match. Now we have to show this person is cybersecurity. The first 3 months, they're going to do this to implement it. The second second quarter of the year, they're going to tie into these certain key areas of the economy or of the national landscape, and then these are going to be the results, right? So you really have to, more than ever before, for national interest, just lay down a crumb trail, paint a picture exactly how what you're going to do is going to help each aspect. It's very easy to articulate a national interest, but the way that they're saying national interest now is show me how your person is going to hit that national interest. It doesn't matter that, we've had the Panama Canal problems and problems in the Suez Canal. I want to know how your naval engineer is going to actually fix those problems. So then you've gone from just saying, hey, I've got a great naval engineer, and I've got there's huge problems that are causing supply chain worldwide, massive damage. Now you got to say, this is what my naval engineer is going to do. He's going to go over to XYZ spot, address, ABC issue. It's going to result in DEF result. I mean, it's a lot more work and a lot more intensity. And quite actually, as a law firm, we have to raise our rates a little bit to correspond with the amount of time that we're having to put in these. I mean, because these are getting to be, much more intense cases than they were before already. Again, I hope in 25 is that what we're presuming is going to happen is going to actually be the opposite. I want to see, like with Elon Musk involved and the emphasis on STEM, that they're going to be seeing, hey, this candidate's great. We know what the national interest is. Approve this, this petition. I can't say that it's going to happen. Those are my hopes, but it sure as heck can't get much harder than it is right now. And we're under Biden. We're under the Democratic Party. This year has been awful for national interest. So, I don't see how it gets much harder than it's been. Philip might have a different opinion, but
no, I agree. I think what we're seeing with national interest and heightened scrutiny has been coming down the pipe for a while now. And what we see is a focus more on immediate economic and job impact rather than long-term contributions. So part of the question was, what key evidence can we provide? Well, some key evidence is we need to have a quantifiable economic impact. What I mean there is we need to show the job creation, the impact, the benefit to the GDP. We also need to show that our applicants that they have industry recognition and they have endorsements within their industry. And we need to show specific examples of how their work aligns with the U.S. priorities, which we see as going more toward infrastructure and other critical industries like healthcare, like technology. That is some of the key evidence that we will have to show to show that these applicants will contribute to the U.S. national interest.
One more thing I want to interject, Raji, is that we've kind of taken a tact on our EB2NIW cases, treating them almost as if they're EB5s. So we like to see at least 10 direct job creations under the business plan. And then we also want to show at least some significant impact on what's called the TEA type zones, the high unemployment, rural, those areas, because those are what, in the government's mind, those are, kind of policies that they want to address. We're trying to use that mindset from over here in the EB5 world, implement that into our EB2NIW cases to kind of make that extra link on the national interest. Say, hey, not only is our person going to do XYZ resulting in DEF, but look, they're also going to create 15 jobs, 20 jobs, direct jobs, which will result in a downstream of 75 jobs, and they're going to help rural or economically disadvantaged or high unemployment areas in this way too. So we're just kind of having to try to get sophisticated, a little more sophisticated, and change the way we think about and approach these cases to kind of try to outthink the adjudicator, if you will. I don't know. It's, if you try the same thing and get the same result, then that makes no sense, right? We want to get ahead of the game.
Okay. Well, thank you for the answer, Rob and Philip. And Rob, you mentioned Elon, so I really hope that he actually takes the national interest to the next level, but doesn't dodge it.
There's things that need to be dodged, Raji. Believe me, I was inside the belly. That could be helpful to us in the long in our interest and your clients' interests. So anyway.
Yeah, that could also happen. So, but Philip, I would like to come to you, and I would like to ask you. But what about the applicants? In the fields outside STEMs, like maybe arts or social sciences. How can they strengthen their case to potentially the stricter definition?
Sure. Well, so applicants that are in the STEM fields, if we're thinking more, which I think USCIS and immigration law on a whole is going toward more of a merit-based system. We know we're pretty certain that under the Trump administration, it's going to be more merit-based. And so taking that into account, and taking into account the effect that might have on applicants that are in the arts or the education or social sciences, I think what we need to do is we need to have a clear, measurable benefit to the U.S. interests. We need to show evidence of these applicants' exceptional ability, and we need to show their national awards, their publications, their broad societal impact, how they're going to help the U.S. national interest. And so really the analysis is the same as any, STEM versus non-STEM, but we may just have to go deeper. As Rob mentioned, a key part is preparing this case as if we're applying for the big EB5 visa. And for anyone who doesn't know what that is, that's the big investor visa where an applicant needs to invest a minimum of $800,000 and needs to provide or create at least 10 U.S. jobs. That's a high threshold. And so I think part of the success that we've had with the EB2NIW petitions is that we take that framework and we try to apply it to these applications that have a lower threshold. But if we can hit that higher threshold, then that's great. And I think that's part of why we've had, and not just us, other immigration attorneys have been doing the same thing. But that's how we would show that a non-STEM applicant can contribute to the U.S. national interest and be successful with an EB2NIW petition.
But so, like, if you had somebody in the arts and social sciences, you just got to think, okay, what's a major problem? All these wars we've had in Afghanistan, all these soldiers that we've had come back with PTSD, part of their plan is going to be, we are going to go out into the veterans community and help kind of, rehabilitate and I don't know what the word is I'm grasping for, but kind of ease the pain of these soldiers through the use of our art program or our social
basically like coping mechanisms.
Social sciences, yeah. Sciences, yeah. So you got to think about how you're going to tie what would otherwise be, hey, this is just a great artist. This will improve our culture. If it was me, I would say, yeah, we're going to do that. But they're also, like, I'm just making this up. We're also going to help all the veterans with PTSD because we're going to go out to them, do outreach to them as a way to help them ease and recover, from the pain, mental pain that they have still from being in war.
Yeah. Mm-hmm.
Gotta get creative.
Mm-hmm. Yes, Rob, you were saying.
You have to be creative. You're just going to have to get very creative in those specific areas. It's not going to be good enough, I don't think, just to say, oh, I'm great at social sciences or great at art. You got to think about doing some other things and tying in some other aspects that you normally wouldn't do, but that are important to the Trump administration.
Right. Okay, thank you so much for that insightful answer. Well, we really hope that national interest, doesn't become, whatever that makes USCIS less bored today. It doesn't change to that because, that also happens, right? So thank you so much for that insightful and detailed answer, Rob and Philip. Now, a lot of people are actually posting their questions. So before I take my questions, how about if we move to the viewers' question?
Sure, whatever. It's your show. You tell us what you want to do.
Thank you so much. Okay, Andre is here and he says, I am Brazilian. And he says, hello from Brazil. And he says, this rule is not God or good. I'm not sure what he means by that. But okay, let's take Asim's question maybe. So Asim says, one of my friends applied for an EB1A NIW visa last year and got denied. He's now thinking of applying again, but the process seems more complicated with the new guidelines. Do you think the new rules are making it harder to qualify? And if so, what different should be done to qualify? Rob, let's start with you.
Like we've said before, Andre, the rules haven't changed. The way you approach the rules, you may need to change your approach because you don't see it. Your Brazilian friend doesn't see it because they just were a one-shot player, right? They just came up to the plate, they swung 3 times, and they struck out. You can retool those same cases, but use a firm like Rajni's or us or whoever you want to hire and rethink as to how they're being adjudicated now. What can we change differently? What can we change in your business plan? What can we emphasize more? And what different national interests can we try to hit and link to in a different way and maybe amplify the impact of your proposed endeavor so that you will be successful this time? Resubmitting it the same way you did it last time, you're going to get the same result, right? But the rules have not changed. The way they're implementing the rules have changed. So you got to stay current with that. You got to stay in the mind of USCIS. You have to stay, have your pulse, your thumb on the pulse of how they're adjudicating. Not just your cases, not just Rob and Philip's cases, but the whole nation's cases. Mm-hmm. And it's not something that a layperson would know because they're just, just throwing it in there.
Yeah, we've got to. I agree with Rob. The guidelines haven't necessarily changed. The bar has moved a little bit higher, but again, EB1A is not an easy visa to qualify for. Yeah. We often tell our clients that it is a superhero visa. We need to show how they are going to be a superhero to the U.S. interests. Mm-hmm. And so if it didn't work the first time, that's okay. We wouldn't discourage you from trying again if you can do it in a creative way where you can really bring to the forefront and highlight your experience, your knowledge, your record of exceptional ability.
Okay, thank you so much for that great answer, Robin Philip. Asim, I hope you have got your answer. In case you're looking for a follow-up, continue posting it in the comments below. Meanwhile, let me quickly take Sanjay's question too. Sanjay says, I have been told that supporting documentation plays a crucial role in the EB2 NIW process. Has the evidence required changed with the recent updates from USCIS? And if so, what kind of documentation is now essential? Philip, would you like to answer it?
Sure. I think documentation and providing the key evidentiary documents is key. It is key to an EB2 NIW application. And the biggest one is a professional business plan, a business plan that outlines every single aspect of the applicant's proposed endeavor. We need to show that they will contribute to the national interest of the U.S., that they will have a substantial impact, that they are that they're well placed to follow through and execute their endeavor. Okay, so a business plan is key, and maybe not stop there. In several of our cases, what we've done is, sure, it's a requirement. Any client that we work with, it is a requirement that they submit a professional business plan that is prepared by an independent company who looks at our applicant's record, CV, and is able to interpret that is able to create a professional business plan based on that record. However, again, we don't necessarily need to stop there. We can provide expert opinions. So in several cases, we have gone out and looked for U.S. experts on the particular industry or topic that the applicant would like to apply based on, and have those experts explain how the proposed endeavor would impact the U.S. national interest, how it would improve, how it would bring significant benefit to the U.S. interest.
Yeah, the average, to answer your question on paper, our average filings in these cases are minimum 500 pages, up to 700, 900 pages. Okay, so yeah, documentation is important. There's critical pieces that Philip's already mentioned. Number one is the business plan. Number two is if you're advanced degree, obviously you have to show that. If you're not advanced degree and you're going for exceptional ability, you're going to have a ton of documentation to prove up, because you're going to have to hit 3 of the 7 requirements, and you're going to have to do those through letters of reference, colleagues or people highly positioned within the government, business or academic sectors, as high up as they can, but they got to know you. They got to know your past accomplishments and what were the outcomes of your efforts, and then also give a really strong prognosis of your future, your potential, your potential energy, so to speak, because these aren't letters of you should give XYZ a job because they're a great person. No, these are letters of hyperbole, like to the maximum. This is the best person I've ever known. They resolved all these problems for this industry. It had an impact on the actual industry overall. And wow, what a great day when they become a U.S. resident, because they have the potential to take their proposed endeavor, shoot it to the moon. So yes, minimum business plan, letters of recommendation, and then all your paperwork you need to back up either your extraordinary ability or just your master's or PhD or your bachelor's plus 5 years advancing professionally in your area. And the thing I like about the expert opinion letters, those are kind of silver bullets. I mean, that doesn't mean you're going to win because of it, but they are very impactful because they're from industry experts in your area of expertise, totally independent. They don't even know this person. They're just reviewing the record and writing a professional opinion. Many times the CVs that they attach to theirs are like 20 or 30 pages long themselves for that particular expert. So, I mean, these are heavy hitters. The other thing I want to tell you is expect an RFE. You're going to get an RFE on everything. Everything. Oh my goodness, I got an RFE. I have a horrible case. I thought you guys said I had a strong case. That's not what they're doing. They're beating you down by attrition. So don't give them all up front, right? One of the strategies is to just hold back a little in anticipation of the RFE, because then when they bring the RFE, you still have some bullets in your gun that you can fire at the RFE, plus maybe go to some of these extraneous sources like an expert opinion letter.
Okay. Thank you so much for that answer, Rob and Philip. So no nepotism. It will all depend on the skills and right. So Sanjay, I hope you have got your answer. So make sure that you have all those documents ready that were mentioned by Rob and Philip, and you have to keep in mind that the nepotism will not work, especially not anymore. And yes, Rob is nodding. He is completely against it, right, Rob? Especially with the EB1A visas.
If you're talking nepotism as far as like reference letter, hey, if you can get a reference letter from Trump, you get that reference letter. We've had cases where we've gotten reference letters from presidents of other countries for the national of that country. Mm-hmm. So don't shy away from that. But it can't be just, hey, this is my niece or nephew, let them in. They got to know your professional abilities, your professional history, and your potential. So they got to speak professionally to that. It can't just be, well, Raji's a great person, so she should really be a resident. It's got to have some depth and substance to it.
Absolutely. And I think that's the reason why President Trump also endorsed, he said now if you are skillful and if you are adding to the US's economy, you will be eligible to get the green cards. And no longer because you are applying and because you are in the wait lines, you will be able to get the green cards. Only you are skillful. And if you are, getting graduated from the good universities of the United States of America, you'll be eligible to get the green cards. Is that why he also endorsed that, Rob?
Yeah, I believe so. I think, I just read an article, it was a Politico, right? Mm-hmm. Which is no friend of Trump or anybody on the right.
Right.
Yeah, so far left article basically saying, look, they are going to be looking for people with skill sets, especially in STEM, and sorry, I got a little off track. What was the question? Raji, what was it?
No, even I forgot. I was too invested in your answer. Even I forgot what I was asking. But I was actually, is that the reason why actually Trump endorsed, the skills?
More of a merit-based system. And in reality, I'll let you go ahead and finish your talk on the article.
Yeah. So the article was saying, look, Trump is an Indian national's best friend because they have the skills, they have the intelligence. They're going to bring, they're going to bring the heat on the areas that he wants. They anticipated the biggest pushback is maybe a problem with Congress getting heat from their constituents because we've had so many problems in the U.S. with irregular immigration that I think people kind of got fed up with immigration and lumped it all together, whether it's legal or, irregular. And so Congress might be more of a problem than Trump and his cabinet. But yeah.
And the thing with the merits-based system is, I think the benefit that I see to the way it's being laid out, or we anticipated it will be laid out, and how it was laid out during Trump's first administration is, I believe we're dealing with the merit-based immigration system as is, at least under the administration. Is they're giving you the guidebook, they're giving you the blueprint. Here are the 10 items that we're focusing on, and here's how you can qualify under each of those 10 items. Whereas to me, it may be a little bit more laid out, a little bit more transparent versus what USCIS may have been doing in the past, where it seems more discretionary, right? So if it's more discretionary and USCIS decides, well, we'll put more weight on this one item versus this other item, a merit-based system that is clear, that is transparent, could do a lot of good for visa applicants who do qualify, as Rob mentioned.
It might be bad for us as attorneys because it won't be as complicated, but I think it's much better for the clients.
Yes,
because they maybe just have a scorecard, right? And I don't know. I think it's going to be good for a lot of people groups around the world. Others not so much, but for certain people groups, definitely.
And of course, and that's how it should be, right? If you have those skills, and if you are a merit-based person, and you should be eligible to get the green cards, and if you're adding to the US's economy, you should be eligible, to get the green cards. Whereas, but then, talking about Trump, that's a whole another conversation, because then what he sometimes says, then his actions are, complete against what he's saying, because, he wants to have the merit-based system for the immigrants. But then coming to his own team, he's picking Linda McMahon as the Secretary of Education Department. So, I mean, that's a little controversial, right? Rob and Philip, I mean, I know that's a conversation for...
Rajni. He's a non-traditional politician, but still a politician at the end of the day.
True.
I won't defend him on that, but I do like Kash Patel and Vivek. I'm not gonna apologize for that.
Well, even I not just Kash Patel and Vivek Ramaswamy, but even Tulsi Gabbard and then Stephen Miller and then Tom Hooman as the border czar. I think those are some great picks, right? Whether you agree with his policies or if you disagree with what he says, but then some of his candidates are really amazing. And thank you so much, Rob and Philip. But I would again like to maybe take a few more questions. Hari is here and he has posted a question from LinkedIn. He says, I'm eligible to apply for this is actually for an H-4 EAD. So would you like to take this?
No, we really shy away from giving case-specific advice to a non-client for ethical reasons. We don't know the facts behind their... If you want to speak generalities, it's fine, but maybe this one's not the greatest one,
So maybe, Hari, what you can do is the details of Rob and Philip are scrolling below. You can directly, if you want to get in touch with them, you can get in touch with them, discuss your case with them. And yes, I'm more than happy to help you out, and you can, directly write to them. And let's quickly take Madhavi's question. Madhavi says, can you analyze the recent USCIS policy changes and court decisions impacting EB2 and IW visas and provide specific examples of how these changes have affected the approval rates and processing times for NIW petitions?
Well, I'll start. So sure, as far as the new cases, I mean, and so the biggest case that we've seen come out with EB2 NIW is the Matter of Danisar case. That's what provided the three prongs that we've been discussing all along that gave it a more streamlined approach to the pre-Danisar era, which was guided by another case, U.S. New York State Department of Transportation, which that required, it was a little bit tougher under that standard because what it required was proof of national scope and specific labor market unavailability. That was challenging for many applicants. And so what Danisar did in 2016 is it now focuses more on substantial merit and national importance. So we were talking about work by an applicant that it has inherent value and can be important to the U.S. interests. So what we've seen is a shift from the focus of market unavailability to the applicant's unique contributions to the U.S. And how I think that has affected the EB2 and IW petitions is it has like we were talking about with a merit-based system, it is laid out. Now you have a playbook with specific guidance as to how you can meet those requirements and have a successful visa application. And what we've seen is there has been an increase in the rates of approval. It's still a tough visa, but we think now we have a clear standard under which to apply.
As far as the court decisions that was mentioned in the last question, one thing that I see all the time on our distros, one thing to keep in mind, the NIW piece is completely discretionary. Completely discretionary. You cannot challenge that in federal district court, the U.S. Supreme Court, whatever. You will get knocked out at the knees immediately on a motion to dismiss your case. So if you lose your EB2 NIW case and you want to fight them in court, for wrongfully denying your case, and if they made that decision based under the NIW piece, it's a loser case, we call it. So if there was other key legal factors in the EB2 qualification part, you may have a case to go forward. But the NIW piece itself, it's in the adjudicator's hands. I don't remember the name of the case, but there was a recent case that came out speaking to vice consul, the inviolability. I always have trouble saying that word. It's inviolable. You can't violate the vice consular's decision, right? They're the judge, jury, and executioner in let's just call it the B1, B2 context, but really in adjudicating consular process cases. This recent case that came out totally strengthened that position. Before, there was a lot more challenges you can make to the consular decision, the vice consular decision-making process. But now they've been narrowed down tremendously, which was weird because just before that, there was a case coming out limiting the Chevron case, limiting the administrative ability of agencies to basically legislate upon, us. So, but since we're specifically talking about this concept, the cases are against any type of appeal to a district court in a federal lawsuit context.
Yeah.
It'd just be a refile would be your
Yeah, and just to add to part of the question was how has it affected processing times? We've seen shorter processing times in general for EB2 and IW. As a matter of fact, right now, as of this morning, we're looking at 10 to 13 months processing time for the Form I-140 for an EB2 and IW case. And then, of course, you think if you do premium processing, which we've discussed some pros and cons about that, then you're looking to a shorter time period of 15 days. So what DataSART has done is it's created a clearer path to the EB2 and IW visa.
If there's one thing I can add to, when we file our cases, we always put for consular processing, even though we hope we don't have to, because you can always adjust status even if you put consular processing on the petition. All you have to have is your receipt number for the approved petition. And if you have a legal way to stay in the U.S. And your case and your category is current, then you can adjust status from within the U.S. If you have to run the gauntlet of consular processing, you're basically going to get re-adjudicated again by the vice consul. You already got adjudicated by the USCIS officer. But that's not the biggest issue. The biggest issue is it's got to run through NVC first in Washington. There's going to be administratively a couple months to get you documentally qualified. And then they just wait. And they wait for post to have an interview available for you. We have cases that have been ready for interviews since September 2023 and still have not had an interview date yet in that country. And I don't know what the case is in in India at the embassies or consulates there. But in general, I think they're taking low priority on scheduling interviews versus the relative family member immigrant visa, which is means the most to Congress because that's the people that vote for them,
Right. Okay. Thank you so much again, Rob and Philip, for answering the question. Let me quickly take Trisha's question because she has also posted one question over here. She says, I'm considering submitting a waiver of job offer for the EB2 NIW visa, but I'm uncertain about how USCIS is viewing these types of cases under the new guidelines. Can you explain how they assess the waiver and what strategies might help to improve the approval odds in this area? Philip, let's start with you.
Sure. Well, with the NIW, of course, as we know, the benefit of applying for EB2 NIW is to waive the job offer, going through the perm process, which is, time consuming, a little bit, more expensive. So what we have to do is we have to show why it's in the best interest, why it's in the national interest to waive the job offer. And explanations of how the way we do that is we need to show that waiting for the job offer is not feasible or practical for this particular endeavor, for the proposed endeavor. We need to show that the applicant's skills and expertise, that they're highly specialized and they're not readily available in the U.S. workforce. That's another way to do it. And finally, a third example is we have to explain how waiving the job offer would accelerate the project's progress. If you make this applicant wait the 2 to 3 years, you're delaying this really important work that they can do in the U.S. So if you waive that job offer, what you're doing is you're accelerating that progress. You're accelerating the benefits that this applicant is going to bring to the U.S.
One other thing along that line on the whether or not it'd be in the best interest of the U.S. to waive the labor cert is to hit if you have a case where it's impracticable, like say this person, if they take a job offer at a certain place in this industry, will have a non-compete clause automatically because that's the industry standard. So they won't be able to benefit the industry as a whole. They will be pigeonholed into one specific employer, which will not help the national interest. So therefore, it's in the U.S. best interest to waive the labor cert. Or this person holds a patent on a widget that, it's impracticable because they own the patent, on the widget, and, no one else is going to get it. So let's bring them in and let's get them started and let's get them helping the U.S. Thrive.
Okay. So, Trisha, thank you so much for your question. I hope you have got your answer. Now, Rob and Philip, there are a few questions posted in a Facebook group by our viewers. So, if you don't mind, can I share my screen and maybe take some of the questions from there?
Sure.
Great. Thank you so much. Okay, I'm quickly sharing my screen. Okay, can you see the screen? Okay, so this person, I think Javier, has posted that he says, I'm a Spanish teacher. I have applied for EB3 and IW I-140. Does anybody know if there is any possibility to be approved? What would you like to say?
I would say no, because there's no such thing as an EB3 NIW.
EB3. EB3. Yeah, we assume she meant. I'm going to assume she means EB2 NIW, and we like to say that no case is impossible, right? We would need more details, but speaking hypothetically, a Spanish teacher isn't automatically ruled out from an EB2 NIW. However, what we discussed earlier, you've got to be creative. We've got to show what experience does she have? How would she benefit the U.S.? In the U.S. here, we're dealing with an ever-increasing Hispanic population, right? And unfortunately, sometimes a lot of the Hispanic population is in underserved communities where someone like the caller, the questioner there, could potentially benefit the community. We have to show how does her experience as a Spanish teacher improve the U.S. economy, U.S. national interest? So again, we don't like to say any case is impossible. That could potentially be a tough case, but it's not impossible.
Yeah, I think if she's got especially if she can hit the advanced degree portion, I think with some creativity and a good business planner, you could easily weave that into a strong national interest argument because of the just like Philip said, the segment of our country right now of the Latino segment is humongous.
Mm-hmm.
Yeah.
Or maybe having the right attorney might help in cases like these, right?
Sure, that is key. Having the right legal team at your side to help you navigate something that complicated.
Right.
Yeah.
So,
sorry.
No, please go ahead, Rob.
Identify the need and then connect the dots. That's what you got to do. Identify the national interest and then connect the dots in the proposed endeavor. It's just very explicit, and I that one alone, I think I could come up with about 35 different ways that we could make a strong argument on her behalf.
Well, Javier, if you're looking for an attorney for yourself, maybe get in touch with Rob and Philip. The details are scrolling below, so you can note them down. And we are also going to, I'm also going to read out the details for you. So if you are looking to get in touch with Rob, you can give him a call on the number 512-293-3023. I would like to repeat the number, 512-293-3023. You can also email him. His email ID is robmelvin@melvinlawgroup.com. robmelvin@melvinlawgroup.com, and his website is www.melvinlawgroup.com. And if you're looking to get in touch with Philip, you can give him a call on the number, which is 979-776-1325. I would again like to repeat the number, 979-776-1325. You can also email him. His email ID is Philip, PHILIP @dosrodlaw.com. Yes, and you can also visit Philip's website, which is www.philiprodlaw.com. So make sure to get in touch with Rob and Philip. They'll be able to help you with your case. I know it will be a little complicated and a little tough in comparison to others, like Rob and Philip mentioned, but they are the experts and they are surely going to help you. Thank you so much.
Just to let your viewers know, Rajni, both of those telephone numbers for Philip and I are also WhatsApp numbers. So if you have any WhatsApp users out there, they can send WhatsApp messages through those channels.
Well, perfect. What's better than that? Rob and Philip are just a WhatsApp message away, guys. So get in touch with them right now. Right. And also, I have one question which was actually posted 2 hours back, and it is from a girl named Kripa, and she says, I have an approved I-140. I'm waiting to file my I-485. My current employer told me that they won't file my I-485. Can I change my employer for I-485?
Well, Kripa, it's not clear what visa you're talking about there, unfortunately. Because what we're discussing is an EB1A visa, which does not require an employer. So maybe some clarification would be helpful. As Rajni mentioned, if you'd like to, you can reach out to us, offline, and we can get some more information about your particular situation and do our best to answer your question.
Perfect. Let me take one last. Rob, Tamer says, does the premium processing affects the approval percent in the EB2? What do you have to say?
That's back when I was young, it was the $64,000 question. Now it's the $64 billion question, right? Depends who you ask. I know some very well-seasoned attorneys, immigration attorneys, that have done tons of EB2 NIWs. They say premium processing is the biggest joke, the biggest waste of time, and it's just a throwaway of money. I know others that say it will actually prejudice you because you're putting heat on them. Remember, these are bureaucrats. I was a bureaucrat. You want to do the least amount of work that you can to get the day over so you can draw your check and build your pension. These are not go-getters. If they can kick you back an RFE in a premium processing case and then kick the can down the road, it's probably what's going to happen. I can't say it with 100% certainty that it will prejudice you. I've heard others speculate that it will. My opinion is they're worthless because of the retrogression. So why, unless there's some like insane pressing need to know the answer in 45 days that I would be glad to discuss with anybody offline. We try to talk our clients out of using it. Some people were so afraid of Trump winning that they insisted we used it. We used it, and they had to go through all the same stuff that anybody else had to go through. Thank goodness they were approved.
Yeah, and let's think about what premium processing does. What Rob mentioned is USCIS. You can't blame them. They've got a lot of work on their desks, and what we're asking them to do with premium processing is cutting down a 10 to 13 month process into less than 45 days, 15 to 45 days. You've got to think about what that does. If we had a project that normally takes 10 to 13 months and we had to cut down to that short period of time, they may have a lot of questions. And so what that may lead to is a request for evidence. So again, you're going to get a different answer based on who you ask, which immigration lawyer you ask. But yes, in some cases, maybe premium processing is the way to go. But what we have seen is in the majority of cases, it may not be the value that people think it is.
In that vein, of all the comments I've heard on premium processing, and I've heard hundreds, if not thousands, I have never heard somebody jumping up and down saying, "Yay, I'm so glad I chose premium processing because it was so wonderful and it was so beneficial to me." Not once.
But Rob and Philip, people are so scared of RFEs. As soon as they get the RFE, they panic and go into that chaotic zone and chaotic mode. So, but RFEs can sometimes also be helpful for their cases, right? So, in situations like this, how should they deal with? I mean, what should they do, and how should they deal with that?
As Rob mentioned early on, you go into, and we always explain this to our clients, potential clients early on, you have to go into it expecting an RFE, right? What we're proposing for our clients oftentimes is a very complicated endeavor. They're highly specialized, they're highly skilled. So there are going to be questions about the process. So we tell our clients an RFE is probably going to come, just expect it. What we do is we're going to be ready with additional evidence if we need it. For example, Rob mentioned the expert letters earlier. Those aren't required in the initial submission. They're not required. The business plan in most cases is sufficient. So sometimes some clients, in order to preserve resources from the initial submission, may say, let's not submit the expert letters right now. Let's submit the business plan. Let's submit the best initial submission we can. And if and when we get the anticipated request for evidence, well, then we provide that additional evidence. Like Rob mentioned, we keep a little bit back just so that we can respond effectively to a request for evidence and provide a clearer picture to USCIS of what our client is trying to do. So again, the takeaway is in this visa category, a request for evidence is likely to come. Just be aware of that up front so that you're not surprised by it when you get it.
The only case that I can remember us having where there was no RFE was the proposed endeavor had a direct impact on the amount of filing fee income generated to USCIS at an exponentially humongous amount. For some reason, that case sailed right on through without any RFE. It was amazing.
Yeah.
Well, I think that's a great way to actually put it. You should go with the expectation that you will get an RFE. I mean, expect the worst and you will never be disappointed, how they say it, right? But thank you so much, Rob and Philip. It was so great having you both on our channel and on our show, Immigration and Jobs Talk Show. We had an amazing show. We were actually supposed to have this for an hour, but we actually did it for an hour and a half, and we didn't even realize it. So thank you so much for being here. And even after doing it for so long, we couldn't even cover half of the questions that we actually planned for you. So maybe how about we do another episode on the same topic and we get into the depth of it.
Anytime.
Perfect. So guys, if you're looking to get in touch with Philip, you can give him a call on the number 979-776-1325. His email is philip@dosrodlaw.com. His website is www.philiprodlaw.com. So make sure you give him a call, WhatsApp him, email him, and also check out his website. And if you're looking to get in touch with Rob, you can give him a call on the number 512-293-3023. His email is robmelvin@melvinlawgroup.com, and his website is www.melvinlawgroup.com. So make sure to get in touch with the both of them. And like they said, their numbers are also available on WhatsApp. So make sure that you also send them a text on their WhatsApp numbers. They are just a text away. So again, thank you so much, Rob and Philip, for being here. Any closing note from the both of you?
No, thank you very much for having us on. It's been a pleasure. It's an honor to be on this show. We know you have a lot of viewers. We know that your show is putting out a lot of good information to all of your viewers, and we're honored to be a part of it.
My only thing to say is, India, keep your chin up. It can only get better, and I think it's going to get better for you. I think you have a lot more people in your corner than you think you have, and I am very hopeful for you, not only just in the EB2NIW category, but also hopefully bringing down the retrogression numbers and the weight that you have for your visas or your adjustments of status. So keep your chin up. Let's keep in there. Let's keep fighting. And we're here to help you out.
Thank you so much. Thank you so much to the both of you. Can't wait for the both of you to be back on the show with our next episode. And thank you so much again for being here. You both have a great day ahead.
You too.
Thanks. You as well.
Ciao. Thank you.
Guys, thank you so much for tuning in, and thank you so much for posting those amazing questions in the comments below. You can continue posting them whenever Rob and Philip are going to be back. Maybe we can take those questions and ask them in the second episode, or whenever they are back for the next episode, or maybe we can get in touch with them, write to them and get a reply from them, and we will post the reply in the comments below. So you make sure that you are continuously posting your question in the comments below. But for now, I'll have to take your leave. But you make sure that you are always tuned in to Immigration and Jobs Talk Show. So stay tuned with Immigration and Jobs Talk Show for every immigration update. I am Rajni, your host, signing off for now. I'll see you very soon. Bye. Keep watching and keep subscribing.
All right.